Hey, Zoe,
Yeah,
are you letting anybody in?
yeah.
Okay, you need to let me know though who you're letting in so that I know I'm not looking for them.
Okay, I'm just going down the list, so
Okay.
I can start at the bottom then.
Yeah. Well, I've already let somebody in that I recognize the names. I just want to make sure that we've got everybody. That's the only problem. Okay. I know. Let me look the other way. Look on the panelists list and make sure who's here. I think we're at a good space right now, Steve, that we've got most everybody in, and then the rest we can continue on later.
All right. Good morning, everyone. I'd like to call to order the Judiciary Committee public hearing for February 26th, 2021. We have one item on our agenda today, and that's Senate Bill 888, which is an act responsibly and equitably regulating adult use cannabis. It is a governor's bill that is before us today, and I know we have a number of folks from the administration here with us, so we're going to start there. Before we do, though, I just want to remind the committee that we have nearly 150 people who are signed up to testify today. At 3 minutes a pop, that's 7.5 hours of testimony straight through without any questions or delays or the like. I would ask the committee today, so that we can get to hear from the public sooner rather than later, that if you have questions, that they be brief, they be direct, and they be to the point, and they not be repetitive. I understand members may be in and out of this committee and other committees today. That's fine, but for the interest of the public and for those who are testifying, if you missed something, we can go back and watch it, or we can follow up, particularly with the administration officials, we can follow up offline. I would ask folks to stay to the bill before us today, and again, keep your questions pointed and direct, so that we can get to the public and hear from them before the wee hours of the night and into tomorrow morning. With that, comments from my co-chair of the ranking members before we begin?
Thank you, Chairman Stasher. I don't have any comments except to put it to echo what you suggested, and to remind people that the 7.5 hours is actually probably longer given the technology platform that we're on. So I don't think we're banning questions, but we're asking people to consider that, because there will be an impact on those who come to tell us what their perspective is on this bill. Thank you.
Thank you. Sorry. Did you want to thank him, and then I'll
go ahead, Representative Fishbein.
I have no problem with non-repetitive questions, but this is the process that we are unfortunately left with in a pandemic, and I understand that it's cumbersome and all of that. There's, I think, 7 people here from the governor's office. There's 6. It would be helpful if the governor himself was here to answer a lot of these questions. Perhaps that would truncate a portion of this. So instead of, handing off and all that stuff, but we'll proceed accordingly. Thank you.
Thank you, Representative. All right, we will begin then. First up, I think to introduce the bill and to give the high-level overview is the Governor's Chief of Staff, Paul Mounds. Mr. Mounds, you may proceed.
Thank you, Chairman Staffstrom. I want to thank Chairman Winfield. I'd like to thank the ranking members and all the members of the committee. My name is Paul Mounds Jr. I'm the Chief of Staff for Governor Ned Lamont. And I'm also joined by quite a few members of our administration representing, being able to answer all your questions and represent the governor directly. And starting with Senior Advisor Jonathan Harris, Senior Policy Advisor Mohit Agarwal, Policy Advisor Patrick Hoolan. From our agencies that are going to be represented today, we have quite a few agencies. So I won't go through everyone's names, but I'll say just the agencies that are represented. Office of Policy and Management, Mark Pelka, who's the Undersecretary for Criminal Justice. Department of Emergency Safety and Public Protection, Commissioner Ravella, representing, being able to take on any questions and concerns as it deals with criminal justice issues. Traffic safety, we have Garrett Ugalito, who's the Deputy Commissioner, as well as Commissioner Magambangi from DMV. Market regulation, we have Commissioner Siegel, Department of Consumer Protection. Revenue portions, we have now official Commissioner Mark Boughton of DRS. And we also have various members of their teams and their staff represented today. I think that's a perfect example to go into this bill. It's a comprehensive bill. It's a bill that will look, as the title says, responsibly and equitably regulating the adult use of cannabis. We have seen across the country and in our region that the regulation of cannabis is here. And this year alone, New York will be pursuing legislation. New Jersey, this past week, signed their legislation into law. We know what's going on in Massachusetts, and Rhode Island will also be presenting legislation. But that's not the real reason in terms of to regulate a marketplace. Real reason is to right wrongs. What cannabis and the war on drugs has done to our communities is unconscionable. And we have to take steps to not only right those wrongs, but take steps to make sure that individuals are not only among the marketplace, but are a part of the marketplace. So the overall, the problem, the governor will say it directly, prohibition has failed us completely. The war on cannabis has did little to protect public health and safety. Instead, it has caused significant injustices for many of our residents, especially people in our Black and brown communities. Cannabis is or will be soon legal in our neighboring states, as I stated. And it's time for Connecticut to join this regional and national movement. The overall solution we feel is necessary to put forth a comprehensive, well-regulated marketplace. So the governor has proposed a comprehensive framework for cultivation, manufacture, sale, possession, use, taxation of adult use cannabis that prioritizes public health, public safety, and social justice. This proposal will build on the significant work that the legislature has done in previous sessions, particularly this committee, as it deals with adult use cannabis, and ensures alignment that the approach is pursued by states in our region. So how did we get here? I mentioned members of my team, my direct team, as well as members of our administration who have worked comprehensively to put forth a starting framework. And the key word is starting. The beauty of the legislative and deliberative process is to make sure that we hear all voices and hear all angles, to make sure all concerns are taken under account and all questions are answered. This is not a final bill. I'll say it again, this is not a final bill. This is a bill that has to go through multiple committees. This is a bill that will have to have multiple voices a part of it and multiple people at the table. This is a bill that the administration feels is saying to the legislature at whole and those who are advocates and those who are part of wanting to bring about this change in Connecticut, we want to sit at the table. We want you at the table, and we want to get a bill to the governor's desk that he will be able to sign that really will have a full, well-regulated marketplace here in Connecticut that takes on all of those elements that I stated previously. You have the governor's formal testimony, and I know Ranking Member Fishbein has stated that he would love to have the governors here. Sorry that the governor couldn't be here today, but you have his whole team. You have the very people who worked on this legislation. You have the very people in the agencies that will have to regulate this legislation. You have the very people who have to promulgate this legislation. They will be here to answer all your questions, go really into details, and really have a full comprehensive conversation with the committee and the public at large. What I would like to do right now, with the permission of the chairman, is pass it off to Jonathan Harris to talk about some other elements of the bill. And you have our whole team and our full administration ready to answer any and all questions.
So thank you, Mr. Mounds. I think, yes, I think this most streamlined way to do this is there's a number of members of the administration who are signed up to testify. And I know there's some overlap, and I'm sure some of the questions will, we want to make sure they're addressed to the right people. So I think what we should do is we will give each of the folks signed up to testify from the administration 3 minutes. We are going to clock them. We ask them to be brief and to the point with their testimony, and then we will open it up to the members to ask questions of the administration, and hopefully the appropriate agency can answer. Because as you said, this is a comprehensive bill with a number of moving parts. So with that, I'd like to give Mr. Harris 3 minutes to testify.
Thank you, Mr. Chairman. Thank you, Chairman Winfield, Ranking Members Kissel and Fishbein, and to the distinguished members of this committee. I also want to give special thanks to Administrator Blanchard, who helped put together this panel in this virtual world. She was great working with, and kudos to her and other staff. I just really wanted to supplement what the Chief of Staff said and start off this important discussion today. Actually, continue the discussion of over the years and set the context by how we got here in the recent months. You know, we were very occupied, as you know, we all were, with the 24/7 effort to address COVID. And in the fall, the governor realized that the equity discussion hadn't advanced as he had contemplated under his bill last year, SB 16. And we didn't want to start these conversations in the heat of the session. It's a complicated issue. There are many different opinions on what equity is and how we can achieve it. So what the governor did is he asked me, Dave Reyes, and some others to pull together the Cannabis Equity Discussion Group. And we met from November of 2020 into January of 21. We met weekly, we pulled in experts, we divided into subgroups. There was a front end subgroup, licensing, that Jason Ortiz headed up, a back end, revenue, what you do with the proceeds, that Hartford Council President Mally Rosado headed up, and we had productive discussions. The consistent message from the beginning was that given the time frame of the discussion group, given the fact that we needed to get the governor's bill to LCO in January, and the fact that we had to take into account all fiscal implications, because we also in the executive branch have to produce a balanced budget on time, which needed to be locked before the end of January, it was highly unlikely that we'd be able to get sufficient details into the original bill. But we would lay out equity markers, as the chief described. We'd continue the discussion with joint and favorable substitute language and beyond that. And that's exactly what happened. There was actually an email that Jason Ortiz sent on January 26, when the budget was pretty locked. He said, "Thanks again to everyone who participated on today's call. We had an excellent group with a wide variety of stakeholders, and I'm looking forward to making these well thought out ideas reality." We had already had the bill pretty much done and it locked. But the one thing that we were able to get complete consensus on, and we did have well before the budget lock, a social equity study did make it into the budget, $75,000. So Governor is not ignoring this discussion group, not ignoring social equity. We want to continue that discussion. And I'll conclude here that we have two bills. We have the governor's bill, 163 pages, probably have some other bills and ideas out there. And we have Chair Porter's bill from Labor, a 24-page bill. One that has a full regulatory structure, takes into account other areas of law, like criminal law, traffic safety, product safety.
Mr. Harris, I'm
Yep.
going to interrupt you just quickly because we are at the 3-minute mark, but also I want to stick to the bill before us here in this committee today. I understand folks may want to compare and contrast, but in the Judiciary Committee, we hear bills that are drafted and presented to this committee. And so I would like, as our conversation continues today, I know folks will want to talk about different topics or issues that may or may not be in this bill, but I'll ask folks who are testifying to try to stick to the bill that is before this committee here today for our public hearing, because that's what has been noticed for a hearing.
Yes, I apologize. I wasn't trying to bring in the details of the bill. I just, I wanted to get to the notion that there are people out there that are saying these are competing, conflicting bills. They're actually complementary. They were forged under different timeframes with different responsibilities. And I'm not just saying that as a member of the executive branch. I spent 6 years in the Senate, 6 years before that as an attorney in the House. So I understand the different timeframes. But what I'm saying is that this is the process. And as Paul said, this is what we want to continue the discussion with not competing, but with complementary ideas. And that's all I want to say. The governor wants to sit down and go beyond this.
Understood, and I appreciate that. All right, we are going to move on. I think next on criminal justice issues, we have Mark Palka from the Office of Policy and Management, who has 3 minutes.
Thank you, Mr. Chairman.
Thank you also, Mr. Chairman, and Chair Winfield, ranking members Fishbein and Kissel, for the opportunity to present to you on the criminal justice sections in the bill, which cover sections 2 through 14. The bill overall creates a robust framework for regulating the adult use of cannabis with licensing and highway safety, taxation, revenue, public health. This section helps the criminal justice system to prepare for the state to regulate the adult use of cannabis in 4 key areas. Number 1, responses and sanctions for possession of cannabis above the limit, erasure of existing criminal records, establishing a regulated market without risk of criminal liability for retailers, and focusing criminal justice system resources. Under the bill, possession of up to 1.5 ounces of cannabis is permitted for those 21 years of age or older. Possession of between 1.5 and 2.5 ounces is an infraction with increasing financial penalties for second violations, and possession above 2.5 ounces is an infraction and then a misdemeanor for second and subsequent offenses. The penalties for underage possession are modeled very similarly to the penalties for underage possession of alcohol, involving infractions subject to suspension of a driver's license, with the ability to refer to a JRB or the diversion or the court for resources. The part I think I'll be focusing my testimony the heaviest on in my limited time is the clearance of criminal records. It is important now for us to address the wrongs involved in the war on drugs and the impact that criminal convictions and enforcement have had on our state, specifically on communities of color. There are 2 provisions, Section 4 and Section 5, regarding criminal records for people with convictions for possession of cannabis of 4 ounces or less. From October 1, 2015 forward, they could petition the court for erasure. For people with older records prior to 2015, they would be benefiting from a equity, efficient, and effective solution using an automated erasure process. Many states that enact adult use of cannabis provisions do include erasure. Connecticut would be a leader in establishing an automated process using synchronization from DESPI, the judicial branch, using CJIS, to notify criminal justice agencies regarding the erasure of these older records. This will enable people to move past these convictions less unburdened. We couldn't address the hardship as a whole, but enable them to pursue housing, employment, education, program, and much more. The governor has included $2 million for the implementation of using IT to provide an equitable solution to the impact of criminal records. We continue to work with the executive branch agencies and judicial branch to implement and plan for this effectively. And there are still some concerns from agencies around the specifics of implementation, and we will work very hard with them to address those areas. Because the automated erasure must cite a specific statute, there are other controlled substances in the automated erasure. Non-hallucinogenic, non-narcotic, and cannabis accounts for the majority, anecdotally, of those convictions. But this will allow Connecticut to address past wrongs, enable people to move forward productively and effectively without those hardships. Regarding the regulation of the cannabis market.
Mr. Palka,
yes.
you're at the 3-minute mark, so if you
Okay.
can just wrap up for me, all right?
Thank you, sir. The following two sections, areas I'd mentioned, enable people to work in the cannabis market without risk of criminal liability, and it helps to focus the criminal justice system resources more effectively under a legalization of adult use. Thank you, Mr. Chairman.
Thank you. Next, we will turn to Commissioner Ravella of the Department of Emergency Services and Public Protection. Commissioner.
Thank you, Representative Sessom. Good morning, chairs, ranking members, and all those folks that are on this call today. I've submitted a letter of support for Governor's Bill 888. Last year, I got a sense of the questions that kind of went across all of DESPE, right, to include the state police, post, and scientific services. So this morning, what I decided to do is bring along a host of experts to answer your questions. I introduced a few of the people. My executive assistant, Scott DeVico, is behind me. My chief of staff, Major Harbeck, and other people on here are Dr. Guy Valero, who's the director of scientific services, Dr. Michael Rickenbach, who's in the toxicology, assistant director of toxicology at Scientific Services. Karen Bovair is the director of POST, which is Police Officer Standards and Training. Dane Silcox, who's also on, he's the manager of SPBI, which is State Police Bureau of Identification, and he can tell you about erasures and criminal records. Lieutenant Bartolotta from the Connecticut State Police and his knowledge of the ARIDE and DRE programs. And not to be overlapping, we'll overlap with some of the DOT testimony today. Sergeant Giannone, who's in the SLFU of the State Police Special License and Firearms Unit. These are kind of the breadth of the questions I saw last year, and I want to make sure we get those answers for you. So we'll do our best to stay in our lane as you hear our testimony, and sometimes, like I said, it'll be overlapping with especially DOT and some with DMV. And as always, if we can't answer a question, we'll conduct our research and get it back to the clerk of the commission in a timely manner. Thank you very much.
Thank you, Commissioner. Yes, I'm sure there will be plenty of questions on the driving element to this, and we appreciate bringing your team along. Next up will be Garrett Eucalito from the Department of Transportation to introduce himself. Mr. Eucalito? No. Okay.
Mr. Chairman?
Yep.
There are DMV and DOT have some approach hearings this morning, so timing wise, that might be what's happening here.
Okay. Well, we can, I know they're around for questions, and like I said, I'm sure there'll be questions. So let's skip down to Commissioner Siegel on Department of Consumer Protection's piece to this bill. Commissioner?
Good morning, thank you. And thank you to the chairs, ranking members, honorable members of the Judiciary Committee. I'm Commissioner of Consumer Protection, and we have actually a fair amount of experience regulating cannabis based on our oversight of Connecticut's medical marijuana program. Our intent is to take a lot of that learning and apply it to this new adult use marketplace. Some of the key areas we're going to be focused on is ensuring product safety. So lab testing of products, limiting serving size, potency, steps to avoid diversion, so security requirements, seed to sale tracking of the product, licensing these businesses. There's going to be focus on avoiding sales to underage users. So requirements on checking ID, child-resistant packaging. There's a lot of rules around what kind of advertising would be permissible. And then another really important part of our role will be protecting the medical market and making sure that patients continue to have access to the medicine they need and ensuring that part of the market works. With that, I'm happy to answer questions about how we would envision regulating this market and what our role would be in that. Thank you.
Thank you, Commissioner. And finally, before we open it up to questions, I'd like to welcome Commissioner Boughton to certainly his first appearance before the Judiciary Committee as Commissioner.
Thank you, Mr. Chairman. It's my pleasure to be here today, and I've submitted written testimony, so you certainly can peruse that. So I'm not going to bother reading it. I know we're on a tight timeline. We have a lot of people that want to speak, and I'm sensitive to that. Our takeaway here from our discussion with me is John Biello, who's our Deputy Commissioner, as well as Lou Beccari, who's our Chief Legal Counsel. And of course, everybody knows Susan and Ernie, who are watching on YouTube, that can also get back to you with questions, answers to questions that you might have later on. If I had a takeaway, it would be this, that DRS is prepared to fairly and equitably administer tax provisions in a legalized, regulated cannabis market. I'm not going to go through all the tax provisions that have been drafted in this bill. I will tell you that DRS is in a stronger position now than it was a year ago to fulfill our responsibilities as they have been outlined. We've launched a first phase of a transformative multi-year modernization project that will improve how we administer taxes, and it has a module specifically designed for the sale and taxation of cannabis. Massachusetts has been down the same road, and we actually are using a lot of their technology that they've already implemented. So we have a system that will work. We certainly will benefit from resources that have been put in the governor's budget as they relate to personnel and technology. And of course, we're grateful for that. We stand ready to answer questions or concerns that the committee may have, and we'll be monitoring here for the entire time of the meeting. Thank you, Mr. Chairman.
Thank you. At this point, I would like to open it up to questions. Representative Fishbein, you're up first.
Thank you, Mr. Chairman. Mr. Chairman, I guess a general overview question for the panel is if they've read the bill and they agree with the content of the bill. If not, what portion they would disagree with.
I guess we'll direct that to Chief of Staff Mounds. It's my understanding that there are different hands that have written different sections of this bill. I know in the past when we've done this, we've bifurcated this across committees of the legislature and the like. I think the thought was to try to streamline that this year and put it all in one bill. So I don't want to speak for the administration, but
well, there is a representation from the administration. This is a working document. So I'm trying to figure out what parts are workable, what parts are not workable. Through that
yeah, no, I'll be happy to address that, Ranking Member Fishbein. Thank you for the question. Without mentioning or talking about any other concepts that's out there, the administration feels that the regulatory portion of this bill is the most comprehensive regulatory bill for marijuana structure that's currently within the legislative process. When we talk about a working process, I think it goes to the fact that this governor and this administration respects the deliberative process of the legislature. And so I think it's more the fact of us really saying, this is us putting forth a bill for the committee. As the chairman Staffstrom has stated, in the past, the bill has been split up for various sections based upon the agency of cognizance of that usual section. But this year, put it all as one. And I think the other thing is, obviously, there has been a lot of respectfully chatter as it deals with the approach by the administration towards this bill, particularly as Senior Advisor Harris was demonstrating as it deals with equity. And I think the key that this administration is saying is, if there are other items that people would like to talk about or other items that they feel is lacking in the bill, we would love to sit at the table and do it in a respectful manner. Obviously, there has, like I said, there's been a lot of chatter that's been outside of the legislative process to put characterization on the governor, his staff, and his administration. So I think that's what, to answer your question, I think that's what we're getting to, is that we feel that this is a very comprehensive bill. We feel that it's a bill that we should get through a legislative process, but we also feel that this is a bill where if individuals, legislators, caucus leaders, and others feel that needs to be modified or changed, we are all ears.
So am I to understand from that answer that the governor and the administration is comfortable with all aspects of this document as drafted?
Yes, we would not put anything in front of the legislature if we weren't comfortable presenting it to the legislature.
Okay, we'll get there in a little bit. So how do I deal with the fact that, I don't know if you took an oath of office. I did. Did you get sworn in to abide by the federal Constitution?
I will say this as someone who previously worked in the federal Congress, both chambers, someone who's worked in public service all my life, and I'm here with a bunch of my colleagues who work under me and the governor who've worked in public service. While there's not an official oath in the Connecticut Constitution that civil servants have to take, we do take an oath of saying that we will work as strong public servants on behalf of the people of the state of Connecticut.
Understood. And that's the troubling aspect of the governor not being here, because he's the only member of the administration that I believe does take an oath to the federal Constitution, which, you know, Article 6, Clause 2 of our federal Constitution, the Supremacy Clause, says generally that when the federal government creates a law, that it is supreme, and that a state cannot pass a law in contravention to that. Are you aware of that? I don't know if you're a lawyer.
I'm not a lawyer, but I can sure play one on TV.
Okay. So how do I, as an elected official who took an oath to abide by the state as well as the federal Constitution, in any way, shape, or form support the concept without there being an allegation that I've violated that oath?
I'll pass it off to Senior Advisor Jonathan Harris, who is a lawyer, for that question.
Thank you, Ranking Member Fishbein. I think you need to delve in a little bit more. What are we violating? Are you claiming a preemption argument here? I don't want to go into like a back and forth on this with you, but you know, what are we violating? We have a medical marijuana law that has been in existence for a while. You can make the argument on that too, I guess, if what you're trying to do.
Was that
other state?
Yep, I didn't want to.
So,
sorry.
No, that's okay. You can continue.
Well, has our medical marijuana law ever been challenged in the federal court?
Not that I know of, sir.
So it has ever been upheld by any federal court, any state's medical marijuana system?
I know no challenges, but again, I'm not here as a lawyer, nor have I been following all the case law around the country. So,
okay, so under federal law, marijuana is a controlled substance. It's on Schedule 1, which under the schedules means that it has no medicinal value under federal law. Just to put that into perspective, cocaine is on Schedule 2, which means that at least under federal law, it has some medicinal value, which I perhaps differ with, quite frankly. But that is the law of the land. So, you know, while I think I agree with the underpinnings of the movement, how do I vote for this without violating my oath of office.
Commissioner Siegel, I saw that you're unmuting.
Oh, I can leave it to Jonathan to answer that, and everybody obviously needs to make their own kind of decision on what that means. I will say the federal government is aware of states' medical and recreational laws and has I'm not aware of it. I'm certainly not aware of any federal challenge to Connecticut's medical marijuana program. The contrary, what the federal government has done way back in, many years ago is put out guidance in terms of how federal authorities will kind of use their enforcement authority in recognition that a lot of cannabis laws do exist throughout the state. So there was a Cole memo issued back during the Obama administration where the federal government acknowledged, and there's been follow-on ones with regard to banking and other things, acknowledging that these laws exist and how federal government should respond to them.
So have we reached out to the president? I know the president has talked about going to Congress, legalizing this product, which would have, alleviate my concern. But certainly right now, I mean, we are the United States of America. I think we fought the Civil War over, states not agreeing on what federal laws we were going to abide by. I just, I don't want to go in a circle here, but I'm having a lot of problems with our state, my state, saying we're just not going to abide by a federal law. We're going to do our own thing and then claim to be part of this United States of America. So we're moving forward, because I know we're going to be here for a while. Under this language, a 21-year-old or older can possess or use or consume this product, correct?
Correct.
Okay. And I know the last time we talked about this bill a couple of years ago, there was a lot of testimony about the mind of a youth and development, and there was a lot of talk about 25 as opposed to 21. Why is the governor picking 21 instead of the 25 here?
Jonathan?
I will turn that over to the criminal justice panel.
Yep.
And I have a response also, Representative Fishbein. I tried to raise my hand before, but when Commissioner Siegel spoke, but I can get back to that after.
Sure.
This is Mark Pelka. The 21 was selected to align with other states' laws regarding the adult use of cannabis and aligns with use of alcohol as well. And there would be a public awareness campaign associated with the legalization of adult use of cannabis that would, and there are a number of other regulations and requirements regarding where the centers could be, the storefronts could be located, and ways to really ensure that there is full public awareness about the dangers of use of this substance.
So what is the fear? I mean, we talk about being a leader, but here we're being a follower. Why was it Connecticut's decision to select 25? Is there a fear that a 23-year-old, to select 21 instead of 25? Is it a fear that if we select 25, that a 21-year-old is going to do it? I'm just trying to, supposed to be leading here. Why, instead of following another state, why did we select 21?
Mr. Chairman, this is, I think, an awareness that, well, for example, state borders are permeable, and that's something we're challenged with now. There are billboard advertisements around stores in Massachusetts already. We would know that a person who is, Connecticut were to make cannabis possession legal for 25 and older, then people falling in lower ages could be easily crossing the borders to make purchases and bring it back. We wanted to, there's been a number of examples of recognition within our tightly concentrated region that people can easily move across borders. So on areas we want to lead, and I mentioned some of those in my remarks where I think we're a leader, and there are other areas where it, for safety, for effectiveness, and consistency is the right approach.
So if Massachusetts changed to 18, then that would be our move as well?
I think 18 would then, I think if Massachusetts were to reduce it to 18, there would be a number of implications that would differ from us having a higher than 21-year age. You know, your original, the ranking member's question originally concerned, what if Connecticut were to set a higher age than a neighboring state? This question involves Connecticut setting a lower age, which would, I think, unveil a number of other considerations that would make it a different proposition.
Jonathan, did you want to add to that? You said you did.
Yeah, I just wanted to go back on the point. I'm glad that Commissioner Siegel brought in the Cole memo, which I remember from my days, that that took the attitude that laid out that if states are acting or people are acting within the parameters of state law, then the feds were taking a hands-off approach. But the reality is that I don't believe we have to follow federal criminal laws. The feds, can enforce those laws, and they've chosen not to.
So your opinion is that Connecticut does not have to follow federal criminal laws?
We can have our own set of laws. If the feds want to enforce their laws in the state of Connecticut, that's their prerogative, as the Cole memo showed, and as the lack of enforcement shows, the feds have taken a hands-off attitude on it.
Well, that's an enforcement issue, but that's different than a state. We'll go on. Under our bill, or the governor's bill, it deals with the Equity Council. And I believe the Equity Council is supposed to be guided by the study that is referenced on lines 534 through 541. Do we know how much that study is going to cost?
Can you say that again? Which the social equity study?
Yes, sir.
$75,000 is in the budget.
And while it's in the budget, have we actually put out any RFP or anything like that? Or is that just a earmark at this point?
That's just in the proposed governor's budget right now. We've been discussing ways to get that done.
And the intent of that study and then the commission is to give preferential treatment to individuals that currently live in disproportionately harmed towns or at any time lived in those towns.
It is not designed to give preferential treatment. It is not a disparity study. It is designed to identify those communities that have been, most severely impacted by the war on drugs. And
yes.
Then, yeah, it's not about the places. It's not about preferences for people.
Okay, but once those places are identified, what is the utilization of that information in the context of this bill?
It would not be based on race. It would be based on.
I didn't say anything about race, sir. We talked about a place. What would be the utilization of that identification of a particular place in the context of this bill?
The utilization would be to identify areas to help try to define what social equity applicants might be, to help try to define where revenues might be steered to help redress the injustices of the disproportionate enforcement of the cannabis laws.
Okay, so that's where I started. The social applicants, once a town is identified.
It might not be a town. It could be a neighborhood, could be a census tract. It's trying to target where social equity should be applied.
Okay, and once that area is identified and the social applicants, how is that employed here? That was my original question. Do they had to have lived there? Do they have to presently be located there? I can't tell from this language how that identification is supposed to be utilized for identifying an applicant.
First of all, that is part of what the Equity Commission will be doing. They're going to be making recommendations based on that. The bill does not flesh that out in detail.
Why wouldn't it? Isn't that the job of the legislature?
As I said before, Representative, we were having these discussions on how to best proceed to define social equity. And the details could not be fleshed out before this bill was raised. To the extent that those discussions can occur through the legislative process, as Chief of Staff Mounds discussed, then there could be more detail by the end of the session in this bill. But right now, the way we have it structured to mark the commitment to equity, to mark the intent to get to these issues, is having a study and a Cannabis Equity Commission to be able to oversee that study, to be able to make recommendations to future legislators to next session is what we have eyed on to make more detailed decisions. Some could happen before then as we proceed through the legislative process this session.
So, and I don't know who would answer this question. On line 583, it indicates that any person shall be 18 years of age or older to hold a cannabis establishment license. And a cannabis established license means that an 18-year-old can get a license to manufacture, grow, sell. But under this language that you all support, that the governor supports, they can't possess unless they're 21. Can you put that together for me? Am I reading that wrong?
Here, I can speak to that one. So you're not reading it wrong. And that's currently in the medical marijuana, you can be 18 to be an employee. And that's consistent, like 18-year-olds can be working in restaurants that may serve liquor. So even though you can't use the product, you could be, for example, in our medical businesses, a pharmacy tech. And so that's a job that's available to someone who's 18, even though they themselves, you know, really anybody who doesn't have a debilitating condition actually couldn't use the product. And so the law matches up where people who are currently employed in the medical program could remain employed in the cannabis industry.
And that's your interpretation of what that says?
That you can be 18 to be licensed as an employee, but you would have to be 21 to actually use the product, yes.
Okay, so where in this bill is cannabis establishment licensee defined?
So cannabis it's all in the definitions section. Yeah. So cannabis establishment is defined in the definitions, and it basically lists out the different types of businesses, and then employee is defined there as well.
Okay, but what 583 says is that any person shall be 18 years or older to hold any cannabis establishment license issued pursuant to this act. So the question is, what is a cannabis establishment license? So let's go back to the definitions. A cannabis establishment means a producer, dispensary facility, a cultivator, a micro cultivator, a retailer, a hybrid retailer, food and beverage manufacturer, a product manufacturer, a product packager, and a delivery service. So where is that 18-year-old under this language that the governor supports, that you're all here to talk in favor of, say it's only the employee?
Well, it's basically what it's saying is that to have any of the licenses that are being created, you need to be 18. So it lists establishments, it lists backers or key employees or regular employees.
So
it's just pulling all, obviously a human person can't be a business, but they are going to be the people who work at, own, or invest in those businesses and get the licenses associated with that.
I understand what you're saying, but that means that an 18-year-old can be a producer, a dispensary, a cultivator, a micro-cultivator, a retailer, a hybrid retailer, food and beverage manufacturer, so on and so forth. But because they're not 21, how do they possess?
So
is it in conflict?
Well, they wouldn't be able to possess, they wouldn't be able to for personal use if in conjunction with their role as an employee.
But they could sell to others.
Right, just like people now can work in the medical marijuana businesses, not be a medical marijuana patient. So they're allowed to sell the product, they're allowed to handle the product, but they're not allowed to use the product. So it would be similar if you had a waiter who was 19, they could serve a drink, but they couldn't drink it themselves.
And okay, well, it doesn't make sense to me, but I guess it does to the administration. Moving on.
Representative Fishbein, this is Mohit Agrawal of the governor's office.
Yes,
just pointing out the language in section 6 of the bill starting at line 368, which specifically allows for individuals who hold an establishment, cannabis establishment license or work there or invest in them to not be subject to the state's criminal laws on cannabis so long as they're doing their jobs.
Well, that's an interesting question, sir, because it doesn't have the word state in there, which is interesting. And it's certainly challengeable because it says that none of these individuals or entities that get involved in this may be subject to arrest or prosecution, penalized in any manner, or denied the right or privilege, including but not limited to being subject to any disciplinary action. There is no way that the state of Connecticut can guarantee that the feds won't revoke a license. So maybe the word state should be in there, which you just read in there, which made sense, but it's not in there. So, one of the reasons also that we shouldn't be treading upon federal law. Moving on to line 820.
Just do that very quickly. Section 18 of the bill, starting in line 590, also speaks to.
Let me go to 590. Hold on.
Mm-hmm. Speaks to the state and federal nexus.
Yes, I circled that one too, and I had the same concern with that one. And that as a standalone does have the word state in it, but the other one did not. So moving on to line 827 with the billboard situation. It appears that you selected a particular medium to ban advertising of this product. Why?
Representative, I can speak to that as well. To our understanding, no billboard in the state would meet the criteria under subdivision 2, so line 800.
Well, let me go to 800.
Where we are directing that 90% or more of the market be composed of individuals 21 years of age or more. And so in order to to clarify our intent. We thought it was clear enough just to say billboards for one are a medium which would not satisfy that requirement. That is an area, again, emphasizing what the chief of staff and the senior advisor have mentioned already. The reason we are here and the reason the governor's bill is in front of this committee is for these discussions. And so we are very willing to discuss exactly what the role of the billboard industry could be in regards to the advertising cannabis.
So is there a study or something that would indicate that it wouldn't be in compliance with the 90% rule as shown in line 801? Because that was, I mean, a newspaper, this arguably, because you didn't pick on newspapers, I would think probably gets more potential view by someone under the age of 21 than a billboard. I mean, newspaper open in the kitchen table. Where did this singling out come from? Because I've got equal protection, First Amendment issues surrounding you just picking on billboards.
So those are good questions, Representative. We are still in both a legal review process and a discussion process on these advertising restrictions. Our conversation with the Outdoor Advertising Association makes us understand that that billboards do not meet the 90% standard.
So that comes from them?
It does.
And what about radio?
I can't speak directly to radio. My understanding with advertising media in general is that there are mechanisms to identify audiences and different kinds of demographics. And so radio, I'm sure, has something that they can point to. But these are standard features of both alcohol, particularly the alcohol industry as well. And so there are metrics in the advertising industry to identify the age of the individuals who are seeing the advertising.
But a child can turn on a radio and a child can turn on the television, but a child can't drive a car, that's going down the street on a billboard and see the billboard. So I still don't understand the basis for singling that out. I did some poking around. I didn't see any industry stuff, but they would support that. But moving on to the ban on names. Well, I'm going to go on from there. On line 853, it indicates that under this proposed language that July 1 of this year, licenses will, for the purposes of where we are, 1 through 8, which starts with retailer and ends with delivery service, the department would start to receive applications. Under this language, when would the licenses 9 through 13 be available to apply for? Because that is not, I didn't see that in here at all.
Not sure what you mean by 9 through 13, but so 1 through 8 are the new ones being created. There are existing licenses, so producers, dispensaries, laboratories. So because those already exist, we don't need a start date for those.
Okay, so the backer license already exists?
Yeah, backer license. So right now, existing medical businesses already apply for backers.
Okay, so the licenses that I'm referring to, 9 through 13, would start on 890 through 896, and they're all, line 890 is parent 9, 891 is parent 10. So that's where I'm getting the 9 through 13. So all of those licenses presently exist?
Yeah, I mean, the way this is set up is elsewhere it talks about employees, backers, key employees getting licensed or registered. And so that would sort of happen as a follow-on once the business itself is licensed. We would need to then, at that point, license people the individuals working there. And sort of once you get to the later sections talking about employees and key employees and backers, it just sort of flows from that.
So I'm just trying to figure out, The licenses in 9 through 13, starting at line 890 through 896, do they presently exist? Because then one can apply for them now. That's all I need to know.
They exist in the medical language. These are going to be ones for employees, key employees, and backers. So right now there are backers and employees in the medical program. Key employee is a slightly different delineation here. But those licenses would start being issued once the businesses are licensed, so that we are then licensing the individuals working at those businesses. So that's the way kind of these sections work in conjunction. Is there's the date we can start accepting applications to identify the businesses that will be part of the industry. As those businesses are identified, they would need to start getting their relevant employees and investors licensed or registered.
Okay, so I guess the root question is, on July 1 of 2021, can I apply for an employee license, which is indicated on, or key employee license on line 891? Can I do that on July 1 of 2021?
Be no cannabis business yet. So we're not going to license you to be an employee till we know where you're working. So
I can't even apply.
Right. So once so you could apply to be an employee at an existing medical business. You can apply to be a backer in an existing medical business, but you would need to have been hired by, or have now an investment interest. We don't just have a whole bunch of individuals licensed to work at these places, and then they go out and get hired. The way it works is once you're hired, you apply to us to get a license to work there.
How does one know that they're going to pass the background check, which is required in here? If they're
the disqualifying conditions are listed in the statute, so you'd see if you had one of those.
So you would have to know if you have one of those before you apply. You get hired, and then the background check is done, which would indicate that you didn't have what you thought you didn't have. I don't get this. Why wouldn't you just allow somebody to apply?
There's not a pre-clearance process on background checks or anywhere in the state of Connecticut.
My last question has to do with home grow. Vermont passed a law arguably legalizing this product, and they allow for home grow. Why is that not contemplated? If all of a sudden this product is now appropriate, why isn't home grow contemplated? And why is this just if the state gets a piece of the pie?
I'll jump in, and anyone else on our team, feel free. I would say, obviously, we put forth a bill that the governor is comfortable with.
And he's not here to talk to us about that issue.
His chief of staff is. He's put forth a bill that the governor is comfortable with at this time.
So why is, and you're unwilling to share the uncomfortability with a couple plants in my backyard?
Well, I think there's more that needs to be looked at thoroughly as it deals with the homegrown related issue. But at this time, the governor felt comfortable putting forth a bill in the structure that's before the committee at this time.
Chief of Staff Mounds, I can just pick up on that. First of all, it's a good question, Representative Fishbein, but homegrown is correct. It's not allowed, but the criminal penalties are substantially reduced, and our criminal team, justice team can tell you about that. And DCP will conduct a study on the subject. One of the thoughts, especially since we have a viable medical marijuana program right now, and we want to get up and running a well-regulated, safe adult use market that protects the public health and safety, that by allowing home grow, it's contrary to that purpose, because you're not going to have a safe, clean, regulated product in the way that you would, or the way that we do under medical marijuana, in the way that you would under this well-regulated market that's being set up under the governor's bill. And that we did not want to jump into that right away. But again, we've reduced the penalties and we have tasked DCP to take a look at that.
I think I did have one for Alex Giannone, desk. Alex, you still with us?
Yes, I am.
Good morning, Sergeant.
Before we go there, can you just identify yourself for the record, please?
Yes, good morning, Sergeant Alex Giannone, Sergeant within the Special Licensing and Firearms Unit, Connecticut State Police, further within DESPP.
Thank you. Proceed, Representative Fishman.
Thank you. Alex, what is the department's position with regard to holders of medical marijuana cards and simultaneously holding a pistol permit? How are you addressing that?
Yes, good question. So there is actually a specific state statute which we rely upon, that when someone has a medical marijuana card and they've done it within the confines of the law, the statute says, and I forget the exact language, we shall not deny, prohibit any license, discriminate upon in any manner, way, shape, or form. So in understanding that law and respecting that law, we do not revoke someone's pistol permit based upon the sole purpose of having a recreational marijuana card. Or I'm sorry, a medical marijuana card. My apologies.
When you say the sole purpose, are you denying and or revoking based upon the usage of that medical marijuana card?
Yes, our understanding is one of the guidelines that the ATF and the FBI provide is that a user of controlled substances can be determined by one of a various number of manners, one of which is a conviction for a marijuana-related crime. Our agency our unit has been revoking pistol permits pursuant to the federal guidance for people who have received medical marijuana convictions. The convictions, if they are a misdemeanor or infraction, per the guidelines, recommend 12 months of dispossessing themselves of a firearm or not possessing a firearm for 12 months. Certainly, if it's a felony, or 21A 279C, I believe, is a state statute misdemeanor disqualifier, you are then prohibited currently from possessing a firearm and a permit.
So your department is abiding by federal law with regard to the fact that this product is illegal, and one who is a habitual user of or addicted to that substance, in your determination, is unable to possess a firearm and therefore cannot be issued a pistol permit.
Right, there's a bit of a dichotomy. So with medical marijuana, there is a state statute that says we shall not prohibit, deny, revoke the license for any reason, and it's very broad. So for medical marijuana, we're not taking any action based upon the state statute providing guidance to us as the executive. With respect to convictions for marijuana, we are abiding by the guidance that the federal guidelines suggest, which is 12 months, and we would be revoking a pistol permit for that 12-month period.
But understanding just having a medical marijuana card is under the statute not actionable to revoke or fail to issue a permit. You can revoke, or I guess it's the department's position, if that card is used. Let's say it's, I think under the law, they can buy an ounce a day or something like that. They're smoking pot every day, and that comes to your department's attention. You're going to revoke or deny, correct?
No. If they have a medical marijuana card and they are doing it lawfully, and there are no conditions of suitability that are presented, meaning they are using marijuana under the influence and carrying a firearm or doing something deemed unsafe, we are not revoking exclusively because someone has a medical marijuana card.
Okay, thank you. And I promised last for Commissioner Siegel, we were talking about the one having a license to engage in commerce or a cannabis establishment license, but they can't possess. And you were talking about the waiter situation. Isn't it true that the 18-year-old cannot get a liquor license?
Right, they couldn't own, for example, a package store, but they can work as a waiter. So this allows people who are 18 or older to participate in the market, but not actually use the product.
In effect, own a package store to vend this product.
Here in theory, they could have an investment. Yeah, they could be an investor.
They could own the whole kit and caboodle if they wanted to. But anyway, thank you. Thank you, Mr. Chairman.
Thank you. I think I had Senator Champagne next, if he's ready. Let's go to Representative Quinn, followed by Senator Champagne.
Thank you, Mr. Chairman. The questions that I have are concerning operating under the influence and how we're going to deal with this. So I'm not sure which one of our panelists wants to jump in on this, but obviously, currently, if someone is operating under the influence of alcohol, a police officer makes a stop. If they have a reasonable suspicion of alcohol, they can then institute field tests. And if there's failure on the field test and they decide to arrest, then we've got a breathalyzer that can be easily used. For marijuana, it's going to be different, though. As I understand it, there really isn't any simple test like a breathalyzer equivalent for marijuana. So you're going to have to obtain a urine sample or a blood sample and send it off for analysis. And right now that takes months to do that. Are we going to treat operating under the influence of drugs, operating under the influence of marijuana the same way as operating under the influence of alcohol? Or are we going to change that?
Thank you for the question, Representative Quinn. Chair Staffstrom, can we introduce the team from the Department of Motor Vehicles that I believe has joined the line? And Commissioner Ravella, if you want to introduce any members of your team on traffic safety. I believe the Department of Transportation has had to go join an appropriations committee hearing.
Let's do this. I don't know who wants to start with fielding that question. That seemed like a pretty broad one. I don't know if it's Commissioner Ravella or someone else, but if folks have not spoken yet, if they're going to speak, just make sure you identify yourself for the record. Commissioner, I'm going to start with you. Commissioner Ravella.
Well, thank you, Mr. Chairman. And I'll start with a quick framing to the bill. And to emphasize what the senior advisor was saying in his introductory remarks, the governor's bill is a comprehensive proposal for the legalization of adult use cannabis, and that includes a significant and important contribution to traffic safety. And there are significant amendments that we're making to the state's traffic safety laws, particularly to 14-227A and 14-227B. What we are doing in Connecticut is establishing, or what the governor is proposing to do, is that we establish a behavioral impairment standard. This is a standard that would apply to the use of any drug that goes beyond just the use of cannabis. And we have to recognize that just scientifically, cannabis behaves in the body in a much different way than alcohol does, which is why a nanogram per se level is an approach that we do not support in the administration. So with that, I know the commissioner is here, I know DMV is on the line, and we have a lot of expertise to share on impaired driving.
So if I may, I'd first like you to turn you over to Lieutenant Bartolotto, who will talk to you a little bit about A-RIDE and DRE for the first portion of Representative Quinn's question. And then I'd probably try to leak into Dr. Guy Valero for some analysis answers, and Rickenbach, Dr. Rickenbach for, you know, where we're going. He's on a task force and where we're going with field testing or those presumptive tests. Lieutenant, are you there?
I am, Commissioner. Thank you. Representative Quinn, you are correct.
Lieutenant, just introduce yourself and your title for me, please.
My apologies. Lieutenant Christopher Bartolotta, Department of Emergency Services of Public Protection. I am currently the commanding officer of Troop A in Southbury, but I have an extensive background both with the SFST's A-RIDE program, as well as the DRE, which is the Drug Recognition Expert Program. I've been declared an expert in this state and another state for testimony on the standardized field sobriety test and drug enforcement.
Thank you. Go ahead, please proceed.
So Representative Quinn, you are correct. We basically use the standardized field sobriety tests. We have several officers throughout the state who are then additionally trained in what we consider the A-RIDE program, which is the Advanced Roadside Impairment Enforcement, Detection and Enforcement. And then subjects, police officers, troopers, who then go to the additional phase of becoming DRE or drug recognition certified. So that would be at the highest level. And that addresses what Mohit spoke about earlier about behavioral analysis. We then do have our blood and urine test, and the language in the law allows us, the officers, to select if impairment is detected and they believe that the impairment is caused by drug, something other than alcohol, they can switch to urine or blood. There is nothing available, although they are researching multiple different angles, and the lab can speak better to that, to assist officers both in the field and then later on when they get processed at a barracks or a police department.
Thank you. And, you know, I know as an attorney who handles these types of cases that as it stands now, if there's an OUI arrest for alcohol, you're going to seize the license for 24 hours and you're going to send it on to DMV if there's been a positive test or a refusal. I think I read in here that that is not the plan with a situation where you think it's marijuana or some other drug, that the urine or blood test is going to be sent off for analysis. If it comes back positive, then it would be turned over to DMV. So there's no 24-hour hold. From a punishment standpoint, you know, operating under the influence for alcohol is an unclassified crime, but I see that we're going to be classifying this as a C or a D misdemeanor. Is it the intent of this law that if someone is stopped for operating under the influence of marijuana or some other drug, that they, as a first-time offender, that they would still be able to use the alcohol education program, which I'm not totally sure would be appropriate under this set of circumstances, or would they be doing some sort of other drug education program? In other words, is there a diversionary road for a first time operating under the influence of marijuana or some other drug, or do we go right into the conviction phase?
I would defer that question to DMV officials. They would probably give you a better answer than I could.
Hi, good morning. My name is Sharon Generakis. I'm an attorney with the Department of Motor Vehicles. I think at this point, the bill doesn't change anything about the criminal prosecution. There are still criminal prosecutions of drug cases every day. What's really changing about this is the administrative per se process. And so that's the part that's handled by DMV. So I think in answer to your question, I think whatever programs drug offenders are sent to now criminally, they will still go to. I don't think that's changed.
And also in reading this, it seems to me that there's an intention to, as part of the suspension process, also require the interlock device.
Right, that is because our statute is combined, driving under the influence of alcohol and or drugs. The penalties under that section are the same. And all I can say to that is, you know, in many cases let me back up. We get about 8,000 DUI reports a year. About 8 to 10% of those we can't do anything with because the person is under the influence of drugs. And by the way, we do, when a urine test is administered, we do get the results in time to process, if we could process those cases, but we can't. So in 25% of those cases, there's also alcohol present, albeit in levels below the 0.08. So, you know, the fact that there are, you know, poly substance users, we would probably keep the IID requirement. I know there's a company now that's just come out with a THC breath analysis device. So probably not too far down the road, you will see technology catch up to what's going on with the law. It's usually the other way around. So, but I also think there's some other things to consider, like what are the alternative programs for a drug offender? You know, we 10 or 15 years ago started to get away from lengthy license suspensions. And so we want people to be on the road, be able to go to their jobs and lead a normal life. And so IIDs help very much with that. The lengthy suspensions, you know, go back to what we used to do, which wasn't effective. The other alternative is a monitoring program. And I think it's South Dakota has a pilot program where they're monitoring drug offenders. They have to go in twice a day and be drug tested. I mean, this kind of a program is very, very intensive and expensive, I assume. So I'm not sure that there's a perfect alignment at this point. As I said, I think in the future, those things will change.
Okay. Yeah, because I would be of the opinion that the IID is probably not appropriate for someone who's doesn't necessarily have an alcohol problem or wasn't even arrested for being under the influence of alcohol. Have there been any studies done in the states that have legalized recreational use about upticks in the number of operating under the influence of marijuana arrests that have occurred?
Yeah, I think there have been, and I believe that I don't know all the results of those studies, but I think overall there's been an uptick in the number of people arrested for driving under the influence. I don't know. Again, I don't know what states those are.
Representative Quinn, I can jump in with a couple of points here. So there have been several studies on traffic incidents and arrests for impaired driving in other states. And the challenge here is causality. The states who moved first on legalizing cannabis are states that are younger. They're on the West Coast. Usage was already booming in those states. And so it's very unclear what the causality is between impaired driving, any increase in impaired driving, and any underlying change in culture, and any change in enforcement patterns, because there's new training provided and there's new equipment provided to police agencies. And so, so some of these numbers are difficult to assess. Our perspective, the governor's perspective here, is that cannabis is already used in Connecticut. Cannabis is soon to be legal or is legal in neighboring states. And so, so we need to put in place a regime for traffic safety that helps our state's police and our state's criminal justice organizations really move forward and keep the roads safe. And in regards to your earlier question on the criminal penalties, we have not amended the criminal penalties in 14-227A. And so what we're doing in the criminal statute is creating creating the use of a DRE evaluation as grounds for behavioral impairment. And we're doing something similar in 14-227B. And of course, as we know, the per se process, the administrative process that DMV leads is the frontline defense for traffic safety, and is critical for us to have a process to assess behavioral impairment and get those drivers off the road. To your question about IIDs, that is a conversation we're willing to have. It requires, as Sharon mentioned, a full rewrite of 14-227B. That is a conversation we're willing to have. However, there is some public policy value in having IIDs for individuals, even if they weren't pulled over for alcohol, since alcohol is often a use as a polydrug combination with cannabis and other drugs. And under 14-227O, there are programs in place to help individuals afford their IID programs, their IID requirements. And to the extent that we need to review 14-227O, that is something we're willing to do. Just very quickly on police training, it is very important to the governor that we get this right, that we get traffic safety right. And so what we have in the governor's budget is a significant investment in CSP, in ARIDE training. There's a significant investment for DRE training. And what we intend to have is, by the time the market opens, a sufficient number of DRE officers available to respond to any situation when a behavioral assessment needs to be made. And on the ARIDE side, what the governor's bill suggests or requires is that every police officer, by the time they do a first recertifications within the first 3 years that they are on the road, that they be ARIDE trained. And so after a period of time, we will have the best trained police officers in the state, in the country, and police officers who are able to assess for behavioral impairment and direct individuals towards a DRE when necessary.
Okay. And so getting back to my original point, though, a first-time arrestee for operating under the influence of marijuana, are they going to be able to use the alcohol education program? And if so, is that program going to be tailored to address these circumstances?
Yeah, I believe that program's in DEMIS. There are a couple of other programs on, it is not, okay. There are a couple of other diversionary programs that are in DEMIS that we are looking into, but that is a topic that we want to continue to consider.
Okay. All right, thank you. And thank you, Mr. Chairman.
Thank you, Representative. Obviously, I think the individual could be AR eligible as well, but you certainly raise a good point that probably something that's going to take a deeper look at. Senator Champagne appears to be back. Senator Champagne.
Thank you. Representative Quinn actually asked some of my questions, but I want to touch base on the DRE recognition expert again, because you said somebody said that the CSP is going to get financing for this. Now it's over $6,000 per officer to send them out of state. So I guess I have two questions. Number one, are we going to bring that training into Connecticut so we don't have to send them to Arizona and Florida? And question number two, is there going to be money provided for local police departments as well?
Thank you, Senator. I'll start on that. The state of Connecticut has a fund through DOT to provide for the training costs of DREs. I'm sure Lieutenant Bartolotta can speak more to what that program looks like. In terms of some of the costs to local police agencies for DRE training, the direct training costs are costs that the state is able to support. And we're in continuing conversations around if there are additional costs, perhaps backfill costs to local police agencies that we need to support. So those are ongoing conversations. Lieutenant or others who can speak to the DRE training program in the state.
Well, I agree. I would concur with what you're saying. It's through the funding is usually federally funded through DOT and DOT grants that normally offsets the majority of the training costs involved with the officers, both whether it be municipalities or with the state police.
Okay, but we're talking majority of costs. Right now, we're talking about a program that's going to be well financed to get enough officers out there to take care of the situation. I mean, most studies show that the number one reason that people don't use drugs is because they're illegal. Now we're going to legalize it, which means we're going to have a lot more people using. And to me, I want to make sure that we're able to keep our roads safe. Do we have somebody from the state's attorney's office on?
I think they're going to testify later today, Representative or Senator. This is just
Okay.
this is just the governor's office and administrative staff. I think the state's attorney is signed up to testify later.
Okay, so I'll have to wait on that question, because I guess one of my questions is going to be how they view the DRE and the ARIDE programs and which ones they're going to use, during prosecutions, which one they're going to rely on the most. From what I understand, most departments would go with the DRE, the drug recognition expert. All right, so I guess a primary on this needs to be, as government officials, our primary job is public safety. That is our primary job. And I want to make sure that before this law goes into effect, if it is passed, that we're going to get enough officers on the road that can recognize this and keep our roads safe. That is a primary with me. Do we have somebody from public health on? Public health commissioner?
We do not.
Well, we don't? Why wouldn't we? I don't understand why we wouldn't do that. I guess my question to them is what comprehensive studies has the Department of Health done on the commercialization of marijuana? Does anybody else have an answer to that?
Senator, yeah, exactly. We'll get back to that. They're submitting written testimony, but we'll get back to you on that.
I think that would be an important one as part of this bill being submitted. Commercialization of it has some products at 100% THC, and that's the Delta-9 tetrahydrocannabinol. And there's some different aspects to that than regular marijuana. Marijuana from the 60s and 70s was 3 to 5%. Now we're talking 100%, and there's a lot of different results from that. I guess number two, how are we going to identify this marijuana, the legal marijuana, from the black market? Because in every state that's legalized, we still have a large black market. Are we going to have tax stamps like we do on cigarette? Are they going to have to keep it in those containers?
Undersecretary Palka can speak to the possession components of the bill, and I think the DRS commissioner can speak to the tax stamps.
Mr. Chair, the criminal justice sections do not require the person to present receipts or stamp or any label to indicate where the cannabis was purchased from, the challenges that would impose on the person, and also the law enforcement official reviewing it seemed difficult to implement. So there are established limits in the amount that can be possessed, but there's not a required stamp or receipt of purchase.
Why wouldn't we do that? I mean, really, you want to identify to make sure that we want to do everything we can against the black market, because obviously this has been put into law, I think, mainly for the revenue. So why wouldn't we put something like that? We do it with cigarettes. Why can't we do that with marijuana? I mean, it doesn't sound like it's a hard job, because the dispensaries are going to be the ones responsible for, putting it on the packaging of the materials.
So just very quickly to make a point here, the primary purpose of legalization of adult use cannabis is not revenue. That is an incidental outcome. Of course, revenue is important. The primary purpose is to stop the prohibition of cannabis. I think we can be clear on that there is an important public policy rationale to make sure that we treat all of our residents in the state equally and that there isn't disparate impact. Okay. The governor's proposal removes from statute or repeals the Controlled Substances Tax Act. That includes the tax stamps that you're mentioning. I know DRS can speak to this more deeply, but just very quickly, that act has been on the books for 26 years or so, and in no way has been an effective deterrent to the use of cannabis or any other drug under its purview. And the impact of that, of those provisions, 12-550 through 560 have been disparate. And the cost, frankly, on DRS has been higher than any revenue we have raised. So the governor is proposing to remove the tax stamp portion of the state statute.
Okay, so we're not putting a tax stamp on it. So we're not gonna, it doesn't matter where it comes from. Then I don't understand why you just don't allow people to grow a plant at home. If you're gonna legalize it, if it has nothing to do with revenue, we're not gonna put a tax stamp on it, doesn't matter where it comes from, then why aren't we allowing them to grow at home if it's not a revenue? That doesn't make sense to me. Anybody got an answer?
Yeah, Commissioner Bowden, do you want to come in on tax stamps or?
Yeah, I mean, I would definitely defer to Attorney Bakari about the history of the cigarette stamps and what the practical application.
I don't want to interrupt you, but I think we're kind of beyond the tax stamp now. We're on to the point of, if we're not going to regulate where it's coming from, if we're not going to regulate because it doesn't matter, we're not going to say, hey, we want to stop the black market. Then why aren't we allowing people to grow at home like they do in Massachusetts? That's my question.
Yeah, so let me make 2 points there, and I know the Chief of Staff and Senior Advisor spoke to this as well. The governor's bill does not propose home grow. It does not. It does move forward with lower criminal penalties on home grow, and it requires the Department of Consumer Protection to study the issue. The standing up of a legal market for adult use cannabis is a major ordeal. This is 64 staff members that Michelle and her needs to hire. You know, this is a major new industry, hundreds of millions in revenue that we need to get stood up. It will take time for us to get this right. And home grow is one of those issues that we are proposing be further studied and be reviewed by the legislature in future sessions. We are starting at a different point on home grow than other states. Connecticut, unlike other states, does not allow home grow for medical. And home grow, there's no question that home grow can lead to greater use and distribution on the black market. So, one goal of the governor's bill is public safety and public health, and that means that we have safe, regulated product. Are we against small manufacturers? Absolutely not. We have a micro cultivator license in the governor's proposal, but we need to make sure that we're doing this market safely. And on home grow, that is something that we are not able to do at this point in time. It is something that we think has negative public policy consequences, but it is something that is under further review and something that we intend to speak about with the legislature in future years. Michelle, do you want to come in on home grow?
If I could just mention quickly, at the risk of sticking my nose into something that isn't DRS related, one of the responsibilities that we have in implementing this policy is to protect the market. And when you look at comparative states, and I give Mohit a lot of credit for the research and work he's done, and we've caucused many a night talking about what's happening in other states. One of the challenges that they found was closing down the back door to the production facility so that there wasn't a black market. So if you were to roll out a full homegrown policy, I think it has to be very organized, very, very regimented to be able to protect the market as a whole so that we can build capacity in the legal market. And that's, I think, probably one of the biggest reasons why you don't see it right off the bat, although they're not, I don't think the bill says no to it. I think it just says it's got to require a little more study to make sure it's done correctly. Mohit, I didn't mean to speak for you.
But I keep hearing the word equity. And when I think of equity, I think of, the whole thing is equity. And if we're legalizing this for somebody to grow at home, I think, boy, that would create equity across, because now people would be able to afford it because they can cultivate and make their own. Not that I'm for this, but I know they do it in Massachusetts as well. And somebody already said that this isn't about the money. And if it's not about the money, why are we protecting the industry? Why are we doing all the rest of this? Allow somebody to grow at home and they can make their own. That's one side of the argument that I was just looking at. And I know, like I said, Massachusetts does that too. And we keep referencing, the surrounding states and what they're doing.
So Senator, I appreciate where you're coming from. I think we're devolving into debate here on this as opposed to.
I know, that's why I'm moving on to the next thing. Thank you. Somebody had talked about during the discussion, about the war on drugs and the fact that, some areas have been affected more than others. I guess my next question is, how many people in the state of Connecticut are locked up under the possession of less than 4 ounces of marijuana?
Under Secretary Palka, is that for you?
It would be difficult to parse cannabis convictions because they're part of a larger statute that includes other drugs. And that was a challenge we came across with kind of criminal histories on it. So low-level possession would not carry a lengthy sentence. And so there would be a small proportion of people in the overall number in the DOC. And that's a credit to ways Connecticut has stood up front-end diversion options, use of probation, use of the diversion programs we discussed earlier, that Connecticut has long moved away from the use of jails and prisons as a response to drug possession. The challenge, though, is that the criminal records remain on the books for people who were brought into the justice system under different policies and practices.
Okay. Actually, wasn't it switched to the possession under 4 ounces was switched to an infraction?
Possession of cannabis under half an ounce is infraction. Less than 4 ounces. Okay, yes, sir.
Yeah. So basically, there's nobody locked up in our prisons for the mere possession of marijuana. Isn't that correct?
The number is small. I can't say nobody because the person could be. There are a variety of ways that you could be.
For the one charge of possession, a simple possession of less than 4 ounces of marijuana. It's been an infraction for what, 8 years now?
In 2015, Mr. Chairman, in 2015, less than half an ounce of cannabis became an infraction.
6 years. Okay, so basically nobody should be locked up for the simple charge of possession of marijuana. Isn't that correct?
Well, I would hesitate to say yes, Mr. Chairman. I'm not trying to be difficult, but the reason also is that people could be on probation or on parole or special parole and use marijuana, and they could be subject to revocation. And that is a way that people would wind up inside jail or prison. So I can't be as definitive in saying the numbers for that reason, and that's why we do have a provision on that.
Okay. Is there somebody here from prisons? Did you guys bring somebody in from the prison department?
Just so you know, Undersecretary Mark Pelka, OPM, is the Undersecretary of Criminal Justice. So when he's giving these answers from.
Okay.
Yeah.
But I always say,
Senator, let me interrupt. What I'm hearing is they don't have that data available right now.
Okay. Well, I was going to make another point. The point being that they're not locking people up for violation of probation or parole right now, and haven't been for the simple bad urine for marijuana. That was the next point I wanted to make. But
Senator Champagne, I can get you some exact statistics on this, but it's not just people being locked up. Of the approximately 70,000 arrests last year in Connecticut, about 10% involved cannabis. So there are people going through the system. There are people that are taking up times in the courts. They might not be ending up in prison, but there still is a legal burden in the system now.
What I'm trying to do, my purpose on what I'm doing right now is making the point that there's nobody in prison right now for the simple possession. Infractions are issued. I understand that, but this whole argument always goes back to, there's so many people locked up in our prisons, and that's not true, and I just want to make that known right from the very beginning. That was my whole point in questioning on that. All right. So my next point, I'm sorry, I'm jumping around here because as people were talking, I was trying to write as many notes as I could. So the erasure, let's go to the erasure contained within this bill on the marijuana. This is an erasure for the possession. Is that the only thing being erased, or are we erasing the drug dealer's criminal history as well?
Mr. Chairman, only possession.
So it's just a mere possession. Okay.
Correct.
And so we're just basically erasing these infractions for the last 6 years.
No, Mr. Chairman, because infractions are only less than half an ounce, and both of these are convictions, higher than infraction prior to 2015, and they go back years and even decades that people have had this on their records. Right. And then we misdemeanor convictions post 2015. So infractions do not remain on your record. So it's
okay. If that possession is contained within a grouping of other charges, such as dealing drugs, because if you're dealing drugs, you also get possession in there. Are we erasing just the possession charge, or are we erasing the dealing charge as well?
Mr. Chairman, only the possession.
Only the possession.
Other charges remain, other charges in the case, other charges in the record. It speaks only to the specific possession conviction.
Okay. The $2 million that's being provided to erase these, how much of that is going to local police departments who contain the local records and will have to actually probably use overtime to remove those records from the police departments?
The automated erasure portion applies to electronic data. So not all departments, but many of them are connected to the network of criminal justice electronic data systems. So we are relying on electronic data for the erasure, beginning with DESP and using the multiple pathways. So the intention here is to not include, erasure does not mean the physical destruction of the record. It means a notation that the record has been erased that can be accomplished through the electronic systems.
So we don't want to erase the local. So if I go to a local police department where somebody lives and I ask for the records, I'll still be able to get that marijuana charge?
The under current law, absolute erasure should lead to a erasure in the local systems. We recognize these are agencies that are part of a network of electronic data systems, many of which are connected to the to local PDs. And we've tried to focus on electronic data systems, not the paper records.
So what do we do about that? Are we going to provide money to get those records on the local PD? If we're erasing it and we don't want this on somebody's record, we should erase it completely. And if we're going to do that, we should make sure that we provide enough money to get that done. That's what I'm saying. So are we going to provide money to the local PDs to erase those paper records?
Many of the PDs are connected to the electronic data system called CGIS. So they would receive it in an automated way, which is the aim of it. Way a PD could use it is to look at the database electronically and see if that's a noted erasure case, and they would know not to provide that information. The aim is
So it's not really going to be erased on the paper side. It's going to be erased so that if I go in looking for it and they pull up that, if they pull up that record, then I don't get it.
That is correct. We're trying, and this is an improvement over having to do it in a manual one-by-one petition process. So
as long as every department in the state of Connecticut is connected to the system, and that's the way they're going to do it. But if not, we should be providing money to assist them in doing that. I'm looking at everything here. All right, so we have all this money that's going to come in from marijuana, and I've seen some people saying we should send it here, we should send it there. In the governor's budget, how much of this money is set aside for rehabilitation? I didn't go through the whole thing.
Senator, I'll start there, and I know others from the governor's office will want to speak about this as well. In the governor's proposal, there is only a single use of revenue. That is a 50% portion of the excise tax that will be collected by the state every year. Will be used to support municipal pilot funds. The other revenues that flow to the state flow to the general fund. The general fund, of course, funds the entire state government, and so there are a variety of ways that the general funds can be used. There are about $1 million in the governor's budget for DEMIS to support prevention and education programming. In terms of treatment, we don't think there will be any significant increase, certainly not immediate in any treatment costs, and so there are no immediate treatment costs budgeted in the DEMIS budget.
We have a major problem right now in the state of Connecticut with drug use, and stuff, and this is money coming in from the legalization of a drug. No matter where, what people's mind is set on it, marijuana affects everybody differently. And I think a large portion of this should go directly towards rehab programs. I think a large portion should go into our prisons for rehab, solving, things beyond marijuana. I mean, we're legalizing a drug here, and we're not putting any large amounts of money of the revenue towards helping people that are addicted to drugs. It just doesn't make sense here. So I will be making, when this gets to the floor, I will be making a motion to add in a large percentage of the funds that would be collected from this to go towards, helping people with addiction issues. That's an important thing. We're losing people across Connecticut constantly. And I think this should already be considered in this bill, but if not. So I'm going to save the rest of my questions because I know there's a lot more people coming along, and I know people have a lot of questions in this. We're probably going to be at this until tomorrow. So I want to thank everybody for coming on, and good luck to everybody throughout the night.
Representative Porter.
Thank you, Mr. Chair, and thank you all for being with us today. My first question is, in drafting this bill, how did you define equity?
Good question, Representative Porter. Thank you. we don't have a firmest definition of equity in this. That's what the reason that we're putting together two things. One, the disparity study, the equity study, and investing $75,000 in that, and also the Cannabis Equity Commission to further drill down on that. The idea would be, again, as I said before, that we would continue these discussions through the session, between now and the JF deadline and thereafter, and perhaps there'll be more detail that we can put into this bill, drawing from other bills out there and those discussions.
Perhaps. Okay. So I think the biggest concern I have is this bill being put forward as a comprehensive bill to include equity, and equity has not been defined. It's on the back burner, I would say. And I'm just going to move on to the next question. The only thing I will say is that I hope that we're not dependent on other states when we have had experts in equity at the table during the drafting of this bill. How were the voices of the formerly incarcerated included in drafting this bill?
Representative, just very quickly on what you mentioned there. The bill has equity. The bill has erasure. The bill removes the tax time provisions in Title 12. There are a number of steps we have taken in this bill to promote equity. To Jonathan Harris's point a second ago, there is more to be done when it comes to equity in the licensing process. And that is, those are discussions that we need to continue to have. Jonathan, do you want to speak to the stakeholders?
Well, I just want to speak to also that just correcting the word. I'm sorry.
Wait, folks, hold on, Representative, just a second. I understand this medium's a little difficult and we've got a number of people, but we do have to get a transcript and a record here. We gotta try not to talk over each other. So Representative Porter, you have the floor. Go ahead and ask your question.
Thank you, Mr. Chair. I just want to go back to Mohit because he's describing things that are being done in an effort to produce equity. And my question was, how is equity defined? So it's my understanding from the answer that I received from Jonathan, Mr. Harris, that they're not there yet. Is that correct?
Mr. Harris, do you want to address that?
I think I answered that. The only thing I want to clarify is the use of the word perhaps. The discussions will happen and there will be, I'm sure, changes. I was not using the word perhaps, Representative Porter, to say like perhaps we're going to get together and try to work out more detail.
Thank you for that clarity, Jonathan. I appreciate that. So I don't know if the question was answered. The second question that I asked were, how were the voices of the formerly incarcerated included in drafting this bill?
Does anyone want to answer that?
Go ahead, Jonathan.
What we have, like Representative Porter, besides just discussions that have been ongoing over the years on numerous bills, as part of the Cannabis Equity discussion group, we brought in a broad range of stakeholders and went through various aspects of equity on the front end, licensure on the back end, what to do with revenue, to the extent that there needs to be more specific drilling down with different stakeholders. That's part of this continued discussion in the legislative process to produce the best bill possible.
Thank you, Jonathan. So I just want to be clear, were any of the stakeholders that you're referring to formerly incarcerated individuals?
I did not ask whether they were formerly incarcerated. I do know, because some were clergy, that they've dealt with the formerly incarcerated population, and I'm sure others in the Cannabis Equity Discussion Group did too, but I did not specifically ask that of them.
Thank you. Of the 64 new full-time positions being added to DCP, how many of them will specifically be to support the equity program?
Representative Porter, I can yield to Commissioner Siegel if she wants to talk about the positions, but the Equity Commission actually will be staffed by 2 positions and administered within the Office of Policy and Management.
Okay, and I think that answers my question. So thank you. Out of 64 new full-time positions, only 2 will be to support equity.
Let me, if I may, Chairman.
Please.
there's still a regulatory portion that has to be taken into account when you come to this bill, Representative. And obviously, this is now creating a large, huge marketplace that has to be heavily regulated. And that's the reason why there are those positions where, while there are positions in there that has dealt with the medical marijuana system here in our state, with this expansion, you have to have the relevant staff, expertise, and individuals to be able to regulate it. And so this is still a regulatory portion. DCP is a regulatory agency. And based upon what we've seen in other states, Michelle Siegel, Commissioner Siegel, in dealing with her counterparts who have who are regulating this marketplace, that is how you get to the number of staff based upon the expansion within the state of Connecticut.
Thank you for that, Mr. Mounds. The next question I would pose to Commissioner Siegel about what will their specific powers and responsibilities be?
Well, our powers and responsibilities are going to go broadly to regulating the market. So we will be, there are going to be 8 new license types in addition to some existing license types that may enter the market. So we would need to put out applications and kind of license those businesses, all of whom will presumably have investors and employees. So we could be talking ultimately, you know, hundreds, if not thousands of jobs and people. In addition, we're going to be regulating the quality of the product. So there's going to be lab testing requirements on how it's manufactured. You know, one of the license types, for example, is food manufacturer. So somebody purchases cannabis and puts it into a baked good. We want to make sure that the safety around that baked good is the same as a non-cannabis baked good, so that all the sort of food safety rules are going to be there for people. So that's going to be a big part of it. We want to protect against diversion. So we would, there's going to be a seed to sale system that we need to implement and put in place so that as product flows through the system from a cultivator or micro cultivator to possibly a manufacturer, then maybe to a retailer or delivery service, we can keep track. One, with regard to diversion, also if there is a problem with the product that we learn about later, we could institute things like a product recall. So we will be dealing with that. Inevitably, in any market, especially a new one, we would expect a lot of questions coming from licensees or potential licensees, from consumers. There will inevitably be some sort of consumer complaint or confusion with things. So we will need to be addressing all of those. We've discussed earlier, there's a lot of advertising and packaging requirements in there. So, and a lot of study requirements. So we need to be thinking, what is the serving size? What should potency limits be? How do we protect the medical program? So we need to have staff sort of monitoring to make sure commitments in that regard are appropriate and being met. We'll need to deal with complaints on the advertising or packaging end to the extent it's being marketed towards people who can't be using it. There's, needless to say, there's going to be a lot of work around just, you know, this is not just a product, but entire marketplace and supply chain that's being created that's going to be new to Connecticut. And that unlike a lot of the other, pretty much most of the other products and services we regulate, there isn't an overlay of federal oversight. So we need to be doing this all within Connecticut to ensure that all the health and safety is being met.
Okay, that was a very general response. My question was specifically about the 2 full-time positions that are currently going to be for the equity program. And the question was, what will be their specific powers and responsibilities?
So that's a question for OPM. Those positions will be in OPM. I think it's, you know, as I understand, their role is to really
we can address it to OPM if you prefer.
Okay.
Or I can take that one, Mr. Chair, if you like.
Sure, John.
First of all, I just want to go back, Representative Porter, that, you know, while the Equity Commission and the oversight of the equity study will be done through OPM, which is part of what those 2 employees will be doing, Commissioner Siegel will be overseeing a licensure structure with 8 licenses. And 3 of those licenses, microcultivator, food and beverage manufacturer, and delivery. While they're not specifically at this point in the bill tied to any equity applicant status, they are equity type licenses in that there are lower barriers to entry, enabling more people to be able to get into the market. And that's part of the discussion that'll occur through the Equity Commission, administered by the Office of Policy and Management, overseeing this study and making specific recommendations to the General Assembly to further define equity on the front end, licensure, and on the back end, revenue, where that revenue goes to. They also will be making sure, this Equity Commission, with the help of these two staff members, that the existing medical marijuana producers and other facilities, if they're proceeding forward, will have an equity plan to make sure that we have a focus to build equity into the medical marijuana existing system. So these are the details that will be fleshed out by the Equity Commission, but it also will be on the table in the upcoming legislative discussions, both pre-JF and post. And as I said at the beginning, not to get into specifics of details, this bill, 163 pages, presents a comprehensive market structure. There are other bills out there, as you know, that have maybe less market structure, but have more detail on equity. These bills are complementary and will be the basis of our discussion going forward.
I definitely agree with that statement and wholeheartedly look forward to working collectively, because I believe that both bills that you're referencing have some really great stuff in them, including the governor's bill. The next question that I wanted to ask was, why is there no mention of labor peace agreements or project labor agreements in this bill, or is there?
Representative Porter, we actually never were given any project labor agreement language. That's something that we would discuss through the legislative process. Labor peace language, actually, the labor in another bill that you might be familiar with is language that I actually was working on that didn't get into the bill at this point with UFCW and AFL-CIO. So those are discussions that we had and that we'll continue to have.
Thank you for that, because I do remember you and I having a conversation where I asked you about labor peace agreements and the importance of them being included in this legislation. And you did advise me that you were talking to labor about that. So I was really confused when the bill actually came out. You know, there was no labor peace agreements in there after we had that discussion. My next question.
I'm glad you could utilize the language, though, that we're working on.
Well, actually, that was language that I worked on.
Guys, I'm going to interrupt for a second. If you want to have this discussion offline, feel free to, but let's stick to questions about the bill and what's in it or not, as opposed to who worked on what, please. Representative.
I agree. You know, I'm not initiating that, so I agree, Mr. Chair. So I guess I want to go back to something that came up around, and this is under the criminal justice piece of the bill, regarding blood tests. Would this bill allow police officers to take blood of a person as a roadside test?
Representative, at least for my purposes, I couldn't hear the exact question. Can you repeat the question?
Yes, I can. The question is, under blood tests, would this bill allow police officers to take blood of a person as a roadside test?
I see. State police or DMV?
Yeah, this bill does not authorize police officers to take blood roadside.
Thank you for that response, Commissioner. Where do I want to go? Okay, I guess one of the questions, because we talk about a school to prison pipeline, how will this bill reduce the school to prison pipeline, if at all?
Mr. Chair, this is Mark Pelka. The penalties for, or the response, I guess, to possession of cannabis for people under the age of 21 or for underage treats it as an infraction. So financial sanctions would be applied in response. Judges retain the ability to respond, to refer appropriate people to diversion or other services. And youth who are found in possession could be referred to a JRB or local services for youth and families. The acquisition of or response with a misdemeanor charge occurs only for people over the age of 21. So that maintains Connecticut's increasing efforts to use non-system means for responding to youth.
Okay, thank you for that, Mr. Pelka. I guess the next question would be, how will this bill address selective enforcement?
What do you mean by selective enforcement, Representative?
A better word for it, selective enforcement. When the question is coming from the fact that in this bill, it's my understanding that we have graduated levels of infractions, 1.5 to 2.5. Possession would lead to an infraction. So who's going to determine?
I think this bill is under 2.5. I think that was last year's bill, if I'm not mistaken.
Okay, well, you get the gist of what I'm saying, 2.5, if that's what it is. In making those determinations, what my concern is that there's going to still be a disproportionate impact on who gets an infraction and who doesn't. And I'm referring to that as selective enforcement.
Mr. Pelka, or somebody want to address how the 2.5 ounce limit was arrived at in this draft? Mr. Harris?
Oh, Mohit, I was just going to say that a lot of what we did in looking at how to form the well-regulated market was take a look at what was being done in other states and pick and choose different aspects of that. Mohit might have a little more examples of the states that we took a look at with that, but we were trying to be consistent with neighboring and other states.
Thank you for that.
This is Mark too, and I got the sense that perhaps the representative was asking about enforcement, and there was a section of the bill we haven't talked about yet to a great degree, and it's probably in part because of I needed to speed up my testimony toward the end. But Section 13 does address stops and searches of vehicles or persons, and the effort of this is to focus on enforcement of impaired driving, and not to use the odor of cannabis to as a prompt to conduct a search of a person or a vehicle. And this was informed by input, I think, of over the several years that Connecticut has invested in the traffic stop report. So we've highlighted a great deal about the highway safety enforcement, the criminal justice portion that I think would provide focus on enforcement of impaired driving, but not kind of so the concerns that the representative had mentioned earlier, perhaps.
Thank you for that, Mr. Pelka. On that note, can you tell me if there was a criminal justice group in that study group?
I don't, Mr. Chairman, I don't believe there was a group convened to produce this recommendation. I believe that kind of efforts to work on the bill consulted a variety of sources for it, but I don't think there was an organized kind of group providing that input. But I may have lapses in my knowledge of the development of it, but that's my best understanding.
Okay, thank you. I appreciate that, Mr. Pelka. So is it true that growing even one plant under this legislation is still punishable by jail time?
I'm going to refer to that section for the response. Mr. Chairman, sorry, I'm just going to pull up that section. It actually, well, the effort in this is to remove home grow of a cannabis plant by removing it from a section of the statutes that imposes more serious penalties regarding manufacture and cultivation. So the effort is to try to mitigate the impact of the criminal justice system on people who grow in their homes. So growing up to 6 cannabis plants would be a Class C misdemeanor for the first offense. It would increase from there, and there would be more serious penalties involved with growth outside of the home. So Class C misdemeanor could have a term of incarceration of up to 3 months. But I think the success is that it does reduce the penalties for homegrown compared to where it currently falls in the statute under cultivation and manufacture.
Right, but there's still the possibility of going to jail. So I guess I want to know how many plants will the current medical industry be able to grow under this proposal?
Representative, the question was the current medical program?
Yeah.
This proposal, they're going to be permitted to grow. I want to know, is there a limit that has been placed on them, or is that not correct?
The commercial cultivators, or under the medical program? I'm not following your question.
Well, let them define it for me, because what my understanding is, if you currently hold a medicinal license, you will have a track, right? What I call first dibs on legalization of adult use cannabis. With that being the case, is there a limit on the number of plants that they will be able to grow?
Commissioner Siegel, are you following this?
There's not, so there's no home grow in the medical program. So but there's not a limit on what, so their producers in the medical program are the ones that grow the plant. It'll be cultivators and micro cultivators. But none of those will have restrictions based on number of plants.
Right, and I'm referring to recreational licenses.
So in all of them, and sorry, I'm not catching the full question, but in neither program will there be home grow, and in neither program will there be restrictions based on plant count.
Okay, I'm not. I thought I was making it clear, but obviously I'm not. I'm going to move on in the interest of time. How many records involving cultivation or sales will this legislation expunge?
Mr. Chairman, none. The policy applies to possession.
And when we talk about possession, Mr. Pelker, how does that work when we talk about expungement of records?
Mr. Chairman, it depends on when the record was created. If it was pre-October 1, 2015, it would apply to the possession statute, and that record would be subject to automated erasure. For records from October 1, 2015 forward, the individual would be able to petition the court for a erasure of the record. There are reasons why it's divided that way. I'd be happy to elaborate further, but that's the contours of the erasure for drug possession.
Thank you, and I'll definitely take you up on the offline conversation regarding that in further detail. Can you tell me how many dollars does the plan specifically set aside for reentry support services?
Mr. Chairman, there is no direct a line in this bill for reentry services. We'd spoken earlier regarding many of the existing programs for drug education, for diversion, and for existing lines, but there's no new dedicated line for reentry under this bill that I'm aware of.
Thank you for that response, Mr. Pelker. I want to talk a little bit about the ownership and licenses part. And this is really DCP. How many licenses was DCP authorized to award by the original medical marijuana legislation? And I want to know how many actually got awarded.
So right now we have 4 producers and 18 dispensary facilities. the legislation didn't place, well, it placed a cap that they're on the producers who are the growers again of between 3 and 10. No limit on the number of dispensary facilities, which are the retailers. And those are the only 2 license types in medical. I mean, there's labs and research, but in terms of kind of businesses.
How many of the businesses are majority owned by people of color that were awarded licenses?
So we don't, that's just not something we ask on the application. So I don't have that information. And I appreciate, I understand social equity, you know, it definitely needs to be part of the conversation. And while I don't have the numbers, I'm not going to dispute that our program, the medical program, is probably not particularly diverse in that regard. And so I do think the Equity Commission in looking at how to do that is important. The way the medical statute was set up, it didn't really put kind of criteria or give any authority for the department to award licenses based on kind of people's race, ethnicity, gender, et cetera. And so that's not even something we ask on the applications.
And I think that really does concern me when we talk about social equity and a comprehensive bill, and the importance of equity that is pretty much on the back burner and seems to be an afterthought. And I'm asking these questions because I want to make sure as we move forward, you know, in the process of this legalization of recreational adult use, that we put that on the front burner, because those are the communities that have been disproportionately impacted. Moving on, I wanted to know how many billionaires own a cannabis business in Connecticut?
I'm sorry, how many billionaires?
Billionaires, yes.
Can I ask a clarification question? Yeah. What are you defining as ownership percentage? Like, we want to be able to understand where you're going with your question, so we can either look it up or get back to you or try to provide an answer at this time. I get there's a slant that you're going, but I'm just trying to get what it is so we can answer your question completely.
You get there's a slant, but you don't know where I'm going. The question is how many billionaires own
I prefer not to assume.
Connecticut.
Honestly, I wouldn't know if to what extent they're billionaires. I'm not going to dispute that you need a lot of access to capital to get into this program, and I won't dispute bank loans are not really a viable option given the federal challenges. So while I can't speak to kind of the diversity, I can't speak to the wealth. I understand your point, and I'm sure whatever those facts would turn out to be, it would certainly reflect that, you know, social equity part is important in making sure access to capital is available to people who don't fall into higher income brackets so they can be part of the industry.
So I guess I'll ask you, Curaleaf, one of the cannabis businesses in Connecticut.
Curaleaf is one of the businesses.
Okay, so
I guess we can say at least one. Boris Jordan is a billionaire.
Representative, I'm gonna jump in at this point. We're getting a little afield. I gave some latitude, but we seem to be talking about the existing medical program as opposed to the provisions of the bill before us that this committee is hearing today. I'm sympathetic to the argument you're trying to make. I'm just not sure. You know, this is the forum. As I said, we've got a lot of people to testify today. So I will give some latitude, but we do need to stay focused on this bill and allow others to testify as well.
And I do believe that's what I'm doing. So I will ask somebody to speak to the connection between the current medicinal licenses we have and what the application process looks like for licenses under this legislation for recreational.
I can speak to that. The way the medical program was set up, it required a competitive process to get a license, and it is a capital intensive business. I'm not, you know, I don't think there's any argument on that. And so it did turn out the people who probably were able to put in the best plans had, you know, significant resources. Also, a number, as the industry has grown nationally, a lot of these businesses have been, you know, they've been bought and sold, and there's, you know, large companies sort of forming as it's grown nationally. And so again, that there is that a big shift that would happen with the adult use market is that process is eliminated, and it's going to be a lottery system is set up so that all the applications gonna get submitted during a time frame. An outside sort of lottery or ranking process would work to identify who should be reviewed for final licensure. And those will be reviewed just on a sort of essentially a pass-fail basis. So it's not going to be, you know, if we get 100 that only the top 20 get it. It's going to be the lottery will pull 20, and as long as they meet kind of the minimum bar of what needs to happen to operate, you know, depending on whatever the business is, whether it's a retailer, a micro cultivator, a cultivator, maybe a food manufacturer, as long as that's met and they can work their way through the licensing process, then they would get the license.
I'm glad you brought up the lottery, Commissioner Siegel, because how does, I mean, you know, we're talking about equity. Well, I'm talking about equity, and I don't see a lottery as equity. Can you just explain the process of the lottery to us? Like, from my understanding, there's retailer, provisional, and then a final licensing. Can you go through that, please?
Yeah, so your first point, yeah, the Equity Commission ultimately we need a definition of who an equity applicant could be, both in terms of like the very specifics of who qualifies, and then, you know, what % ownership they have to be. Most of these businesses are not owned by a single person. So if there's a board of directors and then there's certain key executives, we need a really clear definition. So right now that sort of piece is going to be worked out by the Equity Commission, so it doesn't play in. But in terms of the second part of your question, the way it works is the first step is entering the lottery. And what we've seen a lot of states, ends up being a lot of people interested in getting various license types. So what it may be is that just to get the market up and running, we may only want 10, 20 of a certain license type, but 200 people apply, let's say. It's too much for DCP. We, you know, would be there forever and would need, you know, the 64 people would be nothing to get through all those. So the lottery would kind of, through a random number generating or a random process, rank them. And if we wanted 20, those first 20 would be submitted to DCP. We would do an initial cursory review. Is the application complete? You know, are there any like kind of initial problems with it? And if not, they would get a provisional license, and then they would have a year. So 12 months is how long that would last to then kind of complete their application. And that's sort of, you know, finding a site and getting a location, having zoning approval, filling out their org chart, putting together their business plan, their security plan, the vendor they would use to track product, et cetera. And I mean, that's another important difference in the recreational. All of that part is really expensive. And what, you know, it became clear in the medical program, because the way that is set up is that you just send in a complete application and you get a license or don't. There was a lot of upfront costs before you really knew if you were on a path to license. So this is those higher costs, you already sort of know you've been selected for licensure. Sure. But if you meet all those, then at the end, and you do it within that year that your provisional is in place, then you would get the final license.
What is the cost associated with each one of those prongs?
Sorry, you were cutting out a little bit. If you were asking the cost, sort of the fees are set out in section 26, and it's sort of a lower fee to just initially enter the lottery, but it varies by license type, and then a bit more for the provisional license, and then the final license.
Okay, can you give a dollar amount, please? That's what I'm trying to get to. What is the cost?
Okay, well, if you wanted to be a delivery service, you would pay $250 to enter the lottery, $1,000 for the provisional license. So now you're in the lottery and you're in that 1 year period. And then once you get to the final license, it would be $5,000. If you wanted to be, let's say, like a retailer, it would be $500 to enter the lottery, then $5,000 for the provisional, and $25,000 for the final license. So it goes through and it varies, so that with all the different license types.
Thank you for that response. And the point I'm making is that there's no equity in that process. That's pretty much a pay to play. And when you don't have the money, we have to figure out how to get the people that need to be in business and deserve to be in business legally a pathway. So thank you for clarifying on the lottery process. I think the last thing that I want to ask, Mr. Chair, through you, we talked about the stakeholders that were at the table. We talked about social equity and a study, and we're going to lay out equity markers, and all of this is to come. There were some recommendations that were made around equity from that table of stakeholders that sat with the governor's office. I want to know how many of those recommendations are included in the bill that we're looking at here today.
I can answer that, Representative Porter. I don't know if you heard at the beginning, I was trying to get that out in my opening remarks. We received the main set of recommendations through Jason Ortiz. He and his licensing group did a very good job going through. There was no consensus vote ever, but we got a list of those recommendations by email that I referenced on January 26th, when this bill was already, as I had been telling the equity discussion group from the beginning in November, the bill was already probably 99.9% hardened at that point, given the timing and what we have to do in the executive branch to run things through LCO, one, and two, to be able to make sure, since we're required to provide a balanced budget, to make sure that all the provisions in the governor's bills are taken into account in his budget. And the budget was being locked down probably around that time. The goal is to do it before the end of January. So that is why there was never an opportunity at that point, as I said throughout the discussion process, to put any of those specific recommendations in, but they're in some other bills. We have the recommendations, and they're the basis for discussion going forward with this bill and other recommendations and other proposals.
Thank you, and thank you for restating that, Mr. Harris. So are there any priority licensing in this language for equity applicants?
There are not. There are the 3 licenses that I said that are lower barriers to entry and are looked at as equity, but part of the discussion will be going forward in the legislative session, the information that we get from the social equity study, which was one of the recommendations that we reached a consensus for much earlier in the cannabis equity discussion group, and were able to get that into the budget. That was something that everybody wanted to see happen. So that's the process unfolding through the legislative process, through this equity study, and through the Cannabis Equity Commission, if we don't have all the answers done by the end of the session. And while I think we'll have many more, I don't think we'll have all of them by the end of the session.
Thank you. What about job programs for those with the adverse criminal history?
That is not in the bill.
Any support for our native tribes in this language?
Can you define support for our native tribes?
Partnerships, how will they participate and be able to take advantage of this very lucrative market that we're talking about opening here in Connecticut?
We have not had direct conversations with the tribal nations in the state, both state recognized or federally recognized, and they have not approached us to have a direct conversation as it deals with the bill for this current year.
Okay, well, I'll be sure to make that connection for you because they're having some very deep and thoughtful conversations with us. And I'll leave it there for now, Mr. Chair. Thank you.
Thank you. Representative O'Day.
Thank you, Mr. Chairman. Thank you, everyone, for your attendance. And I mean this, some of my questions are going to be pointed, but I have the utmost respect for you, and I appreciate all of you being here and testifying for us. Mr. Agrawal, am I pronouncing your last name correctly? I apologize.
That's right.
Thank you. You spoke about neighboring states are doing the legalization. And I kind of got the impression from your comments that because they're doing it, we need to get ahead of it and do it as well. Was that your comment?
There's 2 points here. One is simply as a cultural matter, the use of cannabis exists in our communities. And as a practical matter, the use of cannabis is easier when our residents have access to markets in nearby states. And so both from a cultural perspective and a practical one, it's simply it is simply reality that we have to respect that cannabis is something we need to get in front of, something we need to regulate, something we need to make sure is done in a safe manner for the state's residents. And the governor's bill puts forward a comprehensive proposal that represents our best efforts at public safety, public health, traffic safety as well. And so yes, I mean, it matters that other states have done this, absolutely.
So, I mean, look, that begs the question if look, I grew up, I went to school in the 80s. I spent a year abroad, and Amsterdam was known as the place to go for hard and soft drugs. Okay. And certainly I didn't want to go there for that. But my question is, we got to be careful. Would you agree that in looking at other states, teen use increased when there was legalization?
Representative, I'll have to study that issue and get back to you. As I mentioned earlier on a different question, causality is extremely difficult to ascertain due to the just underlying change in culture and behavior across the country.
Let me ask it to everybody. Is there anyone here that would dispute the fact that so far no one has, but I've yet to meet a person who disputes the fact that teen use increases in states that have legalized? Does anybody dispute that fact?
Let me say what's in the bill that responds to the concerns around teen use. There are significant advertising restrictions in the bill. There are restrictions on locations of dispensaries and retailers. And there are restrictions on warning labels, on product types. And most importantly, frankly, the regulated market for cannabis is a market that doesn't start cheap. So we expect an eighth to start somewhere in the $50 range, and these are prices that are not necessarily accessible by teenagers. And so just as a comprehensive matter, the market that we are constructing in Connecticut, pursuant to the governor's bill, is a market that is not accessible to teenagers.
Well, all right. Well, I'll take that as the response is everyone here admits that teen use will increase, as it did in Colorado and every state that I know of that legalized marijuana. But let me get to your
point. I won't admit that because I don't know. What I do know is that the governor's budget has support for a marijuana module in a couple of different surveys the Department of Public Health runs in collaboration with the CDC. That is an issue that we will stay on top of. It's an issue we are aware of, but it's an issue we will stay on top of, and the legislature will know what those numbers are.
Okay, so let me put it this way. Please forward to us any studies that anyone has that disputes the fact that teen use increases in every state that legalizes, and I'll leave it at that. The next thing I want to get into, did anybody look at, in the governor's office, the experiment that was Colorado over the last approximate decade?
Can you be more specific?
Sure. Mr. Agarwal, how long has Colorado had a legal recreational marijuana policy or law?
I believe it started in 2012. I'm going to have to look at the exact date of sale, but it's been a few years now.
So I presume that Connecticut, the governor's office, looked at what worked and didn't work in Colorado with regard to their legislation.
We're doing significant research.
That's all I need, significant research. I assume hundreds of hours looking at across the country what happened, particularly in Colorado, as they were the first state. Is that fair to say?
I believe Colorado and Washington both legalized at the same time. I'm not sure about first sale.
So isn't it true that the black market actually increased in those states that legalized?
I can't speak to that. Just as a general comment, the West Coast in the U.S. has a vibrant black market. California in particular had an approach to marijuana legalization that that really undercut the regulated market and let the black market prosper. And one thing we're doing in this bill is not making the mistake that particularly California made. Oregon had mistakes in terms of producer volumes. So there are things we have learned from certain states. Home grow is part of that, and it's something we need to be aware of and concerned about. But I'm certainly, so I want to make sure we're responsive to the question. So if you have a follow-up.
No, thank you, Mr. Aguilar. And sincerely, I'm very thankful because that was one of my concerns. California was a disaster in how they rolled it out because they put the taxes so high, then the black market just exploded.
It was just a tax situation. In California, there was no legal retailer for, I believe, the first 3 years of the market. But there was also no enforcement. And so the market was full of illegal brick and mortar retailers, which is a situation that we in Connecticut do not face. So in Connecticut, we have 18 dispensaries. They're the only legal sellers of medical marijuana and would, under this bill, be able to convert to the adult use market as a hybrid retailer. And we don't face a situation California had. And in general, frankly, the East Coast and New England in particular has had a better approach to both medical and adult use recreational cannabis so that some of these issues on the West Coast we'd be able to avoid.
I didn't get a chance to go through all 4,914 lines of the bill, but I didn't see any regulation on limits of THC content. Can anybody speak to what the limits are in the THC content in this legislation, if any?
I can speak a bit to that. I mean, what the bill is doing is requiring DCP to set up through eventually regulations, but through requirements, what would be appropriate dosage, potency, serving size, among a bunch of other things. So it's not in the bill itself, but it's sort of teed up for DCP to set before the market sort of launches.
How does the bill handle the gummies and the edibles?
A lot of that is being set up for DCP to do. There are requirements, it can't be products that are geared towards people who would be under 21. So to the extent they're, using, characters, for example, that would appeal to that. But you probably will start to see some things different. In the medical market, there was a similar sort of thing, and we really tried to keep it to medical products. I would anticipate it'd be a little looser in a recreational market, but that's sort of how the bill does it, unless you have more you want to add, Mohit.
Well, my concern is, as other states have found, the edible market is problematic for youth. And I will tell you from the get-go, if you could promise me that nobody under 25 would be abusing marijuana, and I know the legal limit is 21, but I think that health experts all agree that particularly with males, and I would say on the O'Day family tree in particular, 25 is really the age where you mature. And I see Mr. Mounds hopefully smiling a little bit at that. That was intended to be a joke. But
I got your joke.
So, if you promise me we would have some educational programs in place and there wouldn't be the explosion in teen use that some states have seen, I'd be much more comfortable. I frankly have been very disappointed in the testimony so far in what's going to be done to address protecting our teens and the failure to acknowledge that teen use increases with legalization. It defies common sense to say we don't know. But and I understand, Mr. Aguilar, the conflicting evidence because of the illegality of marijuana use. It's not as examined, but frankly, it's common sense that legalization increases teen use. But
O'Day, it's Jonathan. How are you? It's good to see you.
Jonathan, good to see
Someday
you.
in person. It's been a while. I think the issue here is we're not the experts on this, and there are studies all over the place on this, and we don't want to give a false conclusion. But even recently, in December, and it was reported in Forbes magazine, there was a study that showed that new data reveals no link between increased cannabis use in teens and legal markets. So there is data out there on both sides. And we'd like to work with you on that and mine some more of it for you, because I think you're asking some valid questions and we want to do the right thing here.
Thank you very much, Mr. Harrison. And I do appreciate hearing from you and obviously respect and everything you have to say and trust you implicitly. And so I appreciate that. Is anyone familiar with the 2016 study by Barry and Glantz? Along those lines, Mr. Harris, if anyone here is aware of that study?
Not me. Anyone else can speak up, but I'm
not specific.
So that study emphasized that you need Department of Public Health to speak and regulate so that you don't have a tobacco 2.0 problem. And so Senator Champagne was saying, asking about if anybody from DPH was here, and there's not. I got to tell you, my biggest concern with this legislation is teen use and abuse. It's as someone with teenage children, I am petrified that because of the THC content that's out there, gummies having. Let me ask it this way: can we acknowledge that in a gummy pack, one gummy bear or one piece of marijuana or gummy will have a different THC content than another one simply because of how they're made, and it's almost impossible to regulate that. Is that everybody's understanding? Does everybody agree with that?
Commissioner, do you want to speak to the product standards and dosing?
It complicates things. We're looking how other states do it, and sort of before the market opens up, the bill anticipates we will have sort of conversions figured out as to kind of what an equivalent of dry weight is in different product types. So we are looking, and in particular, it's the THC amount that are in different things. So as we think through what potency limits should be, we also are going to need to require sort of delineations of single-sized servings, so that obviously teen use would be of concern, but even with adults, you don't want them to take more than they realize either, which can sometimes happen with an edible if they're not used to sort of a delay in when that happens. So that's one of the things we're going to be looking at, and we're going to be putting out requirements and eventually regulations on.
So can anyone tell us whether this legislation was modeled after how we handle alcohol policies or how we handle tobacco use policies?
In part, so that's certainly an area we looked at. I want to point out in particular the underage possession of portions of the bill. I'll get the section numbers in just a second. 77 through 83. Those sections are directly from the alcohol statutes. And that includes, for example, the social consumption component, parents or other adults giving products to children under 21. So there we learn from alcohol. Alcohol has been on the books for 90 years now. Commissioner Siegel and her team have a lot of experience with alcohol, and we learned a lot from regulating alcohol in Connecticut in putting together this proposal.
So, and from a criminal justice standpoint, I understand why, but from a public policy, public safety standpoint, would you agree that we should treat marijuana more like tobacco?
I don't understand the difference you're trying to draw between alcohol and tobacco.
So tobacco, so can anyone talk to how tobacco use and alcohol use and marijuana use are related or unrelated? Or is that something that hasn't really been looked at?
I'm not sure I fully understand still. Like I said a second ago, there are a couple of surveys the state of Connecticut runs on drug use and drug behavior. And some of these questions around correlations between different drug use, we can look to the data and get back to you on that.
All right, fair enough. This is more along the study, that Barry and Glantz study that I think everybody would agree we had a tobacco problem that took decades to fix, and with youth, and then we had the problem with vaping with youth, because we didn't have the proper education that went out ahead of the problems with vaping and the addiction of nicotine with our youth. I mean, in my own town, in New Canaan, we had a problem for 2-3 years where kids were all vaping because they thought it was safe, and kids got addicted to it. So I guess that's where I'm leading with it. Did anyone with the governor's office look at comparing how we handle tobacco and comparing it with how we should model our marijuana legislation, as opposed to modeling it after alcohol? Because I think we need to look at it more as how we handle tobacco and teen use. Is that fair to say, or does that make more sense?
Let me make a couple of comments and then obviously invite others as well. So the governor's proposal includes funding for DMIS to undertake education and prevention. I believe it's $1 million a year, and that'll be targeted particularly towards individuals who are under 21. The proposal also requests or requires the Alcohol Drug Policy Council to make recommendations, science-based public health harm reduction strategies in order to reduce, these harms, and the bill requires that there be a particular focus placed on the under 21s. And so I think we can all agree that there is an intentionality here to try to make sure that the products are only used by individuals who are of age. And there's also intentionality to make sure that we address the risks of substance use disorder, overuse, any of the other risks that come from any other drug. The reality is cannabis is used and abused today all over the state. And that's a reality that we're trying to respect and the reality that we're trying to respond to.
And Mr. Agarwal, I appreciate that. And please, if there's anything you come away with on this, the most important thing for me is, what is the administration going to do to prevent that? What you just said is my most important, legalizing drug use for people over 25, marijuana use. I am not anywhere near as concerned about as a father. I am petrified of what this could do to the teens and what it does to them. So if you could just help us understand what the program or what the plan is going forward on preventing that, what you just said, that would be fantastic if we could get some more details on that. I believe you said that there were some negative public policy consequences for homegrown use. What are those negative public policy consequences for homegrown use? And if it wasn't you, Mr.
Representative, we've been through this, I think, extensively. I think he answered this. If you want to summarize, Mr. Agarwal, quickly, but we are getting a little repetitive here. So, and I do want to keep this moving.
Thank you, Mr. Chairman. We can certainly follow up with you, Representative. The public policy concerns the governor's office has on homegrown include, support for the black market, so more product for the black market, and concern about product safety. Those are not products that are grown in necessarily sanitary conditions, not processed. They're not necessarily processed using safe solvents. There are a lot of steps that happen to get to a safe market, and that's one reason why Michelle needs a team of 64 people to make sure that this market is done right.
Well, I would just add one other thing, Mr. Chairman, if I can, that the black market piece, of course, is just a concern in the adult use portion also, but we've been very careful to make sure that we have a highly regulated and nationally recognized medical marijuana program where it really truly is medical, the 3 Ps, the patient, the physician, the pharmacist. And, the more you allow home grow, there is a risk that people will go away from that and self-medicate. And within their own houses, not as controlled, without the safeties that we have too. So we're concerned about the impact on the medical market also.
Let me ask an open-ended question to Mr. Harris. You and I had exchanged when on the regs review some good questioning on the handling of medical marijuana and expanding the conditions that allow it. Let me ask you, currently, does the governor's office believe the Department of Consumer Protection is doing a good job with the medical marijuana use?
Yes, without a doubt.
All right. And one of the problems we had a number of years ago was we didn't have enough doctors qualified to take a look at what the medical marijuana is being used for. My understanding is that's been rectified, and the panel the panel that reviews that has been filled with doctors with the right qualifications. Is that correct, Mr. Harris?
I don't remember an issue over qualifications, but I would yield to Commissioner Siegel on that.
You're talking about the Board of Physicians. Yeah, we're fully staffed and they're all terrific and highly qualified.
Thank you. I would just point out for the record, I think if you reached out to the medical community, they would disagree with, with the comment or the statement that we're doing a good job as a whole in handling the medical marijuana situation here in Connecticut. I won't get into that, Mr. Chairman, at this point, but I think I would like the governor's office to reach out to the medical community and get their input on this legislation as well. And I wish we could hear from DP.
Just on that, I've had a slew of conversations on behalf of the governor's office with individuals in the medical community, including representatives of the CPA, CSMS, and others. And so I'm happy to follow up on your specific concerns. But I think there's a strong consensus that so long as cannabis is in our communities, and of course it already is, then we need science-based harm reduction strategies in place. And that is something that the governor's office strongly supports.
Thank you. And look, I actually had a lot more questions, but in respect to the chairman's comments earlier, I'm gonna ask those questions offline, and I'll send them to Mr. Mounds. I'll reach out to you. I appreciate it, and I see that I'm probably boring 90% of the people on this call, so I'll just end with a comment and maybe a question to the group. And I don't want to put words in Secretary McCaw's mouth, because I have the utmost respect for her, and I think she's doing a good job. But when she gave her budget presentation, she said one of the main reasons for this bill was to rectify and fix the injustice and impact of the drug use on our urban communities. And I agree with that statement that we need to help the communities and rectify. And I'm all for erasure of the simple possession charges and more education. But does anybody really believe that by legalizing recreational marijuana, we're going to help those urban communities that were so devastated by marijuana and drug use?
Mr. Chairman, Secretary McCaw is my boss, so I will associate myself with her remarks and agree with her. And I spoke in the criminal justice matters earlier, and I believe if cannabis is removed from 21A 279 and moved into a separate category with less penalties than they would be imposed before, I think the responses that we develop for the possession in use of infractions and graduated penalties is reasonable. I think that the fact that, to say nothing of the regulated markets, you spoke favorably. The good representative spoke favorably to the erasure components, and I think that side addresses the past harms that were inflicted, because it does in an automated way. So I mean, I'd be happy to continue to expound, but I fear that I've already said those things earlier, and I don't want to just keep repeating.
No, my point is, my point isn't about the criminal aspect of things, because I think Senator Champagne had said, and I just want to clear up for everybody, there's not a single person in jail right now for simple possession of an ounce or 2 or 3 of marijuana. Is anybody aware of someone in jail right now for simple possession? I'm not.
It would be very low for a direct sentence, but people could be returned on a probation, special parole violation. Our halfway houses have very strict drug drug restrictions on there, for example. So a direct sentence, and that's a benefit, and that's the work that Connecticut's criminal justice system and policymakers have done to evolve our penalty structure and responses to it. But that's why the erasure piece is so important, because even as our justice system evolves, those records remain and follow those people and limit their ability to access employment and housing. So even if the direct sentences are low, there are plenty of ways our enforcement of drug laws lead to people coming in.
And like I said, I agree. Erasure makes sense. I don't agree with the general premise that legalizing marijuana is going to help our urban communities that were devastated by drug problems. And I don't see any of the education piece that we got with tobacco. We finally learned how devastating tobacco is for the health of everybody. I don't see that education and prevention piece here. And Mr. Pelka, while I have you, just real quick, Mr. Chairman, I'm almost done. Did you say that that we're not going to be able to use the smell of marijuana as probable cause for an arrest when be pulled over for driving erratically?
Mr. Chairman, I think if I could just, one thing that we talked about earlier, I think jails and prisons are one part of the criminal justice system and the impact that it's brought. There are arrests, stops, referrals to programs administered by the criminal justice system or to probation are all ways that the enforcement of drug policy has effects, disproportionate effects. So even though Connecticut's evolution of policy has reduced significantly to very small numbers, people who are incarcerated for simple possession of cannabis, there are other effects that I would like to just make sure I state in the record as having effects. To the good representative's question, it does limit the justifications for use of probable cause for a stop or a seizure. Simply on scent of cannabis alone would not be sufficient. There would need to be other indicators to prompt that stop or the search, including that cannabis possession being someone underage or amount of money along with that cannabis amount or exceeding the amount. So simply the odor on itself would not be sufficient for a search or stop.
And I'm going to just jump in there as well. Subsection C of Section 13 of the governor's bill does specifically have language around a traffic stop and the smell of odor or the odor of cannabis. And so that was a provision that we did look into. We want to make sure that there is no not constraint, but we want to make sure that our police agencies can do the work they need to on traffic safety. Representative, just
what line is that, if I may?
Let me get you a line number. It's Section 13 sub C, but let me get you a line number 475.
All right, but I just want to make sure I understand the line. And Mr. Aguilar, I don't want to cut you off because I want to get back to what you're saying. It's very important. But Mr. Pelka, I got to understand. So we can use the smell of alcohol for probable cause, but we can't use the smell of marijuana. Is that what you're telling me?
That's correct. On itself, you would need to have an accompaniment of a sense of impaired driving. We're trying really to focus the reasons for stop in the seizure and to apply it to impairment. And this is the criminal justice section that involves this, and the other kind of highway safety pieces I think build out the whole framework. But that's right.
Can anyone honestly tell me right now that makes any sense?
Representative,
I know it's
you're getting we're getting argumentative here as opposed to, I think you got an answer to your question.
Oh, all right. I'm sorry. I didn't mean to be offensive, but that does not make any sense. It's just boggles my mind. Okay,
Representative, there will be plenty of time to debate this bill.
I'll move on. Mr. Agua, I'm sorry I cut you off. Can you?
So two comments. One is on Section 13 subsection C. If you're being pulled over for impaired driving, the odor of cannabis remains a factor. If you're being pulled over for a busted taillight, the odor of cannabis is not indicative of impairment. It may be indicative of a violation of, I believe it's Section 90 of the bill, that there's cannabis in the vehicle. So there are measures here that we can take to make sure that we are balancing the needs for individuals to not be subject to criminal prosecution for simply being around someone who is smoking cannabis a few hours earlier. So I mean, cannabis smoke is something that lingers, and we don't criminalize the smell of tobacco smoke, and I think that is the best corollary here, rather than the smell of alcohol, which is just it's different, and it doesn't stick to you, and it doesn't stick to someone who's near you in the same way. Earlier to your comments around communities, low-income communities of color, I want to clarify that drug use behavior is not something that's concentrated in our cities or in certain communities, but rather, drugs are used across the state, and people handle in different ways. And What the bill does is make sure that individuals who shouldn't be using drugs, that there's marketing, there's education provided there. The state of Connecticut already has significant education in our schools. In driver's ed, we have programs in place here, and we're certainly always willing to have further conversations. But I did want to underscore that I think the line of questioning you're going down, made it seem like there are specific communities in the state who are suffering from the use of drugs or abuse of drugs. Rather, the problem is that there are some communities in the state who are suffering from the disparate impact of possession laws and cannabis prohibition, and that is what we're trying to address.
And Mr. Agarwal, if anyone took my intent or my comments to mean I'm not concerned about drugs in my town, that's not true. I recognize that, and I'm petrified for my children to have access and more access to marijuana if it's made recreational. And that's I certainly did not mean to imply in any way that this is related to our cities or any, in any way. It's a problem throughout the country, and I didn't. If anybody took it that way, I apologize. Just let me understand if someone from Connecticut State Police or someone from law enforcement can just clarify here. So if I get pulled over and for say erratic driving, or and I roll down my window and you smell alcohol, my understanding is I'd be asked to step out of the car and walk a line, do some testing, and that's obviously appropriate and something I would encourage the officer to do. Is that a fair kind of summary of how that could go down or would go down? Officer, is it Bartolotta?
It's Chris Bartolotta. Yes, it's a fair assessment. It would be an indicator, something that would enhance the officer's perceptions, and then to start looking for additional clues through questioning or whatever to see if alcohol is in fact causing that erratic behavior or the erratic driving.
And if I say, yeah, I had a drink or two at dinner, but you know what, I got distracted, I had a sneeze, and that was the reason for my erratic driving, and you made me do the test, the alphabet test and the physical test, and you determined, you know what, he's not over the influence, I'd be on my way. But if we do that same scenario and you don't have alcohol, but you smell marijuana, under that scenario, in this legislation, would you be allowed to ask me to get out of the car and do a physical test, do a specific test?
Based upon your question, no. You would have to have some additional, the officer would be trained, and that's part of the reason why we're talking about A-RIDE and the DRE, but they would notice and look for some of the cannabis indicators. Smell would be one. Eyes, watery red would be another. Looking at the tongue to see if there's any type of indicative ingestion. So yes, you would build upon that, but just solely, as Mr. Agarwal said, if it's a motor vehicle stop because of a taillight and you smell the cannabis odor, no, they could not be. The officer could not go forward with his investigation unless he found something additional that will allow him to do that.
So if a taillight's out and you smell alcohol, you can ask me out. If a taillight's out and you smell marijuana, you can't ask me out. Is that what you're saying?
That's my interpretation of the law, yes.
And Representative, let me just jump in here. This is Patrick Ewan. I'm an associate policy director in the governor's office. This is really about keeping, there are a couple issues here which we want to keep separate, right? There's the, a traffic stop for having a tail light out and an associated possible search of a vehicle, right? That's something that can happen at a traffic stop, whether or not there's suspicion of the driver being impaired. But there's also the field sobriety test, right? That's another thing that can happen at a traffic stop. And there's specific language in this section to enable an officer to progress from a stop for impaired driving or for something else to a field sobriety test. But what we don't want is that someone has someone has smell on their clothes from they were with someone else who was consuming cannabis prior. We don't want that to turn into someone's vehicle getting searched necessarily for their association with a totally legal consumption of a product. But if there's any suspicion of impaired driving, right, that's already enough for an officer to order a field sobriety test. So if they pull you over for erratic driving, that's already reasonable suspicion enough to do a field sobriety test.
Is Mr. Doyle on here?
Jack Doyle, State's Attorneys. I believe they'll be joining later.
Okay, all right. All right, well, Mr. Chairman, thank you very much. I know I've been fairly lengthy. I apologize for that. I do want to truly, sincerely thank all of you. I do truly have the sincerest respect for all of you. And if I offended anyone, I apologize. That was not my intent. As you can tell, I'm pretty passionate about this because I'm petrified about the impact on our youth. And I very much appreciate it. Mr. Agrawal, thank you so much for your responses. And please go forward with the intent to help us prevent further teen use. Thank you.
Thank you. Thank you, Representative. We are now 3 hours into hearing from the governor's office on this and have not gotten to the general public yet. So I just want to remind the members of that. Again, if you have direct questions, preferably on topics that we have not covered yet, we obviously will continue on, but I am imploring the members not to rehash or dwell on topics that we've already covered if they can avoid it. Representative Blumenthal.
Thank you, Mr. Chair, and I'll be very brief with my question, and I believe it should be only one, and I think it would be addressed to Mr. Pelka. There was some spirited crosstalk on with a couple of my colleagues about the current criminal justice consequences of possessions of certain amounts of cannabis. My understanding of the current state of the criminal law is that if someone possesses under a half an ounce of cannabis, that is only an infraction. But if they possess an amount in excess of 1/2 of 1 ounce, that is a Class A misdemeanor that is punishable by jail time. Am I correct in that?
Mr. Chairman, the Vice Chairman is correct. It's between half an ounce and 4 ounces, simple possession, misdemeanor A, and marijuana is in that class.
Okay, thank you. And
current law.
Sorry, go ahead. I didn't mean to interrupt you.
No, pardon me. Under current law, and what this bill would do is remove cannabis possession from that into a separate sub statute with a different set of penalties.
Okay, thank you. So, I understand that the actual rate, you've spoken to the collateral consequences that can come from simple possession or from possession of an amount in excess of 1/2 ounce. It appears to me that possession of certain amounts of cannabis can also lead to jail or prison time, potentially. I think you committed to getting back to some of my colleagues on what the actual enforcement priorities and policies and how those have actually reflected in people being punished with imprisonment for possession of cannabis. I look forward to that information, but I just wanted to clarify the current state of the law and that it can lead to imprisonment for amounts in excess of 1/2 of 1 ounce. Thank you, Mr. Pelka, and thank you, Mr. Chair.
You, Representative Dubitsky.
Thank you, Mr. Chairman. I'm not exactly sure who my questions are directed to, so I'll just kind of throw them out and hopefully the right person will respond. I do want to talk about an area that I don't believe has really been discussed yet, which is growing and cultivation. Looking at the definition of cultivator, it talks about that propagation of cannabis plant at an establishment with not less than 15,000 square feet of grow space. That the 15,000 square feet of grow space sounds an awful lot like indoors. Do we know if we are if we're talking about indoor or outdoor, or if there's a difference? how do we know? It doesn't seem to say.
My expectation is we would be talking about indoor, just given the needs for security and other sort of product safety requirements.
Okay, is there any requirement of being indoor?
I don't recall that it's set out in the statute, but so a lot of that, would come again through all the DCP kind of regulations and requirements. So we would need to take a look, but thinking through how we have it with medical and what we have in place to ensure, products are secure and aren't getting contaminated, whether it's with heavy metals, pesticides, other things. We've generally looked for a pretty controlled environment.
Okay, now with regard to pesticides and things like that, with regard to growing, I note that the commission in this, the commissioner in this instance is the commissioner of the Department of Consumer Protection, and the department is the Department of Consumer Protection. So this entire operation is under the auspices of DCP. And I'm wondering why at least the growing end of this is not administered by the Department of Agriculture.
So this program is under DCP because these won't necessarily be grown on farms. These will be grown, and given our experience with medical marijuana, a lot of what's going to be required, particularly on the product safety and other ends, are going to correspond with what we're already doing with marijuana in the medical program. So it's a more logical extension of that program than some of the, I think, farm or agricultural programs that exist at the Department of Agriculture.
Well, doesn't the Department of Agriculture have the experience with regard to the growing of hemp?
They have hemp, and that sort of federal law requires sort of Department of Agricultural involvement, but the manufacturing of hemp products and that piece of it is regulated by the Department of Consumer Protection.
Okay, and how was the decision made not to follow that model where the growing end was Department of Agriculture and the processing and sale is Consumer Protection?
It's really following with the model that exists for medical marijuana, where kind of front to end the regulation is occurring at the Department of Consumer Protection, and so that's sort of how this one is modeled. Although obviously the user end is broader than just medical patients. It also it creates a way for us to have consistency on how we're doing inspections, testing, kind of watching the flow of products. So it becomes regulatory much easier to administer when sort of the full pieces of that are being handled in one place.
Okay. With regard to grow space, it appears to imply that grow space must be owned and controlled by the producer. So is it the intention not to allow any type of leased property, that it must be specifically owned by the producer, cultivator, or microcultivator?
I think they would just need the right to occupy. I could take a closer look at the precise language being used, but I would anticipate, and that's how we have it in the medical program, where you don't technically need to own the space, but you need to have the right to occupy and the right to exclude others from the property.
Okay, yeah, that's line 97. It says specifically that it seems to imply that it has to be owned by and controlled by the producer.
Okay, I see the one you're talking about.
Okay. Hold on, I know I got a bunch of other notes here. Give me 1 second. It's a long bill. I got to page through it. Oh, there's one. There's a section here in section 20. that says no cannabis or cannabis product shall be sold from or obtained from or transferred to a location outside of the state. How does the seed and other materials get into Connecticut to start growing if it can't be obtained from out of state?
That would, I mean, right now there is a fair amount within the state through because of the medical program, but just like the medical program, there may be a little less transparency on how all of that is happening. But this is really meant to be like, once you have your product, what we don't want is it moving across, moving across state lines unless federal law changes and that sort of interstate commerce becomes available.
Okay, so is it the intention that you can buy seed from out of state?
The law just doesn't address that. The law doesn't address that intent at all.
Okay. In section 35, the cultivator is authorized to cultivate, grow, propagate cannabis at an establishment that meets the physical security controls and protocols set forth and required by the commissioner. Have those been established yet?
No, that's one of the many things that will need to be in place before this launches. And again, we would look to a lot of the requirements we have in medical, at least as a starting point.
Okay. How many establishments do you anticipate there being in the state?
Over time, it's hard to know. I mean, eventually we'd like a well-working competitive marketplace. So we'd like to have kind of supply and demand matching up well. So we'll have to see as the market evolves, how that plays out, how demand unfolds and supply. So I don't know at the end of the day how many we would end up with.
Are you anticipating dozens, hundreds, thousands?
Of each, which license? So across the different license types, I would expect eventually into the hundreds. It's going to evolve over time. So, it's hard to know in year one what it will be necessarily, as opposed to as the market matures and we're into year 5 or 6, or if federal laws change, other opportunities open up, there may eventually be different even license types.
Okay. On what section is this? Section 43, when it talks about electronic tracking system, shall track each cannabis seed, clone, seedling, and other commencement of growth of the cannabis plant. So if you've got a bag of seed, every single seed has to be electronically tracked. How does that work?
Well, it would begin as you sort of plant the seeds. Well, the kind of the way these are discussed, and it's fairly common in most states, if not all states that have adult use market, is a seed to sale tracking is what they're referred to. And it's what you really want to keep track of is from the moment you kind of start growing the product to until it reaches a consumer's hand, you want to know where it's going. And that's just one of the many ways to protect against diversion. It can be possibly of assistance to revenue services, and it can be helpful on a public safety end. If there, let's say we learn of a problem with a product, you want to be, and you need to do a recall, you could track back to a batch of products or to wherever maybe the contamination may have happened, so that you can address that issue as well.
Okay, so you're not proposing that when a producer obtains a bag of seed, let's say he obtains a 10-pound bag of seed, which has tens of thousands of seeds in it, that each one of those seeds is somehow electronically tracked.
I mean, if they're all planted and are intending to be plants, that would happen. The seed to sale tracking system is among the many things that, you know, DCP is going to be working on if this bill passes to kind of finalize, get into shape, and get those requirements out to our cultivators, so that they'll know at, you know, at the point in time when they need to start tracking that.
Okay, but just to be clear, so you're talking about tracking it once it's planted. So you have a little pot with soil in it, you put the seed in it, and you start tracking. You're not talking about tracking each seed while it's in a bag.
I would expect so. We need to work it out, but sort of that seems the more logical way.
Okay. Give me a second. I know I had a couple more. In section 73, I'm a little confused about section A and section B. Section A appears to say that hotels, motels, and similar lodging facilities can't prohibit possession and consumption of cannabis. But section B says that they shall prohibit the smoking of cannabis.
Representative, I can speak to that. Cannabis can be consumed in a variety of manners: smoked, inhaled, ingested, and the concern with any kind of location like a hotel is the secondary impacts of smoke and inhalation. And so the goal with section 73 is to make sure that individuals, including, you know, tourists who may come to Connecticut and choose to consume legal cannabis, even when it is legal, have an ability to do so in their hotel rooms, but that hotels should still prevent any kind of secondhand smoke or vaping situation.
Okay, are hotels currently allowed to regulate or prohibit the consumption of alcohol?
I can't speak to alcohol. I can speak to tobacco. So I'll get you the section numbers in just a second, but the governor's proposal includes an update to the state's Indoor Clean Air Act, which also regulates secondhand smoke. So in certain locations, including hotels and other kind of public locations.
Okay, well, I'm more concerned with alcohol than with tobacco. So you've got a motel, let's say it's down near the beach, and you've got a bunch of college kids that are drinking. I would assume that the hotel can say no drinking in my hotel. It would seem odd that there would now be a law that said, but you can't prohibit the consumption of cannabis.
Representative, we can get back to you on that.
Okay, I'd appreciate it. Now, with regard to employment, it says nothing, section 84, section 84C. Nothing in this act requires an employer to, nothing in this act shall limit an employer from taking appropriate action, including but not limited to requiring an employee to take a drug test upon reasonable suspicion that an employee's usage of cannabis while engaged in the performance of the employee's work responsibilities. So let's say the employer knows that or suspects that that the employee is using cannabis quite frequently in his in his or her off hours, and is concerned that that is leaking over into work hours, how, if they take a drug test, if the employee's smoking marijuana off hours, isn't it going to show up in the test, regardless of when the drug test is taken?
Yeah, it's a great question, Representative. So let me provide some framing around the governor's suggested approach here on the employment and drug testing provisions of the bill. First, we have been in constant collaboration with the business community, CBIA, and others on these provisions, and we continue to look into these provisions to make sure that we meet the governor's primary goal, which is workplace safety. And we have every intention of maintaining the ability of employers to have safe workplaces. That is absolutely critical to us. In part, a general perspective that we have both here and in the traffic safety sections is that the level of THC in one's blood or urine or whatnot is not indicative of impairment. Impairment is a mental status. It is not a number from a drug test. And alcohol is very, very unique in that respect, because alcohol has a linear relationship in these drug tests and a level of impairment. So that is why we have to think about drug testing in the context of cannabis, in a more complex manner than when it comes to alcohol. So to your question specifically, subsection B of section 84 allows an employer to establish at-will employment policies, and these policies can include a no drug use on or off-site. And so section 84 would cover the use case that you suggested in section 84B would cover the situation you described.
Okay, so as an employer, I can say, I'm not hiring anybody who smokes pot, even at their own house, off hours.
You can, and there's certainly a business rationale that any business owner needs to think through on what they are doing to their access to human capital, their access to the labor market, by having restrictive hiring standards that are not related to the demands of the job. Certainly, any safety-related position needs some kind of standard around drug use, and of course we agree with that. But what this bill is trying to do is say employers can have that, but let's just be careful about when that's used. And so 84 is 84 sets forth an employment policy, as we just mentioned, that allows the employer that right. To your question around when can an employer do a drug test, that's addressed in section 85, and so there are some restrictions there, and that we can talk about.
Okay, and moving on to section 85, I interpret this to say that even if somebody tests positive for marijuana, it isn't proof that they smoked marijuana or that caused impairment of any type. So what good is the drug test if the drug test is no good?
Yeah, Representative, impairment's impairment. If an individual is impaired, an employer should take action. And a drug test is not the necessary standard under which an employer needs to act. So I think when it comes to impairment, we just have to recognize that an employer should take action. What 85 speaks to is a drug called THC COOH. It is a non-active metabolite of cannabis. It is long-lasting in the blood and urine. And 85 is saying, in a situation when a drug test is being done, at a random time, it is not linked to any kind of situation around impairment. That drug test itself cannot determine impairment.
Okay, so how does an employer determine impairment?
It's a behavioral process that is described in that section you spoke about earlier, 84C3.
84C3. Okay. Now, with regard to police officers take special training to identify and recognize people who are impaired by marijuana, don't they?
Absolutely, and the governor's bill proposes that we increase the number of individuals trained to A-RIDE and DRE standards.
Okay, how many of them are there at the moment?
I'll let the desk or DOT perhaps speak to that.
Senator Baralato, can you tell us how many for CSP? I know Garrett's on too.
Yes, Commissioner. Currently, CSP has 13 officers that are trained as DREs with one instructor. As for A-RIDE, I believe Karen Bover has the better numbers on that. I saw her just go live as well. Mr. Chairman, if I may, I just would like to clarify an answer I gave to Representative O'Day, just to make sure that we're all on the same sheet of music. The bill does have wording, specifically line 472, when we talk about the odor of cannabis. An officer cannot search the vehicle based upon the odor of cannabis, but the odor of cannabis does allow the officer to continue his investigation into a OUI matter, whether it be alcohol and or drugs.
Okay, well, I thank you for that, and I will let me just follow up on behalf of Representative O'Day, who I'm sure will jump in on this when he gets an opportunity. But does that mean that if an officer pulls somebody over and they roll down the window and a big cloud of smoke or the smell of cannabis is apparent to the officer, that the officer can ask the driver to get out of the car and give them a field sobriety test?
That is a correct statement, sir. Yes.
Okay, I appreciate that. Hopefully that answers Representative O'Day's question. My question, so there are 13 officers currently in the state that are trained in the identification of intoxicated people that are intoxicated by marijuana. Is that right?
Representative Dubitsky.
Within the Connecticut, state. Oh, Garrett's on. I'm sorry. Hold on one second.
Representative Dubitsky, this is Gary Eclair. I'm Deputy Commissioner at the DOT.
Yes, sure.
So we have in Connecticut currently we have 60 DREs in Connecticut. Okay. And we do not have a specific number of A-RIDE trained officers. We believe it's around 950 to 1,000. But DOT working with Post is going to be finalizing that information moving forward and asking each agency in the state to get us the specifics.
Okay, but so there are 60 now of the DREs, is that what they're called?
Yes, sir.
Okay, and just very, very briefly, if you could just give me a quick summary of what it takes to become a DRE, what training is involved.
Yes, sir. So, and my colleagues at desk can jump in as well, but it's a very detailed and extensive training. You have to go through numerous steps to reach the point where you can become a DRE. First, you need to become certified through a standard field sobriety test. You have to go through your wet lab, which is conducting field sobriety tests on individuals who are intoxicated. Then you need to also get your A-RIDE certification, which is, I believe, a 16-hour course. Following that, the DRE training is a 3-week course. I think 2 weeks in the classroom, 1 week in the field. So it's not for everyone. It requires a very highly skilled individual. But it is a very detailed training. The program is put together through the International Association of Chiefs of Police, as well as the National Highway Traffic Safety Administration. And there's a technical advisory panel, which has medical specialists in optometry, emergency room medicine, and toxicology who will help with the curriculum for that course.
Okay. And without that training, an officer wouldn't be qualified to recognize somebody who is intoxicated by marijuana?
The training is to help you identify which substance they're intoxicated by.
The standard field sobriety test as well as ARIDE allow officers to determine impairment. And then from that point, once you have probable cause for impairment, and then you can place them under arrest. But then the DRE training, as well as the breathalyzer test you use for alcohol, that's what determines what you are impaired by. Trooper Bartolotta, if I'm misspeaking, please correct me.
No,
Okay,
you're
so-
100% correct. ARIDE, standardized field sobriety test, looks for impairment. There is a piece within a standardized field sobriety testing that is drug related, and it gives a basic overview. ARIDE then takes that to the next level, again, allowing the officer who goes through the training to look for specific roles or levels of impairment due to certain drugs. And then very specifically, the DRE will allow the officer to make an assessment on one of the drug categories, whether it be multiple or a singular, that is causing that impairment level.
Okay, so what kind of training is necessary for to determine basic intoxication under a field sobriety test?
If I could speak to that,
I'll let
please.
Karen Boisvert talk about that.
Yes, if I could speak to that. My name is Karen. Can you hear me?
You're very faint. I need you to get a little closer to the microphone if you can, and give us introduce yourself for the record, please.
Thank you. Can you hear me now?
Yep.
My name is Karen Boisvert. I'm the Academy Administrator for the Department of Emergency Services and Public Protection. I am assigned to the Division of Post. And it should be noted that every basic training program has the field sobriety test. So officers currently have to, based on the post curriculum and regulation, they must take the basic training program for the field sobriety test. It's about a 40-hour program. It does include a wet lab. So every recruit going through a program graduates with this particular training, which is the first step that will lead them to the ARIDE.
Okay, so the basic course is 40 hours?
Yes.
Okay. All right. Well, thank you for that. I appreciate it. So I'm going to go back to sections 84 and 85 with regard to an employer's ability to determine if the employee is intoxicated on the job with cannabis. I think I was told that the test for cannabis cannot be used to determine impairment. And now I'm being told that in order to determine impairment, you need a 40-hour course. So what is an employer to do to determine whether or not one of their employees is intoxicated on the job?
Representative, we'd be happy to follow up with more details, but I can speak to what's in the statute, or excuse me, in the proposed legislation. What the proposal requires is reasonable suspicion of use of cannabis while on the job, or specific articulable symptoms of impairment, and then there's a list thereof. So those are the standards that we are establishing in the governor's proposal for how an employer can go about establishing impairment at work, impairment or use, excuse me, at work. More generally, there are programs in place for employers to have staff trained to identify impairment. The National Safety Coalition in particular is quite active in this space, and they are developing and will soon launch a DRE equivalent program for lay individuals who work at employers who want that level of specificity in identifying impairment. But these are open questions that we need to continue to look into. But we believe the government proposal puts forward strong standards that employers can implement.
Okay. All right. I think that exhausts my questions. Let me just check my notes. Give me 1 second. I think that's it. All right. Well, I appreciate your time and thank you, Mr. Chairman.
Thank you, Representative. I know Representative Fishbein has a very brief follow-up on a second round. Is there anyone else who has not? If not, Representative Fishbein, briefly, please, for a second time.
Yep. Thank you, Mr. Chairman. Mr. Mounds, the governor's staff and commissioners being here today, was that by their choice or invitation or direction?
I'm not sure that's directly related to the bill.
It is directly related because I do notice, and I will have, it's going to be part of the record, that there is absolutely no one here from the Department of Public Health, which commissioners appointed by the governor, and they have not submitted any written testimony based upon what I see on the system, which I find to be very troubling here. So, I don't need Mr. Mounds to answer the question, I guess, whether or not at invitation or direction. I would hope that the commissioner at least would have sent somebody so that they could represent the public health.
I'll make this representation to you. If you have trouble getting in touch with the commissioner directly, we will have the committee directly follow up with the commissioner to answer any of your public health related questions on this bill.
I think the committee itself should have the ability to ask those questions. And I think that was the purpose of today. But anyway, moving on. Does the product
on that, Representative?
Yes, sir.
Wait, I'll take that. Go ahead. Representative, obviously, we're still in the midst of a pandemic. Obviously, the Commissioner of Public Health and her team have been solely very much focused on that. Every commissioner here is not here based upon any coercion or any duress by me. I'll say me personally, as the governor's chief of staff. This has been a bill that, as you can see from its comprehensive nature, that has been worked on by all of these agencies. All of these agencies have provided direct input, including Department of Public Health. We will be happy. I know the Department of Public Health is supposed to provide written testimony that will be on the record, and that will happen. If there's any follow-up questions for the Department of Public Health, the commissioner, deputy commissioner, and down the line, we will make sure that we'll have it not only asked by you, but answered. But I think to the greater point, I think this panel of our of members of our agencies kind of shows directly the collaborative nature that the governor has driven in me to make sure that is shown by our agencies when it comes to working on policies of consequence for the people of Connecticut.
Understood, sir. And I have to say that you don't get any sympathy over the pandemic issue, because the fact of the matter is this bill is not necessary right now. The pandemic, addressing the pandemic certainly is, but this is the bill that's before us at this time. And if the Department of Public Health, can't be here, then maybe we shouldn't be here having this, but I don't want to belabor that. Does the product have to be produced in Connecticut in order to be sold in Connecticut?
Yes.
Where is that in the law? Because I do not see that.
It's kind of in the section that says everything has to happen and can't cross state lines. I forget the exact number now. It was discussed earlier.
I know there's a provision that says you can't bring it outside of the state of Connecticut. But when I look at possession and usage, particularly, it doesn't say shall not possess or use, may possess, use, or otherwise consume, yada, yada. And I'm looking at lines 199 through 206. Product that is created, cultivated, whatever in the state of Connecticut. It just doesn't say that, at least in that section. So, I'll continue to look for that. The
Representative Fishbein and Michelle, Commissioner Siegel, everything has to be done by licensed entities, and we don't license out-of-state entities. They have to be licensed Connecticut entities here.
Understood, but can a licensed Connecticut entity, a retailer, purchase the product from outside of the state for sale in Connecticut?
No, they can only purchase it from a Connecticut licensed cultivator or producer.
And you're saying that's somewhere in here?
Yes. So if you look within each section where it talks about the license types, it talks about who they are allowed to buy from and who they are allowed to sell to. And it's a closed loop system of licensees. So the whole supply chain is being licensed by DCP and will be within the state of Connecticut.
Okay, I'll take your representation. I'll continue to look for that. The my last area of for Mr. Pelka or perhaps Sergeant Giannone, when I look at 21A 29-28 having to do with the issuance of a pistol permit, it bars one who has been convicted of a violation of section 21A 279 for being issued a pistol permit. Now, I heard a lot before about what erasure is under this. How am I to put these two things together? By this automatic erasure provision, is one who was previously convicted of 21A 279 legally able to get a pistol permit? And I don't know which one of you can answer that question.
Mr. Chairman, to the ranking member's question, this is Mark. Looking at the pistol permit application, there are a number of different criteria that could disqualify them from it. One of them is a felony conviction, another are a set of misdemeanors. So if the only disqualifying feature was a conviction under 21A 279C, my impression would be that that record would be erased and that therefore that person would be eligible to submit for a pistol permit. Would certainly want to verify that, but that would be, my read of how erasure would work is that someone receives that erasure, that would apply. Only in the case where there's no other disqualifying feature.
Understood. So, okay, I'll look further into that because the statute doesn't just deal with section C. That's the old statute. Right now it says a violation of section 21A 279. So that would be A, B, or C. So that means that somebody who was convicted of having in excess of 1.5 ounces, which would not be a C, I don't know the answer. And I know, Mark, you and I have talked about this in the past, and I'm just trying to figure out where we're going with this. So I put the bug in your ear, and thank you, Mr. Chairman.
Chairman Winfield.
Yes, thank you, Mr. Chair. I just want to, sorry, my kid's in the background. I just want to first thank you all for spending so much time with us today, and just point out a couple of things that I think are important to point out. That in the last couple of years when and excuse me because I have a back issue, some of you know, so I'm trying to make it through the hearing. But point out that in the last couple of years that I have pointed out that there are studies that suggest that teen use actually did go down. They're easily found in the state of Colorado and in other places. And I also point out that the variant glance study, which I did happen to have a chance to read, makes a lot of good points, especially about the way in which we regulate cannabis in the United States versus what we could do from a more public health standpoint. So I think all of us should actually read it, because beyond what was talked about in the study, there's a lot to really glean from it. But thank you very much for joining us, and happy to hear from the public now.
Thank you, Chairman Winfield. I want to certainly associate myself with your remarks, and almost 4 hours in, go back to where we started with the governor's office, which is, I agree. I think what has been presented to us by the governor's office is a very, very good starting framework of a bill. I think it builds upon the work this committee and others have done in the past, particularly on the criminal justice piece, which is obviously front and center for this committee. I think, I certainly speak for myself when I say I agree. I don't think this is a final product. I think there certainly we've heard some sections that can be improved upon already here today, and I'm sure we will hear others. But I am appreciative of the governor's office for recognizing the role that this committee plays in the deliberative process, for spending as long and bringing as many experts to the table as you have this morning, so that we can work through this and hopefully come out of our committee process with an even stronger bill than what has been presented to us here today. You've done your work. It's time for us to do ours. So, Chief Staff Mounds, Mr. Harris, commissioners, thank you all again for being with us.
Thank you.
We are going to take just a 30-second break. We're going to let them out, and the administrator is going to let our next batch of public testifiers in, and she'll give us a signal when we're ready to go on that.
Next on the list is, right now, Miss Anne-Marie Rosado is not available. Next would be Christine Rapillo, followed by Karen O'Keefe and Bernice Wright.
All right, thank you, Madam Administrator. So we are going to, we're up to number 22 on our list, Anne-Marie Rosado. Ma'am, if you're with us.
He's not here.
Huh?
Anne-Marie Rosado is not here.
Michael Ortati? No? All right, so we're up to Christine Rapillo, the Chief Public Defender. Wait, I see Michael Ortati in here.
Hello?
Yep. Go ahead. Go ahead, sir. Mr. Ortati, I have you next on my list. You have 3 minutes. Go ahead.
My name is Michael Ortati, and I'm here before you today to testify in opposition of Governor Lamont's Bill SB 888 and in favor of House Bill 6377.
Sir, I'm gonna interrupt you. And I understand that maybe folks were tempted to do this, but I want to do this early. We are testifying on the bill that is before us today. The only bill on our agenda is 888, and it would be, in my mind, it would not be appropriate for us to testify in favor or against a bill that's not on our agenda today. There are FOIA issues and others with that. So if you want to talk about Senate Bill 888, you're welcome to do so, but I can't have you testify on a bill that's not before us.
All right. The inclusion of equity in the title is laughable. It does little to nothing to rectify the wrongs done to communities of color impacted by the war on drugs, which doesn't make sense to me. All this talk about a new market structure, we already know what the market structure is going to look like in other states. Other states have it. What bugs me most is that it doesn't expunge records of individuals who sold minute amounts of it, when in reality, if impoverished communities were supported properly, then individuals wouldn't have to resort to selling cannabis in the first place. Instead of rectifying that by prioritizing entrance of disenfranchised communities to the legal market, we're allowing an already established businesses to monopolize the market. It's ignoring the root of the problems in the communities of color and giving crumbs to us and calling it equity. I'm here to say we want the whole damn cake. That's equity. We deserve access to the kitchen. That's equity. The language in other bills that I won't reference is loose enough for it to be used to map out the legalities of the market with a sense of inclusion. That's what the people want, reparative action. In short, SB 888 is inequitable. It does not right the wrongs done by cannabis prohibition. It does not allow discrete homegrown. It criminalizes the youth, which is statistically racist. It does not outline funding from the taxation that will go directly to disenfranchised communities. It does not mention the inclusion and support of our indigenous communities in this industry. It does not mention protections for parents, children, and individuals in public housing. Meanwhile, other bills do. Other bills create programs and reinvest into communities that prohibition has hurt the most, and I support that. I yield my time.
Thank you, sir. Appreciate it. Are there questions from the committee? Seeing none, appreciate you being
Let me just say thank you for coming and just say this. I know that there are a lot of people who are thinking about what the chairman's instruction means for their testimony. I just want to be clear that what we're saying is not that you cannot say that you're opposed to the bill. We're not saying that you cannot make suggestions about what you want to see in the bill. That's not what we're saying. We're saying that this is not structured in a way that it's this bill versus that. But I just want to be clear because I think some people would get the impression that we're saying that you can only come and say things that we're not limiting you to. So I just wanted to put that on the record for anybody who's testifying. And thank you, Michael. I know you're doing a lot of work around this and other issues.
Thank you, Ken. Run for governor.
Thank you, Mr. Chair, and you're absolutely right. You said it more articulately than I did. I just want to be careful about what our rules are and what our constraints are, and not to put this committee in a position where we're taking up or we're discussing a bill that's not before us. It would not be proper for the legislative body to do that, and could run afoul of, like I said, freedom of information and open government issues. That's the only reason for my admonishment on referencing other bill numbers or titles in other committees. Representative Dubitsky, do you have a question?
I do. Thank you, Mr. Chairman. And thank you for coming in to testify today. I very much appreciate it. Now, one of the things that you mentioned and a reason why you opposed the governor's bill is that there isn't a provision for homegrown. Can you explain to me why you think that it would be more equitable and better to have a provision with homegrown in it?
Because it just, in my opinion, it doesn't make sense that we're going to criminalize specific amounts being driven between places while it's in vehicles. And it just, to me, it doesn't make sense. If people are able to grow it in their homes, and there's no excuse for people to be traveling with large amounts of it. It doesn't really make sense to me that we wouldn't be able to grow it in our homes to avoid that likelihood.
Okay, well, one of the things that is supposedly part of this bill is an equity provision, which is supposed to provide some type of recompense for communities that have historically been the victim of the war on drugs. Do you think that having a homegrown provision in there and allowing people to grow their own at their houses would advance that equity position at all?
I believe it would. For one, our communities enjoy cannabis. You know, it's not just about selling. It's more so just about consumption. I wouldn't see a problem with it at all. I think it's absolutely equitable.
Okay, well, thank you for your answers. Thank you for coming in and testifying. And thank you, Mr. Chairman. I appreciate it.
Thank you, Representative. Thank you, Michael. I don't see anyone else. No, I don't see anyone else. Thank you, Michael, for joining us today. Next, we will hear from Christine Rapillo, you may begin. You have 3 minutes.
Thank you, Senator. I'm Christine Rapillo. I am the Chief Public Defender, and I'm here on behalf of the Office of the Chief Public Defender. Our support for the spirit of this proposal, which will legalize regulated amounts of marijuana for use by adults. We think this is in line with our neighbor states, will produce much needed revenue for Connecticut, but most importantly, the decriminalization of marijuana will alleviate the disparate negative impact that enforcement of this has had on our communities of color. Now, there's been some talk today, and I think truly realize that there are very few people who are currently incarcerated for small amounts of marijuana today in Connecticut. But the real impact here are the collateral consequences of the criminal convictions that people have accumulated over time. This has impacted folks' ability to move through other programs in the criminal justice system, impacted ability to get school financial aid, housing, and a whole host of other consequences that would flow from criminal convictions. This will not only erase those convictions for folks who had convictions in the past and allow them to move forward with a fresh start, but it will end the practice going forward. We do have 2 concerns about the enforcement sections of this bill, which are outlined in my testimony. And because I know we're pressed for time, I mean, the biggest, there's 2. The use of the interlock device, we believe, doesn't help public safety at all and puts a real burden on folks moving through the criminal system. It doesn't do anything to measure the use of marijuana, and it would simply be another requirement that would make it more difficult for our clients, particularly poor clients, as they try to make their way out of the criminal justice system when they have contact with it. It's expensive. Oftentimes they don't have cars. We've presented testimony and legislation on that before. We think that it doesn't provide any additional level of public safety related to the bill. Our other concern is I believe it's section 91 that provides for automatic admissibility of the drug recognition expert testimony. And we believe that that's a problem, that it infringes with the criminal defendant's right to confront and cross-examine the evidence against them. Expert testimony is subject to courts determining its admissibility. It's proffered by a party. It can then be challenged by a party. And we don't think that there's a good policy justification to treat this drug recognition evidence any different. I mean, it is at its basis not even a scientific test. It's a trained expert who conducts behavioral observations and then would render their opinion and their expert observations. There's no problem with that, but it ought to be subject to the same types of cross-examination and test for reliability, tests to make sure that the expert stays true to the model that they're supposed to follow, and just subject, as I said, to the test of reliability that any other piece of expert evidence that would come into court would be subject to. As I said, our agency does, however, support the general spirit of this bill, and I'm happy to answer any questions that the committee might have.
Thank you, Attorney Rapillo. I see Representative Fishbein has a question.
Yes, thank you, Mr. Chairman. Good afternoon, Christine.
Good afternoon.
With regard to the last part of your testimony, the DRE testimony coming to evidence, specifically, where is that? What lines are you referring to?
I have the bill in front of me. I apologize. I've been going back and forth. Our budget testimony is today as well, so I've been moving back and forth between the 2 hearings.
Yeah, no problem. And I just, for anybody else, line number would be helpful.
No, it's a few places. It's section 91, and the first place that appears is line 3,508.
Right, so if I go
I'm sorry, I thought I had that marked.
3,005, because I didn't run across that when I was 3,000.
On my copy.
Okay, I see it. If a law enforcement officer is a DRE, the officer's testimony shall be admissible and competent. Well, it doesn't shall be admissible. So that's I don't read that, with all due respect, I don't read that as extreme as you do. And I'm just trying to, it says it shall be admissible and competent. So that gets rid of the objection the blanket objection that it is inadmissible and incompetent, but it's always challengeable. So what you said was that it couldn't be challenged, right?
So what I'm saying is that under this, it couldn't be excluded. So saying that it's admissible means that it would automatically come in. And
No, it says admissible. If that was the case, if that was the case, yeah, admissible, it would say shall be admitted without objection would be the language. I don't know if somebody's, well, if that said what you said, I would have trouble with that, with all due respect. But I don't read it. That's a pretty common phrase that I've seen. But okay, we'll go on.
So in this context, we're concerned that it would mean that that it wouldn't be able to be excluded. It would just be able to be argued, and that if it's not reliable, it shouldn't be admitted at all. And we need to have the ability to test that. And we are concerned that in the context of a criminal prosecution, this would limit the ability to challenge the evidence.
What would that argument be over? It would be over whether or not it's going to come into evidence, right? That's the concern.
Right.
So, and the ultimate constitutional concern would be that it comes into evidence no matter what. That's not what this language says. It says it shall be admissible and competent as evidence, yada, yada. Admissible means one can admit it or attempt to admit it, at least the way in my experience. But anyway, I understand your position on that language.
If it were changed to could be admissible instead of shall be admissible, we would probably feel better about it. But I think the mandatory shall leaves that up to question, and that could be interpreted as not being able to challenge it.
Yeah, I mean, not to belabor it, but I think it's the gatekeeper function, you know. So if you said that it may be admissible and competent, then it would be questioning in the statutory language that it is competent. So I understand your concern. I'll certainly be on the lookout for that. So thank you, and thank you, Mr. Chairman.
Thank you, Representative Fishbein. Representative Porter.
Sorry, Mr. Chair, having difficulties getting to my unmute button. Hello there.
Hi, Representative.
How are you?
Fine, thank you.
Good to see you. I just wanted to ask real quick, I mean, because we haven't been able to define equity in this bill yet. As the public defender, how would you propose bringing equity to what you do? Because I know 5 years later, Colorado has reported that Blacks are still being arrested at double the rate as white people for cannabis offenses. So I just want to know, you know, what types of programs would be necessary to undo the collateral consequences of the war on drugs that you talked about?
So I think this bill makes a good start. It ends it going forward. So, you know, generations of people who would have been coming through the system now would not. I think this ability to easily get records erased for folks who had these type of convictions would be very helpful. I think our office would have to be involved in helping people with that in some way, although it is fairly simple. Its court process is hard and intimidating. I think we're well set up to be able to assist people with that and wouldn't need to ask for any money for it, which is always important. You know, but I think some efforts, you know, probably to look back and make sure that folks who have a past consequence, one of these collateral consequences, particularly employment or perhaps student aid, there may be some additional efforts to try to remedy that, to try to go back and make sure that they're now going to have more opportunities based on the fact that convictions were erased and that we're not criminalizing this going forward. As far as what we do, I mean, we will have to carefully watch what happens with ongoing enforcement of what is now still criminalized. And we will need to keep data. I mean, I think there's been a good push in Connecticut to do a better job of tracking criminal data. We keep some data in our agency. It's only a snapshot of, it's not everybody that goes through the system. But I think through what the prosecutors are doing with their data system and what judicial does, we should make a point of tracking that and seeing what happens and making sure that if we see disparate enforcement, that there's an immediate policy response to that.
Thank you for that. And my last question to you, is sales of cannabis a frequent offense that requires a public defender?
It's definitely, sale of cannabis is definitely an offense that we see. I couldn't tell you off the top of my head how many. I could certainly get you that information, though. We can retrieve that out of our case management system.
That would be great. Thank you so much. And thank you for being with us today. Thank you, Mr. Chair.
Thank you, Representative Porter. I don't see any other hands. So I want to thank you, Attorney Rapillo, for joining us. I'm sorry. No, I'm talking about members of the committee asking questions. So thank you, Attorney Rapillo, for joining us today.
Thank you.
We will next hear from Karen O'Keefe, followed by Bernice Wright.
Good afternoon.
You have 3 minutes. Go ahead.
Thank you. Good afternoon. My name is Karen O'Keefe. I'm an attorney and I direct the state legislative department at the Marijuana Policy Project, where I've worked for 17 years. According to Gallup, more than 2/3 of Americans support legalizing marijuana. Like alcohol prohibition, cannabis prohibition has been an epic failure. It wastes billions of dollars, tears families apart, and has been unequally enforced. Prohibition also makes control impossible. Only legalization and regulation allows for protections for communities, the environment, consumers, and workers. Penalizing adults for using cannabis is also offensive to one of our core values, liberty. Cannabis is far safer than alcohol, tobacco, and many medications, and grown-ups should be allowed to make their own decision about whether to consume it. 15 states have legalized cannabis, and 5 of them have done so last year alone. The sky has not fallen in the states that legalized. There has been no serious effort to repeal any of the laws, and their popular support has increased substantially. In Colorado alone, there are more than 40,000 badged cannabis workers, and the state brought in $360 million in cannabis tax revenue in 2020 alone. Legal cannabis has also improved the well-being of large numbers of people. Research shows that adult use cannabis consumers are often using it as an over-the-counter medicine. In Denver, 65% of surveyed adult use, not medical consumers, reported taking cannabis to relieve pain, and 74% used it as a sleep aid. More than 80% of them said they could stop or reduce their use of prescription and over-the-counter medicines as a result. I live in California and I've seen this firsthand. My husband, Mark, has suffered from chronic back pain for decades. For years, he took substantial amounts of over-the-counter pain medicines, which can cause liver damage, kidney damage, and stomach bleeding. After legalization, he switched to cannabis. I don't have to worry anymore that he might be destroying his organs to reduce his pain. And thanks to cannabis, after he had kidney surgery, he didn't even take the opiates he was prescribed. Many individuals are like Mark, and they use cannabis as an over-the-counter medicine, but didn't ever enroll in the state's medical cannabis program. Mark's doctor admitted he isn't knowledgeable about cannabis, and many people don't even have a primary care physician or don't want to spend the money or get on a government list to do so. Other people have conditions that don't qualify, like insomnia or post-surgical pain. With legalization, adult consumers have a safe lab-tested product. We support the goals of SB 888, but as my colleague Devon Ward will later testify, we urge the committee to revise the bill to ensure social equity in the industry and reinvestment in communities hard hit by the war on drugs. Thank you.
Thank you very much for your testimony. Are there questions or comments from members of the committee? I do not see any. Thank you very much for joining us today. We will next hear from Bernice Wright, followed by Jack Doyle.
Hello.
Hello.
I'm Bernice Wright. I currently live in Bridgeport, Connecticut. I am a participant of the medical marijuana distribution. I do have lupus, and I support this bill, but I also agree on what the young lady said before me. This bill needs to be revised in a lot of ways to me. For the cost of it is very high to maintain. And the ability to be able to smoke in your home or in a public place is not allowed. we can smoke cigarettes and you can drink, but you can't smoke marijuana. And I also just want to say that I'm very proud of Connecticut for even discussing this bill and bringing it up, because there's too many people falling through the systems of small amount of marijuana, and it shouldn't be. I just would like better bills to help us to get rid of them situations and those barriers. Other than that, as far as the equity for this bill, I think we should also include other things that will allow people to form a business, like cafes where other people can be able to smoke, have a ventilator system, things like that, to help give people an outlet. We have places, for instance, in New York where people that's doing crack, and they can go to different sites and get their supplies. I think we should pay attention to some of this. I'm not trying to advocate all drugs to be legalized or anything like that, but marijuana has no effect on our bodies like it's portrayed. Like the lady just said before, and I could show you if I may, I can show you a bag of medicine that I used to take, and I don't really take them anymore. It's because I am on marijuana, and due to the fact that I don't have to take all these medicines, they're just sitting here. And I'll just give you a view. If you can see, these are bags of medicine that I no longer have to actually take anymore, you know, due to the fact that I am on marijuana. It helps me with my appetite. It helps me with my pain. And it also, I don't have any side effects of anything like that. So,
Ms. Wright, if you could summarize your testimony.
Yep. In conclusion, I would love to support the bill. Just revise it, like I said, and just give more support to medical patients.
Thank you. Representative Porter.
Quick question. Thank you for your testimony. I just wanted to know, as a medicinal patient, would homegrown make a difference? Because you did reference the cost of having to purchase it as medicine. How would it help you if you were able to grow it instead of having to purchase it through prescription?
Well, you're correct. That's totally correct too as well. I mean, it would gladly take some money that I can save, because right now, every license that we have to do to get recertified costs us over $150 something, and then we have to pay our doctor another $150, and then in order to get prescriptions done or refilled, that can cost us like $150 every time we go get a prescription. So it could run us over $6,000 a year just on medical marijuana. So to be able to have the ability to grow at home will be tremendous. It will cut down a lot of the costs, you know, and not taken away from going to the dispensary and getting the medicine, but at least it will cut down some of the costs.
Right. It will help to alleviate the financial burden. Thank you so much, Ms. Wright, for your testimony and your time today. Thank you, Mr. Chair.
Thank you.
You're welcome.
Thank you. Thank you, Representative Porter. I don't see any other questions. I just want to thank you for participating and sharing with us a little bit of your experience. Thank you.
All right.
Next, we'll hear from Jack Doyle, followed by Sal Luciano. Mr. Doyle, you have 3 minutes.
Thank you. Senator Winfield, Representative Staffstrom, Ranking Members Kissel and Fishbein, and distinguished members of the Judiciary Committee. My name is Jack Doyle. I am an Executive Assistant State's Attorney in the Division of Criminal Justice, state prosecutor. I've been a state prosecutor for 22 years. And on behalf of the Division of Criminal Justice, the Chief State's Attorney, the Deputy Chief State's Attorney, and the State's Attorneys for the 13 judicial districts of the state, thank you for allowing me this opportunity to testify on Senate Bill 888. We submitted written testimony. It's several pages long. I know that all the members of the committee have that. So I would just summarize what I would have to say on a few points. First, I think it's important for our agency to recognize that the governor's office did several weeks back allow us to have an advanced copy review of this bill so we could address some of those issues. And we did look at some prior versions of it, and we greatly appreciate that so we could provide input to this committee. One of the recommendations that the division has offered is to include a section of the bill that would mirror 1411E. We didn't notice that this morning, but I will recall for the committee there that Undersecretary Pelka did address this particular issue. This was the issue of an underage individual happens to be in possession of marijuana to mirror an individual underage in possession of alcohol. So I believe at some point, perhaps in a future proposal, that would be addressed. In regards to an additional section of the bill, the division recommends is that lines 314 to 315 be revised to state convicted on or after October 1st, 2015, and then add the language, but prior to January 1, 2022. This would allow for the erasure of any conviction under 21A 279 that occurred prior to the enactment of the revisions to that statute on the bill. It's our position as drafted, an individual convicted under 21A 279A as amended by this bill would be able to immediately petition for the erasure of that conviction. And subsection C and D is amended, which allow for penalties for subsequent offenses would be rendered superfluous. We think that's something, we don't know if that was the intent of the bill, but I think it's something that should be looked at. Most importantly for our agency, turning to section 13 of the bill, the division fully agrees that the mere smell of cannabis or the presence of a legal amount of cannabis should, if it legalized upon the passage of this bill, should not be served as the probable cause alone to search a person or a vehicle. However, our courts have established that the determination of whether reasonable suspicion or probable cause exists is not based on a simple factor, but a totality of the circumstances that is well-grounded in state and federal case law. In preventing the police from ever considering these factors, section 13 of the bill fails to account for the fact that these factors, when combined with additional factors, may create reasonable suspicion or probable cause. That being said, we recognize the policy behind that particular section, concerns about police activity, concerns about searches of individuals merely for being smelling or having that odor of marijuana.
Attorney Doyle, I'd ask you to summarize.
Yes. In addition, we strongly support all the sections in this bill that relate to traffic safety, predominantly in sections 88, 89, and through 97, especially the provisions regarding the DRE and the A-Ride instructors. I'm happy to answer any of your questions. Thank you for your time.
Thank you, Representative O'Day.
Thank you very much, Mr. Chairman. And thank you, Mr. Doyle, for your testimony and your service to the state of Connecticut. On section 13, I don't know if you were on when I was questioning the governor's personnel on this section. How would you change, or what would you ask for a change to this section 13?
Well, as we noted in our particular testimony, we think that, and we have had conversations with the governor's office and some OPM representatives. What our concern about that, Representative O'Day, is those three sections, we believe that should be part of it if there's any other substantial or additional factors. Those alone should not justify a search or a seizure, unless unless something's seen in plain view under the case law. But those factors alone, we understand the focus and the intent of this policy, but they should be part of the totality of the circumstances and part of additional factors. So if let's just say hypothetically, we have a situation of 4 particular factors that could give rise to reasonable suspicion and probable cause. If we take those first 3 out that are focused in section 13, all we have is that one, and that one may not lead to probable cause or reasonable suspicion during any particular type of investigation. So we think that we had suggested or have been discussing terms involving wording that be that it get added in, that it be not be one of substantial factors. That would be our concern, our recommendation.
So yeah, so if we just put in not one of the substantial factors, then that you'd be satisfied with the legislation.
That those three factors should be added in. The best way to explain it is, well, I think is if we word it is that those three factors can be used in addition, in conjunction to other factors, but not solely by themselves. We understand, our agency understands, the policy decisions on whether to legalize adult marijuana. That's completely in the policy opinion of the legislature. We take no position on that. But we are concerned about how we enforce DWI enforcement statutes and perhaps other types of cases where evidence may be indicative of another type of crime or another type of situation. And that's what we're concerned. But we would also point out with body cameras and things like that, and the influx of those coming in and becoming more relevant, we can ensure that law enforcement and police officers follow through with the spirit of what what the legislature and the governor wants to establish.
Thank you very much, Mr. Doyle, for your testimony. You and I share the same concerns with Section 13. Thank you.
Thank you.
Thank you, Mr. Chairman.
Thank you, Representative O'Day. Senator Champagne.
Thank you. And thank you, Attorney Doyle, for appearing today. I have a question and concern with the DRE, drug recognition expert, and the ARIDE programs, and how you're dealing with that on the prosecutor's side. Can you tell me, have you relied on the drug recognition expert in when you were prosecuting a case?
Senator, I should indicate, I have been a prosecutor for 22 years. I'm newer up to this position. Prior to this, I spent 10 years in New Haven in the Part A office. So I think the last time I actually handled the DWI itself was about 10 years ago. But I do know that it is a process and something that we were using based on previous testimony. I do sit on some boards and committees where we do address that. And it is, as you've heard from previous testimony today, we highly recommend it. We think it's very important, although we do recognize there's a fiscal component to making sure there's enough officers and troopers in the state trained in that recognition. But it is used by prosecutors every day. And we, not only that, our agency trains police officers and receives training from police officers on how that system works. It is vital to those types of cases.
Okay, and if you have just the training coming out of the police academy, the field tests, how strong are those in upholding a DUI for marijuana?
You mean field tests on the road by
Yeah,
officers?
just the basic field tests you get out of the academy. How strong are those field tests for conviction for a driving under the influence of marijuana?
They're not very strong. They're not used very often because, as we've indicated previously, the ARIDE and the DRE training is necessary in order to support a prosecution of operating under the influence of marijuana or any drug.
Right. I understand they have some new tests coming out, but I haven't seen any of those. And I think we were going to have some people come later on and testify on that. Okay. But, one of my pushes is, we need to provide, as a state, we need to provide money to get more DRE trained officers and the ARIDE. And, before this law goes into full effect, we should have enough out there that can deal with the problem that I believe this is going to create. I think, as far as simple possession of marijuana, it's essentially an infraction now. Yeah. Are you guys seeing anybody even above just the simple possession, even above the 4 ounces? Are you seeing anybody going to prison on that that's not related to drug distribution?
As I've indicated, I've been a prosecutor for 22 years, and even going back to the beginning, I've handled lots of drug cases. And I would indicate to you that even as far back as when I started in 1998, it is rare for somebody to go to prison just solely for the offense of possession of a controlled substance. And that has been the case since the beginning. There are always exceptions to the rules. And I think one of the things, as I'm sure this body recognizes, that even under the simple possession of drugs, even under the marijuana, part of the infractions and the misdemeanors, and even when it was felonies, we have opportunities through the judicial branch for diversionary programs. So it's usually several times if you're arrested for simple offenses where you use the diversionary programs before you're ever even getting the conviction. What I will indicate, there are times where somebody might be serving time for, say, a marijuana offense back in the day, but it's usually in conjunction with something else, another more serious offense kind of a thing. It's very rare.
Okay. And I know somebody earlier testified that, well, we would have it because those on probation or parole who get a bad urine are actually doing time for the simple possession. And I disagree with that, because they wouldn't be on parole or probation because due to the original arrest. Now, what is your take on that? Do you see the same thing that they see, or that it would be a marijuana going to prison for a violation of probation or parole?
Well, I was probably clarify. Parole is a little bit different than probation. Right. I know that because probation is.
That's what I meant. Let's just stay with probation.
Okay. So in my experience, in all that time, no, that would be. I think it would be highly unlikely for an individual on probation, no matter what they're on probation for, to be sentenced or incarcerated for just getting a dirty urine. I think it would be additional factors: failure to comply with whether anger management treatment or drug treatment, or show up somewhere or miss an appointment. And one of the things that the Office of Adult Probation through the judicial branch has had for years is the technical violation units. And that's where, if you're supposed to be following through with drug treatment for probation and you're reporting once a month, but you don't do it and you're in that violation status, they're going to refer you to the technical violation unit, and you're going to have to come in once or twice a week and either get urines or go to treatment. I would indicate probation or judicial branch may have more of the stats or the information on that, but I would posit that individuals who are usually going to prison for violation of probation are more going for a new criminal offense in conjunction with violation of probation. That is the majority of what we see.
And technically, probation, you're still actually a prisoner.
Whether you got a suspended sentence in probation or you are now released from prison after what we call a split sentence and start probation, you're under the supervision of a probation officer through the judicial branch. And generally under state and federal case law, you have less liberty interests, so to speak.
Right. Okay. Thank you. I'm going to leave it at that. Thank you.
Yes, sir. Thank you.
Thank you, Senator Champagne. Representative Porter.
Thank you, Senator Winfield, and thank you, Mr. Doyle, for your testimony. Just to follow up on what the good senator was questioning you on, I am interested to have an answer as it relates to parole. If you come back with a dirty urine due to cannabis, are people being remanded back to prison for that kind of violation?
Representative, I'm not positive about it, but I would presume that yes, there probably are situations where that is done. Parole is treated a little bit different than probation because I think, as was alluded to before, as opposed to the judicial branch, you're under the supervision of the Department of Corrections. Would I surmise that at times somebody gives a dirty urine, whether it's for one type of drug or another, are they perhaps remanded into correctional custody? That could happen. At times, though, do I believe that parole officers you're out on parole, you they may or may not know that you have a substance abuse problem, or you may have had one in the past. Now you have a dirty urine. You may be referred to treatment as opposed to remanded back. You may be remanded back for a period of time until they locate treatment. But I think all of those are possibilities. So it is possible, yes.
Okay, thank you for that response. I do have a very close family member that has advised me that is customary under parole, but not necessarily probation, as you stated. I just wanted to put that on the record that it is customary for people to get remanded back to prison for dirty urine. Thank you, Mr. Chair.
Thank you, Representative Porter. Attorney Doyle, you've been a prosecutor for 2 decades plus, and you've operated in an area where I live. And so I think you have a lot of experience. So there's been a lot of conversation about whether or not simple possession is what puts people in prison or not. And a lot of this is related to the comments on social equity. I want to ask you about social equity as a manner, as a means of righting some of the past wrongs, and not about whether simple possession has put people in prison or not, but from your experience, particularly given what you've seen in more urban areas, has simple possession been a means by which, and we know police don't operate the same in all areas, by which interactions have begun that may have led to other things? And as a professional, I'm asking you an opinion here. I know it's not a fact, but as a professional, do you know or believe that it may be the case that the way in which it happened in one area might be different than the way in which it happened in another area?
Senator, by that, do you mean one area of, say, New Haven, or one area of the state? Do you mean?
Well, I think the truth of the matter, from my perspective, would be the same, probably the same answer.
There's no doubt that, from my perspective, having been, and I should clarify, up until this position, New Haven was where I was for 22 years in both the GA and then the Part A court. At times during my career, I was focused on prosecuting drug crimes and drug offenses for the early part of my career. Have I seen what I think the legislature or this body is concerned about motor vehicle stops or situations where things have occurred and taken a next step based on a smell of marijuana? Yes, I've seen that, and I've occurred that. And that's why I think our agency understands and appreciates and respects the position that this body's been taking about just the smell of marijuana. But I have seen difficult situations. I have seen individuals come into courts for just simple possessions versus sale cases. We've always tried to, as a prosecutor, I've always tried to distinguish between that. Who is somebody where it's a simple possession matter? Who is somebody that needs to be referred to the diversionary program, by difference between who are traffickers and who are dealers. But do I think that there's been some inequities? Obviously, okay, it's seen throughout the country in different levels. I don't know if everything in this bill is going to solve that or reduce that. I don't know whether or not, as far as legalizing marijuana is going to make a big difference there, but that's a policy decision that this body would have to make. I don't know if I've answered your question or.
You did. I didn't mean to cut you off. You did, and I'm asking you because I have some sense of your history and the level of professionalism that you're bringing in front of us. Because I think a lot of conversation has been focused around whether or not people are sitting in jail right now, and I think the issue of equity is much bigger than that. And I think whether people are in jail right now or whether people are experiencing anything right now, there's still vestiges of the policy that we have had that are still in place and having real impacts on community. And there is no way to have a society where we're equal if you don't deal with the issues of the past. So I thank you as someone who might have a perspective that might be slightly different than mine for engaging in that conversation and helping us to understand better the issue of equity. Thank you. Are there questions or comments from others? I do not see any. If that is the case, thank you again, Attorney Doyle, for joining us today.
Thank you, sir.
We'll hear next from Sal Luciano, followed by Ron Petronella.
Good afternoon, Senator Winfield, Representative Strafstrom, and members of the Judiciary Committee. My name is Sal Luciano, and I'm proud to serve as the president of the Connecticut AFL-CIO, a federation of hundreds of local unions representing more than 220,000 members in the private sector, public sector, and building trades. The Connecticut AFL-CIO supports the concept of legalizing recreational adult use of cannabis, but we think the governor's bill requires modification. We encourage the General Assembly to add the missing equity standards and worker protections as conditions for authorizing a new industry. If Connecticut is going to join our surrounding states in legalizing marijuana, it's important that we build a foundation to ensure that the jobs created will be a net positive for our state, and those most adversely impacted by the war on drugs have opportunities to create new careers, establish thriving businesses, and build economic security. The best way to create good jobs in this industry is to make labor peace agreements a condition of licensure and require that construction or renovation of cultivation and retail facilities include prevailing wage standards and project labor agreements. The marijuana industry is a job generator. Without labor peace agreements, there's no guarantee these jobs will be well paid, safe, and respectable. provide livable wages, health insurance, retirement benefit, and paid leave in excess of minimum state requirements will provide stability that will lessen turnover and reduce involvement in the underground market. Labor peace also protects the health and welfare of workers and consumers. A well-trained workforce will be able to produce quality products that meet product safety standards. Prevailing wage standards uphold local wages, protecting local contractors and construction workers from low bids that reduce the market price for labor. They also support safety and skills training program, improve economic outcomes for veterans, and provide pathways into the middle class. Project labor agreements establish basic terms and conditions of employment for all employees engaged in a building or renovation project. PLAs commonly include local hiring requirements, which can be adjusted by zip code or specific geographical area, with commitments to hire workers of color and women. They also promote job opportunities and apprenticeship programs to ensure skilled job training within the local community. I've included a bunch of language and written testimony that I'd like to see there. California and New York require these worker protections in their cannabis statutes. On Monday, New Jersey Governor Phil Murphy signed legislation legalizing the adult use of cannabis in his state. Section 16 of A21, page 57, includes the labor peace and project labor agreement protections we are seeking. Surely it only makes sense that Connecticut cannabis workers enjoy the same protections as those in our neighboring states. SB 888 is a beginning. There's much more that can be done and should be done to ensure that legalized recreational cannabis in Connecticut rights the wrongs of the past and moves forward in a way that delivers the equity promised in the title of this bill. As part of that effort, we respectfully request that the committee amend this bill with the language we have provided. Thank you for the opportunity to testify.
Thank you very much, Sal. I see Representative Porter.
Thank you, Mr. Chair. And I don't have any questions because you answered the questions that I was going to ask you. But I just wanted to thank you for being with us today, Sal, and bringing the importance to this platform and to this committee, why labor peace and project labor agreements are so important to this industry, especially being the amount of jobs that it will present as a billion-dollar industry. So thank you for being here today. Thank you, Mr. Chair.
Thank you, and thank you for all that all of you do.
Thank you, Rep. Porter. Are there comments or questions from other members of the committee? Just being a little careful, I missed the hand last time. I don't see any. So thank you, Sal, for joining us again and offering an important perspective. Thank you.
Thank you.
Next, we'll hear from Ron Petronella, followed by Dave Roche.
Yeah. Senator Winfield, Representative Straffram, and members of the Judiciary Committee. My name is Ronald Petronella. I'm president of UFCW Local 371, a union representing over 8,000 workers in retail food manufacturing, healthcare, and other industries. Nationwide, our union represents over 10,000 cannabis workers. Those are growing rapidly as the industry grows and more workers choose to organize. I'm writing to share my thoughts regarding SB 888, an act responsible and equitable regulating adult use cannabis. The UFCW supports the legalization of recreational cannabis in Connecticut only with the addition of a labor peace agreement as a condition of cannabis licensing and renewal. I'm here to address our unique opportunity to create an entirely new industry in our state from the ground up, and our ability to make sure it employs a diverse workforce and creates family-sustaining jobs. It's my hope that this bill, we are able to create jobs that encourage young people from all backgrounds to put down roots in our state and raise their families on the income they will make as cannabis workers. Labor peace agreements are an agreement between an employer and a union where the union agrees not to strike, picket, boycott, or otherwise disturb an employer's business. In exchange, the employer agrees to allow its workers to decide whether or not to join a union free from intimidation or interference. The unionized cannabis workforce has been rapidly growing in the United States as a result of labor peace agreements, and cannabis workers' wages and benefits have been growing too. Unionized workers make 13% more than non-union counterparts. Our members working in the cannabis industry are able to join our union health benefit plans, defined pension plans, which will allow Connecticut workers who may currently be working in low-wage jobs to get off of public health insurance plans and to finally have retirement security. Local 371 also supports the addition of project labor agreements to this bill. A project labor agreement added to the construction of these new facilities will ensure that those constructing the building will be hired locally and well-trained. Many of our members currently live in the communities which were disproportionately affected by the war on drugs. Enacting a bill that encourages equity and creates good family-sustaining union jobs is important to right those wrongs. And we are excited to be part of those changes in our state. And I've attached language with both labor peace agreements and project labor agreements. Thank you for the opportunity to comment.
Thank you, Mr. Petronella. Representative Porter.
Thank you, Mr. Chair, and thank you for your testimony, Mr. Petronella. You mentioned that UFCW actually has done this in other states around cannabis and that you actually have union workers in the industry. Is that correct?
That's correct.
So what would you say? Would you say that it would be expedient and wise for us to make sure that we do include labor at the table through this process, since you guys already have hindsight into what works and what doesn't work?
Yes, I mean, we do have experience in the industry with the workers in the industry, and we know how the industry works. So we do have experience in the industry.
Okay, and I think that's important.
We have contracts where we represent workers in other parts of the country.
Yes, thank you. I think that's important, especially around workers' rights and what all of what you just stated stands for.
I'm also a trustee on the National Pension Fund, and we have members in the cannabis industry in the fund.
That is good to know.
Yep.
Thank you for your testimony, and thank you, Mr. Chair, for the time.
Thank you.
Thank you, Representative Porter. Are there comments or questions from other members? I do not see any. Thank you, Mr. Petronella, for joining us this afternoon.
Thanks for having me.
Absolutely.
Thanks for all your hard work.
Thank you. Dave Roach.
Good afternoon, Senator Winfield, Representative Strasburg, members of the Judicial Committee. My name is Dave Roach, President of the Connecticut State Building Trades and Business Manager for the Sheet Metal Workers Air, Rail, and Transportation Union in Connecticut. I've been a 42-year member. I represent 30,000 men and women and their families in Connecticut, throughout everywhere, through every town and city and around Connecticut. So I'm here today to tell you I like this bill. The concept of it is good, but once again, it falls short. The labor peace agreements, without them, is wrong way to do this bill. As you look at what New Jersey does and New York does, they did it for a reason. They did it because it's going to build up their lower class to middle class, and that's a gateway for us in Connecticut to take advantage of. Again, not just to get to the middle class, it's taking you out of the poverty class. When you talk about what you just heard Brother Petronella say, they already have the training in place. So instead of not having these peace agreements and some other workers coming up from other states in some of this industry, we'll be able to bring the training up here and train our people, our residents of Connecticut. So I urge you to look at the labor peace agreements. It's very important to us to be successful while helping our communities as well. As far as the project labor agreements go, I think most of you who know me know how I feel about them. I think that is another gateway. We could tailor project labor agreements to any community. We're one of the biggest supporters of hiring veterans, minorities, women, and getting them into our business for a long career. As I said, I have a 42-year one, and I come from that, right? I was born and raised in Hartford, lived over on Park Street, lived off of Hillside Avenue, where I got the nickname Hillside Dave. These things, I go back, and believe me, I may look this way, but I know what happened to me was I got the opportunities that the other people that I went to school with didn't, and I think we owe that to them, to everybody have that opportunity. So I urge you to do that. one thing I wanted to go back to earlier, one of the governor's senior staff advisors was testifying, and I believe somebody asked him about if there was ever any contact with us in the administration to include some of this language, and I believe it was Jonathan Harris, and he said there wasn't. And I just wanted to clarify that, and I have it in front of me, emails that were sent to him on February 4th, and that he acknowledged that included language. And if you want copies of that, I'd be more than happy to. It's not I'm not trying to put Mr. Harris down. I know they're busy, but it was a false statement, and I wanted to clarify that. So thank you for hearing my testimony today, and I'll answer any questions if you would like.
Thank you, Mr. Roach. Representative Porter.
Thank you, Mr. Chair. No questions. You actually just answered what I was going to ask you about any communications with the governor's office relating to PLAs. So thank you for stating that for the record, and thank you for your testimony, and thank you, Mr. Chair.
Thank you, Representative Porter. I do not see any other questions or any other hands raised, actually. Seeing none, I would like to thank you, Mr. Roach, for joining us this afternoon, and thank you for offering your opinion.
Thank you. Thank you.
Next, we'll hear from William Hunn, followed by, I think that's correct, followed by Rudy Marconi and Emily Sabo.
Yes, Mr. Chairman, thanks. Members of the committee, I've worked in the field as volunteer on the issue of teen abuse of alcohol and drugs. And the effort has been to see whether it would be possible in Guilford to change the culture here and actually reduce the use. And we found through the surveys that we take that we actually ended up with like a 50% reduction. So it's been a fun thing to work on, and I think an important thing and something I care passionately about. As I listened to the testimony from the governor's people this morning, it explained to me why there's a hole in Senate Bill 888. And that hole is the public health aspect of this. There are a lot of reasons why legislators want to legalize marijuana, and I recognize that, but there's one major reason why you really probably shouldn't take the step, and that's the public health impact that comes out of it. And I noticed that the Department of Public Health wasn't part of the governor's team, wasn't part of the testimony this morning. It's also something that the task force appeared to miss out on, was taking a hard look at what's gone on in the states that have legalized in the past 3 years. In Colorado, there's been an industry war to increase the potency of their product, the THC in the product. Close to half of the stuff being sold as cannabis is shatter, wax, high THC potency oils, dab, and vape products. And those aren't benign plants. Those are really highly processed chemicals that have a significant impact on public health. The impact on kids was discussed by Representative O'Day, and there's very easily accessible data from a survey by SAMHSA that shows that the 10 states with the worst record on teen marijuana use are the 10 states that have legalized marijuana. Vermont, Maine, Oregon, Washington, New Mexico, Montana, Colorado, Massachusetts, Nevada, California are the order in which that occurs. The consumption data, also something the governor's task force easily could have gathered up, shows that.
Mr. Hunt,
yes.
advise you that you're 3 minutes if you could testify.
Okay.
Summarize, sorry about that.
Yep. It shows that in Colorado, use of marijuana approximately doubled following legalization, and use by heavy users also approximately doubled. And you end up with approximately 145,000 people, additional people with substance use disorders. And I feel like that's something you all and the task force really need to dig into and understand. Thank you for the time.
Thank you, Mr. Hahn. Representative O'Day.
Thank you very much, Mr. Chairman. Mr. Hahn, thank you very much for your testimony. Where did you get that information about the 145,000 with substance abuse disorder?
Yeah, it's really very interesting. There's a report from the Department of Revenue in Colorado on the marketplace, and they've done this report, I think, since 2014, and that has extensive statistics on a lot of different things, but including use. And they're not. It's not like they're a pro-marijuana organization or an anti-marijuana organization. They're really just the people gathering up the taxes, trying to figure out what's going on. So I think it's really good data for the Connecticut legislators to look at. If you want to understand what's going on in Colorado, not hard to get, not hard to do. And I'll email you actually, it's in my testimony. So in my written testimony, you'd have a way to reach that link.
And what is your background, Mr. Hahn?
I'm a lawyer. I was a lawyer for Pfizer for many years. And I had a kid who, my youngest daughter, got addicted to crack as a high school sophomore. And I saw what happened to her. She dug her way out. She's in recovery. She's doing great. Good mother, professional job, but lost her childhood. And some of her friends didn't make it back. So I saw firsthand what can happen to kids. And I decided that my volunteer work here in town was going to deal with that problem.
Well, thank you very much. Was there any other part of your testimony that you wanted to relay to us that you didn't get a chance to say?
No, it's really is the point that you've been making about the public health piece of this, and I think it's a shame that the Public Health Committee isn't going to get this bill, and I think it's really wrong for the governor to have left that out of the group working on this, because the public health part is the one real dark side of the issue, and even the proponents that, you know, the strongest proponents I know care about their kids and their constituents, and they don't want to see people get destroyed by this stuff. So
thank you very much, Mr. Hahn, and thank you, Mr. Chairman, for allowing me to ask questions. I know it's going to be a long night, and I promise to be here till the end. Thank you.
All right, as long as you're here with us, Rep. O'Day, you know. Mr. Hahn, I have a question for you. So, and I appreciate you bringing the information before the committee. And we've had conversations, as you know, for many years about this particular aspect. The information about the 10 states and where they are in terms of drug usage and the issues that they have. Do you know if those states, before they legalized, were sitting in those positions or similar positions? Because it's important, I think, that when we bring the data, that we're aware that it's possible. I'm not suggesting this is the case. I'm going to ask you this question, but it is possible that you could be at the bottom and have legalized and still be at the bottom, but even have made progress. So what can you tell us about that data that you have as it relates to my question?
Well, I know that legalizing does change the state's position on the list, because Massachusetts wasn't on it 2 years ago and now it is on it. So I saw that happen with that state. Vermont, I don't think was on it, and now they are. Vermont's actually number one. It's and it just can't be coincidence that the states that have legalized are 1 through 10. It would be easy enough to have an aide look up the SAMHSA National Survey on Drug Use, and they have the state data, and have them. It would really be very interesting to see what it was 10 years ago, 5 years ago, and the most recent stuff they've got, and that I think would. I think that's the kind of thing that you all really should understand and be thinking about it because it's so important if this is going to hit the kids and make things worse, that's the way to tell.
Sorry, but I didn't mean to cut you off. And I would agree with you. And for the last, and I'm not really doing this year, but for the last 3 times that this bill has come before us, I've actually broken down the data and showed not just what the big thing that people are talking about, but inside of the data, how I think we're missing part of this, right? And a lot of people focused on Colorado, and when you look at teen usage, it stayed relatively flat with a slight dip in it, not an increase, right? So I think if we're going to bring data, what I'm asking people to do is to help me to understand how they interpret the data so that I can get a fuller sense of what they're suggesting to us. Because my read of the data in the last 3 years of work that I've done on this committee to talk about that sense has indicated something different than what has been brought in front of us. But I'm not trying to argue with them. I'm just trying to understand the perspective that people have, having worked on the data that's been in front of us. But I see there's several other questions for you, so I'll let other members ask you some questions.
Actually, if I could just quickly respond to that.
Absolutely.
I think that would be a perfect question for you to bounce to the Department of Health. And there may be other ones that you'd have that, like, I know they could do that in an hour or two of one person's time. It isn't something that takes a 6-month study. They can dig into that and get back to you on what's happened. And it really should be easy to do.
Thank you. I see a question from Representative Porter, followed by Representative Dillon.
I'm sorry, you made the point that I was going to make, because I've actually been looking at data myself that shows that Colorado they've actually reported a 20% decrease in arrests around youth and a slight decrease in youth use. So you pretty much made the point.
Thank you, Representative Porter. Representative Dillon.
I just wanted to thank you for testifying today. I think, and thank you for your concern for our young people too, and taking your own pain and using it to try to help others. I think it would be mental health and addiction, not necessarily the public health department, but I think you've made an important point, and it's really kind of embedded in our federal government, that alcohol, tobacco, and firearms were regulated by the Treasury Department, not by the FDA. And they're seen as revenue. And I remember maybe 20 years ago, I did a bill to regulate nicotine as a drug, and it blew up the building. I mean, people were looking all over, for amendments to see if I had hidden it somewhere. So that our attitudes have changed, but I really want to look at the data myself, and I think the way that the problem that's embedded in some of this, for me, is a justice issue, and I won't dwell on that, and that's because of where I live, which is where Mr. Doyle was the prosecutor, and because I see the disparate effects, because I represent 2 different zip codes. And so, but I think you've raised really something that's really, really helpful. And I really want to thank you for being here today.
Well, thank you.
Thank you, Representative Dillon. I do not see any other hands. Mr. Hahn, again, thank you for joining us, offering your perspective.
You bet.
We have Rudy Marconi, Emily Sabo, and Devon Ward. Is Emily Sabo here? I don't see Marconi. Mr. Attorney Ward. Oh, wait, nope, there's Emily Sabo.
Hello.
Yes, hello.
Good afternoon, Senator Winfield, Representative Staffstrom, and members of the Judiciary Committee. Thank you for the opportunity to testify today on SB 888, an act responsibly and equitably regulating adult use cannabis. My name is Emily Sabo, and I'm a business agent and organizer with the United Food and Commercial Workers Union, Local 919. We represent about 7,000 workers here in Connecticut. The UFCW has been at the forefront in creating and shaping a new cannabis industry across the country. Currently, the UFCW International Union represents over 10,000 cannabis workers nationwide, from seed to sale, including growers and manufacturers, cultivators, processors, and dispensary technicians. On average, unionized UFCW cannabis workers earn 13% more than non-union cannabis workers. We're focused on growing the industry in a fair and equitable way. The UFCW supports the equitable legalization of adult use cannabis in Connecticut only with the addition of labor peace agreements as a condition of obtaining a license, and a requirement that construction or renovation of cultivation and retail facilities include prevailing wage standards and project labor agreements. A labor peace agreement ensures that workers have the choice to form a union in a neutral environment and ensures that the very communities impacted by cannabis prohibition have access to good paying jobs with affordable healthcare and secure retirement. Additionally, union contracts provide equal opportunities to everyone. Without a labor peace agreement, there is no guarantee that these jobs will be well-paid, safe, family-sustaining jobs. Additionally, project labor agreements establish the basic terms and conditions of employment for all employees engaged in a building or renovation project. They also commonly include provisions to recruit and train workers by requiring contractors to participate in apprenticeship and training programs, as well as establish commitments to hire women and people of color. I've attached examples of this language in my written testimony. Both labor peace agreements and union contracts help address the existing inequalities that cannabis prohibition has caused. Labor peace agreements give workers a chance at having a union and, more importantly, a voice in the workplace. We need a bill that will build the framework that Connecticut needs to create family-sustaining jobs with good wages and benefits in a growing industry. And with the addition of both LPAs and PLAs, we will be certainly headed in the right direction. Thank you.
Thank you very much, Ms. Sabo. I see Representative Porter.
Thank you, Mr. Chair. Just really quick, Emily, can you speak to the indicators when we do have labor peace agreements that create spaces for work where they feel safe? What's the end result?
Sure. So when it's proven that when workers have the opportunity to join a union in a neutral environment, they choose to join unions at much higher rates. Thank you.
Thank you, and thank you, Mr. Chair.
Thank you, Representative Porter. I do not see any other hands. Oh, well, I do. Representative Fishbone.
Thank you, Mr. Chairman. Hi, Emily. Hi, how you doing? I just wanted the labor peace agreement. How does that work?
Like, what is a labor peace agreement?
Sure, and it's very fundamental.
Basically, it's an agreement between a union and an employer that the employer agrees that they'll allow their workers to join a union and they won't interfere with the process. And in turn, the union agrees that there won't be any work stoppages, strikes, actions during the process.
Okay, and why is that necessary given that we have federal laws that prevent that sort of activity?
Because unfortunately, employers find a way around those laws. And for the past few years, I've been an organizer with Local 919, and these issues that cannabis workers have aren't unique to the other issues that workers have. So when we have the opportunity to build a new industry and a growing industry, we want to do it the right way and give workers a level playing field, give them the chance for Connecticut workers to have more opportunities and better opportunities.
I'm just trying to link up the two. So employees can gather amongst themselves and decide to be governed by a collective bargaining contract. That's free right of association. How does this different under this concept that's, I recognize not part of this bill, but somehow we got here?
So this means that an employer would agree to stay neutral in this environment. And they wouldn't hold captive audience meetings, for example, or encourage or discourage the workers one way or the other.
Okay, so they wouldn't hold captive audience meetings.
That's just an example, but they wouldn't interfere with the process. They would let the workers, this is about empowering workers to make the choice. Yeah.
Sure, and workers are empowered to make the choice whether or not to associate under a collective bargaining agreement. I'm just trying to, so you would have it that one could not engage in this industry unless they agreed to these labor peace agreements. Is that what I'm hearing?
We want labor peace agreements as a condition of a cannabis operating license. Yes.
So you don't trust individuals to be able to make those choices to associate on their own?
I don't think I understood your question.
Okay, well, you're saying that you would have it that one cannot engage in this industry unless they enter into this agreement, this labor peace agreement. And I'm just trying to figure out if the workers, maybe the workers don't want to do that. That's their choice, right?
Oh, right. We're not forcing workers to have a union. We're giving the workers a neutral environment that if they choose to join a union, they have an opportunity to do so.
So that's, I guess we're assuming that all entrepreneurs and risk takers that would engage in this new industry would do these bad things absent the agreement. Is that the presumption?
Well, if they weren't planning on doing it, then why would they not be willing to sign a labor peace agreement in the first place if that was never their intention?
Well, maybe because they don't want to be overly constrained by the government.
A union isn't a government. It's an agreement that
But we were talking about the employer.
A union and an employer come to a labor peace agreement. Isn't the union and the employer negotiate the conditions of the labor peace agreement?
Okay, but I don't know how the state can control them getting into it if then the employer is determining what is in the union peace agreement, the labor peace agreement. So, okay, I guess you answered my questions, but thank you, Mr. Chairman.
Thank you, Representative Fishbein. Are there other questions or comments from members of the committee? I do not see any. Therefore, thank you, Ms. Sabo, for joining us this afternoon. Next, we will hear from Devon Ward, followed by Elisa Ring and Zachary Mystery. Mr. Ward, Attorney Ward.
Great. Thank you so much, Chairman Whitfield. Thank you, members of the committee, for allowing me to testify today on SB 888. I did submit written testimony, so I'm going to really direct my comments in the interest of time. I wanted to address some of the comments I've heard about adolescents and teen use. There's a phenomenal study that was produced in November of 2020 by the US CDC that shows in legalized states, teen adolescent admission rates have dramatically decreased. Teen usage in legalized states has dramatically decreased. And so, for folks saying that that teen usage in states like Colorado and Washington have increased, it's inaccurate. And also signed up as one of my colleagues, Barbara Brohl, who is a former regulator in Colorado. So folks who have specific questions about what happened in Colorado, she will be up shortly, and you guys can ask her specifically about what's happening and what is happening in Colorado. I'd like to direct the rest of my comments to specifically the bill that's in front of the committee. I am urging the committee to strengthen 888 and then pass it out of committee. And the things I would like amended in the bill are as follows. Section 98 directs cannabis revenue allocation with 50% going to the general fund and pilot. It doesn't specify that any percentage be directed to communities hardest hit by prohibition. It's imperative that SB 888 direct the bulk of the revenue toward equity and community reinvestment. Section 26 allows the department to begin accepting lottery applications for adult use cannabis businesses immediately on July 1st, 2021. It does not require any slots to be reserved for equity applicants. It's essential that a significant portion of the lottery slots be reserved for equity applicants, which should be defined based on the Equity Commission's input. We'd like the bill to also expand expungement. Section 4 provides for automatic expungement and erasure for cannabis possession. We urge it to be revised to allow no-cost expungements for all cannabis-related offenses. We encourage the bill to direct early startup fees to equity. Section 19 allows existing medical producers to sell to adult use cannabis establishments, except delivery licensees after paying hefty fines and getting DCP approval for medical supply. However, it doesn't specify what those fees will be used for. It's imperative that the early startup fees be directed towards equity in the industry. We'd like increased equity in early startup businesses. We'd like a requirement added to Section 19 that medical producers converting to adult use submit a plan approved by the Equity Commission or a successor entity to reinvest or provide employment and training opportunities to disproportionately impacted census tract areas or communities impacted with high rates of drug arrests. We'd like the cap removed for micro license cultivators. We appreciate Section 1's inclusion of a micro cultivator license. We recommend adding language that the micro cultivator license be not capped or subject to lottery. We'd like to see no jail for home cultivation. We urge the bill to allow discrete, secure home cultivation. If the committee doesn't decide to go with that change, we'd at least like the first offense to be a civil penalty instead of a criminal penalty. We'd like.
Attorney Ward, your 3 minutes are up, so if you could summarize.
Yeah, in short, Senator, I think that SB 88's it's a solid start to begin the conversation on how we legalize here in Connecticut, but it certainly can be amended and strengthened. And I'd urge the committee to review my written testimony to look at other ways to strengthen the bill.
Thank you for that testimony, Attorney Ward, and thank you for spending a lot of time talking to us about this. Representative Odette.
Thank you very much, Mr. Chairman. And Mr. Ward, thank you so much for your testimony. I'm looking at a report from the Connecticut, Colorado Department of Health that was released done October 3rd, 2020, but was cited in an article Friday, February 26th, today, where it says that there was a 69% increase in students vaping marijuana over the last 2 years, and a shocking 80% increase and twice the national average over the last 3 years. Are you aware, is that the study? What study are you referring to that was a decrease?
I'm referring to a United States Center for Disease Control study that was released in November of 2020. I will say, I haven't seen the study that you're referencing. I'd be happy to take a look at it, and I'll certainly send over the study that I'm referencing to the committee.
Thank you very much, Mr. Ward. I greatly appreciate it. Again, my biggest concern is teen use and abuse. And that's my focus, adults as somewhat of a libertarian when it comes to those over 25. I'm most concerned about the effects on teens. So please, Mr. Ward, if you could send that to the committee chair, I'd greatly appreciate it. And I'll take a look. And thank you, Mr. Chairman, for your time. Thank you,
Rep. J. And Attorney Ward, I would ask you, if it wasn't attached to your testimony, to please forward the study to the committee. Representative Doucette.
Thank you, Mr. Chair, and thank you, Devon. Good to see you today. Thanks for coming out. My question is, and I know this is a multifaceted issue, and you didn't touch on it, but I know you're basically one of our resident experts on this issue, so hopefully it's something sort of within your purview and research, and if not, you could get back to me. My question is about how the framework under this bill compares to other states with respect to the question of driving under the influence, both in terms of the field test framework and in terms of the criminal penalties. How do we compare? And do you have any thoughts on how we could improve those sections of the bill?
Sure, and thank you for the question, Representative Doucette. With respect to the driving while impaired, those provisions are pretty much on par with other states. Here, the reality is, the unfortunate reality is people are already driving impaired in the state of Connecticut while using marijuana. And this bill wouldn't change how officers are able to effectuate, those arrests when folks are suspected of driving under the influence. It wouldn't change anything with respect to that. It does provide for extra training so officers are able to recognize when someone is driving under the influence of cannabis. And so in terms of what other states are doing, it's on par with what other states are doing in terms of being allowed to, or officers being allowed to make that determination when someone's driving while impaired through the use of a drug recognition expert. And so that's pretty on par. In terms of the penalties, the personal liberty penalties, they are rather small. New Jersey, which just finalized their legalization on Monday, they have put personal possession limits up to 6 ounces. New Jersey, which is a pretty high amount, but just so you can get a comparison of what other states on the East Coast are doing, New York's looking at 2 ounces, Maryland's considering up to 4. And so, the personal possession limits are relatively low. In terms of the fees and fines, they're about on par. There are some fines in the bill related to home grow that are particularly high, and then the fines for youth under the age of 21 usage are a little on the high side at $250 and $500. And so we're really, in part of my comments on the bill, we're urging an amendment to allow for at least a community service equivalent for those fees. But they're not so far out, high where they're so far higher than other states, but they're about in the same region. I would say that New Jersey, like I said, which is the most recent state to legalize, their fee for underage use is $25. So just to give you a kind of comparison.
Thank you. And what's been the experience in other states with DREs? I think we've heard some testimony that, there's obviously some costs and some time to onboard, officers as DREs. What's that experience been like in other states? States like Colorado that have had it legalized and regulated for a period of time. Do they have a good sort of saturation of DREs within their police forces?
I'm not exactly sure. And like I said, my colleague Barbara Bull, who's a regulator in Colorado, is coming up shortly. She'll be able to answer that. But I can get you some more information. I don't know off the top of my head what the saturation rate of DREs in Colorado is currently. I apologize.
Okay. Right. And how about data on arrests and convictions for driving under the influence in the other states? What's the experience with that been? Has it
I think
has there been an increase, or what they normally see for alcohol, or is it sort of comparable? And was it, expected based on, like you said, sort of the anticipated use and the fact that it was already happening in those states?
Right. I think someone from the governor's office spoke to this, and I think Senator Winfield addressed some of the data. It's tough to really parse out the data, because if you look at the data, it seems like there is an increase, but they just started testing for it. They weren't testing for traces of marijuana and DUI arrests before, and so it may appear that it's a little bit of a spike, even though the usage is the same, because they just started testing for it. So it's hard to really look at the data. But I don't think there's been a significant increase in instances of impaired driving in states that have legalized. Massachusetts is a good example of that. They're our neighbor state. There hasn't been a huge uptick of impaired driving in Massachusetts, since they started doing adult use sales in 2018. So,
yeah, it seems to be my impression too. And this is an area of concern, I know, for a lot of people. And it's an area of interest for me. But we, have a lot of data out there and a lot of experience from other states, like you said, Massachusetts, right? Our neighbor. So I think it bears looking at and could help, I think, as with our experience as we roll this out. So that's all. Thank you.
Thank you.
Thank you, Representative. I do not see any other hands. Is there C9? Thank you, and then Attorney Ward, for joining us this afternoon. I'm sure we will speak to you again soon.
Yes.
Yeah, I am told that the next person we have is Sarah Kate Venison. Is Sarah Kate here? There you are. You have 3 minutes. You may begin. You're on mute.
You'd think I would know how to do that the many times a day I do.
We all do it. It's fine.
Right. So both chairpersons and representatives of the committee and other representatives at large, I'd like to introduce myself. My name is Sarah Kate Venison. I'm here today in two capacities, one as a parent and another as a mental health provider. And from the testimony I've seen so far today, I think I'm the only mental health provider who is speaking up. So there's a lot of talk about statistics. I'd like to open my comments with an intersection of my parent role and my mental health provider role. In the last week, our own Department of DPH released the following statistics. In 2016 to 2019, for 18 years old and younger, the hospital admission rate for marijuana intoxication increased by 491%. Likewise, for 19 years and older, we saw an increase of 391% in that same period. The number of hospital admissions for marijuana intoxication do not approach zero until 50 to 55 years old. In analyzing hospital admissions for mental illness with marijuana use only, we saw increases in psychosis, including schizophrenia, up to 300% from 2016 to 2019. So you may be able to see over my shoulder is a picture of my son. My son is one of those statistics. He is also deceased. My son had a 5-year battle with mental illness and cannabis dependence, and ultimately a hell of a battle in the last year of his life with high potency THC. Some of those products have been talked about before. Make no mistake, there are people for which this drug kills. That's all I'm going to say about my parent experience. As a mental health provider, I worked in the child guidance system and the community health system for many, many years. And for all of those years, I oversaw juvenile justice programs, early intervention programs. I'm incredibly aware of how we need to address the criminal convictions, the enforcement issues, the social injustice issues, and economic inequities. I do not think this is the way to do it. I'm going to echo some of the other people saying that we have not had any chance, any representative this morning from public health or mental health. I really urge the committee to take some time, look at all the data, look at all the stats coming out of all the other states, and really, really understand that from my point of view, this bill is policy before science and data, and it is money before people. Thank you.
Thank you, Ms. Venison. Are there comments or questions from members of the committee? Representative O'Dea.
Thank you very much. I'm sorry, is it Dr. Venison? Is it?
No, I'm a master's level mental health provider.
And first of all, I'm so sorry for your loss.
Thank you.
I'm so appreciative of your testimony. I know how I can only imagine how difficult it was or is for you. When was it that your son passed away? How long ago?
March of 2018.
And I'm sorry, where are you, what town do you live in?
I live in Reading. My son passed away in Fairfield. He completed suicide.
I'm so sorry. The statistics that you were giving us, were those Connecticut statistics?
Yes.
Are you, my understanding is Colorado saw the same statistics at even a more dramatic rate when they legalized. Are you familiar with any of Colorado statistics?
I am somewhat familiar. I'm also familiar with some of the data that has been spoken of so far today. I think that there are organizations out there that do a great job of collating all of this stuff. Smart Approaches to Marijuana is one of them. I would defer to people who do that for a living. I can say in my own private practice, I also supervise people across the state in different agencies. I hear time and time again concern for this artificial divide between adult use and young adolescent use. And I thank you, Representative, for using the age of 25 as when you really get your adult brain. After that, I think we can think about other things. I think we have to be very, very vigilant around the mental health of, young adults, starting all the way from middle school, all the way to full brain development.
Well, thank you very much, Ms. Venison, for your very effective testimony, and I very much appreciate it.
Thank you.
Thank you, Mr. Chairman.
Thank you, Representative O'Day. Are there comments or questions from other members? Senator Champagne.
Thank you. I'm sorry, ma'am. I'm so sorry about your loss of your son, but I think you said something that was very important. And that is that public health was not on this call today. And no matter what they delivered, they should have been on this call. And I believe that, without that portion, without them coming forward with a comprehensive study on what happened in other states and what's currently happening, I think it's a disservice. And I want to thank you for coming in today and testifying. And again, I'm sorry for your loss.
Thank you.
Thank you, Senator Champagne. Are there comments or questions from other members? I do not see any. Ms. Venison, I want to thank you as well and express my sympathies for your loss. Thank you for coming out and joining us. I know this wasn't easy for you.
Thank you.
I am told that next we have Jason Ortiz. Is Jason on?
I believe so. Can you hear me?
All right, I do. Jason, you have your 3 minutes.
Fantastic. Thank you so much, Senators Winfield and all the members of the Judiciary Committee. My name is Jason Ortiz. I'm the president of the Minority Cannabis Business Association, which is a trade association of people of color that seeks to get our community to access the benefits of legal cannabis as owners, employees, and as consumers. I'm also a resident of Hartford, Connecticut, and I was arrested at age 16 for simple possession and charged with both simple possession, intent to sell to a minor because my 15-year-old friend was with us, and had to be expelled from school and put through the criminal justice system that lasted years and cost me thousands and thousands of dollars in legal fees. So when I come to this conversation, I'm actually inspired by a lot of the consensus I'm hearing on some things like home grow and the fact that we do want to address the mental health consequences of the war on drugs on our communities. And I just want to focus specifically on the judicial situation in SB 888 and the consequences of arrest. And so as somebody that had to actually have chains put on me for simple possession, I want to make it very clear that the mental health impacts of pulling somebody out of their environment and putting them into the criminal justice system creates the foundation for folks that really have mental health issues, because you're going to end up being isolated and alone. And as we have seen with many studies, that feelings of isolation do lead to feelings of addiction in order to address those issues. So the number one thing we can do for equity is to lower the amount of ways that folks can be put into the criminal justice system based on cannabis laws. SB 888 addresses one of them, but there are many different ones. I'm going to say a few of the pieces that are lacking in SB 888. SB 888 does not decriminalize home grow. It does not decriminalize sales. It does not decriminalize over 2.5 ounces. It does not expunge cultivation records. It does not expunge sales records. It does not expunge over 4 ounces. And if we're going to talk about addressing folks that are reentering society, SB 888 does not let anyone out of prison. It does not provide any pathway to prosperity, and it does not protect young people from the school to prison pipeline. So at the core of equity is decarceration, getting folks out of prison, decriminalization, making sure we're not putting more people in prison, and expungement, making sure the records of whatever interaction they have don't follow them. And so SB 88 acknowledges the need for all of those, but then doesn't actually do it in policy. And so to address finally one last piece when it came to home grow is home grow equity. Home grow at its foundation is, are we going to put people in prison over interacting with this plant? Interacting with this plant is a form of education, of learning what you can grow and how to grow a plant, what kind of medicines and substances affect you different ways. And to say that we're going to deny people the ability to even participate in interacting with this plant, that is not legalization, and it is definitely not equity. So home grow is without a doubt a foundation of equity, because it simply says that folks in my community can interact in the same way that other communities can. And so by including home grow, you do advance the cause of equity. But I want to make it very clear, the core of legalization of cannabis should be about criminal justice reform. And to me, equity means making sure that the benefits of the legal cannabis market go to the communities that were over-policed. And so we have given these definitions to other elected officials. We've presented countless reports on why this is necessary. And so I want to make it very clear that all of the folks interacting in this political process have access to this information. I'll wrap up quickly here. And so I was also one of the folks that did serve on the governor's working group, and happy to answer any questions about that. But again, thank you all so much for taking the time. We want legalization to happen, but we want it better than SB 88 is currently proposing.
Thank you very much. Representative O'Day.
Thank you, Mr. Chairman. Mr. Ortiz, thank you so much for your testimony. I would be more of a fan of homegrown and try and figure out ways to prevent 25 and under to use marijuana. But if you had to go back in time and talk to your younger self, how would you have us educate the youth to stay away from marijuana? How should we have done it to help you better when you were a teenager?
Well, I think what we could have done is more fully explain the laws that exist and let us know that some of those laws are disproportionately impacted on my community. So when I was in high school, I guess I was naive to think that all of the laws are applied equally. And so I got a rude awakening when I found out that was not true. The negative consequences of that interaction didn't come from the plant. They came from my interaction with the criminal justice system. If I would have been told more what exactly the plant is, have a stronger respect for it as medicine, I would have had a different interaction with it. But to be quite honest, the negative consequences there were from the criminal justice system.
So you don't believe there's any adverse medical effects to utilizing or using marijuana with high THC content for teenagers?
I think there are qualified ways that we can make sure those that don't need certain substances can't get them, just like we have restrictions on over-the-counter medicine. And so there are ways to do it. I just don't think criminalization or incarcerating them or giving them a criminal record or any of the current approaches to the school to prison pipeline are the most effective way to do that.
I guess my question is, do you think your utilization of marijuana as a teen was harmful to you? Not with respect
No, not at all. No, it was not. And I continue to use cannabis to this day. And actually, it's one of the best things that has happened to me over my life was finding a medicine that helped me deal with all the various problems I was dealing with. And today I'm a very functioning member of society. I graduated from the University of Connecticut. I've led campaigns. I've started businesses. I lead a business association now. So no, I don't think that there was really negative interactions, and certainly less so than the alcohol I consumed over the course of that same time frame as a college student.
Thank you very much, Mr. Ortiz, for your testimony, and thank you, Mr. Chairman.
Thank you.
Thank you, Representative O'Day. Representative Porter.
Thank you, Mr. Chair. And thank you for your testimony, Mr. Ortiz. Can you speak to what's going on at UConn?
Sure, and I think so. I didn't hear the question clearly, but I think the question was what was going on at UConn. And so folks can check out CureCT.nationbuilder.org. We actually put out a video on this, but the University of Connecticut has a cultivation department and they're growing lots of plants of cannabis and training students how to grow plants of cannabis. And if you're lucky enough to be a college student, you can apply for this course. However, it's the most popular course every single semester. And so only a handful being 400, but only, a quarter or a fraction of the amount of people that want to be able to have that class actually get in because it's so popular. And so if we were to move forward with an equitable legalization of cannabis, the University of Connecticut could use that research, could use their business department, could use all of their various academic services to support an equity movement in Connecticut, an equity structure, a craft cannabis market in the state of Connecticut. So the partnerships that are possible with UConn are tremendous, and they're very clear. They would like to expand their operation if it wasn't for a lack of legalization at the state and federal level. And so we do have the opportunity to sort of unleash the academic potential of cannabis research if we so choose. However, SB 88 doesn't really do that. There are other bills that we could bring together to make improvements to this bill in order to accomplish that. But the opportunity is certainly there, and the cannabis department is definitely interested in growing.
Thank you for that response, Mr. Ortiz. Was there anything else you wanted to add to the testimony?
Yeah, I think there's a situation where folks are trying to understand why some people are able to grow and some aren't, right? And I think at the core of this is a misunderstanding of why we're legalizing cannabis and what equity actually means. And so again, it means reinvesting the resources of the legal cannabis industry to the folks that are most impacted. Now, in the rest of the country, they have concrete equity programs legal structures that provide resources that are either licensing side of it or technical assistance. And in those programs, certain people are able to access them based on their interaction with the criminal justice system as is related to cannabis. So for example, someone that was arrested or they had a family member arrested or incarcerated could qualify to access these programs. Those programs are funded either at the state or municipal level, and that is how they're able to make sure that the funding is targeted. In SB 888, the community investment piece is not targeted. It goes to pilot. The criminal justice piece is not targeted. They're not actually making sure folks are getting out of prison on this and have the reentry support that they want to have. And lastly, it's just not decriminalizing the plan significantly enough to really change the legal landscape that we're doing here. And so by half measuring it, we're going to get none of the benefits. And I think we have to really look to these other states that are doing it, like Massachusetts. Massachusetts has 6 plants to 12 plants of home grow, right? Like they're right across the border. It's going to be the case. In New Jersey, they decriminalized 6 ounces. I think that is something that is just clearly not happened in this bill, of really like taking the best of all the other states and putting it together. And that's unfortunate. And so lastly, we're not talking about the economic side of sales. So when we're talking about decarceration, we've heard a lot about simple possession, that if we were to expunge or stop simple possession, there's not that many people in prison, but everyone says, but if there's an escalating charge, that's different. Well, sales is an escalating charge. And if there are more than one person involved, more than one container involved, and I at 16 was charged with intent to sell to a minor because my friend was 15. And I was lucky enough to be able to get that off my record already, but because I paid thousands and thousands of dollars to lawyers. And so this bill just simply strays away from the whole point, in my opinion, in an unfortunate way, because there's so much information available to us right now. Like there's really no excuse for myself, for anyone in this conversation to not have the information that they need. There is copious studies, there's other states to pull from, there's advocates in this state, and yet somehow we're still dealing with basic definition questions. And I think, there is one thing to be ignorant of a very complicated process, and then there's willful ignorance because you know that the solution to this problem may jeopardize particular political leanings. And so I would just implore the members of this committee, we are in a situation where the state of Connecticut could very much benefit from legalizing cannabis the right way. Massive members of the population want us to legalize cannabis. There are lots of ways we can do it, and we can get it done this year if they just put the right policy in front of us. And so I just really implore the judiciary specifically, because you now have in your power the ability to save the day on this bill by amending the criminal justice provisions, making them stronger, and giving us a bill that we can support.
Thank you, Mr. Ortiz, and thank you, Mr. Chair.
Thank you, Representative Porter. Representative Fishbein.
Thank you, Mr. Chairman. Good afternoon, Mr. Ortiz. I can assure you that my positions are not based upon ignorance, no matter how you characterize such, but moving forward from there, you've made certain representations as to UConn, what UConn's position is with regard to this. In what capacity do you make those representations?
I interviewed the cultivation department myself and met with them for an afternoon tour of their facility.
Right, so you're not affiliated.
I'm an alumni.
Okay. And have they authorized you to come here to speak on their behalf?
No, I earned my degree, and so I authorized myself to represent as an alumni.
Okay. And then you mentioned your situation with the criminal justice system. When did that occur?
In the year 2000 in Norwich, Connecticut. I was 16. I was a sophomore in college. In high school.
And you said you went to Danbury Court?
No, Norwich. Norwich Free Academy, and then Norwich Superior Court.
And you were a youth at that time?
I was 16, so I was treated as an adult.
You were treated as an adult, or you were adjudicated as youthful offender?
Well, I was charged as an adult, but ended up using my accelerated rehabilitation to get the charge lessened.
Lessened, or if you did your AR appropriately, it would go away?
Sure. Yes. I mean, I still
I'm just
went
trying to figure out where
I
representations. I'm trying to get through the ignorance aspect of this, but
so let me
if one
clarify.
doesn't.
Wait. let the question be asked and answer the question both ways.
Sure, sir. If you wanted to clarify your understanding as to your involvement with the criminal justice system, please.
I was arrested at age 16 in high school. They then brought me to the police department, filled out the forms they needed to do. To be quite honest, at the time, I didn't understand what any of it was happening. I didn't have a legal degree at that time, and they told me that I had to go to court on a particular day. When I went to court on that day, I had a lawyer representing me, and I was still 16 at that time. And so I listened to the lawyer and did what he told me to do. Eventually, that charge is no longer on my record because I continued with the process. But that doesn't change that I had to go to court and interact with the criminal justice system repeatedly until that happened.
Okay, so the result of your accelerated rehabilitation application was the charges against you were dismissed, right?
I had to do, yes, 120 hours community service.
Okay. But then you said something about a conviction early on in your testimony.
I was arrested. I was never convicted.
Oh, okay. Okay.
I was never incarcerated. Yeah.
Well, nor were you convicted, because certainly people get convicted without being incarcerated.
Representative Fishbein, I'm going to ask you if you could get more directly to the point, given what you're talking about.
Understood. No, I just trying to unravel that. So that's all I had. Thank you, Mr. Chairman.
Thank you, Representative Fishbein. Representative Pond.
Thank you, Mr. Chair. Hello, Mr. Ortiz. Thank you for your testimony. I have a question about the Minority Business Association, and this is really just for my edification. Often when we talk about minority business enterprises, we're talking about those owned by people of color and by women, who often are left scrambling over the whatever doesn't go to the majority of the business owners. There's no question that the war on drugs disproportionately affected people of color, and I'm not in any way suggesting that white women suffered. I want to be very clear about that. I'm just curious about whether or not you have an opinion about whether women of color entrepreneurs will stand to benefit. Well, do they benefit from your efforts? Like, how does that figure into the work that your group does? What is the definition in your case of minority as regards to the equity piece of helping business owners get launched? I hope I asked that clearly. I'm not sure I did.
I think so. I'll do my best to answer it. So, MCBA is comprised and serves minority operators, but we do have members that come from all walks of life that support the work that we do. But if you were to go to minoritycannabis.org, you'll actually see the board that we represent. There are lots of different types of folks that are on our board. We have both direct cannabis plant touching businesses that are owned by women of color. We also have PhDs, doctors of color, that serve cannabis regulatory fashions and other types of things of that nature. In the legal profession, we have a number of women. Our executive director, Amber Littlejohn, who actually spoke at our press conference earlier, she is a lawyer. Jessica Velasquez is a CPA, and she works on one of the largest tax accounting firms in the country regarding IRS tax filings, but she also serves specifically the tax industry in cannabis. And the list goes on, right? Because the cannabis industry is not just about plant touching, right? There's lots of different ways that folks get involved as chemists, as CFOs, as hemp farmers, right? Every piece of that needs financing, web design, cultivation equipment, all these different things bring in all the different types of trades that can grow from this. Women of color, I would guess, and I cannot speak for women of color, but I can see what happens when I go to communities of color, specifically when it comes to cannabis, and there, to me, seem like a lot more women in the equity movement than there would be in traditional corporate America. And cannabis specifically does have a higher percentage of women in C-level positions than any other industry. It's unfortunately because the other industries, the bar is pretty low. I would like to see more women in cannabis positions, of course, but it is better than most. And so specifically, women of color are definitely a huge part of our organization. But also, generally speaking, I want to make sure we remind folks that when we talk about equity programs, as far as like support services, it's really about interaction with the criminal justice system generally. So women who had a negative interaction with the criminal justice system would be able to qualify for these programs. But on the bigger side of things, oh yeah, there are plenty of women in C-level positions, and I'm very proud to know many of them, and we recruit them as possible. And our most recent president before myself was an African-American woman.
Great. Thank you very much for that. That it does answer my question, and I appreciate your thoughtfulness on that very important issue of that piece of the equity component. Thank you.
Absolutely. Thank you, Representative Palm. Are there questions or comments from others? I do not see any. Jason, thank you again every year for showing up and testifying and helping us to think a little bit on this. Appreciate it.
Absolutely. Excellent.
Is Mary Jane Oatman in?
Yes, I am.
All right, you have 3 minutes.
Well, Himakas Katsiya Nunam Hanyawat Piamsa Kanawatvispa, in the name of the Nez Perce people of the traditional homelands that I'm calling in from, thank you to the committee for hearing from myself on behalf of the Indigenous Cannabis Coalition and the nation's first print publication dedicated to the storytelling and data collection within our tribal communities of THC Magazine. The Indigenous Cannabis Coalition is a not-for-profit national coalition that was created to address the needs of Indigenous cannabis tribes, communities, and support families working towards the implementation of tribal sovereignty in cannabis legalization. I am an enrolled member of the Nez Perce tribe in Idaho and also descend from the Delaware Nation. And I appreciate the committee moving forward with the conversation about legalization. However, I would really like for the committee to consider the integration of a section like in House Bill 6377, Section 32, which provided deference to tribal sovereignty. It is critical for tribes to be able to safely and compliantly enter into the cannabis economies without fear of these constant battles with local and state officials. When a state fails to acknowledge the protection of tribal sovereignty, it tends to fraction other areas of effective government-to-government relationships. An example of that was in California when they legalized under Proposition 64, which the voters approved in 2016. The legislation there was silent on how California would interact with tribes in the legal marketplace, leaving the tribes on the sidelines during this multi-million-dollar cannabis build-out and markets growing rapidly without them. And some tribes that did step forward in this space for cultivation, production, and processing faced illegal raids from county law enforcement. Washington, Oregon, and Nevada all passed legislation that empowers them to sign compacts or negotiate other areas of agreement for shared regulatory responsibility with tribes that are looking for implementing their tribal sovereignty in what we know is a economy that many of our tribes have been pursuing long before any European contact on our homelands with our sacred relationship with all plant medicines. So it's really important also because under the Clean Water Acts, tribes as states or TASs have an extra duty to protect their watersheds and their homelands and have the authority to prosecute violations under these applicable federal laws. So as we move towards equitable federal legislation, it is imperative that tribal sovereignty is afforded in the legislation. There's a unique relationship that states have with tribes. Tribes are not just a traditional stakeholder, they're indigenous homelands with governments. And, many states just happen to have their boundaries within these traditional homelands. So I applaud the efforts of the committee in moving forward with proactive cannabis legalization.
Thank you, Ms. Thank you, Ms. Oatman. That's our 3 minutes. There is a question for you, so I want to get to that. Representative Palm. Representative Palm, did you have a question?
No, I'm sorry, I don't. I don't believe my hand is up.
Oh.
But if it is, I don't see it up.
Okay. Representative Porter.
Thank you, Mr. Chair. I would just like to give Oatman the opportunity to wrap and summarize and offer testimony.
I'm sorry, Representative Porter, I didn't hear you.
Can you hear me now, Mr. Chair?
Yes, ma'am.
Thank you. I was saying that I wanted to ask Ms. Oatman what else was there she wanted to say for the record. I'm actually glad to see that she's here today testifying. And I think that it's going to be important to give her an opportunity to finish up. Through you, Mr. Chair.
So I appreciate you giving me the the opportunity to close that, in summary, applying provisions within a legalized structure that gives deference to tribal sovereignty or recognition of tribal sovereignty is, those efforts to repair communities and our families that have been negatively impacted with the war on drugs. And in many of our communities, it's a plant. It's definitely a, excuse me, did I get cut off there? My apologies, but it's still hard for us, in 2021 to see how legislative processes are making a criminal out of Mother Earth, who is the original cultivator of this sacred plant. So I appreciate you allowing me to finish that.
You're very welcome. And again, I thank you for taking the time to testify on this important issue today. And I thank you, Mr. Chair, for the indulgence.
Thank you. Further questions from the committee? Seeing none, appreciate you being with us.
Thank you for your time.
I believe next up is Ellis Grant.
Yes, hello, Mr. Chair.
We can hear you. Go ahead. You have 3 minutes. Thanks.
Thank you so much to the chairs, ranking members, and to the members of the committee. My name is Grant Ellis, and I am the president of the Massachusetts Cannabis Reform Coalition. I believe I may be the first speaker here from Massachusetts today, and I appreciate your indulgence, allowing me to come down from across the border and weigh in a little bit on SB 888. I myself am a disabled medical cannabis patient. I was a graduate student at Boston College in 2014, working on a quantitative methodology to examine the cogency of public discourse as an indicator of political legitimacy within liberal republics. When I fell seriously disabled overnight following complications from a surgery, I was in and out of the hospital for 18 months before I was able to get out of the hospital. When I left the hospital, I was on a serious amount of narcotics. After 12 months on medical cannabis, I was off all of those narcotics and able to return to, although impeded, a somewhat functional life. In the context of SB 888, I first wanted to say that Section 98, as Attorney Ward mentioned earlier, is problematic for a number of reasons. Because of the way the tax revenue is dedicated to the general fund. As an example from Massachusetts, last year we had $70.6 million in cannabis excise tax revenue. Of that revenue, exactly $0 went to communities disproportionately impacted by the war on drugs, even though that spending on those communities was mandated by the law that legalized adult use cannabis. The reason why that spending didn't happen is that the law left it to the governor's discretion in the budget as to which one of the 5 categories the spending would take place in. Now, I do not oppose cannabis excise tax going to public health. It should go to fund public health. But last year, all $70.6 million of that excise tax revenue went to fund public health in Massachusetts, and none went to the communities who are most disproportionately harmed. I think that's an issue, and I think updating Section 98 of the bill could remedy that. Furthermore, Section 30 of the bill, it's a huge issue because of what Attorney Ward was also, to his credit, talking about earlier as to Section 26. Section 26 creates a lottery, which doesn't even have an equity component. And then Section 30 makes it so the existing medical companies in the state of Connecticut don't have to take part in the lottery. They can just become a hybrid adult use retailer. That is regulatory capture in action. And I have to call it out for what it is. It looks like a deal designed to get those medical companies to the head of the line at the expense of equity and at the expense of a fair application process. And I just don't see how it can move forward in that state. I very much support what this bill intends to do, but there are simply too many functional irregularities within the framework of how it is proposed for it to function as it's intended. And I implore the committee to listen to the wise words of Jason Ortiz, Attorney Ward, and so many others who have suggested the necessary updates to this bill to make it functional in light of the lessons learned from other states. And I will just say I have data that shows that teen use goes down in states with expanded adult use. It does not go up. Thank you, Mr. Chair.
Thank you. And I'm sure the committee would love to see those statistics and studies. So if you have not submitted written testimony, feel free to do so or to email into the committee. Questions? Seeing none, appreciate you zooming in from across the border for us.
Thank you, Mr. Chair.
Next up will be Cyril D'Souza.
Yeah, hi. This is Cyril D'Souza. I'm here testifying as someone who's conducted research on cannabis for the last 25 years. I'm a psychiatrist, spending my time mainly at the VA hospital and at the Connecticut Mental Health Center. Though I am not representing either of those. I'm also a father of a young adult, and I'm someone who drives on 95 every morning. So I speak with these four hats on, and while I have a number of concerns about this legislation, I have four main concerns. The first concern is the impact of cannabis exposure on children. And that starts with the increasing trend of pregnant women using marijuana and the effect on the children they bear, on adolescents and young adults. I want to make the point that brain development is only completed around the age of 25 and 26. We know that the brain has an endocannabinoid system, which when perturbed by exposure to cannabis can lead to long-lasting changes in brain development. So the first issue is children. I also think that as we've seen with alcohol and tobacco, there's no way for us to convincingly prevent drugs like this getting in the hands of children. I know that firsthand as I see this happening in my community. The second issue that is just as important and that we haven't heard much about is the impact on serious mental illness. There is fairly compelling evidence, data from my lab and data from a number of other investigators around the world suggesting a very strong relationship between the rates of cannabis use and serious psychiatric disorders like schizophrenia, bipolar disorder. You may have heard very recently in testimony provided maybe half an hour ago that in the state of Connecticut, we are seeing increased rates of hospitalization for psychosis. And this parallels what we have seen in Colorado. In my own lab, we find that people who use cannabis show a reduction in synaptic density in the hippocampus, an important part of the brain that's responsible for memory and other critical cognitive functions. We know that people with serious mental illness, once they have mental illness, are much more vulnerable to the harmful effects of cannabis. They tend to end up being hospitalized more often. They go to the emergency room. They're often non-adherent with their medications. They get into legal and other troubles, and they often end up homeless. So we need to think about who is going to pay for the increased rates of hospitalization of people who already have serious mental illness, and who's going to pay for the cost of managing people with new mental illness that may be related to cannabis. Just
Dr. D'Souza, I need you to just summarize for me, please.
Okay. And lastly, the issue of the effects of cannabis on driving. We know that cannabis impairs driving. There's data from my own lab that low doses of alcohol and low doses of cannabis are known to disrupt driving. So
all right, thank you. I know we have a couple questions for you, so I'm going to jump into those. Representative O'Day looks ready to go, so I'll start with him.
Thank you very much, Mr. Chair. Is it Dr. D'Souza?
Yes.
And what type of doctor are you? I'm sorry.
I'm a psychiatrist.
And doctor, you said did you say there were four main concerns or three?
Four main concerns.
And I saw the impact on children, and I got number 4, driving. What were the other two?
Addiction and serious mental illness.
And the 3 serious, the addiction, do you have in your testimony, I'm sorry I didn't get a chance to read through all the testimony, there's a lot of it. In your testimony, do you have some documentation, statistics supporting any of this, like for the impact on children, the addiction and serious mental illness and driving?
Sure. I have submitted written testimony of that. And if you'd like me to summarize that, I'd be happy to do so.
Please.
We know that, for example, it's becoming increasingly popular for women to use cannabis during pregnancy. There's a paper that was published within the last year in the prestigious Journal of American JAMA Psychiatry, which is one of the highest impact journals in psychiatry, showing that women who use cannabis, or children born to women who use cannabis, showed an increased rate of serious mental illness in adolescence and cognitive difficulties too. I have the citation in my written testimony. We also know that from data from my own lab, and I would have about 25 papers that I can submit to you, that under the influence of cannabis acutely, that impairs many of the cognitive processes that are critical for scholastic activities, meaning to say, if young people who are under the influence of cannabis, they will not be able to engage in a meaningful way in scholarly activities. That's second. There is some data suggesting that exposure to cannabis in adolescence is associated with long-term outcomes, including cognitive difficulties. That data is hard to actually, one would argue that some of those data are observational, because as you know, it's impossible to do an experimental study in humans. It would be unethical to give one group of young people cannabis or not. But to support these observations, there are animal studies where you can give animals at different stages of adolescence cannabinoids and cannabis and look at their long-term outcome. And these animal studies suggest that there are changes in the brain that are manifest in behaviors that persist into adulthood. So that's the effects on in adolescence. There are brain imaging studies, which I've submitted in my testimony, published in peer-reviewed journals, showing that exposure to cannabis just 1 or 2 times in adolescence is associated with changes in the hippocampal volume. The hippocampus.
What is that?
The hippocampus is the part of the brain that is critical for memory and learning. So it's the most important part of the brain for learning and memory. So that's to summarize the data on adolescence. Related to that, addiction is another issue that we need to consider. So previous studies that were done in the 1970s and 80s suggested that only 1 out of 10 people would get addicted to cannabis. And it's important to put these studies in perspective, because the kind of cannabis that was available in the 60s, 70s, and 80s is very different from the cannabis that's available today. We all recognize that it is the THC content of cannabis that drives many of these effects. And so in more recent studies, using much larger data sets like the NESARC study, it's a large epidemiological study that is not specific to cannabis, but it gives researchers the opportunity to examine the rates of cannabis use disorder, pre-legalization and post-legalization. And they find that the rates of cannabis use disorder are now actually more like 1 in 3, so about 33%, as opposed to the 1 in 10 or 10% that was from studies done in the past. And we would expect, because the potency of cannabis is going up, that the rates of cannabis use disorder would increase. Many people don't believe that cannabis is addictive, but using all the existing definitions of abuse or use dependence, I think we can say with certainty, and you'll hear from my colleague Kevin Severino, who's the head of the Addiction Society, that cannabis is addictive in whatever model you look at it. That is, people will spend a lot of time, money, and effort acquiring the drug, getting high on the drug, recovering from the drug, trying to quit using the drug, and using the drug in situations that could be dangerous, such as driving a motor vehicle or operating heavy machinery. So addiction is another issue. the important thing for you all to remember is that we do not have any treatments for cannabis use disorder. We have treatments for opioid use disorder. We have treatments for alcohol use disorder. We do not have treatments for cannabis use disorder. We don't have treatment programs within Connecticut that are specific for cannabis use disorder. And we need to think of that. We need to have this discussion as this bill is being considered. Who will pay for that for people who are seeking out treatment? We need to set up a surveillance program of the demand for cannabis use disorder if cannabis is legalized in the state. And we do know that some people are much more vulnerable to developing cannabis use disorder than others. There's good genetic data that's coming out that was published just last month in Lancet Psychiatry, showing that we may be beginning to understand who may be vulnerable, but that's not yet ready for prime time. The issue of serious mental illness. There is fairly convincing evidence from many parts of the world that exposure to cannabis in some individuals can lead to schizophrenia. For those of you who know about mental illness, schizophrenia is arguably the worst possible mental illness to have. The reason being that it strikes between the age of 15 and 25. That means it strikes before a person can reach their potential. Often people with schizophrenia are unable to work for the rest of their lives. So in addition to the costs of hospitalizing them and providing them treatment, we also have to support them financially. They are mostly on disability. We need to consider who's going to pay for that. There's evidence supporting the link between cannabis and bipolar disorder in addition. And so the issue of serious mental illness is an important one. And I'm somewhat surprised that DMAS hasn't been considered. The Department of Mental Health and Addiction Services has not been consulted, or the Public Health Committee has not been involved in crafting this legislation. And then the issue of driving. We know a lot about the effects of alcohol on driving. We know a little about the effects of cannabis on driving, but let me tell you very clearly, people do not drive better on cannabis. So if there are arguments being made about we don't see increased motor vehicle accidents in Massachusetts, it's just a question of time, because people don't drive better on cannabis or its derivatives. That's been shown now in many studies from all over the world. Further, another consideration that we haven't really taken into account is that it's conceivable that someone could have one drink of alcohol that's below the limit, legal limit, and have just half a joint of cannabis that independently these two may not have any significant effect on driving, but collectively together, they may have additive or synergistic effects. And it'll be impossible for our colleagues in law enforcement to be able to tease that out or detect it effectively. So I've cited in my written testimony that there have been studies done in Canada trying to estimate the cost of motor vehicle accidents in Canada. Canada has a population of 35 million. It's a much bigger country with a lot of rural areas. The cost was estimated to be several $100 million. That includes the effects on the property damage, the costs of rehabilitating people, and of course, death. And we need to take into account who's going to pay for that.
Is that, doctor, is that several hundred million per year you're talking about?
It was between the period of 2012, I think. I can tell you in a second as I pull up the testimony that I shared.
If it's in your testimony, don't worry about it. I want to. And my last question, doctor, is: are you aware of any studies?
Can I just correct myself?
Yep.
The estimated cannabis-related collision costs were estimated to range from 1.9 to 1.28 billion Canadian dollars in 2012. So not 100 million, but 1.09 to 1.28 billion dollars.
In 2012?
Correct.
In that 1 year, okay. And doctor, the last question, and thank you to the chair and my committee members. I promise to be here till the very end. Doctor, are you aware of any studies about the increase in schizophrenia due to chronic cannabis use anywhere?
Yeah, yes, there are many studies. This is a specific area that I have researched for the last 25 years. I'd point to the most recent study that was published in March of last year in the journal Lancet Psychiatry, one of the highest impact journals, showing that a clear relationship between the potency of THC and the frequency of use and the relationship to new onset psychosis. Psychosis is another word for schizophrenia. This was a multinational study involving several European countries and Brazil. And it showed a very clear relationship between the dose of exposure, as in how potent and how frequently someone was using cannabis, and the risk of schizophrenia.
And is that the reference to that Lancet study? Is that in your testimony?
It may be, but I can give you the last author. It's Dr. Diforti, D-I-F-O-R-T-I.
D-I?
Yes,
Okay.
D-I-F-O-R-T-I. The first name is Marta, M-A-R-T-A.
Okay. All right. Thank you very much, Doctor, for your testimony and your time. And thank you to the chair. I'm sorry. Thank you.
Thank you. Representative Fishbein.
Thank you, Mr. Chairman. Just quickly, Dr. D'Souza, as a researcher, father, and somebody who's been involved in this, what is your reaction to the fact that the Department of Public Health and Demas haven't submitted any testimony and have not appeared before us here today on this?
Frankly, I'm quite shocked that there isn't representation or testimony. I'm curious why that didn't happen. But I would have definitely wanted to see my colleagues from Demas and the Department of Public Health to weigh in here, because one would imagine that they are the experts. They are the ones who can synthesize the information, digest it, and present it in a way that would be easily understood by everyone.
Well, and I thank you, sir, as an expert, having the ability to come before us here today. Thank you, Mr. Chairman.
Representative Callahan.
Thank you, Mr. Chair. Doctor, thank you for being here, and I'll be brief. My interest especially is in the driving aspect of this, whereas would you say a heavy cannabis user can be impaired for perhaps several hours and even days after use?
I guess it depends on what your measure of impairment is. So clearly there are residual effects of cannabis in someone who's using cannabis regularly. And we have, and one can detect some of those effects on tests of cognition. So tests of memory, tests of attention, so on and so forth. I am not familiar of whether someone has actually tested that effect on driving per se. I think it's clear that acutely, maybe 1 hour or 1.5 hours after someone is consumed, their driving will be impaired. But I'm unaware of studies that have looked beyond that.
Thank you, sir.
Senator Winfield.
Thank you, Mr. Chair, and Dr. D'Souza. It's good to see you again. And I'll start off with, we're not going to do what we've done in the past. We're not going to be that long. But I do have a couple of questions for you. You know, the things you talked about happening here in Connecticut have happened under a system of prohibition. And I wonder why you think it would be good to leave the system of prohibition in place as opposed to creating a more regulated system.
So, thank you, Senator Winfield. I'm not an expert on matters of prohibition. I'm really here to testify as a physician, as a scientist, and as a dad. I think there are some obvious advantages to regulating it. That is, if you can make sure that the product that's available to the citizens is being carefully, vetted and tested, and so on and so forth. That said, my sense is that in Colorado and even in California, the black market is actually thriving. And the dent that was supposed to happen to the black market hasn't actually happened to the same extent. And so I remain concerned about those kinds of issues. I should share with you, Senator Winfield, that I serve on the Physicians Advisory Board for the Medical Marijuana Program for the state of Connecticut, and I've served on that since its inception. And there are kids in my town who are able to successfully get marijuana from the medical marijuana program because of diversion. That is to say, people who have been certified to get medical marijuana are keeping some for themselves and selling some of it to young people. And that's happened even before this bill that we are considering right now. So I remain concerned that it's going to be very hard for us to prevent this from happening. Something else related to that is that the perception of young people of cannabis has changed. In the Monitoring for the Future survey, a survey that's done every year amongst 10,000 high school kids across the country, including Connecticut. For the last 4 consecutive years, kids believe that tobacco is much more harmful than cannabis. And it's in part, I'm speculating here, it's in part because of the mixed message that they're getting. They're getting the message that marijuana is a medically approved treatment. They're getting a message that it's okay. And so I remain concerned about the message that young people are getting.
And thank you for that. Are you suggesting that because marijuana is a medically approved treatment, right?
No, it's not. It's not. So, what we have is a palliative care program. I serve on this committee. I've researched this area and studied it quite carefully. There is not that much of evidence to support the use of marijuana to treat medical conditions. There is what's really happening is that people are using it for palliative use. That is, for the 26 conditions or so for which marijuana is approved in the state of Connecticut, there is no medical evidence, no scientific evidence that marijuana actually improves the pathophysiology of those conditions. Let me tell you, for instance, the first condition for which medical marijuana is approved is PTSD, right? There is no evidence. In fact, there is evidence to the contrary that medical marijuana worsens PTSD. So what we are talking about here is a palliative program.
Yeah, could we pause there for a second? Because I want to understand what you're saying. So you serve on the board of what now?
The Physicians Advisory Board for the state of Connecticut's medical marijuana program.
And why are you serving on that board if it's not a medical issue?
I'm serving on the board because the Department of Consumer Protection assembled a group of physicians to advise them on new indications.
Sorry, I didn't mean to cut you off. Go ahead.
No, that's it.
And if there's no medical aspect to this, what are you advising them on?
That's a good question.
I'm not being facetious. You
serve
on the board.
And neither am I being facetious. I think that there's been a long tradition in this country where the first foray towards legalizing cannabis is to establish its use for medical conditions. That happened in California. And that has been the tradition across states. They first legalized cannabis for medical conditions. But again, I want to emphasize the fact that there is really no compelling evidence that marijuana, marijuana treats or addresses the pathophysiology of medical conditions for which it's been approved. It is there for palliative care, meaning to say it's there to make people feel better.
Okay, and I'm just going to ask you one more question on this because I don't want to push too deep into it, and I don't want it to seem like I'm just being combative.
No.
We've done that in the past. I'm going to reframe that question. If there is no medical aspect to this, why did you choose to accept appointment to the board? I'm trying to figure out, if there's no medical aspect to this, why are you engaged in it as a medical professional?
I'm engaged in it for the same reason I'm engaged in this discussion, that I have serious concerns, and I think that I can bring to the table a knowledge based on my research with cannabis and cannabinoids, and help the committee as it makes decisions about the value of any new intervention. In this case, it happens to be cannabis, in the treatment of medical conditions.
Okay, I'm going to move on from that. I just want to ask you another question about the Young Wolf Saravar and Tucker study that you were referring to earlier in the JAMA journal. Do you think it's important that that study was qualitative and not epidemiological?
I'm sorry, which study are you referring to, Senator Winfield?
The study you referred to earlier, talking about the pregnancy and the increased use.
I don't understand what you mean by qualitative.
It was not an epidemiological study, and then also, I guess I'll just ask the questions and have you respond however you choose to. The studies that are embedded in it, the references in the study, go back to 2002, well before we had legalized cannabis. So this was something that was already happening, and I didn't. Not that you were hiding anything, but I didn't get that impression from the information you shared with the committee.
Oh, I want to be clear that I did not. I'm sorry if I suggested that study had anything to do with pre and post legalization. All I was stating as a matter of fact is that women who use cannabis during pregnancy, their children have a higher rate of serious mental illnesses. That's all. I wasn't making the point that this is pre or post legalization.
I'm not suggesting that you were making any point. I'm suggesting that sometimes when people testify in a context, if it's not made clear, we fill that with information that's not necessarily there. The other thing I wanted to say about that study was that one of the references embedded in it suggested that one of the sub-studies looked at alcohol, cigarettes, and cannabis, and the usage increased in those too. So there's something going on that's not necessarily directly related to cannabis itself, and that's about depression and the issues of pregnancy itself.
I think that's a fair point. I think one of the challenges of studying the effects of any drug on pregnancy is that it is typical for women who use one drug during pregnancy to also be using other drugs. So to tease out the effect of tobacco, to tease out the effect of alcohol from cannabis may be challenging. I agree with you. But there are a number of studies that have suggested that the use of cannabis, amongst other things, during pregnancy is associated with higher rates. But the reason I think it's important for us to consider this is that unlike other drugs, pregnant women are using cannabis because they think it treats morning sickness. Cannabis is known to be effective in the treatment of vomiting, right? And emesis. And morning sickness, one of the problematic symptoms is vomiting. And so women are specifically choosing to use cannabis during pregnancy, not alcohol, not nicotine, to treat morning sickness. And that's the reason I'm mentioning it.
Thank you, Dr. D'Souza, for joining us again. And I would just say that my only point is to make sure that we're all clear on the information that's presented to us. And even on that last point about morning sickness, while that's a part of it, I think there's also a suggestion that, like alcohol and cigarettes, cannabis is being used for multiple reasons, some of which are the same reasons alcohol and cigarettes are being used. But again, I thank you for joining us and sharing your information with us.
Senator Kissel.
Thank you very much, Mr. Chair. I've been pretty quiet all day, trying to move this along. I'm not saying I'm in favor of the bill, but I take umbrage that when you say the medical marijuana and situation in Connecticut has no positive impact, as one of the founding creators of that program, and I take great pride in it. And it's highly touted. I've been on general law, I've been on judiciary. It's just really well regarded nationally. I think it has a tremendous impact. And in particular, and people had this misguided notion that like infants were going to be like doing joints. Not the case, but drops of THC. Moms came to testify, and I sat through hours of it, that they had children suffering from multiple epileptic seizures, and the cannabinol helped stop that. And so how can you say that this program doesn't have a beneficial impact?
I'm sorry, Senator Kissel, I didn't ever say that this program doesn't have a beneficial impact. That is not what I said. And I'm sorry you heard it that way. What I said is that there is no medical evidence, as in published medical evidence, to show that cannabis has an effect on the pathophysiology of the conditions that are on the list. So that's another way of saying that.
No. I'm sorry for being abrupt, but if these little kids, these infants, are not going through multiple epileptic seizures because they're getting little drops of THC, how can you not say that there's, I mean, it may not be published, but I mean, I sat through hours of testimony of moms. They were coming down from Maine, other parts of New England, because they were testifying to this.
So, Senator Kissel, there's no doubt that cannabidiol, which is a very specific constituent of cannabis, is now approved by the FDA for the treatment of seizures. But cannabidiol is not cannabis. No one is going to use cannabis if it just has cannabidiol. People use cannabis for the THC in cannabis. And what I'm saying is the THC is not what's reducing the seizures. It's the cannabidiol, which is a very different constituent. Anyway, I'm sorry that I gave the impression that the program doesn't have a positive impact. I'm sure it does. All I was saying is that the scientific evidence is somewhat lacking. And that's just not my opinion. I think if you look at reviews of the literature published in scientific journals, that's what you'll see. I also want to make the distinction between anecdotal evidence and the kind of evidence that's used that we as physicians are used to in looking at. We look at group data, we look at double-blind randomized controlled studies, and to that extent, there is a lack of evidence. That's my point.
Well, you know, I just think it's important to clarify that point.
Okay.
As someone who formed the program, who I think it's been very positive in so many ways. And by the way, I mean, I don't want people going to opioids if they can go to something else. I've had constituents come up to me and say, hey, I'd rather have marijuana than an opioid because I've got back pain or something like that. Doesn't mean I support this bill the way it's written. And I think there's some issues here, but cannabinol versus, you know, full out marijuana, I think that's a fine point. And I wanted to underline the fact that I think that our medical marijuana program with the doctors on the panel has been very positive, and it's been received really well nationally. And I bent over backwards working on that bill. I mean, I think we really made it the best bill in the country. And I think it's got a lot of positives. And I felt like you were just disparaging it out of hand. And you know, maybe I misunderstood what you were saying.
I'm really sorry if that's the impression I gave. I served on that board since its inception, and if I didn't think it was a good committee to be on, I wouldn't be on it. So yes, it's doing a lot of. I was just making the point about medical evidence. So sorry.
Okay, Because all those moms with those kids with those epileptic seizures and all those other neurological problems, that in and of itself would prove the whole system to me. And there's a lot of other good things going on there too. So thank you, Mr. Chairman. Sorry.
No, thank you, Senator Kissel. Appreciate you chiming in on that. Are there further questions from the committee? Seeing none, thank you for being with us, Doctor.
Thank you.
Next up will be Andrew Wilcox.
Hello. Thank you, ladies and gentlemen of the committee. Thank you for giving me this opportunity to speak. If we are finally bringing marijuana laws in line with that of alcohol, we should at bare minimum bring them in line with alcohol's other regulations, namely home production. In all 50 states in this country, microbrewing is a legal activity for any adult over the age of 21, and 12 other states and one district have brought that mentality in line with recreational marijuana home growing. Home growing is a personal hobby just as much as home brewing is, and keeping it criminalized is, at best, a misguided attempt to protect the tax receipts from regulated marijuana, and at worst, a backdoor continuation of the drug war that has devastated our communities for decades. But just as garage brewery setups have not diminished tax receipts from bars and liquor stores, nor has it led to a moonshine anarchy in our streets, home grow in other states has not led to a significant hit to dispensaries and their sales, nor has it led to an increase of erratic driving, violence, or other antisocial behaviors. In those 12 other states, home grow has been an exercise of individual freedom, of maintaining a ready supply for medical patients, and also, yes, for the nascent beginnings of legitimate business enterprise. This bill talks about bringing equity into the discussion to repair the damage done to our communities by prohibition, but it still caps the numbers of and provides no consideration for equity-based licensure for microgrowers or delivery operations, both ground floors for new small business ownership for those with low starting capital. These are the jobs for Connecticut residents trained in Connecticut universities to serve Connecticut residents that we should nurture and protect, or else we open the door for established out-of-state corporate cannabis giants to come and capture our burgeoning new market and render our state mere subject consumers. We also leave the door open for the continuation of the injustice of prohibition by levying criminal penalties for a decriminalized substance. A decriminalized substance we are not automatically expunging the criminal records of, by the way, instead forcing those convicted sooner than 2015 to be subject to unnecessary red tape and court fees, a hindrance only for poor and working people. So we cannot speak of equity while we establish the gentrification of cannabis in our state. We cannot speak of justice while we levy undue penalties on the poor and vulnerable. We cannot pass a legalization bill that maintains marijuana incarceration for discrete personal home growing and also hampers Connecticut's small business owners' chances against these new Philip Morrises of cannabis. We cannot pass Senate Bill 888 as it currently stands. Thank you.
Thank you. Questions from the committee? Seeing none, appreciate you being with us, Mr. Wilcox. Next up will be Michael Sarius.
Hello, can you hear me?
We can.
Hello?
We can hear you, sir. Go ahead. You have 3 minutes.
Okay, I don't know if you can see me or not. Can you see me?
We cannot.
Okay, sorry about that. So Senators Winfield and Kissel and Representatives Staffstrom and Fishbein and members of the Judiciary Committee, I've been an emergency physician practicing in Connecticut for the past 38 years. I'm a past chair of the emergency departments at both St. Vincent's Medical Center and at Norwalk Hospital. I'm a current board member and past president of the Connecticut College of Emergency Physicians. I'm also a past president of the American College of Emergency Physicians and the American Board of Emergency Medicine. And today I represent the nearly 500 members of the Connecticut College of Emergency Physicians in opposing this bill. As a practicing emergency physician, I am all too familiar with some of the unintended consequences of the use of recreational cannabis. I am also aware of the experiences of my emergency physician colleagues in states where recreational marijuana has been legalized, such as Colorado, California, and Oregon. I'd like to point out some of those consequences to you. First, smoking marijuana carries the same risk as smoking tobacco with regard to pulmonary consequences, such as asthma and COPD. Connecticut has made significant efforts to reduce or eliminate smoking as a public health issue. Legalization would be contradictory to those efforts and represent a step backward. Secondly, marijuana is known as a gateway drug in that it not infrequently leads to the user to try other potentially more dangerous drugs, such as stimulants like ecstasy and cocaine, euphorics like narcotics and sedatives. This is especially true of adolescents and young adults whose young developing brains are more susceptible to addiction. Thirdly, inadvertent overdoses, especially in young children and adolescents who consume edible cannabis with consequential altered mental status and vomiting, and they end up in emergency departments for prolonged evaluation and treatment. Fourthly, cannabinoid hyperemesis syndrome, which consists of intractable nausea and vomiting caused by cannabis treatment, both smoking and ingestion. When these patients inevitably present to the emergency departments for treatment, they require intravenous fluids and multiple medications to control their symptoms over several hours at considerable cost. Fifthly, driving under the influence of cannabis causes altered mental status, poor decision-making, loss of coordination, and decreased attention span. This results in motor vehicle accidents with injuries and sometimes deaths. Since there is no reliable way to ascertain an accurate blood level of cannabis, there is no easy way to prosecute these drivers. And lastly, there is also a parallel to the current opioid epidemic crisis, with which I'm sure you are all too familiar. We emergency physicians certainly are. Several years ago, we created a whole generation of narcotic-dependent citizens through the very well-intentioned, overzealous treatment of pain. We as a society are still paying the price for that well-intended effort.
Thank you.
We should learn from our mistakes.
Thank you, sir.
In closing, passing this
up.
bill will predictably increase the consumption and use of marijuana, will increase the misuse of marijuana, will result in more car accidents and deaths, will cause many children inadvertently overdose, will increase the number of users presenting to emergency departments with intractable vomiting syndrome. Thank you very much.
Thank you. Representative O'Day.
Thank you very much, Mr. Chairman, and thank you, Doctor, for your testimony. Did you submit some written testimony, sir?
I did.
And do you have any studies or articles that you've cited in your testimony?
I did not cite the articles, but I can produce those, yes.
Yes, Doctor, if you could please produce those. I believe the 5 or 6 areas you said you were concerned about was similar risk of tobacco with asthma and COPD, gateway drug, unintended overdoses with the edibles, particularly in kids in the ER that you've seen personally. What was the 4th one? Cannabinoid hyper, what was that?
It's called cannabinoid hyperemesis syndrome. It's very similar to vomiting in pregnancy, except that these people are not pregnant. They're just vomiting as a result of the exposure to cannabinoids.
And are you seeing that as part of the increase in the THC content?
Yes, very definitely so.
The 5th was, you said, the altered mental status, decreased intention, increase in motor vehicle accidents, and the fact that there's no reliable BAC test for cannabinoid or type of test.
That's correct.
Okay, and then 6th, I think you said, was the parallel with the opioid crisis that you're seeing in the ERs now?
Yes, we've been seeing that for the last several years, and that's a direct result of trying to treat pain overzealously, which was something that was mandated.
I'm sorry, could you say that again? Privately paid?
It was the overzealous treatment of pain, which was a mandate from the federal government and the state government. And that's how we created this narcotic opioid crisis.
Sorry, yeah, I'm very familiar with that. The hospitals were ranked on how little pain you had, so they doped you up. Yep. All right, Doctor, thank you very much. Is there any other part of your testimony that you haven't had a chance to tell us about that's not contained in your written testimony or that you'd like to give us?
No, I've just summarized what my written testimony is. So thank you very much for your attention.
Thank you very much, Doctor. And thank you, Mr. Chairman.
Thank you. Further questions? Seeing none. Thanks, Doctor, for being with us. Next up will be the House Minority Leader, Representative Candelara.
Thank you, and good evening. Chairman Stavstrom, Chairman Whitfield, and ranking members Kissel and Fishbein, all the members of the Judiciary Committee. I'm Vincent Candelara, State Representative, House Republican Leader, and I'm testifying sort of in my personal opinion on this bill as opposed to a caucus position. One of my concerns generally with the bill, we've heard from a lot of experts today, I've listened in, and in my opinion, this bill has morphed into more of a commercialization bill versus a legalization bill. And with that, it just underscores the general concerns I have in all the testimony and all the conversations we've had over the years. Just specifically a couple of areas that I think we fail to address, and I just want to call the committee's attention that the state of Vermont is looking at a retail model, which was passed in January of this year. They're addressing issues, what age is appropriate? I think this bill should be looking at the age of 25 if it's going to be done. I think we should have a conversation about setting the THC levels to something lower to prevent all the societal ills that we've heard about being testified. I think that we should be limiting the products that are going to be offered. Having teenage children, I can tell you all that over the last few years, the number of products that my kids have already seen and been introduced to is only rapidly growing. And I don't subscribe to the notion that we should jump off the cliff with Massachusetts, California, and Colorado, but rather we should lead in a different direction, because I think some of these states are going to find that they need to put the genie back into the bottle. I'm generally obviously opposed to the commercialization efforts. I do think that the homegrown model that Vermont had started with is much safer. I know that the governor's office testified that they're concerned that we will start seeing self-medication, but that's what this bill actually does. It's going to eliminate our medical market, and we will just see self-medication, because no one is going to go through the process that they need to go through with DCP to get the medical cards, to go through that expense, and work with the caretakers. So I'm concerned that we will just see this model cloak over what we've already established and very carefully put into place. And so I just ask for those considerations to be taken as it's being moved forward. And certainly we do need more conversation with Department of Public Health and DEMIS to really understand what those other impacts are. And then just lastly, the taxes, obviously, if we set the tax structure too high, it is only going to invite the black market into Connecticut even more, because people aren't going to pay an added roughly 20% cost onto a product if they could purchase it cheaper on the street or on the internet through other states that are selling it more cheaply, which is already happening. And thank you for your time.
Thank you. Representative Dubitsky.
Thank you, Mr. Chairman, and thank you, Representative Candelara, for coming in. I think you attacked this from a perspective that I have kind of long been thinking about, the legalization versus commercialization, and I've always wondered why Connecticut is preventing people from growing some plants in their backyard when they can go out and buy it on the street or at a store. And can you tell us a little more about the Vermont model and how that might be a better direction for Connecticut to adopt?
So, I'm not an expert on this by any means, and I would sort of defer to other people. But in my conversations with individuals that are concerned about the impacts, the homegrown model naturally produces a lower level of THC. So if we're bringing this plant into a recreational market, which we're effectively doing, or a legalized market where people would just partake because they feel like it, it's safer to have it be decommercialized, as opposed to putting this onto steroids, where we're seeing different products being marketed for different people, whether it be gummy bears, sodas, or higher levels of THC. By allowing the plant model, it's just a little bit safer. And I know on the one hand, the governor's office did not include it in the bill. They're concerned that homegrown could lead to people using chemicals in the product and it would be less safe. We need to put that same scrutiny on this commercialized market, because to suggest that there might be problems with fertilizing a plant in somebody's house and there could be health effects to that, we really need to look at the health effects of 90% THC, which I think Dr. DeSouza had referenced. And so that's where I think, if you know, I don't like us treading down this path, but if it's going to be done, we should be looking at the way Vermont has done this.
Well, thank you for that. And you also make an interesting point that I had always thought about as well. During the prohibition period of alcohol, there were a number of companies that were legally manufacturing alcohol for medicinal purposes. And while it was completely illegal for recreational purposes, it was legal to some extent and manufactured and distributed and used for medicinal purposes. And once prohibition went away, you certainly you didn't see a lot of manufacturers manufacturing for medicinal purposes. And I can envision that when you can buy very high THC level marijuana at your local store, what would be the purpose of going to get a medical marijuana card and presumably spending more money and more time and more inconvenience? It would seem that the medical model would kind of fade away. And it was interesting that you brought that up as well. Frankly, I do think the model is working in Connecticut. At least I've heard stories that it is, especially among those that are particularly ill and the substance actually helps. But I can't imagine that market would continue if you can just go to your convenience store and buy it. Do you have any comments on that?
Well, I just think we need to recognize the fact, absolutely, that this could be eliminating our medical market or reducing those that will be using the medical market. And I know there are bills in other committees that are trying to address those issues of barriers to entry for patients to get into that market. But I do think it's an important conversation to be having in the context of this bill, because if only this bill moves forward without any fixes to the medical program, I'm concerned that this will be the new policy in the state of Connecticut at the expense of that program.
Well, thank you. And thank you for your answers, and thank you for coming in. And I thank you, Mr. Chairman.
Thank you. Representative Candelara, can I ask just a quick question? Maybe this isn't quite the right form, but you've highlighted a number of kind of issues or concerns with language or sections or tax policy, limits, age, the like. Is there a version of a cannabis legalization bill that if we sat down, we negotiated this, we worked through language, that I'm not asking you to speak for your caucus, but that you would support? It just seems to me that we kind of go round and round on this, and it's, are folks bringing votes to the table or not? Because if they are, I think we can get in a room and hammer the details out.
Yeah, I mean, I think generally speaking, we have never gotten close to that place. The way this bill has always been presented, it has eluded us because it tries to do too much. I think there are areas of this bill that common ground would be easier to find, in particular dealing with the criminal aspect versus the public health aspect. But I think, we still have to tackle the driving under the influence and how those impacts would be. But I think if the bill is going to move forward, we need better conversation on this language, because I think the language leaves a lot of gaps, and I wouldn't want to model anything after other states per se. I think there's opportunities to make things better. Would I vote for this bill? Probably not. But could we make a bad bill better? Maybe. But generally speaking, I think we've got to answer a lot of questions first.
Yeah, I guess, and that's fair. I'm not asking you personally to, but I guess maybe I would just say for the record, as I've said many times, this should not be a partisan issue. There are, statistic after statistic shows the state of Connecticut, the polling, the general public is generally in favor of us figuring out a framework to legalize recreational cannabis in the state of Connecticut. It seems to me that if we got in a room, we could figure this out. So I guess I'll leave that invitation out there to you or to members of your caucus, that as always, I am more than happy to sit and work through language that will hopefully satisfy folks, particularly if folks are bringing votes to the table.
And I appreciate that. Obviously, this is the start of the process.
Good. All right. Further questions or comments? If not, thank you, Representative, for being with us. Maybe you'll tune back in around 11 and watch. While if you're trying to fall asleep tonight. No, we'll be on CTN.
I miss this committee. I'll keep watching.
We miss having you on it. All right. I'm going to turn this. Next up is going to be Olivia Rinks, followed by Norman Plude. Olivia? It's Olivia Rinks with us. All right, while we work on that, let's go to Norman Plude, please. Norman, are you there? Okay. Felicia Jordan.
Mr. Chairman, if I may, it does look like some of them are trying to connect right now. Maybe they're being transferred over to a panelist.
Yeah. Is Olivia Rinks available?
Hello, Norman.
Hello.
Well, okay, let's go. Let's start with Olivia. Olivia, you're up, and then Norman, you'll be after Olivia. Olivia, go ahead. You have 3 minutes.
Thank you. Thank you for that. Okay, I am calling today because I've opposed SB 88, and I'm calling. I have a couple of reasons for that. Number one is just that it doesn't automatically clear the records of people with marijuana convictions. There just doesn't seem to be any reason, in my opinion, why people should still have a criminal record for marijuana possession if marijuana is legal and taxable. So I feel like that should be automatic, instead of something that has to go through the courts or is something that needs to be paid for. Also, home cultivation being illegal, like if it's legal, there's no reason that you shouldn't be able to grow it at home. And also, there's really no, the tax plan for SB 888 does not make a lot of sense. There's no direction for it. It needs a more clearly defined base, in my opinion. Thank you for your time.
Thank you, Olivia. Are there questions or comments from members of the committee? I do not see any, so I want to thank you for joining us this evening. Norman Plude, you have your 3 minutes. Norman, you need to unmute.
Okay. Can you hear me?
We do hear you. We don't see you anymore, but we do hear you.
Let's see. How about now?
Go.
Okay.
Yes.
Good afternoon, Judiciary Committee Chairman Gary Winfield, Co-Chair Stephen Sasthorn, Vice Chair Alex Kasser, Matt Blumenthal, and ranking members of the Judiciary Committee. My name is Norman Plude, and I reside in Seymour, Connecticut. I'm here today to oppose the Senate Bill 888. I have a number of concerns on the governor's bill. My first concern is that we already have an established medical cannabis program, and they have producers and dispensaries. And it appears the way the bill is written that they'll have a leg up on anyone wishing to acquire a license in the cannabis industry in Connecticut. As a hemp farmer in Connecticut, I not only cultivate hemp, I also have an extraction license in manufacturing. There are a number of hemp cultivators in the state that I know that are eager to get into this business, but from what I'm reading through the governor's bill, it's close to $1 million for licensing fees. And not only does that keep residents, but most small businesses, even hemp farmers in the state here, out of the industry. I have a second point, and it kind of goes along with the criminal justice reform. I don't believe that the governor's plan goes far enough, and I believe that there are many cannabis convictions in the state of Connecticut that were nonviolent. I think those cannabis convictions, along with legalization, should be expunged or done away with, dismissed. I have a third point, and again, this goes along with home cultivation for recreational cannabis. And in the governor's bill, as you know, it's not allowed. I believe home cultivation can be safe for the home grower in the state of Connecticut. Dispensaries who would be supplying clones or seeds to the home cultivators be generating revenue not only for the dispensaries or cultivators, but for the state of Connecticut and sales tax on those. Home growers would also be buying equipment like I have here for cultivating hemp at Home Depot or local places, supporting local businesses in their community to home grow. Over the last few years, people have become more accustomed to seeing hemp grown in the state of Connecticut. And I think over time, a lot of residents in this state will come accustomed the same way. Just as home brewing is legal in the state, I think that cultivation of cannabis should be also. Until these three main issues aren't met, I just can't support the governor's bill 888. Thank you.
Thank you very much, Mr. Pluto. Are there comments or questions from members of the committee? I do not see any, so I want to thank you for joining us this evening.
You're welcome. Thank you.
Next is Felicia Jordan, followed by Hector Gerardo. Either Felicia Jordan or Hector Gerardo here.
I'm here.
Ms. Jordan, you have.
I'm here too.
Okay, Ms. Jordan, you're up first. You have your 3 minutes.
Yes, I just wanted to speak on this bill and the legalization the way that it's written now. I do not agree with, because I feel like it supports the big cannabis companies that are in place right now and not the micro cultivation companies that want to come into the space, as well as providing equity for our community, as well as the decriminalization of people that are still being held accountable for carrying marijuana, where we have a medical market here that is legal. I'm cannabis program that's here. I've been a patient for the past 5 years and know the benefits of it. While I do support the legalization for adult use, the way that the bill is written right now, I do not support. So I did hear Devon Ward speak earlier, and a lot of the suggestions he had mentioned, I am in full agreement with and feel like it needs to be looked at from that perspective to adjust accordingly. Thank you for your time.
Thank you very much. Are there comments or questions from members of the committee? I do not see any, so thank you very much for joining us this evening. Next will be Hector Gerardo.
Yes, thank you for having me in this amazing panel. And I'm going to be quick. A lot of the advocates already spoken about some of the things that are lacking on the bill. But one of the things that I want to address that is being back and forth is the use of minors and the concern about minors using cannabis. Most of us have open bottle liquors in our houses right now with kids and everything. Right now, most of us have opioids in our medical cabinets right now. And nobody talking about our young people then. Young people at 18 can go to war and experience death. That's worse than sparking up a little joint. There's young people right now that spend years in solitary confinement. Nobody's caring about young people right now. We talk about, a lot of people here also talked about how, I'm sorry, I'm a little nervous. How the police, there hasn't been arrests over cannabis. The conversation is not about how many arrests has been happening. The conversation, I don't know if you guys read the ACLU 2020 Tale of Two Countries. They racially targeted arrests in the era of marijuana reform. I suggest that you read the ACLU report, and you can see that Connecticutans, Black Connecticutans and BIPAC, Black and brown people that live in Connecticut are 4 times more likely to be arrested for cannabis than any other, in the same racial line, than any other race in Connecticut. 4 times more likely to be arrested. So that's the conversation, is how police go into our neighborhoods and break heads for people smoking cannabis, that a bunch of white people are making millions of dollars right now for the sale of cannabis. So that's the conversation that we should be having. How are we gonna reinvest in our community? How the non-refundable monies that's gonna go into applications is gonna be reinvested into the communities, not into the pockets of politicians. And that's what this bill, not politicians, rich white men in the business, not politicians, I apologize, but in the pockets of rich white men that's in the business, like the Russian millionaire that owns Curaleaf. I won't have a chance to have my own dispensary. You know what I'm saying? Because of people like him. So we as a state, we need to start thinking about how we're gonna reinvest in the communities that's been harmed by the war on drugs, and not about if young people are gonna use cannabis. There's a lot of studies out there that show that cannabis use among youth in the states that have legalized have gone down. Like other research has shown that it's gone up. So at the end of the day, we need to worry about the communities that's been impacted by the war on drugs. And then my last point is about homegrown. We're talking about that you don't want to do homegrown because it's gonna bring the black market. Keep the black market going. The black market is not going anywhere. I'm sorry to tell you, it's not going anywhere. The black market is gonna stay there until we figure it out a way so that we can incorporate the black market into the legal market and give them opportunities to get out of the black market so they can become legal entities. Not putting more police, not putting more sentencing and more criminalization of our people. So that's all I wanted to say. Thank you for your time.
Thank you very much. Are there comments or questions from members of the committee? I do not see any, so I will thank you for joining us this afternoon into the evening. Thank you very much for joining us. Next, I think, is Mitch Schwartz. Did I get that right? Or yeah, Mitch Schwartz.
Hi there, my name is Mitch Schwartz. I'm with Outfront Media. I'm here with a panel of John Barrett and Matt Duddy, who are sequentially right after me. John Barrett is the president of the Outdoor Advertising Association of Connecticut, and I'm going to turn it over to him for comments.
Are you here? I know I saw Mr. Duddy, and I think.
Yeah, I see Mr. Duddy. I'm looking for.
I don't see Mr. Barrett. Mr. Duddy's with you though, correct?
Yes.
Do you want to just have him?
Sure.
Okay.
Good afternoon, everybody.
Oh, go ahead.
John, I guess John is maybe having some difficulties. So greeting to the members of the committee, co-chairs Winfield and Staffstrom, ranking members Kissel and Fishbon, and vice chairs Castor and Blumenthal, and the distinguished members of the Judiciary Committee. I am Matt Duddy, Vice President and Territory Manager of Lamar Advertising. I'm joined by John Barrett, President of the Outdoor Advertising of Connecticut, and also Mitch Schwartz. Our membership consists of Barrett Outdoor Communications, Clear Channel Outdoor, and Lamar Advertising Company, Outfront Media, and Standish Johnson Advertising. In all, we control 88% of the billboards in the state of Connecticut. The OAAC neither supports nor opposes this bill. My testimony strictly pertains to how the bill treats the issue of advertising. Our only real concern is subsection A6 of section 25 that specifically prohibits the use of billboards. Billboards are the only medium of communication specifically prohibited in the bill. Equity and law suggest that the best course for the state of Connecticut is to treat all media the same in connection with proposed legislation. We therefore respectfully ask you to treat billboards the same as all other media and strike the words "or on any billboard in the state" from lines 827 and 828 in subsection A6. The bill sets a very aggressive 10% limit on the opportunity for the under 21 population to see cannabis advertising. There is an effective alternative to codifying the opportunity for minors to see inappropriate messages that is already in effect in Connecticut and the rest of the country. I challenge you to look at other schools, playgrounds, recreation centers, public parks, and places of worship and find billboards advertising alcohol or other products that are illegal to sell to minors within 500 feet. You should not find any even though there is no law against it. That is because on a voluntary basis, the billboard industry and many of the manufacturers and distributors of these products do not allow it. Regardless of whether this body codifies any restrictions or advertising recreational cannabis, the billboard industry will impose its own, as it has done in each jurisdiction where cannabis has already been legalized. If you would be interested in working with us to modify our codes in some way to address any concerns, we will be there in a heartbeat. I thank you for your time and this opportunity to speak, and we are happy to entertain any questions you may have.
Thank you. And I see that Mr. Barrett's in, and I just for the information of the committee, all of the members are signed up, so they're not actually getting extra time. It'll probably work out to be less time. Mr. Barrett, you may proceed.
Well, actually, Mr. Duddy just read my testimony.
If I may, I just want to reiterate that our central purpose for testifying today is based on equity and law, and that it points to keeping all advertising mediums on an equal playing field. That's essentially what we're asking for here today. And I also just want to reiterate that we share the General Assembly and the governor's intention here, which is to be in sync as a general matter in a reasonable way with the states around you as far as cannabis is concerned. And moreover, we are extremely sensitive to safeguarding the youth of Connecticut by imposing protective yet permissive advertising standards. And we're willing, as Matt said, to sit down with anybody and work through those standards to the point where everybody is comfortable with them.
Thank you. Are there questions, comments from the members of the committee? Representative Fishbine.
Thank you, Mr. Speaker. Mr. Chairman, sorry. Different medium. Anyway, thank you, gentlemen, for being here today. You know, I don't know if you were here at the beginning when we started this morning, but I did ask about that particular provision of this bill. And we were told that the reason why you were singled out was because your industry has indicated that it could not comply with the criteria set forth in lines 800 through 802, which states that not less than 90% of the audience for the advertisement is reasonably expected to be 21 years of age or older. Can you fill me in? Is that the position of your industry? What's going on here?
Let me take that. I believe there was some misunderstanding. I did mention in that meeting that when I checked the demographics of my plant, which is strictly on I-95 in New Haven area, that traffic, when we try to run the figures, came out above 10%. But that does not reflect the entire state. That's just one small sample.
Okay, so am I to understand then their representation is based upon not the industry, but a questionnaire that you in particular filled out with regard to your potential with your specific location?
I answered a question and used data on my plant alone, which gave him the wrong idea. The Outdoor Advertising Association does not believe that it's all impossible to do. You know, it's a science to come up with reach and frequency numbers on ratings, and it has to be done throughout the plant and can't be something we can just do very quickly.
Well, thank you. And you indicated that as an industry, you've already imposed some similar criteria along these lines. What is that criteria?
It's a code of ethics that's adopted by the entire outdoor advertising industry. And then some of the companies have put their own version of it together. But in short, we prohibit advertising any products that are illegal or inappropriate for minors to be displayed within 500 feet of any school, playground, church, or area where youths meet. So if you were to go out today and look around all these places, you will not see any billboards advertising inappropriate or illegal material.
And that code of conduct would be directly in line with the rest of what is required of others in lines 825 through 827, correct?
I think it probably goes beyond that.
Okay. Interesting.
Representative, I'd like to add that with regards to the original question with the 10%, we were never consulted by the state. We were frankly surprised when we saw that when the bill was published. So the illusion of the industry gave that standard, we were never consulted with that figure. I think there was an assumption and a de facto ban solely on our industry.
Yeah, I did bring up this, well, I don't need to belabor the point, but certainly, you know, picking on your one industry when, you know, a child can turn on the television or the radio just as easily and it's not controlled here is baffling to me. But, you know, I thank you that, you know, private industry was able to do something without the heavy hand of government. So I thank you, Mr. Chairman, for the ability to ask questions.
Thank you, Representative Fishbine. I do not see anyone else. Are there others who would like to ask a question or make a comment? Seeing none, I want to thank you all for engaging us this evening and have a great evening.
Thank you. Thank you for the opportunity.
Thank you. Is Daniel Fries in?
I am.
You get your 3 minutes.
Thank you. Thank you, staff, committee members, and chairs for allowing me to testify today. I apologize for my background and dress as I'm actually at work right now in the emergency department. I am an emergency physician here in Hartford. I live in West Hartford. I'm the former president and current legislative chair of the Connecticut College of Emergency Physicians. I'm not speaking on behalf of CSEP at the moment, as Michael Carius spoke, I think about 10 speakers ago on our behalf, but also testifying as an individual with similar sentiment. I will try not to repeat much of his testimony, but wanted to talk about some of the health consequences of marijuana use. I first wanted to say that I am fully cognizant of and feel equity issues, decriminalization, judicial reform are all absolutely necessary issues and things that need to be addressed regarding marijuana use and laws in our state. I think there's significant detriment to certain communities, especially of color, and different genders as well. Those things need to be addressed. With that said, as Dr. Carius alluded to and some others have alluded to, simply allowing, having the answer be full open use is problematic because marijuana, as much as it's used frequently, is not a benign drug. It has significant health consequences, as we see in the emergency department on a near daily basis. As Dr. Carius alluded to, cannabinoid hyperemesis syndrome is seen more and more. I'm not bringing studies with me necessarily. I could probably find them. But speaking to my colleagues in Colorado and California, they're seeing a 4-fold increase in cannabinoid hyperemesis syndrome presentations after the legalization in their states. There's significant increases in pediatric accidental and even intentional overdose in the case of teens. And as has been mentioned by others, there are significant cognitive effects, particularly on teenagers, through regular and even infrequent use of marijuana. Listening in earlier, I know there's been a lot of studies back and forth whether legalization increases or decreases use in teenagers. I don't speak to have read every study, nor can I speak to the certain studies that were cited earlier. But in speaking to some people, but in reading some studies on the issue, a way that's rectified is, in fact, when legalization occurs, the amount of marijuana smoking among teenagers goes down, but overall cannabinoid use goes up because there's some deferral of users to edibles, vaping, and other means that are more accessible once legalization occurs. So what I have found in my reading of studies is that cannabinoid use increases among teenagers, though there may be a decrease in actual marijuana smoking. I would finish my comments there. Happy to answer any questions as Michael Carius and others have previously explained many of the issues that I wanted to bring up.
Thank you very much for your testimony. Other comments or questions from members of the committee? Representative O'Dea.
Thank you very much, Mr. Chairman. And thank you, Dr. Fries, for your testimony. Where do you practice?
I practice at Hartford Hospital, though I would clarify I'm not speaking on their behalf at this time.
No, understood. I'm sorry. I'm just curious. So you've had personal experience treating some of these excess exposure or problems that you're talking about, correct?
Yeah, I'd even go with frequently.
You would testify, or you told us that you talked to colleagues at other parts of the country where it's legalized, and there's a 4 times increase in the amount of smoking or use, even though smoking may go down, but the overall use increases?
Not a full increase in use, 4-fold increase in presentations to the emergency department for cannabinoid hyperemesis syndrome, and similar, but I can't speak to 4-fold increases in things such as pediatric accidental overdose, side effects of marijuana use in teenagers, and I'm hesitant to throw out any numbers, but colloquially, I've heard an increase in traffic-related accidents where marijuana was involved, though I certainly can't speak to numbers on that.
All right, Doctor, thank you very much for your testimony. Thank you, Mr. Chairman.
No problem.
Thank you, Representative. Representative Dillon.
Thank you, Mr. Chairman, and thank you for coming to speak before us today, Doctor. You cited Colorado and the number of admissions of, was it poisoning? I don't remember the particular issue. What was it?
My colleagues have seen a significant increase in the amount of accidental pediatric overdose, which is where kids get a hold of typically gummies that look good to kids.
Right.
An increase in teenagers, I hate to say coming in high, but having side effects of marijuana use, as well as what's called cannabinoid hyperemesis syndrome, which I think was explained earlier. It's severe nausea, intractable severe nausea and vomiting, which we're seeing a lot more both locally and exponentially more in states where legalization has occurred.
Now, Colorado uses e-coding, right? That is, they don't have a state mandate like we do, but they register the external cause of injury in the emergency room. Is that true?
I couldn't speak to Colorado the way it's dealt with or coded in Colorado.
I just wondered, well, ordinarily you would say poisoning by X, that might be a particular code that you could, we have that data in our hospital system, as you probably know. So I just wondered what was that an anecdotal sense then that you were getting from Colorado, or is there actually a database where it's reflected?
I think there is both. I don't have the numbers from that database. I know the people I know that have worked on sort of creating databases and looking at them have shown an increase. I won't speak to those numbers because I don't have them. But anecdotally is what I was speaking to. There's a significant increase in those things.
Thank you very much.
In terms of coding, you certainly can code cannabinoid hyperemesis syndrome. Typically, it would get coded as severe nausea and vomiting, as opposed to true cannabinoid hyperemesis syndrome, because it's not something you can necessarily prove with a lab test. But just to answer that aspect of it.
Okay. Thank you.
No problem.
Thank you, Representative Dillon. Can I ask you a question, Doctor, about cannabinoid hyperemesis syndrome? I'm just going to say CHS from now on. When we say there's a whatever number increase or factor, from what point are we referencing that? I guess for my information, because it's my understanding we haven't even really diagnosed CHS for that long in terms of the history of marijuana use.
You're saying how would you diagnose it? It's a clinical diagnosis.
No. What I'm asking is, we say, well, we see a X number of times increase in CHS, right? And what is the reference? X number from when? From how are we determining that there is that number of increase?
Over the experience of my colleagues over the couple of years before legalization versus say the year or two, or probably 2 years after legalization in the case of, I don't remember the exact dates when those things were passed in California and Colorado specifically, as well as Washington, I believe.
Sorry, I didn't mean to cut you. Go ahead.
Yeah. In terms of the amount of people they are seeing where there's a suspicion of, which is typically cannabinoid hyperemesis syndrome, many of my colleagues have said they would typically see it anywhere from about once or twice a week. And now in some cases they are, again, by their self-report, seeing it as many as 3 or 4 times a day. And so again, that's not published data, so I can't speak to the data.
Sure.
That is the colloquial impression that I've gotten from some places.
I guess the reason for my question, and I may be wrong, but I thought we weren't really diagnosing cannabinoid hyperemesis syndrome till around 2004, 2005, and legalization didn't happen that long after that in some of these states. So could it? And I'm not trying to refute your data. I'm just saying it seems to me that it's possible that part of this could owe to the fact that, at least as we currently talk about CHS, we weren't talking about it all that long before the legalization.
I think there's thought that CHS has been underdiagnosed over the last 10 or 15 years. And as we've come to understand it better and it's been more publicized, that maybe we are diagnosing more people with it. But in terms of the symptomatology that people present with, maybe I shouldn't have thrown out fourfold as a specific number. That's what it was told to me verbally. But I think regardless, people are seeing an increase in that symptomatology in those that chronically and frequently use marijuana.
Thank you, Doctor, and I appreciate it. I'm not trying to argue.
No,
I'm just trying to make sure that it seems to me it's possible that part of this is what we track as CHS versus what we might have tracked as just the symptoms. And I really want to understand what the landscape is. So thank you for helping us to think about that a little bit. If there are no other questions or comments, I want to thank you very much for sharing part of your day with us.
Thank you for letting me testify.
Have a great evening. Erin Malakowski, Dr. Gregory Shango, and then Mike will ask you, is Erin on?
Yes.
You may testify.
The creators of this cannabis legalization bill started an equity commission of Black and brown activists so they could use the word equitable, then excluded them in their request for equity from the entire writing of the bill. They didn't include any specific legislation to repair the damages of the war on Black people. The excuses are that they have the framework to add more equity throughout future sessions and that their focus is getting legalization out first, yet they keep claiming that equity is their main focus. This excuse once again invalidates all the hard work and expertise of the Equity Commission that this bill used for political sway, because the Equity Commission has already laid out the entire legislative framework for equitable legalization. Legalization cannot be equitable unless it starts off equitable. The whole point is to give the communities most impacted by prohibition a head start in the industry that will take off. Lamont's bill uses a bunch of broad loophole language so that the lottery of licenses immediately go towards out-of-state corporations and Russian billionaires, so the small oligarch who wrote this bill can hoard all of the revenue from communities of color who need it most, then use that revenue to continue criminalizing them. Lamont's bill states the majority of cannabis tax revenues will go towards state municipalities, which will be used to punish Black people who are 4 times more likely than their white counterparts to be arrested for cannabis in Connecticut, despite equal consumption. This bill allows law enforcement to arrest and jail minors, sellers, and growers, which we all know is disproportionately enforced in Black and brown communities. Ned Lamont has admitted that the Black youth is more likely to get arrested. However, his policies will perpetuate that and their school to prison pipeline. The other excuses for home growers, micro cultivators, and equity applicants being less qualified than big cannabis corporations are also inadequate because the Equity Commission established a clear partnership with UConn that provides job training and expertise. This partnership also provides necessary research that proves the medicinal benefits of cannabis. This isn't a matter of whether or not communities of color have the ability to make legalization work. This is also not a matter of wanting to keep communities safe from drugs, because if it was, you wouldn't have liquor and pharmacies put on every street corner. This is about profit. This is a matter of whether or not you can share a part of the cannabis legalization profit with communities who are directly punished for it due to countless racist systemic policies. Communities of color that come from redline concentrated poverty will continue to run underground cannabis businesses for survival because this system has given them no other option. Instead of reserving and sharing a portion of legal licenses for those who have been criminalized and neglected, this bill chooses to withhold their economic opportunities in favor of a cannabis market only legal for rich white men. Connecticut not only has the chance to be a leading example for equitable cannabis legalization in the country, but a chance to start fixing our reputation for the most segregated state. Ned Lamont, your bill for cannabis legalization is a slap in the face to communities who have suffered centuries of abuse from a racially violent system and will continue the destruction of these families. And then you have the nerve to call it equitable when you rob the Equity Commission of all their time and energy spent towards justice for their people. So you can co-opt the word.
Ms. Malakowski, I would ask you to wrap up. We are past your time.
This bill, you're saying all the wrong things to the media, but doing the opposite behind closed doors so you can scam the people into supporting your rich whites only market. The Black community deserves more than crumbs and symbolic gestures. They need actual support from a system you're responsible for. You wealthy people don't know what it takes to hold a public.
Ms. Malakowski, I'm going to ask you to wrap up, please.
Now let's go back to the tent.
Ms. Malakowski.
Let's go back to the tent, Mom.
Ms. Malakowski, I'm sending you a signal about unmuting. Okay. Ms. Malakowski, we will give you one more second to unmute. Okay. Dr. Shangold.
Hi, good evening, Senator Winfield, Representative Staffstrom, and distinguished members of the Judiciary Committee. On behalf of the physicians and the physicians in training of the Connecticut State Medical Society, thank you for the opportunity to provide this testimony in strong opposition to Senate Bill 888. My name is Greg Shangold. I'm an emergency physician and the current president of the Connecticut State Medical Society. One of our primary objectives is to advocate for the best public health policy and environment for Connecticut citizens. Legalizing recreational marijuana will absolutely harm the public health of Connecticut. We fiercely oppose this bill. Based on analyzing those states that have already legalized recreational marijuana, proceeding down this path will lead to significant harms. The rush towards legalization of recreational marijuana ignores how profit-driven corporations hook generations of Americans on cigarettes and opiates, killing millions and straining public resources. We need to learn the lessons from history to ensure that any legalized marijuana product does not become the big tobacco of the 21st century. At its 2017 national meeting, the American Medical Association approved a policy position based upon recommendations from its Council on Science and Public Health. They concluded that cannabis is a dangerous drug and a serious public health concern, and that the sale of cannabis for recreational use should not be legalized. Our written testimony provides evidence for our public health concerns. These focus on the impact on the developing youth brain and the long-term health consequences. The clear evidence of increased episodes of impaired driving and motor vehicle fatalities. The adverse effects associated with pregnancy and other significant healthcare-related issues. For example, before COVID-19, we were discussing the amount of young people dying and being permanently injured from vaping marijuana. Many people talk about the additional revenue that is projected by legalizing recreational marijuana. However, not enough attention has been given to all of the increased costs. Most people acknowledge it is vital to prevent youth from accessing marijuana. Science clearly shows the human brain develops until the age of 25. Assumingly, Connecticut would create an analogous bureaucracy similar to the Tobacco Prevention and Enforcement Program within DEMIS. Despite the money and the effort invested into this agency, in 2018, there were 225 establishments that were cited for selling tobacco products to children. The current mental health infrastructure is incapable of treating today's prevalence of mental health illness in Connecticut. The COVID pandemic is already stressing the system. A recent article in the New York Times underscores the increased use of marijuana in adolescents and teens as a coping mechanism to deal with the isolation brought on by the COVID-19 pandemic. How much money is needed to create a mental health network adequate to handle the influx of additional patients caused by the legalization of recreational marijuana? Those patients with Medicaid already have trouble accessing medical and mental health care because of an inadequate network. How much money will be needed to create an adequate network so the healthcare system can care for the additional healthcare needs? Colorado witnessed an increase in motor vehicle fatalities and suicides with the legalization of recreational marijuana. The December 2020 Journal of the American Medical Association published an article showing individual driving impairment from marijuana similar to alcohol. What is the cost of more deaths? There are many indications that the public health impacts of legal recreational marijuana.
Dr. Shango, your 3 minutes have elapsed. If you could summarize.
Sure. The impacts far offset any immediate or long-term fiscal benefits to Connecticut. Connecticut has an obligation to protect the health and welfare of the citizens. We strongly oppose Senate Bill 88, and we urge your rejection of this dangerous legislation.
Thank you, Dr. Shango. I believe you have a question from Representative O'Day.
Thank you, Mr. Chairman. Thank you, Doctor, for your testimony. I'm sorry, I haven't had a chance to read it. I will. Could you tell me, is the 12/20/20 journal article that you referenced here in your testimony, is that in your written testimony as well, referenced?
I believe it is. If not, I'll send you the article myself. I have.
Thank you. And did the Connecticut State Medical Society provide a policy position regarding the use of marijuana?
I believe it's in our testimony. Just clarification, what do you mean by policy position?
Sorry, yeah. Does your policy position have a statement that's updated annually? In other words, do you have, when your written statement, does it have I believe there's the Connecticut State Medical Society's policy regarding the use of marijuana. And it looks like it's about 7 pages. Is that part of your written testimony? Or is that
I believe we coalesce that into our testimony about our facts that we've gathered, because more and more evidence is coming out and we want to be updated. We certainly support more research into marijuana, and we think that should be allowable, to be able to do this research and to have this based on science and not based on public opinion or other objectives like revenue. But the science isn't there yet. And what we've seen is that this can be harmful. And what we're just saying is we should have this caution at this time.
So my understanding is the marijuana of the 80s and 90s, even 2010, is not similar to the marijuana of today. Is that an accurate comment?
That's absolutely true. The THC content has been increasing much over the past years. And when you get into these higher THC concentrations, that's where we're seeing a lot of these problems. So the discussion with Dr. Freese and Senator Winfield was talking about cannabinoid hyperemesis, and we're seeing more and more of it because of the higher THC contents. Also, you start to see addiction when you get into these higher ones. There's always that connotation that marijuana is not an addictive drug, but at these higher THC concentration, it is becoming an addictive drug.
My biggest concern, obviously as a parent, is the impact on the youth brain development. Can you tell us what studies have shown about the impact of marijuana, particularly with the higher THC contents, has on youth brain development?
There is an ability for this, being exposed to it, and of bringing out actual schizophrenia. So there is depression, and again, going back to Colorado, there was in 2013, there was a 14% suicide rate, and it went up to 23% suicides that toxicology showed positive marijuana. So more and more of the suicides had marijuana in it. Now, obviously, this isn't causation, but it's certainly cause for concern. And the youth brain, once it gets exposed to this marijuana, there can be permanent damages. And they've seen it even in some of these PET scans that are done where you look at these different areas of the brain. So that's our big concern. And certainly, as I mentioned, we are already inadequate with our mental health. There's children that spend days in the emergency departments before they can find a bed. And we're going to add another stressor into our mental health system within Connecticut. It just seems to be harmful.
Thank you, Doctor. And you're an ER doctor, so you've seen all this firsthand. Is that fair to say?
I've been practicing emergency medicine in Connecticut for 18 years, and I've practiced and seen the opiate epidemics, and now we see more and more medical issues with marijuana that are presenting to the emergency department.
Thank you, Doctor, very much for your testimony. Thank you, Mr. Chairman.
Thank you, Representative. I see Representative Fiorello.
Thank you, Mr. Chair. Dr. Shangold, is your main concern with the mass commercialization of marijuana? Are you okay with homegrown marijuana, sort of more grassroots use of it?
The Connecticut State Medical Society's position is more marijuana, or legalizing the recreational, however we get to that point, increases the access specifically to the youth. And we will see the public harm and the public health harm from that increased access. When you legitimize it, then kids feel that they can use it. And when kids have access to it, we're going to see those harms, especially in the mental health realm. And I believe some of the previous testimony talked about the traffic fatalities. So in the first year where Colorado legalized recreational marijuana, there was a doubling of fatal car accidents. So you can decide for yourself if there's causation. They did have testing for marijuana in their system, but that's going to be an inevitable consequence of doing this. So we are concerned about the public health. And if that means people are getting it from their homes versus the commercialization, I don't want to get into the decriminalization and the commercialization. I'm concerned about the public having access and the consequences on our public health.
Mhm. And I often hear that marijuana is not as addictive as alcohol. And what do you say to that? Is of all the sort of vices out there of things we use, we have some vices. How do you medically compare the vice of alcohol versus smoking some marijuana?
I think it becomes very variable to that THC content. So as we've seen more products with higher THC content, there's more evidence of addiction. Certainly, addiction is, in the clinical term, there's three terms to be aware of. There's dependence, there's tolerance, and there's addiction. And so those are all means different things. Addiction is really when you change your ability to function in society because of your dependence on a substance. So your body could become dependent, it could become tolerant, and then it becomes addicted. And so we are seeing more, I don't know if there's a linear comparison to alcohol of which is more addictive. Both will start to have withdrawal symptoms. And again, when it was a small THC concentration of 3 to 5% in the 70s, you did not see that as much as when now some of the products, even some of the edibles, are up in the 30 and 40% THC concentrations.
Okay, thank you. Thank you, Mr. Chair.
Thank you, Rep. Fiorello. Are there comments or questions from others? Rep. Lodez, your hand's still up, or you want to ask a second? Okay. Thank you for joining us this evening, Doctor.
Thank you very much.
We will hear next from Representative Cheeseman, if she's in with us.
She is indeed. Thank you, Senator, for indulging. Yes, I had to take my 94-year-old father for his second vaccination today. So I hope you approve of my absence from your meeting. Thank you. Thank you, Senator Winfield, Representative Staffstrom, Senator Kissel, and Representative Fishbein. You have my written testimony, so I'm not going to bother to go through that. And as far as I'm looking at this, there are two issues here. One is the issue of restorative justice. As the mother of 5 and grandmother of 4, I know how deeply I feel when my children, my 2 sons and 2 of my any of my children and grandchildren have been treated unfairly. And if that has been the case, when justice has been dispensed unfairly, then let's remedy that. Let's provide expungement of criminal records. Let's decriminalize possession of small amounts. Let's work. I believe I heard someone from the governor's group who came talking about people who had been put in prison because of marijuana convictions when they'd been on parole. We can fix that. On my role as ranking member of Finance, Revenue, and Bonding, when we were looking at that Senate Bill 873, I heard a great deal about the dismay from New Haven residents about what Yale contributed to the city. Yale has a great law school. Why not task the professors and the students with helping people who have been unfairly treated by the criminal justice system with expunging those records? And let's move forward with that. But having established that, let's look at the separate issue of the commercialization, the legalization of a substance where you have heard all afternoon is dangerous, is harmful, and will destroy lives. Surely we can do better than this. If the goal is increased revenue, there are ways to find it. If the goal is increasing opportunities for people from communities that have been disproportionately affected by the war on drugs, again, can't we do better? We hear the governor list his 4, 5, 6, 7, 8 areas where he wants to see growth in Connecticut. Healthcare, biotechnology, advanced manufacturing, cybersecurity. Surely that should be the goal, the aim for all our children. Let's ask more of the corporations who want this skilled workforce. Let's tell them, look, you're talking to us about tax credits. We want your people in our elementary schools mentoring our children. We had testimony from the unions today. There's a box where you pay your political fund. Why isn't there a box that says this is the workforce investment fund? We want to build union membership among minority communities. On my other committee, we were looking at the governor has a bill to
Representative?
you want me to wrap up?
Yes.
Okay, guys, I'm on board with helping expunging records. I'm on board with helping people who've been treated unfairly by the criminal justice system. I'm on board with building opportunities for every child in this state to have a career, to have a way to make a living, to be proud and strong. I am not on board with legalizing a substance that will destroy lives in the way that lives have been destroyed through unfair treatment. And you can guess I feel strongly about this. So thank you for listening to me. And I will be with you to get justice. I will not be with you to destroy lives.
Thank you, Representative. Representative Fishbein.
Thank you, Mr. Chairman. Good afternoon, or well, I guess it's good evening.
I think the sun is set here.
Here as well. Was there anything else that you wanted to mention to us in opposition to this bill?
You mentioned before how disappointed you were that the representatives from the Department of Public Health were not at this meeting. And I think you've heard all afternoon that there are significant, dangerous, and deleterious health effects that will come from this. This is my second testimony today. I was equally passionate this morning. It was the assisted suicide bill. And we heard it. Very moving testimony. In fact, the woman who testified before me, her husband had terminal prostate cancer. He was in hospice. The last 12 hours of his life were horrible and painful. And if she'd only had a way so he could take his life, then it would be fine. And you listen to that testimony and it is taken as fact. And that is why we should allow assisted suicide. You have heard testimony, as I heard in 2019 on all 3 committees that heard testimony on the bills, of families who had seen addiction, who had lost a loved one from drug driving. And yet that's to be overlooked because we're looking for revenue or job opportunities. As I stated before, there are better ways to produce revenue. There are better ways to create those job opportunities. That we would deliberately and knowingly legalize a substance that's increasingly strong, increasingly harmful, knowing people will die, I think is shameful.
And you mentioned you were shocked that there was nobody from the Department of Public Health. I would expect that you're equally shocked that there's nobody here from Demas as well.
Yes. When I look at the governor's bill, the amount that's put into the sort of education prevention, if we're going forward with this, I would like to see far more money devoted to that, knowing what the cost it's going to be, far more money put aside to deal with the social services consequences. And indeed, I would propose we create a victims fund, the way we have a victims fund for someone who's a victim of a violent crime, because people will die, their families will be left bereft. And we've done this deliberately, so why shouldn't we find a way to make them whole?
Yeah, that's a good point. It's something that hasn't come up before because, you know, we've done that with gambling. We legalized gambling and then we had to create a victims fund and a whole group having to do with that. And, you know, I thank you for bringing that to us and for your testimony here today. Thank you, Mr. Chairman.
And thank you, Representative Fishbein. I am going to caution us a little bit. I'll let us just go with this, but I would ask that we ask questions related to the bill and not opinions about whether or not the governor should have had someone testifying or not testifying of the people who are testifying today. They're here to talk about their perspective on the bill. But Representative O'Day, I saw your hand at one point. Do you still want to, you're good to go? Are there questions or comments from other members? Seeing none, thank you for joining us this evening, Representative Friesman.
Thank you so much for listening to me, and thank you for allowing me to take my dad to get his vaccine.
Absolutely. Enjoy the rest of your evening.
Thank you. You as well.
We'll hear next from Michael Askew, followed by Taylor Nicholas, and then Carlos Moreno if they're here. I see Michael Askew is. Mr. Askew, you're on mute.
Good afternoon, Senator Winfield. Representative Staffstrom are my hometown hero. Certainly to the distinguished members of this committee. I had the privilege of sitting on this bill and listening last year before COVID struck. But I've been at this computer all day, listening to a great wealth of knowledge and information. I want to thank all the people that shared. A lot of it's already been shared on what I had to talk about, but I just want to pick up on a couple of pieces that Cyril de Souza shared about the 4 elements. One was addiction. We've heard some issues about the increased THC content that will probably bring some medical issues to the forefront, especially with those under 25 and those under 21 years old. I'm a person in long-term recovery. I represent the Connecticut Community for Addiction Recovery, a nonprofit organization that promotes recovery from alcohol and other addictions. And I've been in recovery since May 28th, 1989. And I share that because in high school, I really had ambitions to be an architectural draftsman. And because back then in the 60s and early 70s, you had electoral classes that you could choose. I chose 4 years of architectural drafting. And I got really, really good at it. But by the 11th grade, I started smoking marijuana. By the 12th grade, I flunked out of school. Now, I can't attribute it to the fact that I smoked marijuana, but I want to show you that I made some real irrational decisions because I was smoking marijuana. So I just want to list a couple of things about the addiction piece that I don't see in the bill with regards to prevention, treatment, and of course, recovery as we move forward. And I'm not sure of this bill. I don't have a stance to the bill, whether it's I oppose or whether I oppose the bill or I support the bill. But I do want to, because I've heard a lot of testimony, leave you with a couple of thoughts about what it will look like once if this bill passes. And how do we measure the data that we need to collect, and how do we support the many lives that will probably be affected because of the use? And I heard, and I looked at the Colorado report with high-end utilizing, and certainly right now we talked about dependence and addiction. And I know that there's through NIDA, the National Institute of Drug Abuse, they have already looked at the increase from dependence to addiction by 10% of those that use marijuana and have a marijuana use disorder. And if they use before the age of 18, those rates increase by 1 to 6 individuals will be addicted to marijuana. I don't know what kind of therapies we're going to have and all those other issues that we're going to have to address, but I do know that the budget that provides Demas with $1 billion will probably need to be increased, but there's a lot of equity that we need to talk about in this bill, because I do see it as a harmful product that will certainly, raise a lot of rampant issues in the urban community.
Mr. Askew, I
With
would
that,
ask you.
With that, I'm done. Senator Winfield, thank you very much for allowing me to come and participate in this ever-enduring conversation.
Thank you. And there's a question from Representative O'Day.
Thank you, Mr. Chairman. Mr. Askew, thank you so much for your testimony. If you have, so looking at this, and my concern is focused on the use of teens and those under 25, frankly, getting addicted. What would you say to your younger self? How would you help us prevent youth from using marijuana?
I think it had to be more education and more prevention. I certainly wasn't introduced to marijuana only because my peers. I was introduced to it because people was talking about it. I was inquisitive to find out what it was about. But if I had gotten more education and more prevention from people that could help me understand why I should not smoke marijuana, I may have been able to overcome that.
Well, thank you very much, sir, for your testimony this evening. And thank you, Mr. Chairman.
Thank you, Representative. Are there comments or questions from other members of the committee? I do not see any. I want to thank you, Mr. Askew, for spending part of your evening with us and for the work that I do know that you do. Thank you very much. Next, we will hear from Taylor Nicholas. Is Taylor here? Okay.
Yep. Here we are.
Okay.
Can you hear me?
Yeah, I hear you.
Okay. Good evening, everyone. Members of the chair and committee, senators and representative. I'm going to try and be quick because I'd first like to thank speakers from both sides of the topic to come out and just get their points out there. This is a very important topic that we should be discussing. I would also like to thank Ms. Milikowski, Mr. Ward, Mr. Ortiz, Mr. Elise, and Mr. Wilcox. They had already spoken before me, and they actually cover quite a few topics that I myself fall similar in lines with. I am not in, or I do not support SB 888 as it currently stands. There are many issues, again, which have been discussed by other people with their testimonies. A little background on myself. I am a Connecticut resident. I have been my entire life. The only time I was outside of Connecticut was when I enlisted in the United States Marine Corps, 1 year of which was served overseas in Afghanistan. Afterwards, I came back home and I was offered a job opportunity in Washington State in the cannabis industry. It was on the security and regulation side. It was going to be a third-party aspect. And so I pretty much picked up my entire life and moved out there. Unfortunately, that fell through. And in that time frame, I found a job working at the largest farm at the time in Washington State, is Grow Up Farms LLC, Fat Panda Cannabis. And needless to say, in that time period, I found my true passion and calling to as to what I wanted to do for the rest of my life. When I was in the Marine Corps, I worked on radios. I repaired satellite systems, as well as the precursor to satellite communication systems. So it was a little bit of a jump, but to say the least, I actually felt some form of peace and clarity while working with the plant. And even though that did mean physical manual labor, like heavy physical manual labor at times, 10 to 12 plus hours a day, every day for 5, sometimes 7 days a week, because it is an agricultural industry. And unfortunately, that really isn't discussed. I really don't feel like that has been touched on a lot. It is still an agricultural industry. Yes, in regards to the Department of Public Health, I would like to be speaking with them as well. I would have liked to see them, just because they need to be able to hear both sides of the topic, both pro and con. And having an absence with them there, I feel as though it is a disservice.
Mr. Nicholas, could
to wrap up, so as a grower, I feel as though this bill is very, it does not allow the local Connecticut person to be a grower. It does not, I do not feel that this bill currently in its aspect supports a Connecticut-based community to grow and thrive.
Thank you, Mr. Nicholas.
Thanks.
Comments, questions from members of the committee? Do not see any. Mr. Nicholas, thank you for joining us this evening and for offering your perspective on the bill. Have a great evening.
Thank you very much, sir. And thank you very much for allowing me to speak this evening.
Absolutely. We'll next hear from Benjamin Zacks. Is Benjamin in?
Yep. Hi.
All right. You may begin.
Yeah, Senator Winfield, I can empathize with you. I have an 18-month-old screaming in the background, so I apologize for that, for everyone, if you hear Lewis. But now I'll begin. Senator Winfield, Representative Staffstrom, Senator Kissel, and Representative Fishbein, and the members of the Judiciary Committee, thank you for the opportunity to provide testimony regarding Senate Bill 888. I am Ben Zacks. I'm the Chief Operating Officer of Fine Fettle. We are a Connecticut locally owned and operated medical marijuana company. We operate 3 of our 18 dispensaries in the state, one in Willimantic, one in Newington, and now one in Mansfield. And we've grown through winning a license during our competitive application in 2018, through entering into a partnership and an acquisition that was completed at the beginning of this month. Our team is Connecticut-based, are Connecticut educated, and we have 40 some odd employees in the state who all are receiving paid time off, company holidays, healthcare, vision, dental, a 401k plus match. And in addition, each one of our managers is a minority in our 3 locations. We support the concept of this bill and the legalization of marijuana safely and equitably, but we believe there are a few elements that are not done to the fullest extent, focusing on 4 key areas. 1, social equity; 2, the taxes; 3, the lottery system; and 4, the ownership and licensure. In terms of social equity, we don't think this bill does enough specifically regarding the folks and the communities that have been most affected by the failed war on drugs. We absolutely agree that there should be an equity commission, but we think it needs to do a little more at 3 levels. And I write about this deeper in my written testimony, but community aid, ensuring exactly where those dollars are going in communities most affected; diverse hiring initiatives from the operating businesses within the community, as well as creating opportunities for diverse ownership in what we've described as our 18-18-18 rule, which would be 18 medical dispensaries, first operating safely and efficiently and effectively under the pharmacists, going adult use, taking on social equity applicant mentees, the next 18 dispensaries being solely awarded to social equity applicants, and then having 18 dispensaries who ultimately are open and available for the general public, large, small, local, not local, but in a competitive process. And we also believe that this should be the case around cultivation and processing. The other piece of that is with the dollars that are made from our business going from medical to hybrid, we believe that that money should be earmarked as grants, non-interest bearing, not loans, grants directly to the social equity applicants to get their businesses going. On the taxes side, by taxing through weight and milligram, we believe that the taxes will become exorbitantly high over time, making our program non-competitive with our neighbors. Sorry, the baby just popped in the room.
Zach, if you could summarize your.
Yeah, sure. So the taxes we think are incredibly high, and we think that an excise tax is an operational nightmare. Again, the next piece is quickly on the lottery, which we think brings not the best operators through a competitive process, but just through luck. And then in ownership and licensure, we think that we need to ensure that licenses can all be tracked safe seed to sale tracking throughout the supply chain.
Thank
And
you.
so,
Yeah.
sure.
I see Representative Bimbis has a question for you.
Sure.
Thank you, Mr. Chairman. Thank you for your testimony. Just a quick question. I listened to your testimony and you had indicated that the managers were minorities. How
Yep.
many of all of your facilities is the percentage of the workforce minorities?
Sure. We're at about 35% in our 3 facilities.
And is there a reason why it's not higher?
Is there a reason why it's not higher? I don't know specifically. I don't hire the specific folks. I think it's based on who we get in and who's the right employee for us. We try and ensure a diverse group of thought as well as a diverse group of being local in our group and ensuring that we have the best, safest employees. In Connecticut, dispensary technicians is sort of the middle rung under the pharmacists in our facility. And there is not an enormous number of dispensary technicians who are minorities. And I think that helps limit numbers. But that's a number that as a business, we believe and think and hope would be high because we think that should be the case across industry and across job employment in general.
So in your business, what type of recruitment and training are you doing of minorities specifically in order to put them in those positions?
Sure. So our recruiting is done honestly mainly through Indeed. We have done staff trainings around having diverse workforce, diverse hiring. We have a director of HR who trains our management teams around those pieces. And that's really the areas that we've done it. We've posted previously at community colleges, as well as programs that are doing the dispensary technician licensing, even though you have to have worked at a CVS or a Walgreens or something like that. So those are some of the things that we've been doing for our businesses. And we do that across our states. Yep.
And
that
has your
includes,
business
minority and in the LGBT community as well.
And has your business provided any type of scholarships or specific training to individuals in order to be placed in those higher positions?
So we have not done scholarships for getting folks to go through pharmacy school. We have trained and brought employees to go from front desk staff to dispensary technicians. Actually, every one of our initial front desk staff from when we opened a year and a half ago has trained to become a dispensary technician and getting that licensure. So we've absolutely done that. Yes.
Okay. And the only reason I'm inquiring is because I couldn't help that a lot of your testimony had to do with these new dispensaries and how much we can do for the minority community. And I thought it was important to know what you're doing currently right now with the abilities that you have with the medical dispensaries that we have in the state of Connecticut. So
Sure,
I appreciate your honest responses. Thank you, Mr. Chairman.
I think that's a great point. And in our sort of levels and it's more written out, we talk about community specific having hiring goals. I know there's constitutionality, but we think it's important as well as the ownership. So we want to hit that from all 3 levels, hopefully within the bill.
And how long have you had your businesses in Connecticut?
So we won the license in December of 2018. We opened in Willimantic in June of 2019. We opened in Newington in September, I believe, of 2019. And then we just acquired the one in Mansfield on February 2nd. So that one's pretty darn new.
Okay, so it's been a few years, and certainly as you indicated, those goals are laudable, but unless they're reached, they're just goals. But thank you for your testimony.
Thank you.
Thank you, Representative. Representative Fishbein.
Thank you, Mr. Chairman. Good evening, sir. You just mentioned you won the license. Just generally, what was that process like in comparison to what's before us?
Sure. So in April of 2018, the State Department of Consumer Protection put out a competitive RFP process, request for proposal. I believe there were 73 applicants for those dispensary licenses. At the time, they didn't note how many there would be. And then in December of 2018, 9 licenses across the state were awarded to go from 9 to 18 dispensaries in the state. Within that RFP process, it was, our license applications we actually put in 4, were 700 pages long. Security plans, security diagrams, local zoning, operational plans, how we would track the product within the store, how we would partner with the local community, a ton of elements about how we would run our business, as well as the background of our teams to represent that we were capable of doing so. In this bill, they discuss not so much the specifics of how it would run, but ultimately a lottery system, which there would be applications getting, how I believe, to a certain threshold. And then the lottery would sort of be done based on those who hit the threshold, versus what I think is right, a scoring system that rewards the best applicants based on a criteria, hopefully run by a group or a scoring system that was non-biased, is how we would generally hope that it would be seen and done.
So you're here advocating for the process that's in this bill or the process that you had to follow?
I think it was more similar to the process that we had to follow, but we think with a initial focus on the next set of licenses being for what the commission defines as social equity applicants. I think the term equity is said a lot, but I'm still not 100% sure how that is defined. And I would believe that that commission would create really strong definitions around that. But I do think that those who are defined as those applicants should be the next group licensed to have an opportunity and a leg up to be in this industry with capital towards them. And then a similar situation for an open capitalism application for anyone who applies.
Yeah, I'm just trying to figure out, so your process that you had to follow, everybody was equal.
Correct.
But the process under this bill, people are unequal.
I'm not exactly sure what you're asking.
Well, have you read the bill?
Yes.
Okay, so at line 560,
okay,
it says that there's going to be the providing for an expedited or priority license processing for each class of license established pursuant to this act for equity applicants.
Mm-hmm.
So that means non-equity applicants, whatever that is, because
yep, sure, non-equity applicants would be after. We agree with that. We think that it should be specific on it within the type of licenses, how many licenses, and what the timelines around those are.
Okay,
and then
so
it shouldn't go to, and then within each sort of grouping, we think it should be ranked and scored within the specific groupings versus a lottery within the groupings.
okay, but before we get to the lottery, we have expedited and priority licensing.
Yep.
We have two classes, the way I read this. We have equity applicants and non-equity applicants, I guess, right? Yep. Equity applicants are not at the same level as non-equity applicants under this language. Okay.
Yes.
So
and
that would be a different process than what you went through, because based upon your testimony, all of the applicants were at the same, they were all equal. They were merited based upon their application, not some other factor, correct?
Correct.
So why, it seems like, equity for thee, but not for me. Why is it appropriate? Why do you think that this process is better than the process that you went through?
Sure, because I think that there has been a lot of history around drugs and the harm done on communities and the harm done on specifically minorities in this country. And that this is an industry that I am not blind to understand that I am a white guy who is in it. And that my community where I grew up has not been hurt as much as others. And so to give an opportunity, this is my view and our view as a company, that to give that opportunity to a group of folks who have been knocked down to then create a playing field that allows them to have a better opportunity is the right thing to do as we look at legalization. We believe that. And I was not a process of how the last applications were scored and done. Maybe this would have hurt us as a business at that time. However, we think this is the right way to move towards legalization. Yes.
Okay. Within your industry, I don't see it within the bill. So I don't know, maybe you saw it, you know, with a bar, when alcohol is consumed and somebody leaves the establishment and gets into a car accident, there's a dram shop. The bar can be sued.
Mhm.
Is there something similar here in this bill or under the medical marijuana provisions? I mean, can you be sued if somebody consumes your product after they leave your establishment and they get into a motor vehicle accident?
Well, so I think there are pieces in this bill around driving. There are also not social consumption lounges allowed in this bill, so there wouldn't be a place where folks can consume. I don't know the specifics of what would be in the bill of where liability would lie if something happened to someone who had partaken in a product that we sold. We also don't produce our own products, so I don't know where the specifics of the legality would be. We're not vertically integrated. A number are in this state. So I'm not exactly sure how that would work. And we do not allow any consumption on site. We don't allow consumption in the parking lot, anything of that nature.
Okay, so you're not aware if somebody's, you know, smokes on their way home, that there's liability for you as the deliverer of that product?
I'm not exactly sure, no.
Okay, all right, that's all I have. Thank you, Mr. Chairman.
Thank you, Representative Fishbein. Is there a question or comment from other members of the committee? Seeing none, thank you very much for joining us.
Representative Tom.
Enjoy the rest of your evening and your little kid. All right.
Thank you.
We will next hear from Hugh Blumenfield. Are you there?
Hi. Can you hear me?
I do hear you and we see you. Good evening. You have 3 minutes.
Good evening to the committee. It's been a very long day for you all. Yeah, my name is Hugh Blumenfeld. I'm a family physician and I've practiced in Hartford for the past 10 years. I'm also a member of the group that's called Doctors for Cannabis Regulation. It's a national group of physicians and other healthcare providers, but it includes among its leadership, Dr. Wesley Clark, the former director of the Center for Substance Abuse Treatment at the Department of Health and Human Services, and Dr. Jocelyn Elders, who is a former U.S. Surgeon General. You've heard a lot of testimony this evening about the legal and commercial aspects of the legislation. I figured I should speak more about the medical aspects and the impact of marijuana legislation on the lives of my patients. As a family physician, I'm charged with guarding the health and well-being of individual patients, but also the community at large. I not only prescribe medications, but I provide vaccinations and screenings that promote public health and participate in programs that promote literacy, improve the availability of healthy foods, and reduce gun violence. So why would I want to legalize what is widely perceived as a dangerous drug? Well, I don't presume to speak for any doctors other than myself, but I would like to explain some reasons why supporting the legalization of cannabis makes sense to so many of us. First of all, and again, you've heard so much testimony today, I don't want to repeat too much, but from my perspective, cannabis is far less dangerous than alcohol and tobacco, both of which are legal. Together, those two drugs kill over 500,000 Americans a year. As far as I know, the numbers of people that are killed by cannabis, depending on how you count, runs in the triple digits at most. And it's virtually impossible to overdose on cannabis. You know, again, we're talking about use of these drugs among adults. I personally don't use cannabis, and I never advise anybody to use any drugs recreationally. I think drugs and medications are a gift from nature and from technology and really to be respected. But there's a lot of legitimate reasons for adults to use marijuana. And if these other drugs are legal, then certainly cannabis should have at least the same status. Cannabis, unlike alcohol and tobacco, actually has a long history of use medicinally. The use of cannabis medicinally goes back over 4,000 years. And as recently as 1942, it was listed in the US Pharmacopoeia that doctors used as a list of medications that were valuable for them to use. And if anything, the evidence for its therapeutic uses has only increased since then as we understand more and more about the endocannabinoid system in humans. The second thing is that prohibition of cannabis has just simply not worked. It's the legislation to limit cannabis use legally started in the early part of this century. There was the Marijuana Tax Act of 1937, which taxed doctors who actually prescribed it for their patients. And then in 1970, it was scheduled as a Schedule I drug. Again, Schedule I is supposed to be for drugs that have no medicinal value, and yet there's copious evidence of the fact that that's not true. So I know that a number of legislators earlier expressed concerns that they were going to be going against federal legislation by endorsing this kind of legislation. But really, the federal legislation that classifies it the way it is, I don't think really stands up. And finally, the use of making cannabis illegal really affects the people trying to use it medically.
I would just alert you, you're 3 minutes up, so if you could summarize.
Right. So for many reasons, and especially for patients who need to use it medically, the fact that it's illegal for the rest of the population puts a stigma on it, makes it much harder to get. And the illegal supply of marijuana is so dangerous that a lot of patients who would benefit from its more casual use, it's too dangerous for them to use.
Thank you very, very much for joining us. Representative O'Day.
Thank you very much, Mr. Chairman. And Doctor, thank you very much for your testimony. I do greatly appreciate it and giving me another perspective from a physician on the benefits of it. I apologize, I'm driving, but I'm careful. My eyes are on the road. I'm using hands-free. So, Doctor, what type of doctor are you and where do you work?
I'm a family physician and I work in Hartford, in downtown Hartford, as part of a larger practice. By the way, as a family physician, I see patients inpatient at the hospital. I'm a hospitalist. I have my own panel of patients outpatient. I do deliveries. I do obstetrics. I'm a medical director of a hospice program locally. And I also, part of my work is in pain management and pediatric care. So my practice spans the gamut.
Thank you, Doctor. I'm the son of a surgeon, and so you have my utmost respect and appreciation for your service. When you say that the marijuana has been used medically for thousands of years, would you agree with the other doctors that have testified that the marijuana today is not our grandmothers, grandfathers, or the Native Americans' marijuana? Is that fair to say?
That's very fair to say. And to my mind, it's one of the reasons why it would be much safer for people if it was regulated.
And have you followed what's going on in Colorado with regard to the THC and the issues with the high concentration rates, because they're unregulated with regard to THC rates?
The actual rate may be unregulated in terms, there may not be limits on it, but what's in any given cannabis product is highly regulated in terms of the content has to be specified on the package. So you know exactly what you're getting. The THC and CBD ratios are given on the labels. The product has no pesticides, herbicides, or toxins in it that could be damaging to people's health, and they have no. They're not adulterated with cocaine and PCP and fentanyl like many of the samples of marijuana around here are. So I understand your concern that the stuff around is very potent, but again, it's not stopping people from using it. It's not stopping teens from having availability of it. And I think that the best way of protecting everybody is to make sure that whatever's in it is well known, so it can be used with education.
Fair enough. And my concern is teen use increasing with legalization. I really don't have much of a concern, frankly, as somewhat of a Republican/libertarian when it comes to, certainly when it comes to this subject. My concern is teen use. So would you disagree with my understanding, and I know there's some disagreement, but do you believe that legalization leads to increased teen use if not properly educated or prevented, like kind of tobacco?
Well, I think the second half of what you said is exactly the point. Without rolling this out in the proper way, there could be some adverse effects. But I think if you look at the idea of rolling out regulation and legalization of cannabis products that are only for adults, that can only be gotten through registered dispensaries and stores, you'll find that teen use actually, again, the evidence is, I've seen evidence of both sides, and that fact makes me think that it's probably somewhere in the middle. But with the right rollout, you can actually decrease the use among teens. We've seen that with alcohol. We've seen that with cigarettes. We make it much more difficult for people to get these products, and also you stop teens from getting it from drug dealers. And if a teen's going to get it, they're going to figure out a way to get it. We're going to make it as highly regulated and difficult as possible. But right now, people are going to illegal venues to get it, and the same people that are selling marijuana are selling PCP, and they're selling fentanyl, and they're selling things that are laced with these things. I think generally, I myself have teens as well, and I'm very, very concerned about the quality of whatever is out there that they might get their hands on.
So, Doctor, would you be surprised, and I know there's arguments on both sides, would you be surprised that actually the black market, studies that show that the black market has actually increased in Colorado upon legalization, not decreased, because teens obviously can't buy it at the state stores or where they're licensed. Mm-hmm. They have to go to the black market to buy it, and there's actually been an increase in the black market. Have you heard any of that, or does that concern you at all?
I don't have any information about that. I'm concerned about the safety of the people who. I'm concerned with education, and again, my one issue with the bill as it stands now is I would like for there to be a stipulation that a certain amount of the tax revenue from the cannabis products goes to education, goes to rehabilitation services, and goes to support behavioral health generally. I think with the proper education, again, you can reduce teenage use. Obviously, we're all worried about what teens are able to get their hands on, and I don't know that the legalization of cannabis products in those states directly is leading to an increase in the black market. Certainly, the black market is going to exist for them, but the idea that they could get their hands on stuff that more easily on products that's regulated just makes more sense to me. Look, 80 to 90% of teens at this point say that you have easy access to marijuana if they want it. And nothing has changed in the last 50 years since the 1970 when it was scheduled like that.
So, well, Doctor, look, I appreciate very much your testimony, and it does give me some comfort that a doctor at least has some is pro legalization, and maybe I'm hopefully I'm wrong in my belief that if we legalize it and kids see their parents smoking and using marijuana, they're going to think it's okay, and that's how I foresee teen use increasing. But hopefully, if this bill does go forward and they listen to you and more money is spent on education and prevention for youth use, I'll be proven wrong if this bill passes. And Doctor, I do truly appreciate your testimony here tonight, and thank you very much. And Mr. Chairman, I did pull over for the record, put my blinkers on, and I'm going to go get back home, but I'm going to continue listening for the rest of the night. Thank you, Doctor, very much.
Thank you. I just want to say that my kids watch me drinking wine and some alcohol products, occasionally, all the time, and what it shows them is that it's okay, but it's also done in a responsible manner. Alcohol. In my experience as a doctor, there's nothing worse than end-stage liver disease from alcohol poisoning, and there's nothing more scary than alcohol withdrawal syndrome and trying to treat that in patients. These are two of the most deadly things that I've seen.
Thank you, Doctor.
Thank you, Representative O'Day, and we heard your signal, so we know what you say is accurate. Representative Palm.
You're on mute.
Representative, you're on mute.
Hi, I'm sorry. Doctor, good evening. Your testimony is fascinating to me, and I think you're probably an outlier in some ways among your profession. Would you say that you consider this substance to have the sort of mix of salubrious effects and deleterious that so many pharmaceutical, like antibiotics, which if they're given indiscriminately can, cause gut flora to get out of whack and whatnot. Do you see legalization of this substance as in that same realm where there are benefits to it, but if in the wrong hands or in the wrong doses can lead to harm?
Well, first of all, I don't think I'm an outlier in my profession. I was saying that this organization I'm part of includes some pretty high-powered people, and recent surveys show that a third of doctors believe it should be totally legal, and another third of doctors say it should at least be legal for medicinal purposes. But yeah, marijuana is a powerful drug. What's interesting about it therapeutically is that there's receptors for marijuana in the central nervous system, and there's a bunch of receptors for marijuana in the immune system. And these account for the fact that medicinally, marijuana is very useful for a lot of neurological conditions, like the ones that are legal under Connecticut law, things like Parkinson's disease or ALS or lupus. And then inflammatory diseases like lupus and Parkinson's disease. I have seen the benefits of marijuana in my practice. The Connecticut law is written so that whoever certifies a patient is supposed to have a bona fide relationship with them. And that was meant so that doctors who take care of patients and who know them should be the ones to certify them and say if it's appropriate. And so I took it upon myself that this means that I should, it's kind of my responsibility to do it if it's legal, because I don't want my patients to have to go spend $300 for a marijuana doc and then another $150 for their follow-up appointment just to follow the letter of the law, not the spirit. The fact that it's so powerful is I think one of the reasons why I'm called on to try to help people use it responsibly. Right now, people are using it, hodgepodge. The patients that want to use it medically, I can help them use it, but there's a whole slew of people that use it, I would say medicinally. They use it for relaxation. They use it for sleep. They use it for, chronic pains. And they're the ones that have no access to safe marijuana. And marijuana, when used responsibly, I think is much safer than opiates. It's much safer than NSAIDs like ibuprofen. A number of other people have mentioned how ibuprofen causes a lot of kidney disease. And I've seen it here. I've seen it in the hospital care. People come in with renal failure all the time, and it's because they use NSAIDs. And then Tylenol, one of the most commonly overdosed drugs is Tylenol, and leads to liver failure. Again, all these drugs I think need to be respected. But the more
thank you. And thank you. And by the way, I wasn't in saying an outlier. That wasn't a trick question. I was just trying to say that, we've heard from some medical folks who have been opposed. And it's refreshing to hear to me from a doctor who has the full, an understanding of the panoply of substances. And I also appreciated what you said about alcohol disease. I have a lot of alcoholism in my family, and I've seen the devastation, and I appreciate your bringing that up, because I do think there is a certain level of denial about this other substance that we accept so readily and regulate, and in which many of us imbibe, but we don't really want to talk about drunk driving or liver disease or the devastation that can bring, including mental disorders. So thank you for bringing that up, and that was really all I wanted to say. Appreciate it. Thank you, Mr. Chair.
Thank you, Representative. Representative Fishbein.
Thank you, Mr. Chairman. Good evening, sir. You were just talking about other individuals that are not eligible for medical marijuana that you would see having a benefit medically from this product. Is that fair to say? You gave the example of going to sleep.
Yeah, no, I just have to be careful, because there's some things that there's medical evidence that marijuana is very good for. But there's a broad number of people who, whether there's evidence or not, they use it and they say that they have benefit. Now, there may be medications that would do things just as well and possibly safer. And I often will counsel people, and even in the cases where I do certify people for medical marijuana for totally legitimate and medically proven cases, I try to make it. I make a point of making it part of a larger medical management of their condition, and not just you can depend on marijuana for curing this condition. But whether we like it or not, people are using it that way, and I just think it's anecdotally they say they get a lot of relief.
Yeah, no, understood. You know, I get frustrated with the people are doing it anyway, so we're just going to legalize it because, you know, people are doing cocaine too. I mean, I haven't heard anybody advocating for legalization of that, but
I think they just did that in Washington State, didn't they? Or Oregon?
we're here in Connecticut.
Yeah.
So a different issue and perhaps for a different day. But if that's what you see as a benefit, then why not just advocate for an expansion of the medical marijuana program to those individuals? Why, as a professional, do you see going to the nth here?
Well, for two reasons. Like I said, one reason is that people use marijuana for all kinds of reasons, for relaxation, for socialization, for the same reasons they use alcohol. And you know, it's not necessarily medicinal, but it's in some ways therapeutic. You know, whether we keep it illegal or not, people are going to continue to do that, and it's, you know, part of it's cultural and part of it's just societal. It's where we are. But the fact that people can relax with alcohol, which is so deadly, but can't relax with marijuana, just doesn't make sense to me as a physician. Again, I take care of I take care of the effects of people smoking all the time. I take care of the effects of people doing alcohol all the time. Marijuana, if it's used in ways that don't make sense, it can cause serious side effects, but it doesn't kill people the way these other drugs do, and it doesn't cause social violence, and it doesn't cause car accidents at the same levels that these other drugs do.
When you care to characterize social violence, because certainly I'm aware of, you know, marijuana transactions that have gone bad, that have ended up in people dying.
Yeah.
So what social violence do you claim that marijuana is not part of?
Oh, so, you know, people who smoke don't generally get into fights, you know, bar fights, that kind of thing. People who smoke marijuana generally don't, it doesn't lead to domestic abuse in the ways that alcohol does. You know, people who smoke marijuana generally don't have those behaviors.
And the last thing was, are you able to prescribe marijuana?
No, I'm not. The way Connecticut law is set up for doctors is there's about, at this point, there's 30 conditions that are recognized as either proven or likely proven to be beneficial, to be benefited by the use of marijuana products, or cannabis products, I should say. And all I have to do as a physician is to certify that they have one of those conditions and therefore qualify to use cannabis products under the law. So in my practice, in almost all those conditions, at least until 2020, there was actual physical evidence for those conditions, things like Parkinson's disease, things like ALS, things like lupus, things that you could document. PTSD was one, for a while, was the one condition that you don't really have objective proof for, but it was advocated because I think a lot of veterans were advocating for the ability to use cannabis products for PTSD.
I'm sorry, I didn't want to.
Yeah, so just to sum up, I generally don't diagnose the patients and then certify them. I count on a professional in the field to give them a diagnosis. And then if they have the diagnosis, I certify them so that they can get a card from the Department of Consumer Protection.
So somebody else, some other doctor makes the determination that the individual would benefit from that product, and then they send them to you?
No, they make the determination that the patient has the condition that Connecticut law says your ability to do it, ability to use it. I kind of, with the patient, I try to make sure that marijuana would be appropriate for them. I've had some patients that I didn't think marijuana is appropriate for. And for instance, if I have a patient who's being seen by a psychiatrist or a neurologist, I always consult with that specialist before I certify them for the marijuana. My job is to see that they have the certifying condition and also make sure it's appropriate for them specifically.
But
in
your practice, someone else makes that determination whether or not they have the certifying condition.
Well, like I say, usually I recommend, almost all the conditions have objective evidence that go along with them.
Sure.
And for the couple that don't, I do rely on somebody else to make the diagnosis so that I'm not in the position of saying, oh yes, you have this disease, and oh yes, you can have a card.
Okay, and then isn't it true that you can't issue a prescription for marijuana because it's illegal under federal law.
Correct. Correct.
Okay, well, I just, because at the beginning of your presentation, you had said something that you didn't agree with the federal law or something like that. I didn't.
Oh, well, the federal law is really interesting because, you know, it started out as a tax on doctors who prescribe marijuana, cannabis products. And as I said, up until 1942, cannabis products were on the US pharmacopoeia of things that doctors could legitimately use for their patients. You know, it's not like cannabis has always been considered an illegal, very dangerous drug. You know, the dangers of its use, it's interesting that all this happened after. So after we had this whole debacle with prohibition of alcohol, it looks like the government may have just, you know, switched its attention to something else, a lot more marijuana. And maybe in response to prohibition of alcohol, more marijuana was coming up from the south of the border. That's when it started being called marijuana. It was in the 1930s. It was part of the campaign to make it illegal. Before that, everybody knew it as cannabis. Calling it marijuana, and one of the reasons I don't use that term is because it stigmatizes it and it gives it, you know, associates it frankly with, you know, people migrating from Mexico and from other parts of Latin America.
I'm just trying to link up what you said at the beginning with that you didn't understand that it was illegal under federal law, or you had referenced the discussion earlier. And I'm just trying to...
It seems like a lot of the representatives were nervous or concerned that by making marijuana, cannabis products legal, that they would be going against federal law. And the federal law from 1970 scheduled marijuana and cannabis as Schedule I substances, when in fact they're really not, because it's always been acknowledged that they have medicinal use. So that's a part of the federal law that I think.
Under what? Because I checked as of last night, marijuana is on Schedule I of the controlled substance schedule. So you're saying that it's not?
No, I'm saying that I'm not sure that it should be.
Well, that's a different issue.
Well, but that's what I was trying to say.
But that's not an issue.
But the definition of Schedule I is supposed to be, you know, drugs that have no accepted medicinal use. And that's never really been true about marijuana.
No, well, evidently our legislators in Congress, I guess, think so, because I mean, we've got representatives in Connecticut, we've got 2 senators, we've got 5 Congress people. I don't think any of them have put in a bill to make this legal under federal law, so, or to take it off of Schedule I. And while I may agree with you, it's still illegal under federal law. So anyway, okay. Yeah. Thank you, Mr. Chairman.
Thank you, Representative. Other comments or questions from other members of the committee? Seeing none, thank you very much for spending a portion of your evening with us. Hope you have a good rest of the evening. I'm sorry? Thank you. We will next hear from Duncan Markovich. Duncan, are you here?
Yes, I'm here.
All right, you have 3 minutes.
All right. Good evening, and I would like to deeply thank everyone for the opportunity to speak on this topic. My name is Duncan Markovich, a Brantford native and current resident, and I'm representing myself and my local cannabis therapeutics company, Better Ways LLC, with these following statements in reference to not supporting SB 888 in any capacity whatsoever as it currently stands. I feel that this bill significantly falls short of what is necessary in order to implement a successful legalization plan. I feel the essential foci of any state bill regarding adult use marijuana consumption must at the very least include a regulatory framework around granting all related licenses equitably to proactively prevent any kind of early monopolization, the creation of a sustainable and forward-thinking environment for industry growth, space to allow for state-backed university research and industry collaboration, but most importantly, the empowerment of all people from all walks of life, regardless of color, creed, or background, to have the same equal and equitable representation and opportunities within this emerging industry. The state's fiduciary responsibility
and public transparency of all tax monies collected from cannabis sales and how they're used ideally towards community reinvestment, such as safe cannabis use education and law enforcement re-education and ancillary public safety training, the long overdue examination and steadfast rectification of the damages done to our communities, and specifically communities of color by the war on drugs. And lastly, and probably most importantly, the paramount rights for all adults over the age of 21 to grow their own plant-based medicines, just as anyone over the age of 21 is allowed to brew their own beer. I wholeheartedly feel to my core that this emerging industry and the cannabis plant itself has the innate ability to unify communities through education and much needed healing. After having survived my 4th open heart surgery in 2010, and subsequently having endured an unnecessary exposure to opiates to the degree which I was overdosed twice in the hospital, I found that the use of cannabis was fundamentally superior therapeutically than any prescription pharmaceuticals that were recommended by doctors. Having sound information and access to safe and effective cannabis alternatives is why I founded my company Better Ways in January 2019, after the Farm Bill Act was amended in 2018. Since then, I have helped many people in my community near and far through education and advocacy of daily use of cannabis, but I continue to uncover problems. The 2 major issues I've found in the retail sector is the fear of cannabis-related drug testing by employers and the need for health insurance companies to be able to be billed for these products, as with any other medication for those on fixed incomes.
Mr. Markovich, if you could summarize.
We all must have a place at the table for respectful dialogue and collaborative integration if we are going to successfully move forward with this amazing new industry. This is our watershed and we must act now. I am committed to doing my part in this narrative to help all of those in our community and those with decision-making powers become as educated and acclimated in this field in order to ensure that informed and fact-based decisions are being made, not ones based in fear, greed, ignorance, or apathy. Thank you for your time.
Thank you, Mr. Markovich. Representative Davidsky.
Thank you, Mr. Chairman. And thank you for coming in to testify today. As we have been here during the day, we've had a number of people from the existing cannabis community come in and testify. I'm thinking the overwhelming majority, if not all, have not liked this bill for one reason or another, as just like you. And I'd ask you, obviously you're in favor of some type of legalization, but not this bill. So my question to you is, would you rather see nothing pass as opposed to having this bill pass?
I think that creates a perspective of disparity. I think that this bill has the opportunity to be amended and include the many things that still need to be a part of it. But I think we are all equally as frustrated with this process, that this has just gone on too long. And I don't feel comfortable saying I'd rather kill this bill and not have anything happen. But we can do better. We absolutely can do better. Other states are doing better. They have implementation in place. They're leading by example. And it just, for those of us in the community that are not comfortable with SB 8888, I think we all just need to get back to a more open level of discussion and transparency on all capacities, and those involved drafting this.
Okay, well, with regard to your frustration, all I can say is welcome to the legislature. But with regard to, so you know, without trying to impose the position of spokesperson for all the cannabis community. I guess my interpretation of what you just said is that you'd rather see this pass and try to fix it later than to see nothing pass. Is that right?
No, what I'm saying is I would rather see it fixed first.
I understand
and
that,
then
but
pass.
assuming it's not going to get fixed.
Well, if then given the ultimatum, then no, I don't want this passed at all.
Okay, so you'd rather, if this is the bill without the things that you just mentioned, you'd rather wait till next year and try to get something else through. Tell me why you would rather wait to get a good bill than to have this bill passed now.
Because I'd rather lead by example in this industry than fake it.
Okay. Do you have any fears that if this bill passed as it is, that the larger companies and out-of-state companies would essentially corner the market early on?
I don't have that fear. That's an observation of what's occurring, and it's. I think it would be reckless to assume that wouldn't happen with the language of this bill.
Because we've heard other testimony from people who were concerned that that was going to be the case. So I was just, wondering if that was one of your fears, because certainly it's the fear of other people in the community.
I think most, if not all of us that are opposed to this bill are still waiting to have a much more diverse and dynamic conversation about what defines equity and how everybody that is currently involved in this industry or interested in entering this industry should have an equal place at the table in conversation. And it shouldn't be based on the fact that I have access to more capital resources than somebody else. Why should somebody who ran a dispensary out of state, who's now a Connecticut resident and knows how to give quality products and quality education to the community, why should they not be allowed an equal place as somebody who's, a corporate investor who knows very little about this industry?
Right. Now, have you reviewed the fee structure with regard to licensing in this bill?
I have.
Okay. What's your feeling about it?
I think you're simply costing out individuals who could do just as good a job, if not better, just because they don't have access to certain thresholds of capital. It's, as I think the term earlier said today, was pay to play.
Okay. Now, we were told by the governor's representatives that the structure of this bill is not designed as an income generator. Is that your feeling about the bill?
That my feeling that the bill is set up as an income generator? Is that what you're asking?
They said that it was not.
It seems to be geared towards that. And again, as esoteric as this might sound, but this has been a telos of my life and has been documented well throughout many books of literature. If you focus on making money, you'll never make enough. If you focus on making meaning, the laws of the universe will tend to take care of itself.
Okay, well, I guess I will leave you at that answer. And thank you for your time, and thank you, Mr. Chairman.
Thank you, Representative Dubitsky. Are there other comments or questions? I do not see any. So thank you, Mr. Markovich, for joining us this evening. I hope you have a good evening.
You as well. Thank you very much for your time and opportunity.
Next, we'll hear from Maria Cahill. Is Maria on? I see you. You have 3 minutes.
Hi, Mr. Chairman. Thank you for taking our testimony today. I am here with two of my colleagues from Abbott, Aaron Holmes and Fred Delfino. If they could also be activated into the meeting, that would be great. My name is Maria Cahill. I work in government affairs for Abbott Laboratories. Again, thank you for allowing us to testify before you today. As the state embarks on their pathway to legalization of recreational use of cannabis, we understand that one of the priorities of the governor's bill is to protect public safety. So today or this evening, we're here to speak to public safety on the roadways and the issue of impaired driving. One of the things that Connecticut may learn from other states who have already gone through the legalization process is to increase access to public safety tools that are utilized by law enforcement. This includes officer training in the form of DRE training and A-RIDE, but should also include the allowance of testing for the presence of THC and 5 other commonly used drugs via oral fluid testing at the roadside. As I mentioned, I have colleagues today with me from Abbott. Aaron Holmes is our Director of Global Road Safety, and Fred Delfino is the North American Product Manager for Sotoxa, which is our oral fluid testing device. Aaron will speak to the underlying data, which shows the prevalence of drug driving in states which have passed legislation to legalize recreational use. And then Fred can answer any questions the committee may have about the technology. Aaron?
Hello, can everybody hear me? Wonderful. Yes. Okay. Thank you. Good evening, everyone. As Connecticut considers the legalization of cannabis, the legislature has an opportunity to consider the potential impaired driving implications of this policy, as well as how to adequately prepare. To save lives, we encourage you to authorize the use of oral fluid screening, which is reliable and accurate technology that can aid law enforcement officers in impaired driving investigations. Drug-impaired driving poses a critical threat on our roadways. Numerous studies paint an alarming picture of a growing problem. In 2013-2014, NHTSA administered the National Roadside Survey, which found that roughly 22% of drivers tested positive for impairing drug, cannabis being the most commonly detected substance. CDC data from 2018 found that 12 million people reported driving under the influence of cannabis in the past year. And analysis of data from Washington State, which of course is one of the first states to legalize recreational cannabis, showed that the percentage of drivers involved in fatal crashes who tested positive for cannabis doubled since legalization was enacted. 1 in 5 drivers involved in fatal crashes in that state in 2017 tested positive for THC. And even during the pandemic, the prevalence of drugs detected in seriously and fatally injured drivers has increased significantly, with 65% of those drivers testing positive for drugs, according to a new NHTSA study. It's obviously a serious problem, and we need solutions. Testing is one of those solutions. As Maria mentioned initially, oral fluid screening devices such as Sotoxa offer many advantages. These devices are quick, easy to use, minimally invasive. They capture recent versus historical drug use. They can be collected proximate to the time of driving, and they also have the ability to create general deterrence amongst the public. Those results are not admitted as evidence in court. A secondary confirmation sample, which is typically blood, is collected, and that's what is submitted to a laboratory for confirmation testing. The screening results, however, provide officers with information in real time to support their observations of impairment in the field. It is that combination of the officer's observations of signs and symptoms of impairment, along with a positive oral fluid test result, that can help establish probable cause for a DUI arrest. It also signals to that officer to call in a drug recognition expert to do a drug evaluation, and also to get a warrant to get a blood draw as quickly as possible. The deployment of oral fluid screening devices can assist law enforcement in identifying a larger number of drug-impaired drivers on the roadways.
Ms. Holmes, we've reached the 3-minute mark, so
sure.
I need you to summarize your testimony.
Great, thank you.
All right.
We welcome any questions that you may have with respect to programs that are already in place. There are a number of examples here in the United States, Michigan and Indiana being some of them. And Fred can certainly answer more questions with respect to the technology and how this can be utilized to save lives in Connecticut and elsewhere.
Great. We're gonna jump into the questions here for the Abbott team. I think Senator Champagne has some questions for you.
Thank you. I had some questions about your oral fluid test. The test, does it give you a level of THC?
So this is Fred Delfino, the product manager for North America for the device. The testing does not report out a negative. It's a preliminary screen. It gives a qualitative versus a semi-quantitative result. A positive or negative is displayed for each one of the drug classes that the instrument will test for, which there's 6 of those. And it's based on the cutoff value that is set for that specific drug. More specifically, the concern here is marijuana. It's set at 25 nanograms of oral fluid. It's not a one-to-one correlation to blood.
Okay, you said 6. What are all 6? You got marijuana.
Amphetamines, methamphetamines, THC, benzodiazepines, opiates, and cocaine.
Okay. And obviously this is just for probable cause.
Correct.
So it can't be used. And what is the cost of like per unit?
It's really
Is it
dependent.
reusable?
Yeah, so it really depends on volumes and purchases. List pricing is in the $4,500 range for the instrument. And then the testing price range at around $25 is the list price. But the real advantage allowing oral fluid is you're giving your law enforcement the opportunity to get that data, as Aaron said, closest proximity to stop. That blood is still a gold standard, right? We're not saying it replaces the blood. What's happening is the delays in blood, collecting the blood, the THC is dissipating within 90 minutes after use. Now, when we pull them over, obviously they've used prior to that. So it's more supportive in a case to be able to get the oral fluid sample reflecting the most recent drug use.
Mm-hmm. Okay. And obviously it's just probable cause, but the DRE, if done correctly, is basically going to be the conviction tool.
Yes.
All right. That's the only question.
Thank you. We call it a tandem process. You have the DRE's evaluation, which is a 11th step, the 12th being a toxicology drug test. So this really is that toxicology screen that supports this finding. So now we move forward with the impairment based on what the DRE sees. The instrument does not say you're impaired. It says this drug is here, which in THC case reflects most recent use.
Okay. Thank you.
You're welcome.
Representative Fiorello.
Thank you, Mr. Chairman. I'm looking for your testimony in our system and I don't see it, Mr. Delfino. Can you guys make sure that you send in your testimony with the statistics on drugged driving that you have in the states that have this, and also information about your device?
Most certainly.
Yes, we will include that, Representative. I'm sorry we didn't have the chance to get it out to everybody prior to the hearing.
Oh, super, thank you.
Sure.
Further questions from the committee? Seeing none, I'd like to thank you all for being with us tonight.
Thank you.
Next up, I believe we have Amy Parmenter. Ma'am, you're muted.
Thank you. Can you hear me?
Can now.
Okay, great. Thank you. Good evening, co-chairs, vice chairs, ranking members, and members of the Judiciary Committee. My name is Amy Parmenter. As Manager of Public and Government Affairs for the AAA Allied Group, I offer this testimony on behalf of both AAA clubs in Connecticut, the AAA Allied Group and AAA Northeast. Together, both clubs represent more than 1 million members across Connecticut, and both are also longstanding members of Connecticut's statewide impaired driving task force. As a matter of national policy, AAA opposes the legalization of recreational cannabis strictly as it relates to drug-impaired driving, which, as you just heard, is already a major traffic safety issue in Connecticut and nationwide. Sorry, That said, we acknowledge and appreciate the efforts of our lawmakers to address traffic safety concerns in this legislation. And in fact, there's much about this bill that aligns with AAA policy relevant to drug impaired driving, which we've detailed in our written testimony. We've also provided additional recommendations, such as the training of all officers in A-RIDE, that AAA believes would go a long way to addressing the drug impaired driving issues that already exist on Connecticut roadways. Still, there are significant traffic safety concerns that cannot be remedied through legislation, despite the best of intentions and dedicated dollars. I'll name just two. First, the unique enforcement challenges in terms of marijuana and driving. You've heard a lot today about the vital need for DRE officers. Connecticut has only 64 DREs at this time. That number is expected to diminish in the coming months. That's compared to more than 500 DREs in New Jersey, where marijuana has just been legalized. Despite the best efforts of our DOT, the agency has been increasingly challenged to grow the numbers of trained DREs, not just because there's not enough money for training, but because there are not enough officers who are willing, qualified applicants. And the second challenge is lack of public education around the dangers of marijuana and driving. As a result, many people think it's safe to drive after using cannabis. A recent study indicates that almost half of all cannabis users think it's okay to drive under the influence of marijuana, and AAA research found that more than 70% of Americans don't think a driver would be caught by police for driving under the influence of marijuana. I think it's important to note that these two issues do not exist for alcohol. Police can determine roadside with a simple BAC test. There have been decades of public education. We all know friends don't let friends drive drunk. And yet, year after year, Connecticut is one of the top states for fatal crashes involving a drunk driver. We were even number one in 2017. So I offer this as a backdrop for you as you consider the legalization of recreational marijuana, which is, as you've heard today, much more challenging from a traffic safety perspective. In closing, AAA recognizes that the legalization of recreational cannabis is a complex issue. Our opposition is specifically related to the unique challenges associated with combating drug-impaired driving and the increased risk that legalization of marijuana would pose to all road users, especially given that at this time, fatal crashes are up and the use of cannabis by drivers involved in fatal crashes is up. Still, I underscore that AAA stands ready to work with our legislators to improve Connecticut's drug-impaired driving policies. We'd be happy to answer questions or provide any additional resources that would be helpful in your deliberations. Thanks so much for your time.
Thank you. Ms. Parmenter, what's the basis for your statement that there's not enough officers who are willing or qualified to be trained as DREs in the state of Connecticut?
Okay, so in order to be trained as a DRE, you would have to first be trained as an A-RIDE officer. So that's one of the limiting factors. And then apparently there are other limiting factors that I don't necessarily, that for whatever reason, law enforcement officers have decided not to apply for the program. And that's been a growing challenge for our DOT, that they can't fill the seats in the classrooms.
So the testimony from DOT this morning, I believe, was there's something like 950 to 1,000 air ride trained officers, and there's only 16 who are trained as DREs. And I thought the testimony this morning, or at least the questioning this morning, was that part of the reason for the gap is the additional cost and travel associated with becoming a DRE. But you're saying there's something beyond just cost, and so
exactly. So just to clarify there, the testimony this morning, that 13 or 16 number, that referred to the number of state police who are trained as DREs, but actually overall, the number of police trained as DREs, there are 64 right now. And the 950 number of A-RIDE, that's about 10% of all of our officers. That's one of the lowest number of trained A-RIDE officers compared to other states across the country. But yes, I am suggesting that there is another factor that just providing more money for the training will not resolve.
So I'm asking, what is that factor?
That police are not interested in signing up, unwilling at this time to sign up for this particular training.
And what are you basing that off of?
I wouldn't begin to speculate as to what the thinking is behind why for a time it was a popular program and now it's not.
So are you speculating there's not enough officers who are willing and qualified?
No, that's a fact that they have. The DOT has been trying to increase the number of drug recognition experts for several years now, pretty much as long as I've been kind of engaged with them. And it's been a challenge. We've had, I think a couple years ago, we had around 50. Now that number is up to 64. I think it's expected to diminish in the coming months because of reassignments and retirements. So it continues to be a challenge.
Senator Haskell.
Thank you very much, Mr. Chair, and thank you, ma'am, for your testimony tonight. I really appreciate some of the suggestions that AAA puts forward. I feel like in this building, they might be referred to as friendly amendments right there. They certainly don't undermine, I think, the spirit of the bill, but instead strengthen it. I'm particularly interested in the public education campaigns about the risk of cannabis impaired driving. So I have two questions for you this evening. One is, have you seen this done successfully in other states that have legalized cannabis? You mentioned that in at least one state, there were 33% of teens who thought that driving under the influence of cannabis was legally permissible. We certainly don't want that to be the case in Connecticut. What examples can we follow or avoid in terms of other states in this regard?
I'm not familiar with all of the public education campaigns that have been rolled out in other states, or if there have been public education campaigns rolled out in other states. Certainly AAA would be happy to contribute, do research and contribute to what public education campaigns could be most effective. I know we actually have research about how to affect behavioral change, which is very, very difficult, whether it's PSAs or whatever. But we do know, and alcohol would be a perfect example of that. I mean, we've had several decades of friends don't let friends drive drunk, and yet it's still a significant problem across the country and specifically here in Connecticut.
Yeah, I would argue, though, that those public education campaigns have been, they certainly haven't eradicated drunk driving, but they've been wildly successful among my generation, I think, which is less likely to drive under the influence of alcohol than my parents' or grandparents' generation.
Yes, we agree with that. And that's part of it, is that we need to catch up in terms of the marijuana impaired driving, because we know that many more people think that it's okay to get behind the wheel high than those who think it's okay to drive drunk.
Understood. I know that we have a lot of other people sign up to testify, so I'll move on to my second question, which is, I appreciate the fact that one element that AAA has cited as being a positive aspect of this bill is that the drug recognition expert testimony is admissible as evidence. I'm not sure if you've been listening all day, and it's admittedly been a long hearing, but the public defenders have requested what I find to be a reasonable amendment to the bill, which would just make sure that that drug recognition expert testimony is not automatically admissible, that there's still that sort of judicial gatekeeping that goes along with every other sort of expert testimony. I assume that isn't something to which AAA would object.
Yeah, that's actually, I was listening to that as well, and I reached out to our DMV right away to say, wait a minute, I'm hearing that there can't be any cross-examination or something. Is that actually true? And I was told that that was not accurate. So
you wouldn't, although it is important to make sure that that DRE testimony is admissible, it isn't mission critical in the perspective of AAA to make sure that it's automatically admissible, that it would still be subject to proper judicial questioning and gatekeeping.
Yeah, I think that what is wanted is that, and I don't know all the legal intricacies, but the way it was explained to me is that it would not have to go through a Porter-Dauber hearing in order to be admissible.
Understood. Well, thank you for your testimony. I could dig in more, but we've got other folks who probably want to ask questions. So thank you very much, ma'am. And thank you, Mr.
Okay.
Chair.
And if I can provide additional information offline or in some way, I'm happy to do so.
Thank you. Further questions from the committee? Seeing none, thank you for being with us.
Great. Thanks so much. Appreciate it.
Next up, we'll hear from Mark Spellman.
Good evening, members of the Judiciary Committee. I commend you on your stamina. I've been hanging in with you all afternoon. You're sharp as a tack still. I'm a psychologist. I represent the Connecticut Psychological Association. I'm also in private practice in New Fairfield. If Connecticut passes SB 888, we would advocate that it include a spirit of science-based harm reduction. Harm reduction is an approach to care that recognizes that we humans have a penchant for intoxicants and euphorics. And the goal is to reduce as much as possible that the harm that their use causes. I'll give you 4 examples. There would be many. This isn't comprehensive. The first would be schizophrenia. If you have a family history of schizophrenia, if you're at risk for schizophrenia and you're a heavy marijuana user, your risk of a first break is 6 times greater, 600%. And future psychotic episodes are equally likely to be much more severe for heavy marijuana users. We need public health messaging. We need counseling at dispensaries. Legalization would provide an avenue to provide those public health messages and counseling. Secondly, we're concerned about heavy use. Unquestionably, but there are risk factors involved in marijuana use, and they fall disproportionately in the heavy use group. The psychological risks, the physiological risks are disproportionately found in the heavy use group. We can counsel people about that. We can warn people about that. And yes, there's addiction, maybe not physical addiction for tolerance and withdrawal, but certainly many users find they can't stop when they want to. We need a hotline for if you can't stop when you want to, call us. Of course, we're concerned with how much more potent marijuana has become. And it seems from the research we see, seminars I've attended at APA, that as we bred up THC, we inadvertently bred down CBD. And it would seem that CBD buffers brain damage risk that THC poses. But we've not only made marijuana more potent, we've also taken out some of the buffering safety factors natural marijuana once had. I believe pharmacists at dispensaries could counsel on this. Public health information could counsel on this. And we urge that a harm reduction science-based policy be wrapped into implementation of this bill. Thank you.
Thank you, and well done on timing the 3 minutes. Questions from the committee? If not, appreciate your succinct testimony and to the point. Next up will be Carl Torella.
Good evening. Thank you for the opportunity to testify on Senate Bill 888. My name is Carl Torella, and I'm the general manager of Acreage Holdings, which operates 3 medical marijuana dispensaries in Connecticut: Prime Wellness in South Windsor, Thames Valley Relief in Uncasville, and Compassionate Care Center in Bethel. And my chief pharmacist is available in queue to answer any pharmacy questions you may have. In the interest of time, I won't read my entire testimony and will focus on the medical market. We will make ourselves available today or in the future to discuss all aspects of SB 888. We ask you to consider the following items that, in our opinion, improve the bill before you. Patient fees. Currently, patients pay hundreds of dollars annually in expenses and fees. This may not seem like a lot of money, but when monthly out-of-pocket prescription costs are factored in, annual fees can be a costly impediment to patients seeking care. Unlike proposals in recent years, SB 888 does not eliminate the annual fees for patients and caregivers. We ask that the legislature amend the bill to eliminate all patient fees. Taxes. Sticking with affordability, the bill as written has an excise tax that doesn't differentiate between cannabis grown for medical use or adult use, therefore significantly raising costs of prescriptions for patients. We recommend a simplified point of sale tax structure that not only keeps Connecticut competitive with states in the region and discourages purchases on the illicit market, but doesn't increase the cost of the medical marijuana prescriptions. Medication limits. Under this proposal, patients are allowed to purchase up to 5 ounces of medical cannabis for a 1-month prescription. However, on the retail side, customers may purchase up to 1 ounce of cannabis per day, every day. We request that you allow the prescribing physician to have the discretion as to what the appropriate prescription limits should be for their patients, instead of an arbitrary limit. Qualifying conditions. Currently, the Board of Physicians created by the DCP meets at least twice per year to consider adding qualifying conditions to be treated with medical cannabis. Under this bill, the language is changed to have the board meet, quote unquote, as necessary. We appreciate the time and the energy the Board of Physicians has been dedicating to Connecticut patients. However, similar to the medication limits above, we think it would be better to allow treating physicians to determine whether medical cannabis is best for their patients. They, more than anyone else, know their patients and can make decisions in a timely fashion, rather than patients having to wait months or even years for the board to make its decision on qualifying conditions. Thank you again for allowing me and my chief pharmacist to testify before you. We are happy to answer any questions you may have regarding these or other issues addressed in Senate Bill 888.
Thank you. Questions from the committee? Seeing none, appreciate you being with us.
Thank you.
Next up will be Thomas Burr.
Yes, good evening, Representative Stafford, Senator Winfield, and members of the Judiciary Committee. My name is Thomas Burr. I'm the Community and Affiliate Relations Manager of the Connecticut State Office of the National Alliance on Mental Illness, otherwise known as NAMI, Connecticut. And I am testifying today regarding SB 888. NAMI is dedicated to building better lives for those with lived experience with mental illness and their families. NAMI Connecticut and its 9 local affiliates provide support groups and education programs for people with mental health conditions and their loved ones, and advocates for policies to improve the lives of people affected by mental health conditions. You have my written testimony, and I want to echo the testimonies of Doctors D'Souza and Scheingold. We know that legalization will increase consumption of marijuana here in Connecticut. Marijuana addiction rates among teens in states that have legalized marijuana are 25% higher. We also know that approximately 5% of the population will have a very negative reaction to ingesting THC. In those with underlying psychosis-related conditions, such as schizophrenia and some types of bipolar and depressive disorders, marijuana may trigger a further episode of psychosis. This may land them in the ER and possibly inpatient psychiatric hospitalization. It may also trigger first episode psychosis. I have experienced this exact scenario with my son whenever he smoked marijuana. If you have never witnessed a loved one in psychosis, be thankful, for it is truly frightening. For millions of individuals with these and other psychiatric problems, research has now shown that marijuana will exacerbate symptoms and render their illnesses much harder to treat. Not surprisingly, there is a 2015 study that found, quote, overall evidence from epidemiological studies provides strong enough evidence to warrant a public health message that cannabis use can increase the risk of psychiatric disorders. Connecticut should have no illusions that the legalization of marijuana will have any fiscal upside. It will absolutely have a negative societal cost. In fact, for every dollar gained in tax revenue, Coloradans spend approximately $4.50 to mitigate the effects of legalization. Therefore, we would expect that a significant portion of the revenue realized by the state of Connecticut from the sale of marijuana should be applied to prevention education targeted towards middle and high school students, treatment for mental health and addiction concerns, and research into the effects of cannabis on the developing brain and society as a whole. You should also know that Illinois and Oregon have both allocated 20% of their marijuana tax revenue be set aside for mental health and substance use services. In summary, NAMI Connecticut and our members are opposed to the legalization of cannabis unless and until a significant share of any realized revenues are directed towards the appropriate budget line items for the inevitable uptick in people needing their services. Thank you for your time and attention. I will now gladly answer any questions you may have.
Thank you. Questions from the committee? Representative O'Day.
Sir, I just want to thank you for your testimony. I don't know if, can you hear me?
Yes, I can.
Okay, I just want to thank you for your testimony. Where did you get the $1 to $4.50
It's in my testimony, the reference. If I'll bring it back up here, I can tell you specifically. But it was definitely footnoted in my testimony. Let's see, that was number 4. That was, oh, for crying out loud, my computer's giving me fits. That was from the biological calpsychiatryjournal.com. It was an article in that
Okay.
publication, but it's in my testimony, so you can see the link for that.
All right, great. Thanks. As long as that's in your testimony, that's the main thing I wanted to hear. Thank you very much, sir, for your testimony and your time today. And thank you, Mr. Chairman.
Thank you, Representative Fiorello.
Thank you, Mr. Chairman. Mr. Burr, if there is, money allocated 20% or the example set by Illinois and Oregon, as long as there's money allocated toward the services that would be needed by mental illness patients, are you okay with the passage of this bill, the commercialization and of recreational marijuana?
Well, that's a great question. Honestly, I'd like to see that number a lot bigger because, as some of the other people have testified today, Connecticut is in a mental health tsunami right now. We were not in a good place pre-COVID, and what with COVID and all its fallout, all its trauma, we are in a really bad place now. And I hate to draw the parallels between what we're seeing in general in the mental health world versus revenues from just this bill. But certainly when we testify in front of the Appropriations Committee next week, we're going to be asking for a huge increase in money because, it may have been raining before, but it's a monsoon now in the mental health world. We're just drowning. The people that reach out to us now, it's unprecedented. We're running support groups online constantly ever since March. And I personally, do a support group for family members who have loved ones that are dealing with mental health concerns. And it's very common that I hear that, their son or daughter is abusing drugs and alcohol and they're just a mess and they need help and they don't know where to go. And there's, waiting, long periods of wait times in ERs. I've heard some kids are sometimes in the ER for literally days because there just aren't enough places for them to go for treatment.
So your organization is a national organization. Are you saying that Connecticut is unique in having this mental illness tsunami? And if yes, why is that? And is this COVID related only, or is it even before COVID?
Representative, I don't mean to cut you off, but we're getting at a late hour and there's a number of folks to testify. If you can tie this back to the bill before us, that's fine. But I just don't want to get us off on a tangent if we can avoid it.
No, I understand. Thank you, Mr. Chairman. I was thinking of Dr. Spellman, who testified, and now Mr. Burr. If there's a particular harm to those citizens who have mental illness, I just wanted to understand, do we have a lot of mental illness citizens to consider?
Yeah, Connecticut, like all the states, is, facing issues with not only COVID, but this, wave of legalization that's happening across the country. And it's a problem. I mean, I'm speaking strictly for the Connecticut chapter, but as a national organization, yeah, we hear it from some of the other states. They're also struggling with a huge uptick due to the legalization of cannabis in their states.
Okay. Just one more statement then. Is it fair to say, for those of you who are really aware of mental illness and all of its implications, that there is a wish among you activists to see this wave sweeping across the country be stopped in Connecticut? That we be the first state that really says no?
And again, another good question. See, the devil's always in the details. We all know that marijuana exists in a black market situation, and it's a big problem already. Legalizing it, I don't think solves that. What we're concerned about is it certainly has the unintended consequence of making it seem like it's okay. And we certainly don't want people going to jail for possession. We were very happy when it was decriminalized because people with mental health conditions and substance abuse problems, they need help, not handcuffs. No one gets better in jail. It's not a therapeutic environment. And it shouldn't be a crime to have an illness that somehow gets you tied up in the criminal justice system and adds just another big hill to climb. The mental health and substance abuse issues are hard enough to deal with on their own without throwing a criminal record on top of it.
Thank you.
So I think there's a better way to just approach all of this. And I hope that answers your question. It's not really a black and white yes or no as far as we're concerned, really. It's a lot more complicated than that.
Thank you, Mr. Chair.
Thank you. Further questions to the committee? Seeing none, Mr. Burr, thank you for being with us.
My pleasure.
Next up will be Tamika McPhail.
Hi.
Hey, ma'am. Go ahead. You have 3 minutes.
Hi, my name is Tamika McPhail. I am here. I'm a mother of 6, a lifelong Bridgeport resident. I'm the state director for Minorities for Medical Marijuana, and I'm also the state director for National Expungement Week. Minorities for Medical Marijuana serves as a leader and resource within the cannabis industry, providing advocacy, education, and cannabis legislation, research, training, outreach, health, and wellness within the cannabis community. National Expungement Week, we provide free access to expungement and pardon services. And I want to say, I applaud the governor's office for putting forward SB 888. And I also applaud the governor's office for being open to collaborating with people and hearing more about social equity and social justice. But I cannot support the bill as it stands because there's still too much criminalization for possession and grow. There's been a lot of testimony of cannabis being harmful and all these studies, and there's one study that refutes another study. The truth of the matter is we don't have enough studies to give us concrete answers. And so one thing that we would like to see is social equity business model be added to this bill. And that will include policy that supports providing technical assistance, business formation, licensing, and funding for minority and women-owned businesses, low-income business owners, and business owners who have come from communities most impacted by the war on drugs. Another aspect we would like to see is a social equity criminal justice business model. And that is policy that's written that restores and repairs communities. We would like to see automatic expungement and people not have to go through a lengthy process. We like to see a social equity community reinvestment model. And that's policy that is written that ensures that a portion of the tax revenue collected is reinvested in community programs, cannabis education, consumer protection, job creation, and social service programs for communities, again, that were most impacted by the war on drugs. We would like to see a social equity youth prevention model, and that will provide funds for all of these. I think everybody on here that's a parent or a human being, we don't want to see misuse of cannabis by the youth. And so we would like to see a model that adds youth cannabis education and prevention programs. We would also like to see a social equity public health and safety model, and that's policy and funding for community cannabis education and for maybe consumption lounges so people have a safe place to consume cannabis. We would like to see a social equity workforce development model. And that is where a portion of the tax revenue is going to be allocated for workforce development opportunities, education and training, and even career exploration within the cannabis industry.
Ma'am, you're a little over the 3-minute mark.
I have one more thing. The last thing we would like to see is a social equity supplier diversity economic development model. And that's a policy that promotes and measures diversity among all of the licensing applicants. I just want to say really quick that we in Connecticut are in a beautifully unique place. We don't have to, we can look at where other states got things wrong and we can do it right. We have the biggest wealth and education gap in this country, in Connecticut, here in Fairfield County, and we can right that. We can fix that.
Great. Well, thank you, ma'am. Appreciate it. Are there questions from the committee? Seeing none, appreciate you being with us, and thanks for zooming in from the great city of Bridgeport here. Next up will be Al D'Amica.
Yes, we were linked with Carl Torella, so I'm all set.
Oh, okay, great.
Thank you.
Then after that, I have Ulrich Boysen.
Good evening.
Good evening.
Thank you, Representative Staffstrom, members of the committee. My name is Ulrich Boysen, and I'm a senior analyst at the Tax Foundation. So we don't take a position on the bill, but I wanted to share some research on cannabis excise tax design, which is a subject that I have studied extensively. It's a crucial element of legalizing recreational cannabis, the excise tax design. And most states have done this by opting for a price-based ad valorem excise tax. This may seem like a simpler way to go, but it doesn't necessarily offer an equitable or long-term solution. While ad valorem taxes may look like general sales taxes, there are important differences. The reason we levy an excise tax is to target specific, unique characteristics of a product. It's often negative externalities. You can think of it like the harm that cigarette consumption does to the consumer or to anyone around them, or the fact that we tax motor fuel to pay for the roads. General sales taxes, they normally fall on most consumer transactions. So it's important to have a distinction there. Because this is why we levy an excise tax, it should also correspond to the harm that it's addressing, and in effect, internalize the cost. Neither of these things have anything to do with the price. So in SB 888, the tax would be $1.25 per dry weight gram, 50 cents per dry weight gram of trim, and 28 cents per gram of wet plant. There would also be a 3% tax at retail and a general sales tax. And what this tax design does succeed in, it does succeed in targeting the negative externality. Weight is a good proxy. As I said before, price would be a bad proxy, but SB 888 targets the weight, which is very positive. I did a calculation. I thought you might find it interesting to look at the effective tax rate that this bill would result in. So if we take all the taxes in the bill and add the general sales tax, the effective tax rate would be something around 24% when the market's matured. In the early years, it'd likely be around 20%, which is pretty competitive with neighboring states and certainly across the other states that have legalized. Furthermore, in the first year or so of legalization, taxes won't be that determining in terms of price. Low supply is likely to have a much bigger impact on prices than taxes will. Another positive outcome of taxing by quantity is revenue stability. We've seen prices go up and down in states that have legalized. For instance, in Colorado from 2014 to 2019, the price of a gram of cannabis flower declined from almost $11 to $4.50. There was an average decline of 16% year on year. When you tax the quantity, you're going to see a stable revenue collection regardless of these price discrepancies. The last thing I wanted to comment on was longevity of the tax. There is a risk that the federal risk or opportunity or chance that the federal government may make some moves on federal legalization. Now, if you have a price-based tax at retail,
So you're a little over the 3-minute mark, so I just need you to wrap up.
I'll round up. I just wanted to say that going with a quantity-based tax protects the longevity of the tax system, whereas a price-based tax, which some are advocating for, would create problems in the event of a federal legalization. I appreciate your consideration.
Thank you. Are there questions from the committee? Seeing none, appreciate you sticking out with us here.
Thank you, guys.
All right, next up we have Anderson Curtis.
Good evening, members of the Judiciary Committee. My name is Anderson Curtis, and I am the Senior Organizer and Policy Advocate for the American Civil Liberties Union of Connecticut. The ACLU of CT supports this bill only if it's amended to fix the concerns I'm about to raise that are described in detail in the written testimony of my colleague Kelly Moore. We believe in complete decriminalization of cannabis. We also believe that legalization must push for equity for individuals and communities harmed by the racist history of enforcement of cannabis offenses in Connecticut. Therefore, some of the equity provisions in House Bill 6377, an act concerning labor and peace agreements in modern and equitable cannabis workforce, are essential additions to this bill. This bill continues to criminalize simple possession of cannabis, and that needs to be changed. In the proposed bill, possession of just 2.5 ounces creates criminal liability on a second offense. Youths are criminalized the second time they attempt to buy cannabis underage. Growing your own cannabis plants is criminalized at all levels. And SB 888 creates the potential that an adult can be incarcerated for up to a year for negligently allowing a minor to possess cannabis. If Connecticut does not want to repeat the mistakes of its past, it should not apply criminal penalties to simple possession of any type of cannabis in any amount by any person. First, while the bill does provide for some automatic erasure mechanisms, which we support, it doesn't do nearly enough. It caps erasure to possession of under 4 ounces and doesn't include any offenses other than simple possession. This bill also retrenches collateral consequences by implicitly allowing landlords to deny housing to people with convictions for possession of greater than 4 ounces of cannabis. The bill would allow for people to be sent back to prison for technical parole violations based on legal possession of cannabis. This bill would do nothing to help people currently incarcerated for those kinds of violations. This bill allows employers to fire employees for off-work legal use of cannabis. It also allows for DCF to determine that a child is at risk of harm based on a positive drug test of their parent for a legal substance. In short, this bill makes minor efforts to limit the impact of past cannabis-related convictions, but it fails to include enough offenses to take steps to reduce most harms. There are numerous due process concerns with the conduct of DUI stops and the supposed drug recognition experts. Our written testimony details those problems. Connecticut can make significant strides toward equity and liberty with a strong and equitable cannabis legalization bill. To make this bill as strong as possible, we encourage this committee to amend the bill in ways I've described with other amendments in our written testimony. The war on cannabis, like the war on drugs overall, has been a failure that has ruined millions of lives, torn families apart, and decimated communities, all while perpetuating racial injustice. Connecticut cannot repeat these mistakes by passing a recreational cannabis bill that creates new and different opportunities for disparate harm to people of color. Yet without the amendment, parts of Senate Bill 888 would do just that. If and only if those amendments are made, the ACLU of Connecticut will support Senate Bill 888. Thank you.
Thank you, Mr. Curtis. Questions from the committee? Seeing none. Representative Blumenthal.
Sorry, just a quick one, Mr. Chair. Mr. Curtis, thank you for your testimony. Appreciate hearing your perspective. My understanding of the new criminal penalties purpose is that if we're going to create a legal regulated market, then we need to keep people from going to the black market and to keep them in the legal market. And is it your position and the ACLU's position that there should be no consequences for going outside the legal market? Or is it the position that the consequences should just not be criminal ones?
Consequences should not be criminal, and that is for people who have legal means to obtain the marijuana and to use it legally. I'm not talking about illegal things.
Okay. Thank you, Mr. Curtis. Thank you, Mr. Chair.
Thank you. Thank you, Mr. Curtis, for being with us.
All right, everyone, have a good evening. Thank you for your time.
Next up will be Kevin Severino.
Yes, I hope you can hear me. Thank you, chairs and members of the committee, for sticking with this for so long. My name's Kevin Severino. I've been treating persons with addiction since 1991. I'm currently president of the American Academy of Addiction Psychiatry. I'm an associate clinical professor of psychiatry at Yale, and am consulting psychiatrist to Gaylord Hospital in Wallingford. Today, I speak as chair of a subcommittee we formed on cannabis legalization of the State Advisory Board to DEMIS. So this is the first you'll hear from a member of DEMIS. We voice opposition to the, I'm not a member of DEMIS, I'm on the advisory board, but our subcommittee and now the State Advisory Board voices opposition to passage of SB 888 at this time for several key reasons. And you've heard many of these, so I'll go through them quickly. First, today's high potency marijuana is more addictive and more likely to induce psychosis than that studied in the past. You've heard that the THC potency of smoked cannabis is now about 20%, and dab and waxes can be over 90% THC content. Hence, while it used to be estimated that about 9% of those who used cannabis would become addicted, today that number is 30%. And somebody had asked before, what is it for alcohol? That number is about 9% for alcohol. The current bill allows for full commercialization of all cannabis products, including shatter, wax, and vape liquids. It doesn't limit potency and taxes on the basis of weight, so it encourages sales of higher potency products. Only on page 25 of the bill, I apologize, I don't have the line number, is there mention of future possible limits through DPC, which feels after the fact. It's not an easy thing to determine and regulate potency. Second, commercialization of cannabis and normalization of use in the eyes of youth will lead to increased use by youth. It's hard to understand how this could not occur. California saw a 23% increase in the past 30-day use among school-age children after legalization, despite sales to such individuals being illegal. And in my submitted testimony, I reference Dr. Pascal's article on that. The frontal lobe of the human brain, critical to decision-making, continues to develop up through the mid-20s, consistent with earlier use resulting in greater addiction. We ask that legalization be restricted to those 25 and older, and more research be conducted to reduce youth exposure. Third, in Connecticut, cannabis legalization will result in about 16 extra MVA deaths per year, and I extrapolated that from Colorado data. For those that don't die, last year I alone treated 3 patients in their 20s who suffered cannabis-related motor vehicle accidents. One with severe brain injury who could no longer talk to me, one with quadriplegia, and one with paraplegia. Their lives were forever changed for them and their families. How many more will there be when this use goes up? And finally, as has been argued before, the public health and administrative costs to Connecticut will far exceed the tax revenues from cannabis legalization. I note Senator Champagne was already surprised DPH has been so little involved. The current bill describes adding 64 positions to DCP, large increases in officer training, public education, additions to the staff to DMV. And add to this the cost of the increased MVAs.
Sorry, I gave you a little leeway. You're over your 3 minutes here.
Okay.
So you should wrap up.
And I feel when you calculate these costs in the proposed bill will far outweigh what we will gain from tax revenues. Our subcommittee submitted to the Judiciary Committee a letter providing more detailed explanation of our concerns.
Yeah, I'm gonna ask you
Thank
about
you.
this, sir. I gotta ask, and I gotta clear this up for the record. So you started by saying you were testifying on behalf of DEMIS.
On behalf of the State Advisory Board to DEMIS.
So what is the State Advisory Board to DEMIS?
The governor, not only do the regional advisory councils have representatives on that, but as well the governor has appointees that serve to advise the commissioner of DEMIS.
And the advisory board, did the advisory board meet and authorize you to testify on their behalf here today?
Yes, and my letter is signed by the head of the advisory board as well as myself.
Okay. And did you get clearance from DEMIS to testify on behalf of that agency?
I'm not testifying on behalf of DEMIS. I'm testifying on behalf of the advisory board. Okay. So they were present when the head of the advisory board signed off on my testifying.
Okay. No, I just have to clarify for the record because your testimony is contrary to the testimony that's been submitted by DEMIS itself. DEMIS has submitted testimony in support of this legislation. Are you aware of that?
I'm aware of that, and I cannot speak on behalf of the actual commissioner. and other members of Demas as they are appointed and employees of the governor.
But you are aware that Demas itself has testified in support of this, has submitted testimony in support of this legislation.
I have not read their testimony. They have told me they did that.
Okay. All right. I just have to be clear for the record that you're not testifying on behalf of the agency, that the agency has submitted its own testimony in this matter.
That's correct.
Okay. All right. Representative Blumenthal, did you still have your hand up from the last one, or do you have something on this? Representative O'Day.
Thank you very, very much, Mr. Chairman. Doctor, thank you for your testimony. I'm sorry if I missed the beginning when you said your specialty and years of practice.
I've been practicing since 1991. I'm specialized in both addiction medicine and consult liaison psychiatry. That means I work inside a hospital.
And is it okay? Could you mention which hospital you work at?
At Gaylord Hospital in Wallingford, Connecticut. So we see a lot of spinal cord injuries and brain injuries.
So you've had extensive experience treating a number of people with extensive marijuana use abuse?
Yes.
Have you heard the testimony today from a number of different doctors on pro and con?
All day. Yes.
So you may have heard my number one concern is, so when you mentioned that you want the age limit to be 25, I'm as Chairman Staffstrom can testify, I've never claimed to be a doctor or the smartest person in a room, but it sounds like you and I are in agreement that 25 is an age in which the brain develops, and that we want to make sure that people don't use and abuse marijuana. Is that fair to say?
Yes, two reasons. A, the brain seems to do a lot less development after 25, and in some of our cases actually begins to regress. But then the other thing is that earlier use of cannabis leads to higher rates of addiction. And so if you start later, it's safer.
The THC content was also something that's been mentioned. It's increased dramatically over the last even just 5 years. And so what have you found in the difference between the THC content and the impact on particularly the teen and youth?
Well, remember, I don't really treat children and adolescents. I treat young adults, but I can't say I have enough experience over the last 5 years to say I'm seeing a huge difference other than parents complaining about vaping. Fair enough.
And is your written testimony, does it have references to the statistics you referenced?
Yes, it does.
Okay. All right, doctor, is there anything, I know you ran out of your 3 minutes there. Is there anything that that's not in your testimony that you wanted to relay to us this evening?
No, I think it's been covered before, and we're set.
All right. Thank you very much, Doctor. And Mr. Chairman, thank you very much for your indulgence.
Thank you.
Thank you. And despite the bait, Representative O'Day, I will not take you up on your offer to comment on your experience as a doctor or lack thereof, but you certainly left a softball there for me. All right. Next up will be Representative Fishbein.
Thank you, Mr. Chairman. Good evening, Mr. Severino. I would be remiss if I didn't indicate to you that I'm very familiar with Gaylord Hospital, being here in Wallingford, and I think one of the greatest victims of COVID is the Gaylord Gauntlet, which I have for many years participated in on the grounds there. But that being said, sir, I did pull up the 1 page of testimony from the Commissioner of Demas, and little troubling. I see in there that they reference the $283,000 expenditure fiscal year 22 and $1 million in expenditure in 23 to assess and manage public health impacts related to the implementation of this bill. So based upon that, I would believe that there's going to be public health impacts. So are those impacts that you've already addressed, or, because I can't tell from this document, and I know you're on this subcommittee, what those impacts are?
I think what they're trying to do is establish more of a surveillance system to understand what the impacts will be. Because as you've heard today, there's controversy about, will motor vehicle accidents go up? Will there be increased use by youth? And so now that's only surveillance. It doesn't provide any funds for increased treatment, but that's what that surveillance is meant to do. So I'm anticipating what they think is, once there is more data down the road, there may be amendments to the bill.
Yeah, it does say that this funding will support secret shopper and minor decoy programs and awareness campaign and prevention and education activities. So I would have liked to have been able to ask them, but okay, thank you, Mr. Chairman.
Thank you. Senator Haskell.
Thank you, Mr. Chair, and thank you, sir, for your testimony tonight and for your patience. I know it's been a long hearing. You mentioned that you deal extensively with medical issues pertaining to young adults, and I just wanted to follow up on that. I certainly do not have the medical training to doubt your assertion that the brain isn't fully developed until the age of 25. But I just wanted to sort of, if that's true, and I don't have any reason to doubt that it is, would you recommend that we then raise the drinking age, for example, from 21 to 25?
I would.
And how about the age to drive a motor vehicle?
Well, that's interesting, is, you know, we do know that the young, especially when they first start driving, can be more impulsive, but then there isn't any counter data that driving is damaging to the developing brain, unless of course they have an accident. So I think that's a little more complicated and outside my area of expertise.
Fair enough. I'll just ask one more question for the sake of brevity, if the chair will allow. When you say that youth addiction rates, forget rates, but when you say that you've witnessed youth addiction related to cannabis, you're not referring to the sort of chemical addiction that one might find in young people who smoke cigarettes and consume nicotine, right? Or is it your medical opinion that same addictive quality of nicotine is present in cannabis?
I am referring to the same thing. In fact, just in the latest, what we call DSM Diagnostic and Statistical Manual for mental illnesses, DSM, cannabis withdrawal is now a recognized entity. So the key hallmarks of addiction are loss of control of use and adverse consequences. And those happen with nicotine, they happen with alcohol, and they happen with cannabis.
But surely, Mr. Chair, if you don't mind one brief follow-up, surely there's a difference in the sense that nicotine triggers a chemical reaction in the brain, whereas it sounds as though shoplifting is an addiction, for an example, that would satisfy those two criteria that you mentioned, something that certainly has negative consequences for an individual who engages in it, and something that becomes a behavioral need for an individual. But isn't that different from the sort of chemical addiction that one's body actually begins to crave nicotine? Isn't there a distinction to be drawn between things that are behaviorally addictive and those which are chemically addictive?
Well, some would argue that there isn't. So there's a big argument about whether gambling, internet addiction, shoplifting, sex addiction should be listed under, quotes, addictions, because they all result in elevated levels of dopamine in something called the nucleus accumbens, which is kind of a final reward pathway. But you're right, those aren't chemicals. But cannabis is, nicotine is, alcohol is. So they are substances that induce that increase in dopamine in the nucleus accumbens.
So aside from perhaps negative mental health consequences, are there physical withdrawal symptoms from an individual who stops using cannabis in the same way that there would be physical withdrawal symptoms chemically triggered in the brain resulting from an interruption of the regular use of smoking a cigarette, for example?
Well, it is recognized now that there's a lethargy, an amotivation, decreased appetite, sort of the counter to the munchies, but it is not as, doesn't tend to drive use as much as recurrent nicotine addiction. And it's nowhere near as physically challenging to the body as alcohol withdrawal or opiate withdrawal.
Understood. Thank you, Doctor, for your testimony. And thank you, Mr. Chair.
Thank you. Representative Dillon.
Thank you, Mr. Chair, and thank you, Doctor, for joining us.
Thank you.
Just a question based on your statement and some of the testimony today. Is the degree of addiction and the I don't know what you would call it, sequelae, whatever, is that dose sensitive?
The development of the addiction, the rate of development of addiction is dose sensitive. So in other words, not only the potency of THC, but how frequently you smoke the THC. After that, it's probably more a matter of variation between an individual than it is the potency of the cannabis. The immediate intoxicating effects, in other words, the effect on impairment in driving, is sensitive to the THC content.
Well, one of the questions that would be prompted would be in the regulatory scheme, whether there should be a look at the THC content and whether that regulating the THC content would remedy, or not remedy, but maybe mitigate some of the concerns.
Well, I would agree with that. And I believe, now I may be wrong and there are others that know more than I believe Vermont has some regulation as far as potency. And my understanding is that the plan in the bill is to have DPC begin to monitor with the potency and possibly set limits in the future on that.
Mm-hmm.
Just the idea of saying we label it as saying it's 10% THC or 50% THC. I really don't think that protects consumers that well, because a hallmark of addiction is loss of control. So the people that get addicted will not be able to heed the warnings that are on the package.
No, I understood. It's being sold now illegally, and we don't know what's in it, right? And people are being picked up or stopped in their cars very often based on what they look like, so that many of us are very aware of what's happening now. So if there were going to be a regulatory scheme, I really was just interested in your testimony and curious about whether you would think about the THC level as being an opportunity to mitigate the bad effects.
Right. I think it is for that is outside, that is within the legitimate market. But I also think that in terms of, as you said, the kind of the racial disparities in enforcement, until we have something like a better ability to measure levels in the field, the unfortunately disparities in racial enforcement will probably continue to occur.
Okay, thank you very much.
You're welcome.
Chairman Winfield.
Thank you, Mr. Chair, and good evening, Mr. Servino. I have a question about some of the studies that we're talking about. Do you think that, well, let me ask you this question. If the study looked at the period of a year, do you think it would be correct of us to draw a conclusion from that study necessarily?
I'm sorry.
If the period observed in one of the studies, we talked about a lot of studies of what has happened with teenagers. If the study looked at the period of a single year, that wouldn't be a study we would probably reference. I would assume.
I'm not aware of studies that just look at a year now.
2
They
years?
compare 1 year
How
to
many?
another.
I'm sorry?
They'll compare 1 year to another.
What about a period of 2 years?
You mean from the beginning of the 2 years to the end of the 2 years, or just what
Sure.
happens within the 2 years?
What happened within the 2 years?
The National Survey of Drug Use and Health, which is one of our biggest epidemiological studies, looks at every year.
Well,
And-
my question is, would we draw, at what point are we feeling, you're an expert, so I'm asking you, at what point, in terms of the length of the study, can we draw the types of conclusions we're talking about today about whether or not teenagers will do something or not do something? In this case being use cannabis because of the use, the legalization because adults are using, whatever the case may be.
Right. There, it really depends on statistics. So if I looked at the country, I might be able to, in 6 months, have enough numbers to say I can reasonably calculate to a P of less than, in other words, a probability of less than 0.001, that there's a statistical difference between the two. But if I'm just looking within Connecticut, my guess is we'd need a couple of years at a pop.
Okay. And the Mally Pascal study that you referenced looked at the years 2017, 2018 in terms of a school year, 2018, 2019. And so that's 2 school years. And do you feel that that is enough time to draw a conclusion that is concrete?
There's one other California study that's similar to it, but I would agree that today we've heard from people who are saying they've seen studies where it goes the opposite. What I am saying,
I recognize. I'm trying to keep us to the study that you brought out.
Right.
As an expert, you brought information in front of us. So
Yeah.
I want to focus. I don't want to focus on everybody. I just want to focus on what you've said.
yeah. So I think the Pascal study is valuable in that California is a very regulated state, and they worked very hard to try to prevent youth from using. And even there, according to that study, which is an observational study, in that particular study, they failed.
That's interesting because I'm not going to make an assumption. So I'm going to ask you the question. I'm not trying to be, but I just want to make sure you've read the study.
Yes, actually,
Okay.
I've got it right here in front of.
Sure. Okay, good. I just don't want to make any assumptions because I'm aware that that in talking about what the study means, it is suggested that when they're talking about the part where they're not sure, it's not as conclusive as some people think it is, because that's in there too, right? When they're talking about that, they're talking about the variability of policy in Connecticut, and yet you're just suggesting to us that California, you're suggesting to us that California has more, which sounds stricter than what the study suggests in terms of policy. So can you clean that up for me?
I think what they were saying is one of the limitations was the study is they were looking statewide, and that county by county, there's variability. And so when in any study, it's always good at the very end, there's a whole section on limitations. And one of their limitations is California's a big state. So they don't have an explanation as to causality about why youth use may have gone up or not.
Right, and I believe they even suggested that for the at least the 2018, 2019 year, the prevalence of vaping may have something to do with this. That's not completely dependent upon the legalization of cannabis as well. Is that correct?
Right, because vaping has been skyrocketing everywhere.
And I just want to make sure that we're clear for the record. And I've done this earlier. If you've been watching, I'm not trying to play gotcha with you. I just want to make sure we understand what these studies say. And it was also suggested, kind of to what we were just saying, that states that are looking to legalize cannabis, and this is coming out of the study you referenced, would benefit from stricter controls where there's not as much variability as California would have, and evidence-based prevention programs. And is that part of your testimony as well? That's what we should be doing if we choose to legalize? Is that in your testimony?
If we do, it's not in the testimony, it's actually in a letter I sent to the Judiciary Committee. a number of harm reduction approaches. But one of is if we want to take the time to maximize our ability to reduce penetration to youth. And I think so there is variability between states, and the states that are more successful in that, we should try to pattern after that. Because there's not.
You can continue. I'm not trying to cut you off.
No, that's okay. It's late. My brain doesn't work well.
I understand that really well, probably more than I want to. And just finally, I would just suggest this. And I don't think you meant to come here and suggest that the study is any different than it actually is. I would just put forward for the record that even Dr. Mally Pascal would suggest that they actually need more research before making a conclusion, because that's what they say in the study. So thank you for bringing it before us. I just want to make sure that we're all operating off the same information.
I definitely support more research, and I do support the rescheduling of cannabis so we can do more research in this country.
And you know what? Thank you for that, because there's been suggestions that, well, we don't know this or that about cannabis and we don't have research. Part of it is because of the way it's scheduled, which is kind of a chicken or egg problem that we have. So thank you for pointing that out as well. Have a great evening.
Thank you.
Yeah, thank you, Chairman Winfield, and thank you, Mr. Savino. I think that's a point we can all agree on, that this should not be a Schedule. I hope we can all agree on this should not be a Schedule I drug, so that we can do more of that research. Representative Fiorello.
Thank you, Mr. Chairman. Dr. Severino, I just have one quick question. In your testimony, you list out disproportionate harms. And in section B, it says people of color. And there's a sentence in here that I don't quite fully understand. And while I have you here, while we have you here, I wanted to give you a chance to explain it better. It says the banning of cannabis dispensaries in many predominantly white areas of states where dispensaries are legal would raise dispensary density in the poorest areas, exposing the most underserved to higher cannabis availability and increased use and harms. How can you just explain that a bit more?
That was in the testimony or in the letter?
It says February 22nd, 2001, Joint Committee on Judiciary.
Yes.
It looks like a letter.
2021, yes. Yeah.
So what do you mean by that?
Let me pull that up again.
It's on the page with the images of the brain scans.
Yep, I'm getting there. So read me the line again, since my computer's acting funny.
Sure. It says section 4, disproportionate harms 2, and then A is mental illness, B is people of color.
Oh, yes.
And is that enough, or do you want me to read it again?
No, I've got it. B is people of color.
Okay.
And I bring up the Washington study where, in fact, we're still having more people of color arrested on cannabis charges than whites. The current, let's see. Okay, the banning of cannabis dispensaries in many predominantly white areas of states where dispensaries are legal would, yes. I probably, as I shortened this, didn't make that very clear. The bill allows municipalities to basically, as long as this is a purely retail operation as opposed to a hybrid or a medical, can actually have zoning laws that would prevent cannabis sales in that zone. And so now I don't have papers on this, but as others have told me in their states, such as Colorado and California, then retail dispensaries end up in mainly underserved areas in inner cities. And I feel that would raise dispensary density in those areas. And just like we know with alcohol, where there's a greater retail density, there tends to be greater use. And so I think there would be greater harm there. So the way you could, I'm not sure how you would modify SB 888 to avoid that possibility, because fairly wealthy areas tend not to approve retail cannabis outlets in their areas.
Okay, thank you. That explains it. Thank you. Thank you, Mr. Chair.
Thank you, Representative. Seeing no further questions, we appreciate you being with us, Doctor. Next up will be Jonathan Johnson.
Thank you, chairs and distinguished members of the committee. Thank you for your time and attention. My name is Jonathan Johnson. I'm a Connecticut resident from New Britain. I'm not speaking directly as vice chairman of the Libertarian Party of Connecticut today. I'd like to speak as a concerned citizen and a parent of 2 children in the state, a 6-year-old and a 3-year-old. Let's be clear about what this Senate bill is truly proposing today. This legislation is primarily focused on creating corporate pot shops. No matter how you phrase this bill or how many times the word racial equity has been added to the narrative surrounding legalized pot shops in Connecticut, where we end up with this legislation is only legal, taxable corporate pot shops. Personally, I prefer not to have my children living in a state where there will now be a corporate pot shop in every town and in every city. Mommy, what's that store? Daddy, what's that store? For all the talk about racial equity and how much any bill proposed would attempt to provide financial buy-in to communities that have been discriminated against regarding cannabis laws, the main beneficiaries will be A, corporate cannabis entities, and B, the state's tax coffers. We have numerous citizens in our state who are selling cannabis illegally for decades. These people have been risking and actually getting arrested and distributing cannabis to people who want to consume this plant. Their historic risks are why we are having this conversation today. If we truly cared about equity in the cannabis industry, particularly for those most adversely affected, here's a simple legislation you should make law. 1, expungement of all cannabis arrests and prosecutions. 2, home grows. Allow citizens the right to grow cannabis on their own personal property, similar to homebrew laws. And 3, microbusiness. The most direct way to give equity to those most affected and to give opportunity for legal profits to those same people is to simply legalize selling of cannabis on private property. Basically, legalize the local cannabis entrepreneurs. It's been proven in California and Massachusetts and Colorado and Canada. Legalized dispensaries is not going to eliminate black markets. It's just not. In fact, you're going to increase demand overall and black markets will continue on. Taxes and tax revenue are the only drivers for legalizing cannabis in Connecticut. Not fairness, not equity, not supporting communities unfairly discriminated against regarding cannabis laws. If legalized cannabis is such a great thing, why is the only discussion and bill so highly focused on cannabis, corporate cannabis shops? Why is this legislation not providing our citizens more freedom and allowing people to grow their own cannabis for their own consumption and allowing the entrepreneurship and microtransactions that are already happening in the black market to simply continue on a legal basis? It's not about equity. It's not about legalizing human activity regarding cannabis. This is all about taxes. Please pass a bill that legalizes these activities that adversely affect cannabis consumers and micro entrepreneurs. Thank you.
Thank you. Representative Drabitsky.
Thank you, Mr. Chairman, and thank you for coming in. And I'm going to ask you the same question I asked another person who came and testified. If this were the bill, 888 were the bill, and there weren't changes to include the homegrown and all the things that you just mentioned, would you rather see this bill pass or nothing pass?
At this point, my personal opinion is I'd rather see nothing pass than this bill pass.
Okay. Well, thank you very much.
Thank you.
Thank you.
Thank you, Mr. Chairman.
Further questions? Seeing none, we will move on to Nathan Tinker.
Good evening, Senator Winfield, Representative Staffstrom, Senator Kasser, Representative Blumenthal, Senator Kissel, Representative Fishbein, and other fatigued members of the Judiciary Committee. My name is Nathan Tinker. I'm the Secretary of the Academy of Medical Marijuana Dispensaries and also CEO of the Connecticut Pharmacists Association. The Academy of Medical Marijuana Dispensaries is an affiliate entity within the association, and with licensed pharmacists at the core of the program's success, Connecticut's dispensaries serve the health and wellness of over 50,000 patients. You already have my written testimony, which goes into greater detail. So I will just touch upon the top line things that are in there. And also, you've also heard from a couple of our AMMD members earlier that have also touched upon those issues. In short, my message is this: make sure any adult use program does no harm to the medical marijuana program. And that touches upon several issues. One you've already heard about, taxes and fees. It imposes an excise tax on medical marijuana, and it does not do away with the current fees and that are imposed upon medical marijuana patients. And although technically medical marijuana is tax-free, annual patient fees effectively and unfairly tax medical marijuana patients for their medication. So please do the right thing and for patients and eliminate those taxes and fees. On the issues of product supply and potency, in any parallel market environment, medical marijuana patients should be guaranteed primary access to product. There must be enough producers to fully supply both the medical and adult use markets. Current state regulation allows up to 10 producers, 10 producer licenses, of which only 4 have actually been put out. Medical marijuana patients should not be restricted to product allotments that are smaller than those of adult use consumers. The adult use market should be able to offer, the adult use market should not be able to offer any product that is prohibited in the medical market. And in a similar vein, the available potency of medical marijuana products should be substantially higher than that of the product in the adult use market. Those should be limited, and those limits could be set low in order to be able to as the pharmacists say, titrate up if necessary. But that's where things we believe should start. There are some specific technology issues. In order for medical marijuana dispensaries to take part in the hybrid program, SB 888 requires dispensaries to have real-time reporting capabilities to the state's prescription monitoring and reporting system. The technology to do this is available, and indeed some of the AMMD dispensaries already can do this. However, the PMP itself would need to be upgraded in order to accommodate equivalency measurement and perhaps more importantly, to actively return allotment information to the dispensaries. This capability will not only assure that dispensaries remain compliant, but that patients themselves are protected as well. We would be pleased, of course, to work with DCP to assure the system works for all and that dispensaries are able to fully comply with that regulatory framework. Finally, just in regard to microcultivators, we're concerned about the idea of microcultivators, largely because to allow them unfettered access and delivery services would mean that medical marijuana pharmacists who consult actively and closely with patients to enable the best treatment options for them would no longer be able to assess whether patients are self-medicating or otherwise stepping outside of their treatment regimens, and thus endanger patients by increasing the opportunity for abuse.
Thank you, Trevor. I just need you to wrap up. We're at our 3-minute mark here.
That was literally my last line.
Good timing. Representative Fishbein.
Thank you, Mr. Chairman. Sir, it appears to me that you would have different criteria for the recreational marijuana industry as opposed to the medical marijuana industry. Is that fair to say?
Well, I'd say that there are 2 different markets with 2 different consumer cohorts. As an academy, our interest is in protecting the medical marijuana program, medical marijuana patients. So, we appreciate the fact that SB 88 offers the opportunity for dispensaries to take part in the hybrid program, but there are, it's essentially 2 different regimens in many, many ways.
Would you agree with me that if marijuana is legalized in Connecticut, it would basically dry up the medical marijuana market, such as I think that happened with alcohol?
I don't. And I think there is evidence in other states that the medical marijuana program has actually increased because of the focus of it and the access it gives to patients who actually have medical conditions that require, or not require, but are open to the medical marijuana space.
So you're saying that the legalization of recreational marijuana makes more people acceptable of medical marijuana?
No, I think that there are two different ways in which those markets are affect consumers. One is that there is a tax regimen around medical, a tax adult use, the adult use regimen. Medical marijuana is untaxed, and there is a very specific set of disease states that are allowed into the medical marijuana program that would not be available to the consumer, the adult use market.
All right, well, thank you for that. I don't know, have you been here all day with us?
Oh yeah.
So you might know that, one of my biggest impediments to my being in support of this is the fact that it's illegal under federal law, and you're here on behalf of the Connecticut Pharmacists Association. Have you asked our federal delegation to change that, to get rid of my impediment?
No, we've not talked to the federal delegation about this, but I would point out that in December, the House of Representatives actually passed a bill that decriminalized marijuana across the board and had substantial civic and criminal penalties withdrawn as well. So it's a topic that is certainly being reviewed and considered at the federal level. But we work within the strictures of the state of Connecticut law and adhere closely to that.
Well, I would say that state of Connecticut law says that we must abide by the Constitution, but we don't need to go there at this point. So thank you, Mr. Chairman.
Thank you. Next up, we will hear from Nicholas Stein.
Good evening, members of the Judiciary Committee. My name is Nicholas Bard Stein, and I'm before you tonight to give some testimony in opposition to SB 888 as it's currently written. My written testimony goes into 5 main improvements that could be made to SB 888. But I really want to tell my story and focus on one really important improvement that could be made to this bill. My story. So I have been arrested for marijuana possession and intent to distribute. I was convicted of both those crimes, separate crimes. One of them occurred at UConn, and for that crime, I served 20 days in jail. I also served between 2 crimes over 5 years of probation, and in general have experienced a lot of the negative effects of having a felony on your record. So with that perspective, also last year, I actually achieved my pardon for that felony. So I went through the Connecticut's pardon program. And from that perspective, I just want to offer testimony that this bill does not do enough for equity. And specifically, it doesn't do enough for equity because it does not extend the automatic expungement of criminal records to marijuana crimes that include felony cultivation, felony possession of more than 4 ounces, and felony distribution, which is the one that or intent to distribute, which is the crime that I had. So some ways that this felony negatively impacted my life, where it did impact my ability to get a job. It would have impacted my earnings, except for I had a series of understanding employers once I did find someone to get me into my career, which was a good aerospace career. Now, I know that there are so many people in Connecticut who have felonies on their record for marijuana crimes that do not have the support network that I have. So while I was able to get through the criminal justice system and then, achieve employment, I actually ended up finishing my college education at Eastern, got good employment in a prominent Connecticut aerospace company, and then develop a career. There were so many people who were not able to do that. And the reason is because they couldn't afford the lawyer that I had. They didn't have the just general base of education that I had, and they didn't have the support network that I had. So I just want to share a couple things about the pardon process. And the reason why I think that it should apply or be extended, the automatic erasure should be extended to people with felonies, is because the pardon process is so difficult and not everybody has equal access to it. So I was able to pay $3,000 for a lawyer to do my pardon, which was a big help. I also had to put about 80 hours of my own time in, which I'm not going to lie, I did a lot on my work time. So I had a pretty flexible sales work schedule, and I was able to use some of my time to do that. Not everybody has to do that. That also means I was able to use my best hours of my day to put into my pardon. And then finally, I had a support network of people in the community who were upstanding individuals who were able to write me letters of support. Those are all not necessarily minimum requirements, but they're all very, very necessary for me to have achieved my pardon. And nobody has access to those who has a felony on their record. Thank you.
Sir. Appreciate it. We're at the 3-minute mark. I would also encourage you that I think later in our hearing process, not today, we have another bill on clean slate erasure that would cover your circumstance. And I know the committee would appreciate hearing your expertise on the pardon process during that bill. So maybe you can come back and sit with us for another full day. In the meantime, Representative Fishbein as to the bill before us.
Yeah, I just wanted to, about the pardon. I know I don't want to go down that rabbit hole. I just trying to figure out about the erasure and this gentleman's particular situation. Sir, aren't you, I think I remember 2 years ago you testified before. Oh, sorry, my video's not on. Sorry. There you go. You testified before us. You were the gentleman who with the shipping the marijuana to the college. Is that the situation?
Yeah, I testified last year. I may have given you some details, and that was I received a package of marijuana from Colorado. Yes.
Yeah, on a couple of occasions, I think it was. Yes, and you were convicted of a felony a few years ago, and now it's been erased off your record utilizing the pardon process.
Yes.
Okay. And you said that the pardon process isn't available to everyone.
The pardon process is available to everyone. Everyone can apply for it. Just not everyone has equal access to the advantages that I had that were able to get me that pardon within 8 years of having the felony, right? So of 8 years of being convicted of that felony. So those advantages, like I said, were a support network of people in the community who were willing to write these letters of support for me. They were the ability to hire a lawyer, which cost me about $3,000. And they were the people, and it was my time and my education that I was able to put a lot of work into putting together an 87-page pardon application packet with 87 pages of backup information about why I was a good candidate for that. There are thousands of other marijuana felons out there that have just as good opportunity of giving back to the community and have done the things that I've done, but they haven't been able to demonstrate that to the Board of Pardons because of the onerous process. So I just feel really, really strongly that if you're erasing misdemeanors, then it's really important that you extend that to the felonies that I mentioned earlier.
Okay, so it's your position that this erasure in this bill doesn't go far enough, that those that are charged and convicted with possession with intent to sell, possession within a school zone, all of that should just go away automatically without having gone to the pardon process.
Well, it's not going to go away because these people have already, presumably served their time. This is a plant that's becoming, generally legalized, though regulated. Ostensibly, these people have done the same thing that corporations are about to make millions of dollars on. I get it. They broke the rule of law. One of my biggest problems was that I broke the rule of law. And, that's a challenge. That's something that I have to improve in myself. That was a failure of my ego, right? So that's something that I have had to deal with. And by doing that, I've been able to get to a point where I deserved that pardon. So other people have done that and they've addressed the problems that have led to their issues. They just haven't been able to demonstrate that they deserve a pardon because it's an onerous process. So if this bill has the opportunity,
I'm just trying to establish, where does it end? But I understand your answer. So thank you. And thank you, Mr. Chairman.
Thank you. Representative Fiorello.
Thank you, Mr. Chair. Mr. Stein, you are a representative of a cannabis industry entrepreneur, you yourself, or you represent an organization of entrepreneurs?
I don't represent it. So I am just a brand new recent entrepreneur. I left the aerospace industry about 1.5 years ago to pursue this advocacy. And I'm opening up a CBD and medical cannabis accessory shop in Colchester, Connecticut next month. And it's an already existing store that I'm buying into, and we're expanding to Colchester. So this is my first foray into entrepreneurship, but I'm very, very interested in entrepreneurship.
Okay.
In the cannabis space.
Right. You had 2 suggestions to improve this bill. One of them was related to the licensing structure. You said that it should be a 1-to-1 licensing ratio. What do you mean by that, and how does that improve the bill as it's written?
Yeah, so that goes to another point of equity that would really be improved in this bill, and that there's no direct ownership by both people, by equity applicants, however that's defined. But for me, it's people who have been disproportionately impacted by the war on drugs, both as individuals and for individuals from certain communities that have been disproportionately impacted by the war on drugs. So what I'm suggesting there is that for every 1 license that goes to a person that's not an equity applicant, another license goes to an equity applicant. And then in this process, you flip-flop back and forth. Now, I heard earlier Ben Zacks from Fine Fettle actually said the first 18 dispensary licenses he's in favor of going to equity applicants. I'd rather see that. Props to Fine Fettle fam, by the way. That was a great idea. But, some sort of insurance that a certain portion of this industry is going into direct ownership by equity applicants and repairing the harm that the war on drugs and the war on marijuana has had against those communities and those individuals.
Okay, and then just lastly and quickly, you also said that you think that the legislation should include a certificate program to make sure that those who sell this are educated and know how to make sure that consumers are educated. Am I right to think that you want that because you acknowledge that it's dangerous to be sold to younger people, or that it's dangerous to be sold to people with potential mental illness issues? You're trying to mitigate some of the dangers of it?
So the specific danger, one of the credible dangers of legalizing recreational marijuana is that there's going to be an influx of new customers who have absolutely no experience using this product, or very, very little. Either it's been a very long time or they've never used it before. Now, if one of those people goes to a recreational marijuana dispensary where an unscrupulous sales agent were to, let's say, sell them, I'm just going to use an example of a 5-pack of pre-roll joints, right? And this person has never used marijuana before, and they consume the whole joint their very first time, they're not going to have a very good time. So what I'm proposing is that first off, through our community college system, the Quinnebog Valley Community College already has a 1-year certificate program that's doing great. It fills up every year, and it's a cannabis studies program. And it just gives like the basic knowledge of how of cannabis and how it affects your system. So I think something like that, but maybe tailored a little bit more towards product safety. I'm not going to get into specifics, but some sort of program like that that would allow the sales and marketing representatives to have knowledge of a basic level of knowledge before they're out there as the front line of sales recreationally, to put these things in the hands, put these products in the hands of people who may have never used them before. And really, from my sales experience, I've been in sales for the last 6 years. It's the most important thing about sales is education with anything. You really want to educate your customer. You want to get to know where your customer's at with their challenge, and then provide a solution, right? So, in doing that, the first step is having a base level of knowledge of your product.
Okay, thank you. Thank you, Chairman.
Thank you. Seeing no further questions, appreciate being
Mr. Chairman, I'm sorry. I've changed computers. I can't figure out how to raise my hand, if I may.
Yep, go ahead, Representative Ada.
Thank you. Mr. Stein, thank you very much. Just quick question. If you could go back in time how would you recommend that we help Nicholas Stein as a teenager to stop from using marijuana?
Looking back, there's nothing you would have done to have stopped me. So we have what's my family called well, never mind. There's nothing you would have done to have stopped me given my past and the group of people that I chose to be friends with, and just generally being a independent soul. The only thing you could have changed is the impact of the law enforcement system on the decisions that I made. I don't see that my crime was ever anything having to do with the plant itself. My crime was breaking the rule of law, and that had a lot of really negative impacts. It delayed my career, and it really could have, if I wasn't born into the life that I was born into, I would have had just so many worse things happen to me. So there's nothing you could have done to have stopped me from using marijuana when I was 16, 17 when I started, but there's certainly some changes that hopefully this law will make so that no one ever goes through what I went through, and other people don't have to go through even worse than what I went through.
Do I understand in your testimony were you dealing at 16, 17?
No, I started dealing like 19, 20 when I was in college. I started using at 16, 17.
All right. Okay. Well, thank you, Mr. Chairman. I appreciate your testimony, Mr. Stein. Thank you.
Thank you. All right. Next, we will hear from Sean Perez.
Hello, how are you doing?
Good. How are you, sir?
Good. Distinguished committee members, thank you for the opportunity to testify in support of legalizing and regulating marijuana. Having spent my career as a police officer, I'm now a representative of the Law Enforcement Action Partnership, a nonprofit group of active, retired, and former police, prosecutors, judges, and other criminal justice professionals working to fix the criminal justice system. Our mission is to make communities safer by focusing law enforcement resources on the root causes of crime, building stronger relationships with the communities we serve, and exploring evidence-based alternatives to incarceration. At a time when trust in police is at a 27-year low, we need to seize every opportunity to build bridges between public safety officers and the people they serve. Decriminalizing marijuana was a smart move. It allowed officers to focus on what really matters, crimes against people and property. But it's not enough. The criminal market still controls marijuana in our state, and young people still have easy access to marijuana. As more states legalize, illegal sales and trafficking decline. Moving marijuana into a legal marketplace reduces crime, defunds potentially dangerous criminal enterprises that sell marijuana, and places a barrier between young people and marijuana. Legal marijuana businesses undergo a rigorous licensing process, which limits criminal organizations from entering the market and are subject to taxes, safety inspections, and strict regulations. If they make a mistake, we know who to talk to. While regulating marijuana for adults is smart policy, the Law Enforcement Action Partnership has some concerns about the lack of equity provisions in this bill. We don't want to further disempower those who have had their lives destabilized by marijuana prohibition. SB 888 does not specify how much revenue will be allocated to equity and reinvestment in the communities hit hardest by prohibition, namely low-income people and people of color. This legislation should specify exactly how much revenue will be used and in what ways, which can be determined by the Equity Commission's recommendations. The Law Enforcement Action Partnership believes SB 888 should also allow for no cost expungement of all marijuana-specific offenses, not just possession cases. Those convicted of selling marijuana should not have those convictions remain on their records, creating barriers to success for the rest of their lives, while legal industry accumulates millions in profits. There should also be revisions to this bill that ensure equitable access to business licenses. The license lottery should not proceed until the Equity Commission has released its full recommendations on licensings, and a substantial portion of licenses should be allocated to qualifying equity applicants. Without amendments for equity provisions, SB 888 will fail to address the scope of damage caused by decades of marijuana prohibition, which means that communities most impacted by our current system, the same communities that do not trust the police, will have little incentive to trust that our justice system has state government are looking out for them. The smartest public safety strategy is to legalize marijuana in a responsible, equitable way. The Law Enforcement Action Partnership believes that SB 888 needs to be amended before that will be possible. Thank you for your time.
Thank you, sir. Representative Fishbein.
Thank you, Mr. Chairman. Good evening, sir. You
Are you here on behalf of the Law Enforcement Action Partnership?
Yes, sir.
And you mentioned that it's comprised of police officers and judges, and I think there was another group that you
Law enforcement professionals, like anybody in law enforcement that's been here.
Okay. So do you have any current law enforcement involved with your group?
There are numerous individuals involved. You can go to the website. There's the whole list of
I'm on the website. Do you have any current law enforcement? That's there's nobody on your board. There's nobody on the staff. Trying to figure out and before we get to do you have any current law enforcement?
I wouldn't know any names off the top of my head. I'm sorry.
Okay. Do you have any former law enforcement other than yourself from Connecticut on this?
There was one other person, but it's just me right now.
So you're the only former law enforcement individual from Connecticut affiliated with this group.
Correct.
And what about judges? Do you have any current judges that are affiliated with this group?
I don't know about in Connecticut or any local area, any current judges.
Right. So you have any current judges anywhere in the country affiliated with this group?
Not that I'm aware of.
Okay. And do you have any former judges from Connecticut affiliated with this group?
No names that I know, sir.
Okay. That's all I had. Thank you, Mr. Speaker, Mr. Chairman.
Representative Dubitsky.
Thank you, Mr. Chairman. And thank you for coming in to testify. I've asked this question to a number of proponents of legalization that all ask that amendments be made to this bill, including equity and homegrown. So let me ask you, if this bill were to be put up for a vote without amendment, would you rather see this bill go through or nothing?
Probably nothing.
Okay, thank you very much. Thank you, Mr. Chairman.
Thank you. Representative O'Day.
Thank you, Mr. Chairman, very much. Just briefly, thank you, Officer Perez. Just curious as if whether or not you have any problems with Section 13, the probable cause section. If you pull somebody over, you can't utilize the smell. I'm sorry?
You're talking about the plain smell part of it?
Yes.
Other states, they got rid of that a while ago too, the whole plain smell idea. I guess my problem with it would be what was mentioned earlier. If you have somebody else who smells like it, and there's no issue with associated with somebody else who smokes. It doesn't mean you're a smoker. And if they smell like it, they smell like it. I'm not going to down somebody for doing something in their own private life. And then, but I shouldn't also take the consequence for them being around me.
Fair enough. Fair enough. But for example, if I'm pulled over because of a tail light and they smell alcohol in my breath, and let's suppose I just had 1 or 2 drinks, they pull me out of the car for the smell of alcohol, and I pass the
specific verbiage that I've personally written on DUI reports is alcohol emanating from their person, like from their breath or from their facial area. So that's specific as to tying it to consumption, whereas smelling marijuana in the vicinity of somebody is completely different.
What if you smell it directly from them when they're talking? You can smell
it coming out their breath, and they smell like they just burned something, or it smells like smoke. That's a different situation. I can write that down. I can explain that.
But I think under this law, we've been told that that's not enough for probable cause to ask them to step out of the car. Do you believe that if you smell it on their breath, it's emanating, that you should be allowed to pull them out of the car?
I think it can be articulated. I think you're articulating it differently when you're saying it. You're smelling it from a car and then smelling it from their person. It's two different things. Now you're tying it to them specifically using it, as opposed to just smelling it in the vicinity. And I think that could be argued.
I'm just saying that the statute or the proposed bill doesn't allow you.
Representative, I think he's answered it to the best visibility at this point. I think there's also been conflicting testimony on this today. I would draw your attention to lines 475 to 495, 475 to 479. I think we can debate this and work on this language as we move forward, but I think the witnesses answered the question with the best visibility.
Fair enough, Mr. Chairman. I appreciate that. Mr. Perez, thank you very much for your service, sir, and I appreciate your testimony.
Further questions for this witness? Seeing none, we'll move on. Thank you for being with us, sir.
Thank you.
Next up will be Barbara Broll.
Thank you. Mr. Chair and members of the Judiciary Committee, my name is Barbara Broll, and I was Colorado's chief cannabis regulator from 2011 to 2017. During that time, one of my primary responsibilities was the successful implementation of Amendment 64, which was the legalization of adult use cannabis in Colorado. As Colorado embarked on as the first state in the country and frankly in the world to legalize recreational marijuana, we developed 3 overarching objectives to guide us in everything that we did. 1, to keep marijuana out of the hands of kids. 2, to keep the criminal elements out of the regulated industry. And 3, to minimize diversion to other states. We developed a robust regulatory framework that served as a model for many other states as they embarked on their marijuana legalization efforts. Colorado's system includes strict licensing and stringent public health and public safety regulations balanced with burden on the industry. These include fingerprint-based FBI criminal background checks, extensive financial background checks, and disclosure of all persons with a financial interest. Additionally, Colorado requires video surveillance, alarm systems, seed-to-sale track and trace systems, restrictions on edible marijuana-infused products, and mandatory testing for potency, homogeneity, residual solvents, and contaminants. There are also requirements for child-resistant packaging, extensive labeling requirements, underage compliance checks, and advertising restrictions. A key component of our regulatory framework was a focus on youth prevention, and very early into our implementation, we launched a campaign on youth prevention. Colorado is not experiencing an increase in youth usage of cannabis. Reports from the National Survey on Drug Use and Health, NSDA, and the Department of Public Health, the Healthy Kids Colorado Survey, confirm that. Additionally, Colorado has not seen an impact of cannabis use on high school graduation and dropout rates. In fact, graduation rates are not only up, they are the highest graduation rates that Colorado has seen in a decade, rising from a low point of 72% in the 2009-10 school year to 81.9% in the 2019-20 school year. Colorado's Department of Public Safety has also reported that generally crime has not increased. An area of major focus, however, is that law enforcement and prosecutors are actively and aggressively pursuing cases of illicit market activity. All of these programs are paid for by cannabis tax revenues. Overall, to date, Colorado has collected $1.6 billion in tax revenues since 2014. Excise taxes support school construction, and sales taxes are used to pay for the Marijuana Enforcement Division and other regulatory oversight, youth prevention, substance abuse prevention and treatment, public education campaigns, and homeless initiatives, in addition to grants to local law enforcement. Local jurisdictions use their taxes to pay for local initiatives such as public works projects and college scholarships, or they put it in their general fund. I strongly believe that the thoughtful regulation of cannabis is a far better approach than prohibition. And I'm going to leave you with just one last thought, and that is harm reduction constitutes more than decriminalization. To truly address and reduce harm, cannabis should be tested, traced, tagged, and taxed. Tested for potency, mold, microbial, residual solvents, pesticides, and other contaminants so that cannabis consumption is safe. Traced so that if cannabis is contaminated, it can be easily identified and recalled. Tagged to inform consumers and regulators appropriate information about the product, test results, product sourcing info, THC content, serving sizes, and taxed to raise the money needed to address the social costs related to cannabis, as I have mentioned them. Thank you for allowing me to appear and testify before you, and please let me know if you have any questions.
Thank you. Questions or comments from members of the committee? Representative Blumenthal.
Thank you, Mr. Chair, and thanks for being with us, Ms. Broll. Really appreciate you joining us. I was just wondering, is there anything you think we've been missing in this discussion, and/or are there any lessons that you learned in Colorado from which we should learn? Mistakes you made that you wish you had known when you started out?
Yes, thank you. One of the things that was really important to us was gathering data. And because if you don't gather data until you legalize, you can't tell what the difference is of pre and post. In particular, because pre-legalization, you don't generally stratify data by marijuana usage and other drug usage. It's all just drug usage or non-drug usage. So that was one of the things that I've always thought would be a really much better way to start. The other thing is to really address your edible products. As one of the other witnesses said earlier, when people begin to use it that are not sophisticated users, and I use that term with a kind of, it's an interesting concept, as medical patients are very sophisticated. They understand dosing. Individuals who are going to just start for the first time, and there aren't that many, but there will be a few that, you know, it's going to be a novelty bump interest. They're not understanding how edibles work. And so we had to put out a public education campaign that basically said, start low, go slow. And the reason was because when you have smokable marijuana or smokable cannabis, the effects are felt pretty quickly. However, edibles can sometimes take 2 to 4 hours before the effects are felt. And so they take more, and then they take some more, and then they take some more. And before you know it, they do have a very bad experience. So those are the kinds of things that I would definitely recommend. The other thing that I would recommend is one that we did do, and that is making sure that you have kind of a continuous improvement process throughout this, because there is no way to get this completely 100% correct the first time. You know, prohibition on alcohol, because I regulated alcohol as well, was, you know, ended 80 some years ago. And we still have every year liquor bills. So I'm going to tell you, there are going to be tweaks that you're going to continuously have, and that's okay. But bring in a group of stakeholders. Make sure that the industry is there, your regulators are there, law enforcement is there, parents groups are there, physicians are there, so that you can just hash it all out, and you will always come out with a better solution than if you don't use that stakeholder process.
Thank you. That's very helpful. And through you, Mr. Chair, one more question. Did you find that the kind of continuous improvement process, well, first of all, during the continuous improvement process, did you do that through regulatory changes primarily or through statutory changes? And would you recommend going through a repeated statutory process or passing some sort of enabling legislation that would allow the regulatory process to do some of those continuous improvements?
The Amendment 64 gave the state licensing authority, which is what role I played, great authority to implement these requirements. When the enabling statutes also gave the Department of Revenue's Marijuana Enforcement Division and me a great deal of authority to do that as well. So within the construct of what was already statutorily and constitutionally allowed, I was able to bring in that group and we could take a look at it. For example, when we found out that people were not understanding how to consume edibles, in other words, what was a serving size, how long do you wait, we brought the team back together and we were able to identify standard serving sizes, ensure that they were demarked so they could be easily broken, and that the tags, the labels were very clearly identified. And that we were able to do outside of a statutory process, outside of your legislative process, because I was given that authority. So I think that if you wanted to work faster, you'll have, it might be better to go through the regulatory process. But if you want to make sure that you're pretty strictly addressing things, you might want to put parameters around that in your legislative process so that the regulator knows what to do.
Thank you very much. And thank you, Mr. Chair.
Thank you, Representative Blumenthal. Representative O'Day.
Thank you very much, Mr. Chairman. And Ms. Brohl, thank you very much for your testimony. Are you in Colorado now?
I do live in Colorado now.
And you do not regulate THC content, is that correct?
No, we do not have a cap on THC content at this point. However, we do have a requirement that it be tested for potency and that potency be identified on the label.
And have you read the July 31 Department of Public Health Environment Report on THC concentration in Colorado?
I believe I've looked at it.
They're talking about the dramatic increase in the amount of THC. If you had to do over again, I know you were asked this question, a similar question. Do you think the legislation should have had a cap, at least in some form, or no?
What I will say is, if you'll give me just a minute to kind of explain why I'm saying what I'm saying. Actually, no, and let me tell you why. And the reason is because when you're regulating this, I wanted to make sure that we brought everybody who was using and consuming into the regulated market, because I could control those businesses. I could control a lot of things. I could control making sure that underage usage was minimized as much as possible, a number of those things, that it was as safe as possible. If there is a demand and that demand is not being satisfied by the regulated market, it will be satisfied by the illicit market. The illicit market doesn't check for IDs. The illicit market has extraction equipment that is not safe. And we had to actually make it illegal for individuals to extract, because there were actually homes being blown up. So what I'm saying is, if you want to really regulate this well, you've got to allow for everything that's going to be in demand in the process. And the only reason I say it is because what doesn't get, if they aren't able to obtain what they're used to getting, they will try to get it on their own.
Now, there's been some conflicting reports cited about increase in teen use. Initially, apparently, there was some articles written in 2016, 2017, there was some decrease in teen use, and then there was seen as an increase over the last couple of years. Can you tell us what your understanding is in the amount of teen use upon legalization and as of late?
From the people that study this from a statistical perspective, and I've talked with them, they tell me that it is not statistically significant, so that you'll always see a little bit of changes. What we have seen is the migration from smokable marijuana in teen use. So about the same amount of teen use. Okay, it's pretty much stayed the same or started to go down. But what they're doing is they're changing from the smokable marijuana into concentrates and other things like that. Now, I think it's because parents are becoming a little more in tune. They're watching, they're doing the smell test, they're doing things like that. But even so, that is what came out of the last survey that occurred and the last report that occurred in the last year. The Department of Public Health did not feel that it was necessary to do any changes immediately, except for continuing to educate parents, continuing to educate the youth, and continuing to educate and provide tools for educators as well.
So I don't know if you've been listening to the testimony all day. My big thing is trying to prevent the teen use. I'm very concerned about it, and I don't think this legislation goes far enough to educate and help prevent it. What is the best thing that Colorado did to help reduce or limit teen use? And what, if you could do over again, would you implement to prevent or help reduce teen use?
So education, public education, I think is really important. And I think it is absolutely critical, because parents don't always have the ability to really understand what kids are putting in their mouths necessarily when they're teens. They're not always with them. So one of the things that we did, and I would have liked to have done that at the very beginning if, hindsight's always 20/20. And that is we put a lot of restrictions around edibles. So we developed a universal symbol, and every edible had to have that universal symbol imprinted upon it, either stamped in it, branded in it if it was a muffin or whatever it was, but it had to be there. And it had to be on every single serving. So if you had a candy bar that say had, 6 little squares in it, and they were each, one serving, every single one of them had to have that universal symbol on it in order to make sure that if it was left out and someone else saw it, that they would be able to identify that it had THC in it. I heard from parents, I heard from educators, I heard from school resource officers that this is what they needed. They needed to have everything identified, not only on the label, not only on the wrapping, but on the product itself. In addition, for those things that you can't imprint the universal symbol on, such as liquids or like granola, we required that those only be in single servings. And that was so that you wouldn't really be able to take the liquid out of the bottle necessarily. It wouldn't make sense. Or if it was only a single serving, or the same thing with bulk products. So, and in addition, what we did is we said that they could not be in, in shapes of animals or people or anything like that, that could also, maybe, cause a smaller child to inadvertently consume. So those, you and I are on the same page. I really tried hard to make sure that we limited underage use, all the way from very small children all the way up until, teens. So those are the kinds of things that we always were looking at. And frankly, having those stakeholder work groups and having physicians, having parents groups, having the industry itself come in and talk really helped, because what we found is the industry also wants to be compliant. They put a ton of money into this and they don't want their licenses revoked. So they were willing to do whatever was necessary to help us put together a good system.
So do you have a medical background in any way?
No, I have a legal background and a regulatory background, but we worked very hard with public health. We worked with a lot of the physicians out of Children's Hospital.
And I certainly wish we could have had public health here today. And I know that the governor's office is committed to providing their testimony. My question to you would be on page 32 of that July 31, 2020 report. It says at the very bottom, evidence statement, we found substantial, and the word substantial is in all caps, evidence that THC intoxication can cause acute psychotic symptoms, which are worse with higher doses. Have you, in Colorado, was there a finding of particular medical problems associated with chronic or high THC content use on a regular basis?
I don't know if there was. What I will tell you is that we are trying very hard to make sure that that's where those public education campaigns come in. And the fact that, if someone is having a negative experience, bring them into the hospital, take care of them, don't leave them at home, those kinds of things. But I think what I will say is this. What we found when we were doing our demand studies, and we were doing a lot of the studies as to who is consuming, for the most part, the people that were already consuming continued to consume. For the most part, people who were not consuming continued not to consume. Then you have a little bit of a bump in the middle. You have those that are adults that had two things going for them. One was either they had a novelty bump kind of thing. It seemed like it was very cool now and it's legal, so let me try it. I never did before. Or what we started to find was the over 60 crowd started to increase their usage as well. And we think that was a wellness type of thing. But obviously you're going to have teens that are going to try alcohol, that are going to try marijuana and other things that they shouldn't be trying. And so that's where we have the Colorado Kids Healthy Survey, the Colorado Survey Healthy Kids program. And that's where we try very hard to educate them on a number of issues that are harmful to them, including the usage of cannabis.
All right, I'm not going to belabor. I very much appreciate your testimony. Have you been in contact with anyone in the governor's office as they were developing this legislation to help, or is this?
No, I have not. I have taken a look at it a little bit, but I've not been in contact with the governor's office.
Were you asked to testify here today by anybody?
Yes, I was asked by the Marijuana Policy Project. And the reason for that was because of the fact that I have testified in front of other state legislatures, and I have testified in front of other countries' legislative processes. And for me, I'm very independent because I have a regulatory background, but I have a very, my position is harm reduction. And that's why I gave you that last little spiel. And so I want to reduce the harm of anybody who is consuming, and I want to reduce the consumption of teens.
That's my number one goal. If somehow we could figure out a way to let people over 25 decide what they want to do. But my concern is that they see their parents smoking or doing edibles, and just inevitably you have higher teen use than if you legalize than when you don't. But I appreciate your testimony, Ms. Burrell, very much. Thank you. And Mr. Chairman, thank you for your indulgence.
Thank you.
Thank you, Representative Palm.
Thank you, Mr. Chair. I have three questions, ma'am. One is, in 2016, the Denver Post said that they did a survey, or the state did a survey about whether or not voters regretted the decision. Do you have periodically, do you review as a state what the public thinks over time about that decision to be the first in the country? And do you know how the satisfaction rate generally polls?
Yes, generally it polls well, and because people are believe the same way that I do for the most part, and there is enough freedom around it. And let me tell you what I mean by freedom. Local jurisdictions are not mandated to allow for the cultivation, the product manufacturing, or the sale of cannabis in their jurisdictions if they don't want to. They can ban it outright. And many have, and many have not. So local jurisdictions can actually decide on their own. And within that, so can the people within there, because the constituency within that local jurisdiction, it's a representative government, they understand that. But for the most part, people are not, when you take a statewide survey, I would say that you're still gonna have the majority, more than 50%, that will say this is, they want to continue with this process. Are there problems? Sure, as we've discussed. But what we want to do is just continue to make it better.
Thank you. My second question is about the amount of income. I keep seeing differing figures, but 2 billion or so. How much of that goes into the general fund for the state?
Well, to date, there's been 1.6 billion state tax that has been collected since 2014. So it's all kind of lumped together. Excuse me. It doesn't go into the general fund initially. It goes into the marijuana tax fund. And from that, because in Colorado, we have something called the Taxpayer Bill of Rights. And when you impose a new tax here, you have to go to a vote of the people, and you have to tell the people what you're going to use it for. So this was to be used for marijuana purposes. And so it was to be used for regulation and youth prevention processes and a number of things, like as I mentioned before. And that's what it's used for, as well as some school construction. There is the ability, though, however, to, at different points, move some of that into the general fund, but not very much of it goes in there. The majority of it gets directly appropriated to different things. For example, a couple of years ago, about 4 years ago, we started appropriating directly to local law enforcement so that they could go and do their work much better than they were able to with the appropriations that they were getting. And so those are the kinds of things that it does. And so, and the reason, so let me just give you one thought too, and that is, I think it's a good thing that it doesn't go directly into the general fund. And the reason is because when you begin to depend on money for everything from roads to, whatever, you might not make the best policy decisions going forward as a result of that. What this does is, because we're not dependent on that for road construction or anything else, we can make really good policy decisions, our legislature can, and know that they're not then defunding something else. So, but as I said, it does take care of all of its regulatory requirements.
Thank you. And the part that gets diverted for the local police, and you said so they can carry out their work, that includes work that is not specifically cannabis related? So
no, it's cannabis related. It's generally cannabis related.
There's
two tax dollars that go to the local jurisdictions. One is from the marijuana tax fund that gets appropriated for their cannabis work in, illicit grows, those kinds of things. But they also, each local jurisdiction that has a store within its jurisdiction will get a certain amount of sales tax revenue that goes back to them, and they can use it for whatever they want. Some have, paved their roads completely. They have no potholes. Others have done other public works. They've, built new buildings. Others have used it to provide scholarships for college students. So, and then they can use it for, additional police officers if they choose to as well.
Okay, thank you. And then my last question is concerns one of the sticking points that we've been grappling with all day has to do with equity. And obviously, I think it's a pretty well-known fact that Connecticut has among the worst disparities of poverty in the nation, probably far worse than yours. So my question is this the thing that you had to grapple with in forming this bill? Was there an equity piece having to do with expungement of records and incentives for minority businesses and the kinds of things that we're grappling with?
No, we didn't do that at the outset. And because remember, this was a constitutional amendment, so it's a ballot initiative. People were voting for it. We were the first that it ever voted it in. So it was written pretty narrowly. And I think had there been items in there like criminal expungements and things like that, it may not have passed. And so I think the drafters were very careful. Now, I will tell you that what will happen or what may happen if you don't have some sort of social equity piece in it from the beginning is that you will assign all of the licenses to the potential licensees. And then what will happen is that there will become kind of a sufficient number of businesses already there. And so when you do try to retrofit social equity policies, they may not fit really well. And so it's best to do it from the beginning because it's really hard to retrofit it. However, having said that, you also want to make sure that perfect isn't the enemy of good. And so you may have to figure out a way. My recommendation would be to figure out a way that you allow for, say, a certain amount of social equity, but provide maybe some guidance to a regulatory body or to another committee that will then flesh it out and with a requirement of what needs to be done so that you can get this through and then you can continue on, because it's going to take some money to do all of that. And so that money will probably come from your tax revenues in being able to either educate disadvantaged communities or disadvantaged businesses, those kinds of things, or to allow for loans, things like that have to happen. And so it's an interesting thing. And if you look to see what Illinois has done, they actually tried for probably 3 years to legalize, but couldn't get enough of their social equity components in it. And finally, they were able to get that in. And so since Colorado did not do it from the beginning, I think you'd be better informed by looking to see what Illinois has done.
Okay. Thank you very much for that insight. Thank you, Mr. Chair. That's it for me.
Thank you, Representative. Representative Fishbein.
Thank you, Mr. Chairman. Good evening, ma'am.
Thank you.
I see on the list that you're signed up under BJ Broll Strategies. Is that do you work for?
Yes, I have a small consulting company. I consult in regulatory affairs and government work.
Okay, so you're being paid to be here today?
No, I'm not.
Okay. I'm a little puzzled because on the CTN feed, it doesn't mention BJ Broll's strategies. It says former executive director and chief cannabis regulator, the Colorado Department of Revenue. So I don't know where that came from.
I am the former executive director of the Department of Revenue in Colorado and the former state licensing authority. I was on Governor Hickenlooper's cabinet until the end of 2017 when I left. And then I started a small consulting firm to do government consulting, government affairs. And because of the 6 years that I spent regulating cannabis, this is a major part of what I do.
No, I understand. I'm just trying to figure out where they got that from because the list is different. But you left Colorado Regulation Department of Revenue in 2017, right?
Right, the end of 2017.
And in your role there, you didn't work with the Department of Public Health. You were a tax attorney, correct?
So the Department of Revenue had responsibility for taxation as well as for the Marijuana Enforcement Division. So the Marijuana Enforcement Division, all of the individuals who did all of the licensing work, all of the compliance work, all of the auditing work came from my department. We worked very closely with the Department of Public Health and Environment on issues that were closely related, as well as the Department of Agriculture. And then ultimately we brought in the Department of Regulatory Agencies for banking purposes and other things like that. So one of the things is that what we did is we had what was called a marijuana working group at the cabinet level. And we would get together the department heads of all of the agencies that had some impact in this legalization effort and afterwards to address issues that were common. For example, let me give you an example. Pesticide use, that really required a very close coordination between the Department of Agriculture, the Department of Public Health, and the Department of Revenue's Marijuana Enforcement Division in order to make sure that we identified prohibited pesticides that we considered a public health issue if they were used, and my department then would go in and make sure they were not used.
Okay, thank you. Thank you, Mr. Chairman.
Thank you, Representative. Representative Dubitsky.
Thank you, Mr. Chairman. And I appreciate your coming in to testify today. You've given us a lot of information about what goes on in Colorado. Have you read the bill that's up for debate today?
I have read the summary, but I haven't, committed it to memory.
Okay, so you haven't read the actual bill?
No. Are there things in the bill that you would like to discuss?
Well, I was going to ask you what you thought about the bill, but if you haven't read it, I'm not sure we would be getting an accurate representation of what you think about it. Why don't you tell us what you think about what you've read in the summary?
Well, I think that it's very similar to the one that Colorado has as well. I mean, there is a portion of being able to have on your person, so to have in your possession a certain amount of cannabis, and that is what we do as well. There are some requirements around business licensing, and those are the kinds of things that I think are really going to be important. Doing the background checks is important. We did really extensive criminal background checks. I think that's really important if you're wanting to keep the criminal element out. Also having extensive financial checks. We kind of use the model of gaming and gaming licensing because I also regulated that. And so those are good things. And I've kind of started to see how you're doing that. Taxation is going to pay for all of the things that you want to do. The thing that was really of interest to me, frankly, was your Social Equity Commission and the things that you were going to do from a social equity perspective. I really liked the fact that you're going to be using portions of tax dollars to support these communities that were disproportionately impacted, setting up some real specific qualifications. The one thing that's really going to be important is that, and I think that's where you get into ownership and financial interest, because what we've seen across the country is there's a tendency at times to have the minority business owner be basically a figurehead, and others are actually running it. And if you really want to make this a social equity piece, you want to make sure that you're doing it in that way. I like the lower fee structure. I really liked, especially, was the part where you would have businesses assist businesses that were already established, assisting those that need to become established, because I think that's kind of the concept that you have when you have a prime contractor, and then you have some of the subprimes that go in, they work together and they get to learn from each other. So those are the things I think that were really of interest to me, because like I said, Colorado, we're retrofitting it as we speak.
Is it your feeling that in Connecticut we would have pretty much the same results as you had in Colorado?
I don't know. I think you can put in place the regulatory process that you can get some of the same results. Let me just tell you, the Marijuana Enforcement Division has probably about 120 people that work there. The majority of them are investigators and licensed specialists. And so there was a great deal of emphasis on doing that. I don't really know whether you're going to have a separate Marijuana Enforcement Division type of agency, or if it's going to be, some other states have just added it to their liquor control boards, and they are two very different animals to regulate, especially because one is not legal at the federal level and one is. One you can transport across state lines and one you can't. So there may be some things around that. So I can't really say what your results would be without knowing how you plan to staff your agencies and what their requirements would be.
And reading the bill, of course.
Yes.
Okay. Well, thank you for your time. I appreciate your coming. Oh, one more thing. You had said that there was some entity that had asked you to come in and testify today. Who is that?
That entity was the Marijuana Policy Project. And I don't work for them. I'm not consulting with them. It's just that they understand the kinds of testimony that I have done in other states. And so they asked if I would be willing to come in and testify here. And I said, yes.
Okay, thank you. Thank you for your time. Thank you, Mr. Chairman.
Thank you, Representative. I do not see anyone else. Are there any others who would like to ask a question or make a comment? Seeing none, thank you very much for joining us this evening. Enjoy the rest of your evening.
Thank you very much. Thank you very much. I really appreciate this.
Thank you. Representative, Mayor Justin Elicker, you have 3 minutes.
Thanks, Senator Winfield. I just want to start by saying it's a long night for me, so thank you all for all that you're doing. This is going to be a very long night for you all. Senator Winfield, Representative Staffstrom, Ranking Members Kissel and Fishbein, and members of the committee, I'm here to speak in support of cannabis legislation. Despite decriminalization, Connecticut does not currently have a system to regulate or tax an industry that already exists within our state. Instead, consumption of cannabis remains without oversight and does not utilize revenue from its sale to address the long-standing inequities caused by its prohibition. The governor, including this proposal as one of his priorities, is a major step forward from years past. And as you know, advocates have been fighting an uphill battle to put a serious proposal for the legislation of cannabis on the table for years. And I want to acknowledge the governor for putting this bill in front and center, and hopefully will lead to a long-awaited passage in this session. I also recognize that those same advocates, many of them that have spoken today and within the legislature, do not believe the bill as currently written does enough to ensure that the legalization of recreational cannabis benefits the communities most harmed by its status as an illegal substance for the past several decades. Black and brown communities have disproportionately been impacted by the war on drugs, systemic racism and inequity, and a criminal justice system stacked against them. In the legalization of cannabis comes an opportunity for both entrepreneurship and for additional revenue from taxation. These opportunities in the investment of tax revenue must be to the benefit of those communities, and legalization should only take place if that's its principal impact. Members of the New Haven delegation have been advocates for years regarding the ways legalized cannabis can be done thoughtfully and equitably. House Bill 6377 includes a range of proposals that would make the legalization of recreational cannabis more equitable, and I firmly stand behind the efforts of Representatives Porter, Candelaria, and Senator Winfield, and many others who have done this work for many years. I do not, however, believe that this must be a question of either or. The governor's bill can be the vehicle by which we achieve legalization, so long as the recommendations.
Mayor Ellicott, just so you know, we're not directly mentioning other bills.
Okay.
We're just talking. Thank you.
Fair enough. Thank you. Thank you. There's an urgent need for investment in our communities, support and access to capital from our minority business owners, opportunities for our reentry population, and more. I'm confident that everyone is willing to work on behalf of Connecticut residents to get this right. Let's work together to ensure that in this legislative session, recreational cannabis is legalized and that it is done in a fair, equitable, and thoughtful manner. Thank you again, all.
Thank you, Mayor Ellicott. Representative Dubitsky.
Thank you, Mr. Chairman. Thank you for coming in to testify. As with a lot of the people who came to testify about who from the cannabis community, you seem to think that this bill is fatally flawed. So I'll ask you the same question. If it were a choice between this bill unamended and nothing, which would you rather see pass, this or nothing?
Thanks for the question, Representative Dubitsky. I don't think the bill is fatally flawed at all. And I think, as all of you know best, this process is one where the language of the bill will likely change over the coming weeks. And I think there's a huge potential here to hone and craft the bill to make sure that it's right for passage. I think that
that was not my question.
I'm working on answering your question, Representative Dubitsky. I think that we have a lot of potential, not just in this session, but should this pass, even in its current form in future sessions, as the previous person testified, to make sure that it is right. As many things, this is will be a living document that over the years will change.
Okay, so you'd rather see it pass in its current form than nothing at all?
I think that's fair to say.
Okay, thank you. Thank you, Mr. Chairman.
Senator Winfield, you're on mute.
I hit the button twice. Thank you, Representative Dubitsky. Representative Porter.
It's getting late, Senator Winfield. No questions for the good mayor of the city of New Haven. Just wanted to thank you for coming out tonight, hanging in there with us, and for your testimony. Thank you, Mr. Chair.
Thanks, Representative Porter.
Thank you, and I hit it only once this time. Senator Haskell.
Thank you so much, Mr. Chair and Mayor Ellicott. It's great to see you. Just one very brief question. In media reports covering cannabis legalization, the revenue that it brings has often been referred to as honest. The IRS is expecting $33 million in the first year of sales, rising to $95 million.
It's a little bit hard to hear you, Senator Haskell. I'm not sure if it's me or.
Oh, it could be me. I'm on.
Oh, it's way better now. It's way better now.
Way better? Okay, great. I was just saying the revenue projections have been referred to in the media as very modest related to cannabis legalization, rising from $33 million in the first year of sales to eventually $95 million. And of course, some of it will eventually go to reimbursing distressed municipalities. Some of it's going into pilot. I think of New Haven as a prime example for why it's so critical that we fund pilot. So I just wanted to give you an opportunity, if you'd like, to talk about why it's critical that even if this funding might be thought of by some as conservative estimates or perhaps modest, why every dollar into pilot would be helpful for your city.
Yeah, I mean, I think that the revenue question is important here. The use already exists, and it's important that we take the opportunity, especially when there's other states doing it, to tax that use. And every dollar can certainly help New Haven, as many of us that are living in New Haven know right now, and certainly as we try to close this deficit that we're seeing in this coming year. But I think that the bigger picture is about the inequities that have been created over many, many years, particularly in communities of color. And we're seeing the negative impacts, not just on the revenue side, but on the fact that we have 900 people returning to New Haven who have a criminal record every year. And some of that history is related to criminalization due to drug use and drug sale. And that imposes an incredible cost on our city, not to mention the ethical issues around not giving people an opportunity to re-enter our society and take the next step. So I think that the components of expunging records and making sure that we're giving people that have historically been negatively impacted by this an opportunity to potentially benefit economically can help us much more than even the revenue component of this bill, which certainly will help as well.
That's really helpful to know. Thanks for sticking with us in this long hearing, Mayor Elicker, and thank you, Mr. Chair, for the time.
Thanks, Senator Haskell.
Thank you, Representative Rabinbis.
Good evening, Mayor. Thank you, Mr. Chairman. Mayor, I don't know if you had an opportunity to hear some of the testimony earlier regarding the allocation of the tax revenue in Colorado, a significant portion being allocated to future education as well as current education to not only parents, but our youth regarding the risks of marijuana use, et cetera. And earlier, we also had representatives from the communities that have challenges and mental disabilities, et cetera, that this would have also a very strong negative impact in that regard. I thought I'd pick your brain a little bit, especially in light of the fact that certainly, you're passing local budgets and things of that nature. Looking at the scheme of the potential revenue that's being represented, would you agree with the estimates that are being made regarding the tax revenue that would be received from the taxation of this in the state of Connecticut?
I wish I could answer your question, Representative Rabinbis, but I do not know the details of how the revenue will be distributed. I can talk to you about New Haven revenues and expenses till the cows come home, but I can't give you any answers on the details there.
Okay, and I could certainly appreciate that. And Mayor, would you have an idea as to what percentage would be adequate in order to provide for either, let's say, rehabilitation facilities? As you know, we have a huge shortage in that regard of beds for people who need to go into rehab, things of that nature. And it's been pretty, testified to this evening that there potentially could be a lot more impact on people with mental disabilities needing assistance. Do you have any thought as to the breakdown of percentages of what the tax revenue would bring in, what should be allocated to education, what should be allocated to addiction, what may be allocated to law enforcement?
Yeah, I can't give you an answer on that. What I can say is that when you compare the city of New Haven to a lot of our suburban communities and our ability to fund many of the resources, it is already overwhelmingly inadequate compared to other suburban communities. So the state's ability, we've talked about pilot, but in this bill and many other bills to help try to support communities that are really struggling right now is vital.
And I would absolutely 100% agree with that in that regard, which is one of my other concerns, as the testimony earlier was regarding the locations of some of these facilities tend to be in the cities and dense areas, especially if we're talking about trying to really identify those communities that have been disproportionately potentially hurt as a result of the war on drugs in that regard. So potentially there could be a stronger strain. And also I think, the cities, for many different reasons, transportation, resources, and the like, certainly are hard hit when it comes to individuals with challenges. So that's a strong concern of mine as well. So I just, again, thank you so much for taking the time to testify before us, especially at this late hour. But certainly your perspective and the experiences that cities are currently experiencing, I think, is something that we need to seriously consider as we move forward in this regard. Because unfortunately, I think the focus has been a lot on, what could we do for the state of Connecticut, whether if it's road repairs and other types of filling in budget deficiencies, it's late, deficiencies that we may have. But I think we really need to focus on what we need to do moving forward. If this were to pass, education, additional beds for addiction rehabilitation, things of that nature, and additional services. So once again, thank you very much for taking the time. Thank you, Mr. Chairman.
Thank you, Representative Rubimis. And if I may just respond to that, I think there's a temptation to specify where exactly a lot of the funds will go for many of these types of bills. And while I appreciate the spirit of that as the chief executive in New Haven, it makes it increasingly difficult when there is a lot of restrictions on every piece of revenue that we have. And so I do encourage you all to invest in the things that you think are important, but at the same time, consider the bigger picture and the flexibility of the executive to make sure that they spend funding on the vital sources that the state needs in general.
And I'd certainly agree with that, and hope that moving forward, these are discussions that we'll have to be realistic as to where this funding has to go. Thank you again. Thank you, Mr. Chairman.
Thank you, Representative Rubimis. Representative Fishbein.
Thank you, Mr. Chairman. Good evening, sir. How are you this late hour?
I'm good, thank you.
Being a former resident of your city, my ears peaked when you were mentioning 900 people per year return to your city. Can you just repeat or just tell me what was going on there?
There's 900 people coming out of prison each year that return to New Haven.
Okay, so, and I think
approximately, obviously.
Okay, so that's prison from marijuana or from just anything?
It's from everything, from a variety of different things.
Because I don't know if you were here earlier today, there was a lot of testimony to the effect that nobody's in prison in Connecticut for marijuana. It might be a VOP, a violation of probation, but so I didn't know the relevance of that to what we're doing here tonight. Was there a reason why you wanted to? I didn't understand the connection.
Sure, I think there's a strong relevance. While we have decriminalized marijuana in Connecticut, historically, marijuana has been associated with criminal activity and was a crime in the past. And anytime someone has gone to prison and comes out, there are incredible barriers to them re-entering society. There's barriers to them getting a job because people look at a criminal record and make it difficult for them to get a job. They make it difficult to get housing. It's very, very difficult to get housing. And therefore you create a cycle where people continue to go back to prison when they come out. Recidivism rate is very, very high. Over 50% of the people that go to prison go back to, or come out of prison, go back to prison in the next 3 years. And so this is a cycle that we have to break. And marijuana is a significant contributor to that historically, even though today it's decriminalized.
To the crime aspect, or, I understand the second chance society aspect, and I understand the implication and all of that stuff of somebody getting out of prison. And, we're working on that through other vehicles, but just trying to draw the connection here, but I'll continue to think about your statements.
Thanks, I appreciate it.
Thank you, Mr. Chairman.
Thank you, Representative. Brad, are there other questions from members of the committee? Representative Statstrom.
Thank you, Mr. Chair. And Mayor, good to see you. And I certainly want to thank you for I think your tone is a correct one in my mind, at least, that while this may not be a perfect bill, it is a start of a framework, as I think you said to Representative Vitsky. But what I wanted to hone in on, and I think you're one of the only people we've had some 12 hours into this to actually talk about the governor's proposal to send half the funding back into the pilot program as a result of this. Do you believe that's where the funding should go? That half of the funding from the sale of recreational cannabis should go into the pilot pool?
I mean, I'll be direct that our cities desperately need funding. and are struggling. There's many of struggling towns that are facing serious economic challenges as well. They desperately need funding. And whether it's through MRSA, whether it's through pilot, whether it's through some other avenue, we need funding. And, you know, as mayor, it is unbelievably important that particularly municipalities that are struggling right now because of historical structural problems in the state of Connecticut, where we don't have counties, where we don't share our resources, where cities have, you know, New Haven 60% non-taxable property, and we're heavily reliant on real estate taxes in the state because of all those structures. We need that support. I feel quite strongly that pilot is a good avenue to ensure that that funding comes back to cities like New Haven that have a history that has been significantly negatively impacted by the state policies around cannabis. That's not the only avenue whereas a state could do that, but I think pilot is quite a good avenue that the state has already created a significant structure around.
But will you agree with me that the current pilot formulas we have, predominantly the vast majority of the pilot funding in the formulas we currently have support 2 municipalities in the state? The vast majority of the funding goes back to Hartford and to New Haven, and not nearly the same percentage goes to the other distressed municipalities in the state. Correct?
You know, I think that, for example, this new tiered pilot formula, and I want to be careful not just to focus on the marijuana bill at hand, but the tiered pilot formula benefits many municipalities around the state. And those municipalities that, because we're heavily reliant on real estate taxes, have a very large percentage of non-taxable property, makes it very difficult for them to raise revenue. In New Haven and Hartford are 2 examples of those. But there's many others around the state that have a large percentage of non-taxable property. I mean, Hampton's another one. And it makes it, because of the state's heavily reliant real estate, or causing municipalities to be heavily reliant on real estate taxes, it makes it very difficult for municipalities to raise that revenue, and pilot is a way to balance out that inequity.
I guess I understand that. I guess what I'm saying is, if we're trying to say a significant portion of the funding should go back to either distressed municipalities generally, or to the communities most impacted by the war on drugs, that there should be some recognition that should be based on some either population formula or some other socioeconomic formula other than just those 2 communities that seem to have a much higher percentage of, at least under the current pilot formula, partially because they have wealthier nonprofits than others. So I guess my question is, are you're, I would say, quasi support of this bill? Is it tied to the fact that the funding is currently going to pilot, or are you open to and appreciative of some other formula to get money back into those distressed municipalities or those communities who are most impacted by the war on drugs?
Representative Stafford, let's be real. Bridgeport has been impacted very significantly by this as well. And municipalities like Bridgeport and New Haven shouldn't be fighting for funds. We should be working together to ensure we both uplift each other and make sure that we get the resources that we need.
Sure. Thank you.
Thank you, Representative Stastrom. I don't see any other questions, so thank you for joining us here tonight, Mayor Elicker. Hope you have a great night.
I'm going to go to bed. Thank you all. God bless you for keep it up. All right.
Bye. We have Brian Renier. Is Brian here? Brian, I see in the list. Are you here? Is John Blair here?
I am here. How are you, Senator Winfield?
I'm doing well. You have 3 minutes.
All right, I'll be quick. I'll be under the 3 minutes. Good evening, Senator Winfield, Representative Staffstrom, Senator Kissel, Representative Fishbein, members of the Judiciary Committee. Thank you for the opportunity to present testimony today. My name is John Blair, Associate Counsel at the Connecticut Business Industry Association. CBIA is Connecticut's largest business organization with thousands of member companies, small and large, representing a diverse range of industries from across the state. 95% of our member companies are small businesses with less than 100 employees. Today, we're focused on Employer Protection Section 84, 85, and 87 of Senate Bill 888. CBIA is encouraged to see that these sections within the governor's proposal already include some employer protection language. CBIA would like to keep an open dialogue with the governor's office to ensure reasonable employer protection language is part of the final drafting of this legislation. The legalization of cannabis for recreational use is a serious matter that will impact every element of our state, including businesses. Employers of all sizes across all industries are validly concerned about how the legislation of recreational cannabis will affect safety of their workplace, the health of their employees, and exposure to liabilities and contractual relationships with vendors and customers. It is important to recognize that 9 other states have passed recreational cannabis laws, and employer protections that retain the right to conduct a pre and post employment screening test and the rights to refuse hire based on positive test results. Affording employers reasonable protections to protect their rights to ensure a cannabis-free workplace is commonplace and is in the best interest of all employees. We look forward to continuing work with the governor's office on sections 84, 85, and 87. I'd be happy to answer any questions.
Thank you, Mr. Blair. Are there any questions? Rep. Stastrom, is your hand up from last time?
No, Mr. Chair, just super briefly, if I could.
Oh, sure. Yeah.
Mr. Blair, I recognize that you're new in your role, but this bill or iterations of it have been before us for several years in a row. I'm wondering if CBIA has presented either in your testimony or elsewhere language that it would find palatable on workplace protections.
We are working, we talked to the governor's office this week, Representative Staffstrom, so we're alerted to the fact that we could work with them to produce some language. So I am working with some of our member companies just this week to begin to draft up some language. So we don't have it readily available, but we're assured by the governor's office we can continue to work with them to come up with something that works for everybody.
Frankly, sir, I've been asking for that language from CBIA for the better part of 4 years. So if you could hurry up and get us the language that's acceptable to you